morning and welcome to Making Law Simple. My camera's a little askew. It is early. It is 6:43 in the morning my time, but welcome everybody. We are going to finish up from day 5, where we left off. I might be in and out a little bit, but hang on a second. Okay, so we're gonna yes, I'm early this morning. Welcome all everybody in chat. We are going to finish up where we left off. I think I found the right spot. There was a lot of interesting things because of course I did continue to listen. I just wasn't streaming it. So there's a lot of interesting things that came out of these text messages that we're going to go over. But I do have closed captioning up, so that's nice. It's nice to have that. In the meantime, I'm going to play it at 1.25 speed just to make sure that we have enough time to get caught up before we go live with court, which should be in about, I don't know, hour and 45 minutes or so. And we have 2 hours of testimony, so that's why I'm speeding it up a little bit. You missed the best part about Jennifer getting into the Costco. Getting it on in the Costco parking lot? Oh, God. Okay. Well, I imagine 2 years ago was a little different story than it now, but still gross. But let's get going with it.
Knowing Jennifer, did you believe she felt horrible? You wrote back to her in response to that comment, you didn't do this, correct?
Correct.
And on page 35, I'm scrolling down further, she lets you know, I'm scared, correct?
Correct.
And you say to her, I bet you literally need to disappear once you are free to do so, yes?
Yes.
Why were you suggesting that she needed to disappear?
Just because of the public, everybody knowing everything that's going on with their names and everything, you just can't be in the public once that your name's out like that.
So not being in the public, you were suggesting to her, you need to disappear in terms of not have the public see where you are, things like that, correct?
Correct.
On page 36,
Well, I mean,
Mrs. Crumbley is
when you
talking
got to
to you a
get it
little bit
on,
more
right?
and mentions to you, my son did this.
This
I
is
still
Costco
can't
parking
even
lot
figure
romance.
out
You just
where
saw
his
that.
brain snapped,
That's
correct?
Correct.
That was what she said to you on December 1st, so the day after the shooting, correct?
Correct.
And your response to her, when she says she doesn't know how his brain snapped, was, I do not know, right?
Right.
You have no idea what could have happened.
Correct.
You had no idea or reason to see personally that something like a shooting was going to happen, right?
Correct.
So when you were testifying earlier that you had concerns that day and thought a shooting might happen, that's a new opinion you have that's different from this day when you were messaging Jennifer.
That was, I wasn't ever thinking a shooting was going to take place. I was thinking more he would hurt himself.
So you never thought a shooting would take place at that time, after that time, or now?
Correct.
So if you were concerned about anything from any conversations with Jennifer, it was about him hurting himself.
Correct.
Jennifer goes on and she's talking to you further about her reaction to everything that happens. And on page 36, she tells you, I want to die. Is that fair?
Yes.
And on 36, you told her, be careful of anything you type on Messenger or text. It will all be subpoenaed and kept track of. The FBI is involved. They can access anything and everything, correct?
Correct.
And on that day, you were informing Jennifer, just know everything you say, law enforcement can get.
Correct.
And you were sending that because that's what you believed.
Correct.
And this is an example of everything they could get, correct?
Correct.
And at no time did Jennifer say to you, delete certain messages or anything, correct?
Correct.
And she didn't say to you, oh God, I gotta go delete all these messages, right?
Correct.
In fact, she just keeps texting you through the next couple days through Facebook Messenger.
Correct.
Even after you gave her the advice, they're gonna get it all, yes?
Yes.
I'm going down to 39. And at 9:25 a.m. on 12/1, Jennifer Crumbley's told you that he is being arraigned and tried as an adult, watching it now. You would agree with me she's talking about her son at that point,
Yes.
the shooter.
Yes.
You told her you had just heard it and asked how she was doing.
Correct.
And her response at 9:26 was, I'm sick.
Correct.
And then I'm going down to page 40. I'm skipping a couple messages, but if you need me to go back, you can let me know. Trying to find a place to stay right now. Jennifer sent that to you at 9:47 in the morning. Yes?
Yes.
And you would agree with me that when she sent you this text and said, trying to find a place to stay right now, you knew she could not go to her home.
Correct.
And you also would agree with me that this was at a time when there was lots of threats, as we've discussed.
Objection, again, specificity, and we've already talked about this.
There was negativity. There was lots of negativity, correct?
I think that's a determination for the jury to make.
Now, on page 41, you say to Jennifer, I'm glad you're safely out of the area. Jen, I can't even imagine being in your shoes. Why did you say those things?
Going back to like all the messages and everything where something involving her family or something happened and I can't imagine being in shoes like that, bro.
Now, going down, she's asking you if you've heard anything, any other rumors, correct?
Yes.
You're telling her, I haven't heard anything.
Correct.
And then she says to you on 12/1 at 11:10, we heard we may get charged too, correct?
Correct.
And your response at 11:12 was, that was mentioned on a news station. I don't know how both of you can be charged. I can only assume they will charge James with the handgun not being secured, correct?
Correct.
Now, at that point, there was a message that was unsent that said, we had the string lock on it, came with the case, correct?
Hold on, objection, unsent, was deleted.
Right.
Already been sent.
Okay,
So,
go ahead.
okay, so the message she sent you that was deleted is we had the string lock on it, came with the case.
Correct.
Okay, so Jennifer's representing to you, we had the gun locked.
That's the message I'm seeing now. I don't know.
Okay,
I don't.
that's the message you're seeing now,
Correct.
and that's the message the prosecution is saying she unsent you.
Correct.
Objection, it's not the prosecution saying this,
Yes,
it's the evidence.
the expert who testified about
Thank you.
what happens to unsent messages.
Well, I don't believe that he would know what the expert said, but Mr. Keyston's questioning said,
Okay, well, his objection was that you mischaracterized that.
okay, the message about we had the string lock on it, do you know what a string lock is?
There isn't a string lock, but I know it was being referenced to it. A
What?
cable lock was being referenced.
A cable lock?
Correct.
So the message to you does not say, oh my God, the gun was unlocked, right?
Correct.
Even if she unsent the message to you and you never got it, the message says, we had the string lock on it.
Yes, deleted, again, it's mischaracterizing the evidence.
It's unsent.
Well, no, it was sent and deleted. They retrieved it
Yes.
through extractions.
Okay, but I guess my point is the message that was retracted does not say we left it unlocked. That's what I'm asking.
Edward, he can testify that what the messages are. I introduced the exhibit. Edward Wogrowski already testified to what this means. So I think that speaks for itself.
Well, I think she switched to a different question. You didn't get a message from her but saying that the gun was unlocked.
Correct.
On page 44, there's another message that appears to be deleted. Deleted or unsent. Which word would you prefer me use? Deleted,
It's not my word,
retracted?
Judge.
I'm asking you just so
Asking
we
the
can avoid.
counsel.
Pick a word.
I don't want to be addressed by
Okay.
counsel.
Okay, well, ask the question. Okay, there's another message that was sent. and
Pick a
then-
word. I
Okay,
like this.
there's another message that indicates it was unsent on page 44.
It would have been message that he received, right? So it would have been message he received.
Okay, so the message was everything was secured, not loaded, bullets stored away separately. Oh my God, oh my God, oh my God. Correct?
Correct.
Jennifer did not send you any messages that says we were careless with that weapon.
Correct.
She did not send you any messages like, oh my God, we left it unlocked and left the bullets in it, correct?
Correct.
Your understanding of what Jennifer says is secured, not loaded, bullets stored away separately, correct?
Correct.
and she is saying, OMG, 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 you agree with me, that means, oh my God, oh my God, oh my God. Jennifer goes on page 45 and says, there's an unsent message at 12:42, okay? And so the next message has the unsent message, and it reads,
Judge, I hate to keep doing this, but it's mischaracterizing the evidence.
Yeah, it was sent to him and he received it and then it was later deleted.
I guess I'm not understanding this unsent thing. Okay, so there's a message Jennifer Crumbley deleted
But it was first sent,
that was first sent.
and then it was extracted.
So it's extracted, it was ultimately deleted. That message says, oh, no, I'll never be okay. I lost my son, and he's a murderer, and I'll forever have to live with the guilt of that, correct?
Correct.
And she says, I'm not even sure life is worth living anymore. Correct? Jennifer Crumbley, at this point, from knowing her and receiving these texts, feels, from what you know of her as a person, you would believe she feels really, really, really awful.
Speculation.
Well, it's over speculation.
I asked him from what he knows of her.
Still speculation.
Jennifer also texted you,
I think
messaged
the
you.
jury can draw conclusions from it.
I have nothing left to live for. B was it. And I take it to mean he was it. I have nothing to live for. He was it. Does that message make sense to you?
Yeah, yes.
What is your understanding or belief about it?
Assuming that was he was it, that's what she was looking for.
On page 48, so I'm going down a little bit further. You gave her a warning at the top of that page about anyone that goes to your house will have their pictures, license plates, and identity plastered all over social media. People have lost their minds and need to rein it in before they get into trouble, correct?
Correct.
And you also said he wasn't, I've met him. That message is accurately displayed, correct?
Correct.
Okay, to give it some context, above that, Jennifer wrote to you, Ethan wasn't a bad kid, Brian, on 47, correct?
Yes.
And when you say he wasn't, I've met him, that's because you've met Ethan, correct?
Correct.
And you knew about Ethan from talking to Jennifer.
Yes.
So earlier today, when you testified, you've never met Ethan. You actually have met Ethan.
Oh, I don't remember ever testifying I had that.
Oh, I apologize. I thought you said you had not met him. I apologize.
Just
if I
starting
said it wrong.
early. Just starting a little early so we can get everything wrapped up from yesterday. Can you guys hear me okay?
You continue on and say, I can't condone or justify what he did, but I do know that he wasn't a bad kid, correct?
Correct.
So from what you know from Jennifer, prior to any of this, she had never complained to you that
My
he was a
volume
bad
good?
kid. She had never complained to you that he had any kind of mental health issues or suspected mental health issues.
Correct.
Jennifer's position on page 49, she says we will never be the same. And then her next text is, it's like mourning the death of my child, correct?
Correct.
It's fair to say that Mrs. Crumbley expressed sadness in these messages to you about her feelings with her son, correct?
Correct.
She expressed sadness about what happened to the victims and their families, correct? And the whole.
Well, objection to the characterization of this evidence, Judge. You can read what's on the text. You can't testify to what Jennifer Crumbley was trying to express. Just words.
Did she ever state that? Did she ever state that in the text?
Just what I'm reading here is I'm reading right here. I'm sorry.
So these texts speak for themselves.
Exactly.
Okay, and I apologize that I have to go through these one by one.
You
I
got it.
didn't have these
Well,
This
before.
is the,
I didn't know they were being
man
used.
she
Now
was
that I know
having
they're
an
being
affair
used,
with.
They have important information the jury needs.
okay.
But it was
Okay.
definitely more than just
Very close to
um,
On page 49,
playing with each other's parts.
Jennifer tells you, don't apologize. Ethan's life is over. I need to focus on saving ours. Staying out of jail and not going into a financial hole, correct?
Correct.
And then she says to you, I really need my giving phone back. Knowing Jennifer, having texted with her many times, she meant fucking phone, correct?
Objection, again, Judge, can't speculate.
Well, he doesn't know.
I don't know.
Okay. You respond to her, yes, you support her in this. Yes, you really need to focus on you, capital letters. Nothing you do and no attorney is keeping him out of multiple life sentences. You need to get an attorney to defend yourself, correct?
Correct.
Then you say you don't know how or what they'll charge, but they will try.
Correct.
And she says she's working on retaining an attorney.
Correct.
Now, she mentions to you on the bottom of page 50, they're saying involuntary manslaughter, correct?
Right.
This is on December 2nd at 1:30 in the afternoon. Or, you know, I'm sorry, 1:30. Is that correct?
It's morning, isn't it? I believe that's it.
Oh, I'm sorry, you're right. So it's at 1:30 in the morning. Jennifer says they're saying involuntary manslaughter.
Yeah, the time is not correct. I'm sorry, the 1:31 p.m. is at UTC, right? We're going back, so it's like 9 in the morning. I'm just trying to clarify, so I don't.
Yeah,
lose right back. I'm sorry.
The-
I put my time
I
on.
have to be honest, I don't remember how that
Okay.
goes, the plus or minus, but ultimately, this text was sent to you before official charges were announced.
Yeah, it appears. I don't.
So the basis of knowledge that you're relying on is what you're hearing in media and what people are telling you, correct?
Correct.
It appears on page 51 that Jennifer deleted another message that she sent you and deleted that says, we're on the run again, helicopters, not sure where to, I'll message you, correct?
Correct.
Now, when Jennifer says to you, we're on the run, she also verbally told you, we're running away from the threats in the media.
Objection, I don't believe there's any evidence that they had any verbal conversations.
Yeah, I didn't hear him testify to that yet.
Well, let me back up and ask a different question.
Okay.
Did Jennifer say anything to you that they were on the
Yeah,
run,
they're going to.
running from police?
Objection, say, I mean, let's be specific here.
Yeah, did you talk to her on the phone?
They made a pretrial motion to admit Ethan's medical records, and it seems to be preliminarily granted. But then there's a whole thing about Ethan not testifying, and who knows where that'll shake out.
I don't recall.
Okay, so when she says helicopters, do you know what that means? And if you don't, that's okay.
Yeah, I don't know what that is. I don't.
Do you know why she typed that to you?
No, I'm really not. Sure.
Okay, then that's okay. That's okay, thank you. On page 54, Jennifer says to you that she's deleting accounts and deactivating accounts, but she talks to you about that again, correct?
Yeah.
Now, on page 55, so going further down, we're on December 2nd, later that morning. I'm going in order in terms of your testimony. Does that sound fair?
Yes.
Okay, so going down more, on page 55, we can agree that Jennifer told you she just got into her email and there's so many death threats and hate. I literally just want to die. That's what Jennifer says to you. It says on here at 12/2/21 at 5:23 p.m. UTC +0, correct?
Correct.
This is before the charges against Mrs. Crumbley were announced.
I believe so. I'm really having trouble with the dates. What day is this compared to shooting? I'm sorry. I'm getting a little
No, that's
trouble.
okay. The shooting was on November 30th.
30th. Okay.
Okay, and we're talking now
2 days
about
after.
December 2nd.
Okay.
And
2
then-
days after.
Just to make sure you have the context, on December 3rd, that was the day the press conference was held and Jennifer Crumbley was charged.
Okay.
Okay, so does that help?
Yeah.
Keep it straight? Okay. So she tells you that she got in her email. Okay, then the next thing she says on page 56, which is the next page, is that her texts are even worse, correct?
Correct.
On 59 through 61, there are a variety of screenshots that we see here. Did you see those as I went through on page 57?
Yes, I don't know. I can't see what they are, but I see you showing me screenshots.
That was going to be my question. And if you don't know, just tell me. Do you have any recollection of what those were?
I do not.
On page 59 through 61, you sent a variety more, it looks like screenshots. You don't remember what those specifically were, correct?
Correct.
Any messages that you were forwarding were negative towards Mrs. Crumbley. Is that fair?
I don't know what these are. I can't see them.
At that point in time, were you still seeing negativity on social media and in the public?
I don't recall.
On page 62, Jennifer says, I need people who know us as parents to be behind us more than ever, correct?
Correct.
She never said something to you like, I need you to lie for me, right?
Correct.
There's 3 more screenshots sent. Any idea about those?
No idea. I've seen them.
Okay, then on page 64, Mrs. Crumbley sends you some screenshots. Do you see those?
Yes.
Now, I do believe the next text after may refresh your memory on what those screenshots were. Jennifer Crumbley wrote, this is what they found, a non-threat. When you were testifying earlier, you testified to the prosecution that that was when Mrs. Crumbley sent you copies of those math, the math worksheets.
Correct.
You began asking questions about the school and said they fucked up badly, correct?
Correct.
And she tells you there was a paper they showed that had things scratched out.
Yes, I see.
Okay, and towards the bottom of the page, Jennifer Crumbley says, and this is on December 3rd.
You
at
like all the
17 UTC plus
fair
0.
drama stuff?
No,
That's where you're
counselor
hooked
and
now.
dean were in the room. They have us counselors' names to call, but said they didn't see him as a threat and he could stay in school, which he wanted to do. His fucking backpack was with him. Why didn't they search it? That's the text you received from Jennifer Crumbley.
Correct.
At that point, and at no point, you didn't say anything to Jennifer like, this is your fault, correct?
Correct.
It was unfathomable that something so awful would happen. On page 66, Jennifer continues to tell you different things by messages. And she says, no officer was notified, and apparently there were threats and no one, not even us, notified, correct?
Right.
And you said, I don't understand how the school was so nonchalant about this and prior threats, correct?
Correct.
You sent that text because your belief was there were prior threats that Mrs. Crumbley had never heard about.
I don't know. I just know what I'm writing here. I don't recall exactly.
Okay, fair enough. If Mrs. Crumbley and you had ever discussed prior threats she knew about, you would have said something to her like, you knew Ethan had made prior threats, correct?
Correct.
You don't say anything like that to Mrs. Crumbley at this point.
Right. I don't.
Okay. And then Jennifer says, I don't know, but it failed my son and 4 other families, correct?
Correct.
And then she says at the end of that page on 66, yes, but my child is alive. And he was responsible for, in capital lives, the loss.
Sorry, I didn't mean to pause it right in the middle of the quote. But anyways, Tara with $5 super chat. Thank you very much. Prediction after the lover 2 times said he felt threatened during the interviews with the cops. I bet she brings the cop in her case and plays the video. You mean Karen, the prosecutor? She might. This might actually extend because I thought the state was going to end yesterday. Obviously, we got a little delayed, but they might actually extend this a bit because of this. So it might be a little bit longer of a trial now.
Of lives.
Correct.
I'm sick. Correct?
Correct.
On page 67, so I'm just going down further, he told you his eyes not right on his mugshot. That's not, in capital letters, my son.
Correct.
Is that correct?
Correct.
You responded, I said the same thing. That does not, in capital letters, look like Ethan.
Right.
Why did you say that?
I'm gonna say because it doesn't look like the pictures of you that I've seen.
Okay.
That's all I can say.
At that point, were you feeling shocked in any way?
I was shocked about the whole thing. I can't.
Now, on 68, you end up telling Jennifer, it's so sad, I'm so sorry, and thinking about you nonstop, correct?
Correct.
It's fair to say that you wrote that because you were so sad, you did feel so sorry, and you were thinking about
No,
her.
it makes no
and
sense
what
for Shannon to
everyone,
bring in
everything
the
that's
cop.
happening nonstop.
Not at this point. But thank you very much for the
Jennifer
tuning.
responds about how she's doing when you ask her, are you even sleeping, correct?
Correct.
And she says no. You say, I figured, correct?
Correct.
Okay, I'm on page 69 now. She says, I haven't slept in 3 days, and I have been eating the same quesadilla for 3 days, correct?
Correct.
You told her you need food and sleep, but I'm sure it will take days before you can do either, correct?
Correct.
You said that because you could tell the person you knew felt really bad.
This is the state's 19th witness, Brian
Jennifer then
Maloche,
says, I'll have plenty of
firefighter,
time
friend of
on
Jennifer,
jail.
had an
Correct?
affair with Jennifer.
You know Jennifer to be a sarcastic person, correct?
Correct.
You would agree with me, and if you don't, please let us know. That was a sarcastic remark on her part.
You can't agree with that, there's speculation.
Do you know?
I don't know. Look ridiculous.
On this date, back on December 3rd, you wrote, your attorney will prevent that. I'm still very pissed off at the prosecutor and system for charging you two. They are doing it to appease the public. That's called a witch hunt, not justice, correct?
Correct.
And to that, Jennifer replied, I'd rather die than go to jail, correct?
Correct.
Not the first time throughout this thread she said she wants to die.
Correct.
As the text thread continues, on page 72, I'm going down, but again, if you need me to slow down, let me know. Although we're going slow. She said, you've helped us a ton, just being a friend and not judging has helped. Your remarks within those text messages, messages, not text, was I'm trying my best. That's what real friends do, correct?
Correct.
At that point in time, on December 3rd, 2021, you would characterize yourself as real friends with Jennifer Crumbley.
Correct.
And James Crumbley.
Correct.
Following that, there's discussion about horses on 72. Is that fair to say?
Yes.
Sarah sent me pics of the boys. You know she's talking about animals.
Correct.
On page 73, she indicates to you, yeah, we're painted out to be monsters, and I can't defend myself because we're fearing our lives. Correct?
Right.
So on December 3rd, the day before the day charges are announced, Jennifer is saying that she's painted out to be a monster.
Correct.
You end up responding to her, and
Can you
I
guys
have to
hear me
ask,
when I'm talking?
is
Oh, no,
this
you can.
sometime in the afternoon?
Are we asking these messages right here?
Yeah, I'm asking, what's your memory of when these messages were?
Well, it showed almost 2 p.m., so I'd have to back that up 5 hours, correct? I don't know how to do UTC. I know it's 5 hours. I'm not sure how that does that.
So it
Did I
would,
put that at 9 in the morning?
okay,
I
well,
don't know.
it's sometime that day, and obviously the times, we can sort those out later. They're on the text, right?
Yeah.
On the messages. And you said you have more support than you think, but right now, anyone who publicly defends you and James gets exposed, crucified, and threatened. I've been defending you and explaining to anyone who contacts me privately,
And
correct?
that didn't make the news.
You were defending her knowing that there was a lot in the media and
Anyone who supports her or shows any sort of support will get. What did they say? I'm going to back this up. Cat's trying to climb the wall.
on the messages. And you said you have more support than you think, but right now, anyone who publicly defends you and James gets exposed, crucified, and threatened.
Anyone who shows support for you and James gets exposed, crucified, and threatened.
I've been defending you and explaining to anyone who contacts me privately, correct?
Correct.
You were defending her knowing that there was a lot in the media and things people were saying that are not true about Jennifer Crumbley.
Objection to the vagueness of the question, Judge.
Well, I think you kind of put words in his mouth.
That's you.
I guess I'll ask you, why did you say that you felt like anyone who publicly defended her and James was exposed, crucified, and threatened? What did you mean by that?
That it was such a horrific incident that nobody could possibly stand up for anything that has to do with other than the loss of life and anything. That's the only way you can say anything about that. You can't try doing anything any other way about that.
So it's fair to say you certainly didn't want to make public statements that you were friends with Jennifer, correct?
Correct.
And at that point, Jennifer says, I know, thank you. I don't want anyone in danger, correct?
Correct.
And further down, I'm on page, let's see here, 74. This is at December 3rd, 2021 at 2:36 p.m. UTC plus 0. So we'll calculate that out later. At that time, she says, not yet, waiting on my lawyer, correct?
Correct.
Now, that was in response to your question, have they advised you of all charges? Have they issued warrants, right?
Correct.
So her response, not yet, waiting on my lawyer, that was the response she sent to you. And at that point, you wrote to her, follow his or her advice carefully. Do not fuck yourselves. Be careful. Jen and my thoughts are with you. Why were you telling her not to fuck herself?
Just to make sure she followed legal counsel advice.
And
Not to do anything else.
from all of the messages you had with her or any communications, Jennifer Crumbley never said to you, I don't plan to follow my lawyer's advice, correct?
Correct.
Jennifer Crumbley never said, I'm going to lie about things.
Correct.
After that, there's some exchanges on page 75, 76 about reaching out to her, talking about money with Kira. Do you recall those messages?
Yes.
So at that point, you were trying to assist her in selling the horses.
Correct.
And ultimately, this is towards the end of the messages, the end of your communication with Jennifer Crumbley, correct?
I believe so.
Okay. She gave you
Welcome,
lawyer's
Flux.
number.
Where have you been
And then
this
there's a
whole
phone
time?
number. If we need to do any type of legal sale of the horses that Kira needs, I can't get into my house to get the
Didn't know
papers,
excited.
correct?
Correct.
You tell her I'll put it in my phone, meaning you'll put the lawyer's number in your phone. Is that right?
Correct.
So at that point, you did save the number for the lawyer in your telephone. Is that a fair
For
statement?
those of you who are just joining us,
Okay. You said
this is the end of the day. This is end of day 5 that I wasn't able to stream, so I'm getting caught up. And we should be ready to go in about an hour and 15 or so by the
you
time
were going to do
We'll
that
close
at
live. Hour, 15,
4:13
hour and
and
a half.
35 seconds, UTC plus 0, at whatever time that is, correct?
Correct.
You told her I'll message her as soon as I get home. Do you want to call
only
me?
if you're
And
lucky.
she says to you, send me your number, correct?
Correct.
At that point, Jennifer did not have if you know, and if you don't know, you can let me know. Do you know why she was asking you for your phone number?
I don't.
The last message you got from Jennifer Crumbley was on December 3rd, 2021 at 5:57 and 25 seconds, UTC plus 0. That was the last message you heard from Jennifer Crumbley.
Okay.
Is that correct?
I don't know. I can't see what. Yes.
Would it be fair to say that the last message you sent to her was this last message we see on the thread? Any chance that your neighbor can get the papers for the horses? I can sign them. Kira seems to really want those purchases.
Yes.
I have to ask you just a couple of quick questions about your relationship with Mrs. Crumbley. When you and Mrs. Crumbley spent time together, most of the time, what part of the day was it?
Morning.
Was it mornings of work days or weekends, if you know?
Work days.
Okay.
Thanks, little
And
pill.
I am sorry to invade private details, but
I'm just tired.
approximately, did you have a usual time that you would see each other?
I don't recall normal time.
During those times, you're not aware of where Jennifer Crumbley's son would be?
School. I don't.
So it would be fair to say that times you and Jennifer Crumbley were together were when her son would have been school days, correct?
Correct.
In terms of the extent of your relationship, were there many trips or overnights or things like that?
No.
That if it ever did happen was very minimal, correct?
Correct.
And at the end of the day, despite the fact that you and Mrs. Crumbley may have had an affair, you never believed that Mrs. Crumbley didn't care about her son, correct?
Correct.
Her relationship with you was very separate from her relationship with her child.
Correct.
And the amount of time that she spent with you was very minimal compared to the amount of time you knew she'd be at home and with her son
Oh,
and doing
that's
other things.
speculation, unless he
Well,
has a
yeah,
lot
we
of
have
details.
Yeah, that, he didn't say that.
All right. So essentially, what this case is Jennifer Crumbley is being charged with intentional or involuntary manslaughter, which, under the state's theory, she was grossly negligent and failure to perform ordinary care for her son, who was obviously, she had to have known he was going to do this, right? So there's a known component. Essentially, the state needs to prove that Jennifer knew that Ethan was likely to do this and failed to take any reasonable care to prevent it, or she knew he was likely to do this and then gave him unfettered access to a firearm, or both. That's essentially what the state has to prove. If they prove that, then she is going to be found guilty of 4 counts of involuntary manslaughter, which will which has a maximum. Geez, I could talk today. Maximum sentence of 15 years each, but we serve concurrent, not consecutive, so it will be 15 years, which is what you'll get. The state's been putting up a lot of evidence that there's stuff going on, but nothing that really rises to the level of she knew he was going to do this, right? And so if she doesn't know that there's a high risk involved under the, you know what, let me just do it this way. Under the involuntary manslaughter charge. Here we go. Okay. So the state needs to prove the following beyond a reasonable doubt. First, that the defendant caused the death of another. That is, that those 4 people are dead as a result of Jennifer Crumbley failing to protect society from her son. Second, that doing this act caused those 4 deaths and the defendant acted in a grossly negligent manner. Now, grossly negligence means more than just carelessness. It means willful disregarding the results to others that might follow from an act or failure to act. In order to find the defendant was grossly negligent, she must find the following beyond a reasonable doubt. The defendant knew of the danger to another. Okay, so first we have to show that she knew of the danger. This was a situation that required her to take ordinary care to avoid injury. That the defendant could have avoided injury to another person by exercising ordinary care. Well, that's even speculative. What is ordinary care? Getting him to the counselor? Okay. Would that have prevented this? Who knows? Third, that the defendant failed to use ordinary care. So that's essentially what the state needs to prove in this case. They've been talking about a lot of things, but in my opinion, not enough to reach the level of gross negligence that we need here. That's all setting aside the fact that we have an intentional wrongful act as an intervener cause. So we have this first part here. It says the defendant is charged with the defendant caused the death of these 4 students. Well, how could she have caused the death of? We have a general practice or general rule that the intentional wrongful act of a third party acting as an intervener between your negligence and the results nullifies it. So, so we have a hard time with that as well. But I'll just keep playing it here. We're at 1.25 speed. I'm trying to get
I
caught
can
up.
ask a better question.
Day 5.
Throughout the days,
Welcome
while you and
everybody.
Mrs.
Welcome
Crumbley
all.
would
I
talk
see
to
you
one
all.
another,
I'm just trying to
you
get
would
some work done in the
frequently tell each
background.
other
Normally
what you
this
were
is my
doing
work hour.
as the day went on, correct?
Yeah.
I guess overall, during a typical week in 2021, how many times would you say you would see Jennifer Crumbley in person?
Once, maybe. I don't know.
Okay, so we're
Yes,
not,
John, I did. And she's the better.
so we're not talking every day or anything like that, correct?
Correct.
I have no further questions.
You're right.
Thank you. Why did you stop communicating with her?
As soon as I saw in the news that the warrants were issued and they were being apprehended, but not.
They're not turning themselves in?
Correct.
Okay, so I just want to make sure that we're all clear. You're not accusing anyone in law enforcement of threatening you, are you?
No.
Okay, and in fact, when you interviewed with investigator Mike Thomas, December of 2023, he actually referred to you as brother. Would that be right?
Correct.
And you guys left the interview with exchanging phone numbers, and you actually called him the
Your
next day.
Honor, I would ask the leading question stop.
Okay, so what was the tenor of that conversation? Was it an interrogation? Was his voice elevated like mine, or was he calm?
It went back and forth. It varied.
Okay, did you feel like you were being yelled at?
At some point.
So one point he asked you about your pension. I'm going to look at the transcript here. When he first introduced himself to you, he was talking about you, how long you've been a firefighter, and your answer was here 21 and a half years. He said okay, and I worked for Independence, and I was on call for 7 hours before here. And then Mr. Thomas said pensioner is straightforward. She asked specifically if he was threatened that his pension would be revoked. I think it's important that the jury understands what that context was.
Your Honor, all I'm asking for is that I get the chance for recross, because if the prosecutor's gonna pick tiny parts of this transcript and not the whole thing, that's a problem.
You have-
Hold on, yeah.
No, I don't have the transcript.
She
I
has,
don't-
okay, first of all, the allegation of picking tiny parts, she accused 2 veteran officers of threatening when this witness said, no, he wasn't threatened. And I think it's important for me to go through that transcript, that interview, to talk about the portion that she brought up.
First of
He
all,
can pick whatever questions he wants on there. He doesn't have to, he can ask her whatever he wants about that. You don't have a transcript.
I don't.
She can make her own transcript. She's a
I
retained
don't.
attorney.
It's
Okay,
fine.
Okay, wait, you have,
I've seen the audio. I took my own notes from it.
okay,
Okay.
all right.
So, okay. You
You've
said
seen the interview.
Yes.
Yeah.
Okay.
your pensioner is straightforward one. You said pension. How much longer you got? 3.5. You got a COLA, cost of living out of it? Your response, yeah. What's your COLA? Oh, I don't know what it is now. I think what's your multiplier? 2.8. Was he threatening to take your pension away?
No.
Okay. Did you ever feel like he was going to have your job taken from you?
No.
Okay. You were asked, Mr. Thomas asked you about the importance for the truth. Now, as a veteran firefighter, are you surprised that law enforcement wanted to gather the truth?
No.
Okay. And in fact, you agreed.
Your Honor, I would ask objection to leading questions.
Judge,
You would
on
agree
redirect,
leading-
I am entitled to some leeway, especially in light of what counsel asked.
not to leading questions.
No, not leading
So that didn't
questions.
suggest the answer.
I know you can do it, Mr. Keats.
All right. Sir, you were interviewed by law enforcement?
Yes.
Yes, okay. And in December of 2021 was the first interview.
I love how the judge is like, I know you can ask non-leading questions. I have faith in you.
Okay. So you were asked specifically about certain things that were said in that interview. And you did tell the police in the interview that she said she was worried he might hurt himself or something like that. That was your type statement.
Yes.
Okay. And you repeated that again in December of 2023.
Yes.
Okay. And then you testified to that today.
Yes.
That's never changed.
Correct.
All right. So the very first interview you had with law
Your
enforcement,
Honor, objection to leading questions.
I didn't even ask the question.
Well,
The last 3 were
he
leading.
asked him, did you make this statement in your written, did you say this in your written statement? Yes. Did you put this statement, did you testify to this? Yes. So I don't think that was leading.
You told the police in December of 2021 about an extramarital affair.
That's leading.
What did you tell the police about your relationship with Jennifer Crumbley?
Correct.
What did you tell the police?
Extramarital.
Okay. Did you give all the details?
No.
Okay. Did you tell the police how many times a week you would meet her?
No.
Okay. Did you tell the police about trips and specific times during the week?
No.
Okay. Now, why didn't you give all of those details in December of 2020?
Because I don't want those made public.
Okay. Are you happy about being here today?
No.
Okay. What was your thought in withholding some of that information?
And it would protect people in my life, other people in my life, my family, my wife.
Imagine you've had to have some conversations since that time.
Yes.
Did you know how Jennifer Crumbley parented?
No.
Okay. Was that ever a topic of conversation?
No.
But you do know that you met her in a Costco parking lot across the street from her employer. Is that right?
Yes.
Okay. And that would happen, as counsel said, during the work days and during work hours.
Correct.
Okay. And you don't recall how
Right,
often
guys,
that
y'all
happened?
gotta
Was
say
a
it with
regular
me.
thing?
Yes.
You also told us that Jennifer Crumbley in that Facebook post told you she had a string lock. Is there such thing as a string lock?
No.
Okay. You also told us that she told you that her son's friend committed suicide and that the school didn't send her the original drawing. That's all in those Facebook posts, is that correct? Okay. And did you come to learn that those 3 things were actually not true?
Yes.
Ooh, I would object to that. They didn't send her Well, they gave her 2 copies of the drawings, right? So she's probably confused at that point. We have 2 copies of the drawing they're referring to, people. This one, which was the one originally sent, and
Did
then
Jennifer ever
this
tell
one,
you
which was
the
what was
details about that
discussed at the
with
meeting.
school?
Not that I recall.
Did she ever tell you anything about her son in the spring of 2021? Did she ever tell you anything specifically about March 9th, 17th, 20th, 21st of 2021?
No.
Did she ever tell you about anything with her son's life in April of 2021?
No.
Did she ever tell you anything about her life in June of 2021?
No.
Okay. Did she ever tell you that she didn't have to be at a meeting
I'm
later
crazy
today
cat
on
right
November
now.
30th, 2021? In fact, she was able to leave work to meet you when it pleased her.
Yes.
Sir, when you were subpoenaed, you were told that we were not going to bring out the extramarital affair. Is that correct?
Your Honor, objection. As far as it goes with legal issues, that is not appropriate questions in front of the jury.
Why is that not inappropriate?
Because the prosecution's trying to allege that that I've done something to put this witness in a bad spot when the evidence in this case requires the jury know all the information.
I think this question is directed at the fact that Mr. Melange was probably taken off guard when he testified today. Isn't that what your question's about?
Yes, Judge.
Yeah, you didn't know you were going to ask those things.
No.
Okay. Jennifer wrote to you that she felt like she failed as a parent
That was in the message.
in the messages, yes. But she didn't tell you any of the specificity, any of the details regarding that.
No.
So she didn't tell you anything about the background of her son and her husband.
No.
And again, I just want to make something crystal clear. In the interviews you had with law enforcement, nobody ever told you that you would be fired, correct? No one ever told you that you had the risk of being fired.
Correct.
What were you told to do when you came to court today?
And tell the truth.
Okay, and have you told the truth?
Yes. Correct.
Thank you. Nothing further.
Your Honor, may I have 2 questions?
Yes.
Okay, Mr. Malesh, it's fair to say you testified earlier, you have memory issues.
Yes.
Okay, describe those memory issues for this jury.
Judge, that's been asked and answered. It's beyond the scope of my redirect. And unless we're going to go through all of our consistent statements,
I'll withdraw that question. I'll withdraw the question. Earlier,
She
when you
needs to stop
testified,
giving up so
this is
easy.
my last question. You did say you had feelings that there was pressure on you about certain areas of your life being affected by your statements to police,
hold on,
correct?
Judge. That's mischaracterizing the testimony. He's testified multiple times. He was not threatened.
Okay, she didn't ask that.
She
I
has
asked-
asked that.
Well,
I
you
did
know,
ask that.
I've gotten, I guess, a little bit of inconsistent. I don't know if it's testimony or vibe from you. Did you, at any point, you said the police didn't threaten you, but,
There were veiled threats.
well, I asked that. Did you feel like there were any veiled threats? He said yes, but he didn't tell me what those were. So, did you feel pressure to tell the police some things? And if so, what were those pressures? You said that your job wasn't threatened.
Yes, Your Honor. Can I specify what I tried to clarify?
Please.
I tried to clarify. I felt I was guarding myself in my statements, and being the investigator was pushing it and inferring that this would all get out, which it has now, with what was going on. He didn't threaten my job. He was asking questions that were professionally related, because I know he was trying to establish some sort of rapport with me because he worked in law enforcement, so he asked about pensions. He did get more aggressive with it, and it was threatening, as in personal information getting out about me out in the open to the public and stuff.
Okay.
I shouldn't say stuff, but did that help?
Okay, do either of you have any questions based on that?
I do. Did he ever tell you to say something that wasn't true?
No.
Okay, you were told to tell the truth.
Yes.
Thank you.
Anything else?
You were asked questions repeatedly, the same question over and over, as we've done in this courtroom today, correct? Thank you.
All right, I'm gonna let you step out in your excuse. Okay, tell me what we're doing next.
We have a witness, right?
Okay, you guys need a break? How long is this witness, do you think?
I'd say the direct is about 30 minutes.
Okay. All right, I'm gonna excuse you until 4 o'clock. Okay?
All right, for the jury.
We can approach after the jury. Excuse me.
All right. Now we have the crime scene investigator coming up. We'll just jump forward to him, and then we should be good to go live once court gets up and running this morning. Welcome, everybody who I haven't spoken to yet. I am just being a little distracted at the moment because this is my work time instead of my stream time. But I'm glad you're all here. And we are getting caught up. There's 160 of you waking up bright and early with me this morning. That's amazing. That's awesome. Love that you are all here. David, please tell me why the repeated question was a good last question there. Just because it reinforces it. You kind of want to, like the jury, the last thing the jury hears is the thing that resonates with them. So you reinforce it, leave them on that. It's sort of like the theme of the witness, that sort of thing. So it's always good to have the last word. That's why I'm never a fan of the state always having the last word, but it happens. And I understand the audio fix out here a little bit. Here we go. All right.
Please state your name for the record and spell your first and last name.
No problem. My name is William Creer. William's common spelling. Creer spelled C-R-E-E-R.
Go ahead.
I misspoke and called you officer, which is probably a good way of introducing you to the jury, but I'm just gonna call you Mr. Creer.
I'm always amazed that these are civilians
You
too
are not an
doing this job.
officer. What is your title?
Forensic technician.
And who do you work for?
Detroit, City of Detroit Police Department.
Okay, can you explain to the jury how you work for the City of Detroit Police Department, but you're not an officer?
A lot of people do this, by the way.
They send me out to the scenes. I collect the evidence.
There are a lot of
Pictures,
private
package the evidence, and
contractors
that's
that
why I
do this too.
And how long have
Not
you been doing
even
that?
like direct
20 years.
employees.
So is your title forensic lab tech?
No, just forensic technician. There's a difference. Lab techs are actually the people that test the evidence I collect. I just go collect the evidence.
Okay, you don't work in the lab.
No.
Okay.
I had half a bottle of Moscato and I was enjoying the show. Thank you for asking me right now.
So is it correct to say that you're a civilian working for the police department?
Yes.
All right. I want to
Psychologically, it does
December
jump. You
3rd of
just don't know it.
2021. Do you remember that day?
Yes, ma'am.
Were you working?
Yes, ma'am.
Yes, Mr.
Were
Clear.
you at some point dispatched to a building with the address of 1111 Bellevue in Detroit?
Yes, ma'am.
And were you made aware there was a search warrant being executed at this location?
Yes, it was.
To be
Okay, how
fair,
many times
there's not a
have you
lot that comes out from
Roughly,
this
can you
guy. A
estimate
bunch of
gone
photographs
to
of
a
the
crime
inside of the
scene
unit.
and,
By the way-
collected evidence?
No.
I'll just talk over him for a minute because this doesn't matter. He was called out to the unit where they were arrested. He took a bunch of pictures of stuff, and we're going to see the pictures. But I did yesterday on my way down to the Detroit Opera House, stopped by the building that James and Jennifer were arrested at, and I took a little video of it, just showing the outside, and I posted that. So if you guys want to see that, for whatever reason, 1111 Belvedere Street, Detroit, Michigan. It is in my it's in the playlist, but it's also in the just in like the most recent videos that I uploaded. So you guys can check that out.
Highest working officer at the scene when we arrived, and we got the request over the radio. He was the one that dispatched the officer dispatched requested for the scene process.
Okay, and what did he ask you to do?
When we arrived at the scene, we went into the building, and that's when we were made aware that this was regarding the Crumbley case, and how we were.
It's an old warehouse from like the glory days of the Motor City. It was an old car factory and then turned into a warehouse, and now it's a bunch of private commercial and semi-retail spaces, art studios and things like that are in there. The guy who testified earlier yesterday that he saw them, the one that called 911 and saw the vehicle, he has a coffee shop, and his roasting operation is out of there. And so there's just a bunch of different things going on there.
We do our walkthrough. He points out evidence that's important to be collected.
It's kind of a cool
While we're
place.
doing our walkthrough, my partner or whoever I'm working with that day will point out items that we believe might want to be collected. And then at that point, we start taking pictures, documenting the scene, and collecting the evidence.
Okay, so do you only collect evidence they point out you need to collect this, or do you determine based on
Take
your own
pictures of everything.
experience what
Look at
what you
everything.
should collect? And how do you ever collect anything that's not visible when you first walk in and law enforcement directs you to?
After we do the walkthrough with the investigator, and then if they give us permission or we agree that we want to do a more thorough search, we see.
I just say I
items that
love
might
having
want
fucks in the
to
chat.
further, Then we will do additional searches.
Okay, so the items that you find, did that sometimes, does that lead you to the other parts of the scene that you want to search? Or do you search only what the law enforcement tells you to?
Again, depending on how things are. In this particular scene, we use this particular scene
Yes,
as an
please.
example. They had already initiated their search. They had already found items they wanted. They, at this point, they said, hey, if there's any additional items you to see or might want to go over, have that.
Okay, so you were given free reign of the entire room.
Yes.
Okay. is it part of your protocol to just collect what you see out in the open, or do you actually do you conduct searches?
We conduct search in this particular case, yes.
Okay, is that something routine, or is that unusual?
It varies by scene to scene.
Okay, when you walked into the room, what did you observe?
Again, the search warrant had already been executed. We took our overall pictures of the scene. We saw, items that were already collected from or found by law enforcement. There was foodstuffs on the table, just as you directly in front of you as you entered the room. Mattress and clothes scattered around the room that had already been found.
Okay, I'm going to show you pictures in just a moment, but I wanted, with your permission, get a little bit more detail about the things that you first discovered. When you just said you saw some food stuff. Do you remember specifically what you saw?
I believe bananas, jug of orange juice. I want to say maybe alcohol. I wouldn't say Prosecutors. That's all I can remember off the top of my head.
Okay. Did you see anything else that stands out to you right now?
No.
Okay. Okay. I'm going to show you well, before I do that, can you describe what did you think that room was when you walked into it?
When I walked into it, I was an art studio of some guy.
Okay.
So I remember seeing portraits and just art stuff around the room,
Right.
Tables, kind of reminded me of an art class or something like that.
All right. Did you see anything else on the floor?
Saw a mattress.
And what did you think of that?
Apparently somebody sleeping on a mattress.
I'm sorry.
It looks like somebody sleeping on a mattress.
Okay. I'm not sure. I actually know I didn't ask you this. Did you have contact with Jennifer James Crumbley when you were searching the room?
No, at the time. They had already been arrested and believe taken to open count jail.
Okay, so you didn't see them?
No.
All right. So I'm going to show
Not
you.
at that particular time.
Right, we're going to get to that. Okay, I'm going to show you some pictures, and then I'm going to pull out just 2 or 3 things just for demonstrative purposes for the jury. But these are photographs, exhibits 348 through 400.
I'm sorry, 348 through 400.
So on the exhibit list, they're listed from 348 and
The 348,
the description.
351 were previously admitted, but 350 was not, right?
I'm just checking. We have no objections on these. Thank you.
All right, so can you tell the jury, I'm going to just go through the pictures, and you can, if you will, just describe what we're looking at.
That's the scene location.
I'm sorry, Mr. Peer, about what time did you arrive on scene?
Around 2:40.
AM?
Yes, sir.
Were you just working the night shift, or were you at home, or where were you when you got
On
home?
assignment midnight shift.
Okay, gotcha. All right, so this is what?
That will be the crime scene location.
It should be under monitor, is it?
Oh, yes.
Okay, great.
I'm just looking.
All right,
That's the scene on Bellevue. That's another angle of the scene on Bellevue.
okay. Can you go back one? Can you see the windows of the art studio that you searched in that photo?
I don't recall.
Okay, next photo. Does this look familiar to you?
Yes, ma'am.
Can you tell the jury what this is?
So those are the reporters that we saw when we were pulling up, and we asked them to move to their pictures.
Okay, was that something common that you encountered?
Yes.
Next. What is that?
Again, we're at the crime scene location, the exterior shot. We asked them to move to their pictures.
Okay, was that something common?
This is the only thing that was like super relevant that I thought out of all of this was look at the press. And if you doubt that James and Jennifer Crumbley were running from the press, just look at all those people lined up at 2 a.m. Outside of a warehouse just to say they were arrested.
And that you encountered?
Yes.
Next. What is that?
Again, we're at the crime scene location, the exterior shot.
Okay, and the next.
That would be the vehicle we're also allowed to, requested to photograph.
Okay, so did you take these photos?
Oh, no, Harlan took these photos.
Were you there when she took them?
Yes, I was.
Okay. What is that?
If you zoom in, you can see cigarette butts that we were requested to collect.
Okay. And what are we looking at?
Looking at more cigarette butts we were requested to collect.
Did you know why you were requested to collect those?
Because of possible DNA evidence.
Next. What is this?
That will be Suite 130, at the crime scene location.
So the art studio was Suite 130, or actually is 130 the art studio you searched? I'm sorry.
130 is the art studio. We searched the actual crime scene address was 1111 building.
So the building was 1111 Bellevue.
Yes,
Okay. And the art studio was what?
130.
What is this?
That's inside Suite 130.
All right. And the next picture.
Again, we're inside suite 130. These are overall shots of the entire room. To get an idea of the items in the room and the room in general.
Where, in relation to the door to the studio, is there one door or more than one door?
There was just one door in and out of this room.
Okay. Where in relation, in this photo, where's the door?
The door is, from this angle, the door is directly behind and to the left.
And the next,
Again, we're kind of circling the room with overall shots.
okay,
Again, the door is behind it, it's pointing behind it to the right.
okay. What is this?
Again, I would take an overall room. The door is directly behind us, and we're taking a shot across the room.
Do you see a mattress in this photo?
No, but if you go back, I believe you can see the mattress there, bottom of the screen, the two drawers on top of the mattress.
Okay. Right. And the next photo,
Again, that's the shot from across the room. The door in and out of the room is directly behind the hard to take photos.
okay. And the next one is 360. This is just a different view.
Different angle.
Is that the mattress there in the right bottom corner?
Yes, ma'am.
Did you put those drawers? Are those drawers?
I believe the drawers, and they were already there at the time that we were on.
Okay. And 361.
And then you have a better photo of the mattress and the drawers.
And the next. Okay, what is this?
Now we're circling around with a photo of the mattress, flat object, and whatever cover that the mattress was resting on.
Okay, in a minute, we're gonna get to the actual items individually, photos. But did you take pictures of those individually at some point?
I will have to go through the pictures to make sure I'm picture again.
Okay. And what's your recollection? What is that? When you said it's an item, is it a blanket? Is it a piece of clothing? Is it something else?
I believe it's a clothing last year.
Okay. 364. What is this?
Again, we're circling the room. As you see at the top right-hand corner, that's the table with the food items on it. You see the orange juice in the top right corner and a bottle of Coke. Bottom left corner of the room, you got a Snipes clothing bag.
Okay, right next to the orange juice, that circular object on the counter there. What is that?
Right next to say it again?
There.
Oh, those are solo cups
Okay.
or plastic cups.
365. What is this?
Oh, it's a photo of the clothes that was inside Snipes bag.
Okay, can you tell the jury what those are?
A few pairs of socks, a sweatshirt, and again, you have the flag item in the baseball cap that was in the previous pictures.
Okay, and are the socks attached to anything?
They're attached to, just like we'll buy them from the store, paper that would connect the socks together.
So they're new.
Yes. There's also the receipt in the picture, just by the sweatshirt.
Okay. And do you, I think there's a closer photo of that actual receipt, which we'll get to. 366. What is that?
This will be by the mattress. Between the mattress and the shelf is like a pink shelf.
Okay. 367.
And there's a better picture of the picture.
So did you or somebody else take it and lay it out like that?
Yes.
368? What is this?
It's another shirt.
Where was that found?
Can't quite remember off the top.
Okay. Do you need to see, did you write a report?
I did write a report.
All right, would that refresh your recollection?
It would, thank you.
Mayor Pro Tem.
Sure.
Thank you. Yes, it was in one of the plastic bins.
Okay, that shirt was in a plastic bin?
Yes,
Okay, I think if we proceed through the photos, that this will make a little bit more sense. Okay, is that a plastic bin?
that is one of the plastic bins. Yes.
Okay. How many total plastic bins did you find items of interest in this search?
I believe 2 plastic bins.
Thank you for the $4.99 super
Okay,
chat
were they
there.
in the same
Let's
place or two
go.
different places?
There were 2 different places.
Okay, where was that plastic bin?
That plastic bin was along the north wall of the room. Under the food.
Oh, whoever censors these messages spends the entire
Under the table
evening
with
with
right there.
Right.
And so,
Facebook
correct me if I'm
and
wrong, is the mattress on the other side of this table?
The mattress is on the other side of the table. Yes.
Okay, was
You haven't
the
talked about that
plastic bin
yet.
found
Yeah.
like that with the lid off and the backpack sitting up?
No,
Something's up
looked
with
at it,
that
it looked
case.
funny. Just out of place under the table a little bit. The top.
All of a sudden, like my mouse is being weird, so I'm having a hard time controlling things. But Can we the Vince McMahon thing? Oh my god. If that is true, oh my god. If that is false, oh my god.
It was kind of a jar, and that's what found out, and
Okay, and we're gonna get to the contents of what was in that backpack in a moment. Can you look to 370? Okay, what is this?
again, that's the table with all the food items.
All right, can you describe to the jury what you see, all the items there that are on the counter?
Probably you have the bananas, you have an orange, container of orange juice, container burners, especially a box of Special K.
The ice is for the orange
and,
juice,
bottled
gentlemen.
water, along with some solo cups or solo-like cups.
Okay, I see some paper towel there.
Yeah, there's paper towel and
Um,
a box of Kleenex.
And Mr. Keese is going to sort of highlight some of the other items that to ask you what those are. You know, what is that?
A box of, can't quite make it up.
Okay, do you want to look at your report?
Yeah,
That refresh your recollection?
My report says food stuff items.
Okay.
Food items, plastic cups.
Okay.
Paper, food items, plastic cups, and plasticware.
Okay, so those are boxed something.
Yes.
Okay. If I told you that says Lara Bar on it, would you have reason to dispute that?
No.
Do you know what that is?
No.
Okay, they're granola bars.
Okay.
Or energy bars.
Okay.
Okay, so you've never had a Lara Bar.
I've never had a lower, no.
Okay, what is the next item Mr. Keese is showing with the magnifier, if you know?
Bottle of lotion. Something.
Is it lotion or is it shampoo?
I believe it was lotion, but
Okay. What is that?
I'm not sure.
What does the bottle say?
Real?
Minute Maid?
Oh, you're talking about the plastic bottle
Yes,
behind?
yes.
Yeah, that's a minute.
Okay, and then there are two other cups right there.
Yes,
Is that the way you found it, or
that is exactly how we found it.
next? This is what?
That is again a plastic bag with a pink foot bag inside.
Okay, and the next one? What is that?
It's a plastic bag. We removed it from the plastic bag. I mean, the pink bag we removed from the plastic bag.
Okay, what are the items to the left?
Those are the fruit we started removing outside the plastic.
Okay,
I mean, pink bag.
and what did you describe to the jury what you found in the pink backpack?
In the pink backpack, there was a second bag, and various clothes,
What kind of clothes?
intimate clothes, underwears,
Okay, men's underwear or ladies' underwear?
ladies' underwear,
Do you know how many pairs?
about 4 pairs.
Okay. And that gray item next to the pink backpack to the upper left, what is that?
That's just another bag that was inside of.
Okay, and 373? What is this?
Again, we have another angle of the pink bag, the gray bag, and a pair of pants that was also inside the bag.
Okay, and 374?
We have another angle of the pink bag and a pair of dark colored pants.
Okay, the green bag underneath the pants, was that found in the, yes, was that found in the backpack?
Yes.
What did it have inside of it?
I don't recall.
I'll hand it to you in a minute.
Okay.
Next slide.
Again, we have a picture of the brand of pants, the fact that they're stretch, and the size on the tag under the false proof.
Okay, and the next slide. What's this?
Again, we have more of the intimate items, intimate clothing items, and a plastic bag with,
That's a business card?
yes,
Okay, and what's next to it?
several bills inside the container. I believe they're caffeine bills.
All right, and the next picture?
Again, we have a closer picture of the business card and the bills.
Okay, and then 378. What is this?
It was an ointment container and an injectable medication or something.
And where was it found?
That was all that was in a plastic bag, which was inside the pink book bag.
Okay, were you able to determine whether those were for human beings or horses?
4 horses.
Okay, and the next slide?
We have another picture of the intimate female clothing and more clothes. And also the 3 bags you asked about.
Okay. What is this?
It's a key card
And what is,
for an extended stay in America.
okay, where'd you find that?
It was inside of a jacket over the chair. If you go back, way back at the beginning of the pictures, you'll see a black jacket over the chair.
Okay, and the next slide? What is this?
This is inside of a garbage can. It was near the table with food items on it. It's a whiskey bottle. There was a few pictures before that I didn't see us that showed what the garbage can was in relation to the table of food items.
Was the bottle empty or did it still have something in it?
It was
Next slide. What is this?
it's a receipt with from Rivertown Market.
And what does the date and time say? I'm not sure it shows it in that.
Yeah, I'm not sure it shows it.
Okay. All right, the next. Okay, what is this?
It is a bag of ice, and it's also I can't remember what fruit that's in.
If I said avocado, would you?
It's an avocado.
It's okay. So you said there were just 2 bins. Is this the second bin?
Yes.
Okay. Where'd you find this?
It was, if I remember correctly, this bin was going to be alongside the.
We're gonna go back and
West
show
wall.
a picture of the whole room again when we go through each thing, but this was in the room that night.
Yes, sir.
Okay, was the ice, can you go back to this, to the receipt? What is, can you read if we give a close up what the items on that receipt were?
Bagged ice, a Larabar, 2 Larabars actually, a Robitussin, Clo Cup, Pantene, a nut tray, orange juice, Diet Coke, K deposit, I believe, probably for Diet Coke,
Mhm.
Organic bananas, extra large avocados, and an iced nut.
When you, what is the ice sitting in?
It's sitting in a metal tray.
Okay, a receipt later says lasagna pan, but if you know, would you call it, you don't know, do you?
I would
Okay.
call it a metal tray.
Okay.
It's similar to what you, if you have family gathering, if you're cooking for family, you have lasagna, you make a large
Okay.
dish of lasagna or takeaway.
Got it. Was the ice melted or was it still intact?
It was melted.
Okay, next picture. What is this?
It is a receipt, I believe it's bottom half of a receipt,
What's the date and time?
12/3/21, 4:09 p.m.
Okay, and that's, looks like it's for how much, if you can see? Does it say
No, I don't see it. I'm not seeing it.
up at the top?
Sold items, $1.04.
Okay, and it's to the state of Michigan?
Yes,
Okay. What is this?
photograph the mattress, so we went through.
The item at the bottom of the screen, what is that?
It's a blue solo type cup, plastic cup.
Was there anything in it?
No,
All right, and 386. What is this?
that's another plastic bin.
Okay, so were there 2 plastic bins or 3 plastic bins?
There were multiple plastic bins
Okay.
in the room.
The items that you found, were they in 1, 2, or 3 plastic bins?
2 plastic,
Okay, so there's the one that the backpack was in.
which was under the table.
Okay, and then what's the other one?
That second plastic bin was with ice that was melted. And
Okay,
we have this third plastic bin that actually, which I would say the second plastic bin, which actually has items that are important to this.
okay, so you weren't counting the one with the ice?
No.
Okay, all right. Where was this located?
This will be alongside the west wall.
So was it next to the mattress?
No, the mattress, again, as you come into the room, you have the table that had food items on it, and then you have the bed. As you work your way further west of the room, you have their wall that you took, that we go through the earlier pictures, have a picture with the paint splotches or whatever.
All right, well, I don't mean to interrupt you, but we'll show you a picture.
Okay.
So was this next to the other bin with the backpack?
No.
Okay, about how many feet away from that bin was this one?
Can't quite call it off my head, but about more than 8 feet.
And what was inside this bin?
It was a purse.
Was this securely latched?
Yes, if you can go back to the further picture, you can see how it was more firmly latched.
Okay. And did you pull that bag out?
Yes, we took pictures in sequence so you can see as we're moving, opening up the actual plastic, the plastic bin and actually pull it out first.
Okay, and the next slide. Is that the bag that was in the bin?
Yes, ma'am.
And this is your protocol? Is that, I don't want to put words in your mouth. How do you approach the photos in terms of sequence?
As we go through the purse or any kind of item that you're like, any kind of item, we open up the purse and take a full photo of how the items are in the purse at the time of collection. And then we start pulling out the items and kind of setting them up and showing the items individually that was inside the purse, bag, whatever.
Okay. Let's go to the next slide and we'll go through all of the items because you actually take each item out of the purse and photograph it.
Yes.
Okay, what are we seeing there?
Those are 2 envelopes with cash inside.
Okay, and 390? Oh, I'm sorry, what's underneath the envelopes?
That is the tabulation return. Whenever we do a crime scene, there's an officer there that takes notes on all items we collect from the crime scene.
Okay. Look closely at that search warrant tabulation. Who's Peschke? Do you know who that is?
No.
Okay, if I told you it was an Oakland County sheriff, would you say that this was the search warrant for that room?
Yes.
Okay. Is it continuing? Okay, there were two search warrants. Well, there were many search warrants executed that day. The search warrant that was executed on the art studio was one of them. There was also a search of the defendant's home.
Okay.
Do you know whether this was a tabulation for the art studio or the defendant's home?
This should be a search warrant for this location, this scene.
Okay, we'll get to that. Next. What's this?
Again, we're taking more photographs inside first.
And what's visible in the purse?
Most visible is you have more cash, cash inside first.
Okay, and then some other items?
Yes.
What's to the right?
You have pills, bottles of pills.
And then what are those items?
Along where, if you look, there you go. You have the keys, and as you go further to the right, you start to see the cell phones, and we also collect.
Okay, next picture. That's a close-up of the cash?
Yes, ma'am.
All right, and 392?
No, you have a close-up of the pills and cell phones, and also the keys to the key outside.
Okay, how many cell phones?
4.
All right, and did you notice anything about these cell phones? Well, first of all, were they on or were they off?
All the cell phones were off at the time of we collected.
All 4 of the cell phones were off?
Yes, ma'am.
Okay. Anything else did you notice about the cell phones?
As you see, one cell phone is, as I say in my word, severely damaged.
All right, and that's the front screen?
Yes.
Okay. So would you say that's multiple cracks indicating damage or a couple cracks?
I'm comfortable with saying severely damaged.
Next. That's a close-up?
Close-up of the keys that we collected from inside first.
And what is that card, if you know?
It says card activation. It's like a kind of date card or something.
Okay, next slide. All right, this is a close-up of the medications.
Mhm.
All right, and can you read what the medications, first of all, are they prescription?
They are prescription.
And who are they prescribed to?
Jennifer Crumbley.
All right, and do you know what each prescription bottle is for?
You have 2 bottles of Adderall, and then the third bottle I can't quite make it out.
Okay,
Okay. There was a text message sent from James to Jennifer back in like March or April about possibly giving Ethan a Xanax. And so I was really concerned with these medications were actually, if either of them were Xanax and they were prescribed to the parents, and they could make the inference based off those text messages that they were giving them to Ethan. And if they weren't prescribed to him, that might be a problem, but it might also show parents who are caring, trying to do something. I don't know. It's going to be, maybe back or forth, but I was curious as to what these were. I missed this. And then I saw a comment yesterday on Law and Crime clip that said shocking evidence around the Crumbley case or something. And people were like, I can't believe they didn't go to the police. James called the police right away. And then the news blurbs from today. Oh my God. Jennifer refused to get over her phone. How about the fact that she did not want to turn over her phone because she didn't have anyone's phone numbers written down. And then when the officer gave her a notepad to write down all the important phone numbers, then she handed over her phone. How about that? Is that not in the news? That doesn't make a sexy headline though, does it? And then the officer, they're going to talk about they were on the run, they were fleeing, they had burner phones. The police officer is the one that recommended that they get burner phones because we were going to seize your phones, people. But that, again, doesn't make a sexy headline. I hate the
I'm
news.
going to close up there. What is that?
And the government. What does the government say? Or what does
All
the
right, do you know
government?
what that is?
What do you say about the
Okay,
government?
if I told you it was Xanax, do you have any reason to disbelieve that?
I would have it in this.
Okay. Next.
Give me a photos of the cell phones.
Okay. And the next one? What is this?
That's when we started pulling out cash and counting.
Is that your protocol? You lay out all of the bills?
Yes,
Okay. 397. That's
we're continuing to count the money as we find.
Okay.
And we're still counting money. And we're still counting money. That's last photo.
did you count all the money?
Yes, we counted all the money.
What was the total in cash that was in the purse?
$6,617.
Okay. 400. What is this?
It's another photo of receipt. I believe that's the top section of the receipt from earlier.
And what is the date and time?
12/3/21. 437 p.m.
Can you read the items on the receipt?
No problem. Jeffrey giant lasagna pack, Furners 2 liter, kind of recycling fee of charge, paper towel, Kleenex Ultra tissue.
Okay. All right. Lieutenant Melissa's going to help me just for demonstrative purposes pull out just some of these items that are not exactly clear in the photo. So I just wanted to ask you in detail if this was the item that you photographed. Is that okay?
Yeah, no problem.
Okay. The first is the book pack, the backpack.
that does appear to be a photographic.
And that's where the packet is with the horse medication. It looks like, was this in the backpack?
It wasn't that.
Okay, and then the clothing items were also in there.
Yes, ma'am.
Okay. And then the next,
That's 427 for the record.
427.
okay,
What's 427?
For demonstrative purposes, the backpack. So it's identified for her.
do you recognize these items?
Yes, those items that provided.
Okay, so are those clothing or are they blankets?
They appear to be blankets.
Are those also 427?
Yes, sir.
That's the Snipes bag, correct?
Yes, ma'am.
Okay. What's the socks? I'm just gonna get that. So these are some, where did what is this?
That's the sweatshirt. We already went over it, through the picture, over the pictures over.
And where was that found?
That was found near the Snipes bag.
Okay. What is this?
That was a jacket that was over the chair.
Okay.
That had the hotel room card inside.
Okay. And then that's sort of just like, and then the only other thing we're gonna show you is the last item found in what you call the second plastic container, which I call the third. Is this that in that container?
Yes, that's the first.
Okay, and were the cell phones found in this bag?
Cell phones, the money, yes, that was in the bag.
Thank you. All right, before I go back, lastly, to show you the pictures of the room so you can orient us and where these things were found. Did you ever come in contact with Jennifer Crumbley?
We were requested to look down the jail photograph both the properties.
Okay, and why were you asked to do that?
We were just requested to take pictures if there are any injuries regarding their arrest. Because the request was not only for a search warrant, but if you look at my report, the request was to process the scene of a search warrant and arrest at the address at 1111 Beverly Street.
Okay. Do you see Jennifer Crumbley in the courtroom today?
Yes, I do.
Can you point her out and describe something she's wearing?
She's right there. She's wearing a blue jacket or a suit jacket.
May the record reflect that he's properly identified the defendant.
The record will say.
Okay, lastly, I just want to take you to the initial photos that you took to the room to try to point out where exactly you found each of these plastic bins. Okay. Right, is this a good photo to show us?
Yes.
Okay.
I'll go back one more. One more. There we go, right there. The first bin is going to be to the just to the right of the table with the food items on it, on the floor, and it was kind of under the table. That was the item that had the book bag in it, if I remember correctly.
Okay, and the mattress is on the other side of the table?
Exactly.
Okay, where was the ice and the avocado found?
Ice and avocado were still were more out in the open, still in that same area of the first bin.
Okay, was the second plastic bin that contained the purse with the cell phones and the cash, where was that?
If you look straight ahead, as I mentioned before, the portrait that had the paint splashes along that wall, you have that table just up under it, and just beyond that, and you move around, that's when you see the container with the.
Behind
Yes.
that workbench on the left?
Yes.
Is there a better photo of it? Can you see it from that?
No, we're looking.
How about there?
Come around. That area, just one more over. There you go. You have the bench. I misspoke. You have the kind of yellow
Cart?
the yellow cart with the tubs.
Yes,
Just to the left of that, you have the items with the paint, and then just behind that would be the tote.
okay. And that was securely fastened?
Yes,
Okay,
and it was securely fastened, but in another bin. As you when you go through the picture, you can see that bin is in another.
was the bin inside that bin also closed?
No.
Okay, and was the bag zipped or unzipped?
That was it. This time. Well,
Okay, and that's where you found the cell phones that were turned off and the cash?
yes.
Okay, and how did all of that evidence get here?
After we took pictures, all these pictures, we then collected the evidence and we secured them in these items and turned them over to the Detroit Police Public Safety Headquarters and evidence lockers.
Can you guys still hear it okay?
Thank you.
The sound just shifted.
Oh, definitely. Yeah. And I'm like, man,
Okay, that's it. There was no cross of this witness, and they're done for the day. That was a lot quicker than I thought. Yeah, I mean, there's no sound. I can hear it. They ended this witness's testimony. They ended the direct, and then the defense had no cross.
For example, witnesses who swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, do not go on Facebook, don't post, don't do research.
The judge is emphasizing don't go on social media for the night.
Any questions about the schedule?
What's interesting is that the second or third day of trial, it might have been Monday, the third day of trial, the jury came in and said that they were concerned because there was a news article that described them to some degree. It didn't give their name or anything, but 35-year-old white female chiropractor, blah blah blah, whatever. How is it that the jury knew that if they weren't looking at the news? I did not hear anything regarding passports or enhanced license. Although it wouldn't be terribly uncommon for people in Michigan to have those, because we travel to Canada a lot. I've always got my passport card with me, or my wife has her enhanced license. So I'm going to go back a little bit, because the most entertaining part was where cross-examination started on witness number, whatever his name is, this guy. Witness 19, Brian. So we still have about half hour before the court goes live. So I'm going to go back a little bit to yesterday and play this portion of it. If you guys didn't catch it live yesterday, we'll go there. They're being charged with running. No, the only charges is 4 counts of involuntary manslaughter. No contributing to the delinquency of a minor, no child neglect, no fleeing, no attempted escape, no nothing. It's 4 counts of involuntary manslaughter. There's no lesser included. It's either guilty or not guilty, and all four are going to be the same, either guilty or not guilty, and that is it. And the husband is charged the same way. Now, depending on the outcome of this, they could potentially charge her with other. No, I think they'd be barred from charging her with anything else, but they could amend James's charges, depending. This is the trial highlight so far. Open the door and come on in.
Of 2023, law enforcement did a 3rd interview with you, correct?
This is great.
And that interview was almost 3 hours long. Is that a yes?
Yes.
So you were interviewed.
I actually sent Shannon Smith an email because of this. I said, been watching your trial on my channel, and I know these things are draining, and I'm very concerned about this case, but I have to give you props for yesterday.
once at the very beginning of the case, right after the shooting, correct?
Correct.
You were interviewed a second time months later in February for about an hour.
Correct.
And recently, within the last couple of months in December, you did this 3-hour interview.
Correct.
It's fair to say that throughout all 3 interviews, you tell law enforcement repeatedly that you have memory problems, correct?
Correct.
You do not have a good memory.
8:30 to 9
I am not trying to be
a.m.
mean to you,
Eastern.
but you have repeatedly said you don't have a good memory. Is that correct?
Correct.
Now, when you initially talked to law enforcement, they told you they would like you to write a statement, correct?
Yes.
And you did, in fact, write a statement. You typed one out, correct?
Yes.
Now, the date you typed one out, did you do this on the date you were first interviewed?
It was morning after.
Okay, so the morning after, so it says you were interviewed Friday, December 10th, 2021, correct?
Correct.
So the statement that you actually typed out and wrote would have been done on December 11th of 21.
Yes.
Now, it's fair to say that in the statement, you gave law enforcement and police as much information as you could remember, right?
Yes.
And this time, when you wrote your statement, this was way closer in time to the shooting than we are today, correct?
Correct.
Now, when you wrote your statement to police, a lot of the new information you're sharing was not in your original statement, correct?
Correct.
And you would agree with me that during the hours of interviews you've had with law enforcement, they have given you different pieces of information against Jennifer Crumbley, correct?
Correct.
And you have not had the opportunity to take all this new information you're getting against Jennifer Crumbley and talk to her about it, correct?
Correct.
The last time you talked to Jennifer Crumbley was December 4th of 2021. Is that a yes? It's fair to say that police, they have asked you the same questions over and over and over. Is that correct?
Yes.
And when they ask you the same questions over and over and over, you can tell sometimes they don't like the answers they're getting from you. You can tell that. Is that a yes?
Yes.
Okay. I need you to be loud. Okay? Thank you.
Oh, yes.
So when you can tell they don't like the answers, you keep talking to them, correct?
Correct.
And when they've been interviewing you, they have started to talk to you about things like your job and your benefits, correct?
Correct.
And they have said things to you like, if you're helping Jennifer Crumbley, you could lose your job as a fire.
Yeah, they're implying that because they were running, that they were guilty. Consciousness of guilt. If you think about Armstrong, the Armstrong trial, where she ran to whatever country in South America, they're saying that she ran because she consciously knew she was guilty, and that is proof of that. But in this particular case, there's no intent, right? There's no intent to do anything wrong. They didn't intentionally pull the trigger. They didn't pull the trigger, period. So consciousness of guilt, I don't think really works. And I'm surprised the court allowed it in, but they did.
Fighter, correct?
Correct.
They have said things to you like, if you're helping Jennifer Crumbley, you're going to lose all the benefits, your pension, things like that, correct?
Correct.
It's fair to say that when you've talked to law enforcement, they have said things that make you feel like you're going to be in trouble because of your friendship with Jennifer Crumbley.
Correct.
So when you're up here on the stand today saying some of these things, we can agree they are brand new within the last few months.
Yes, knew that. I've seen.
Okay, so and largely what has influenced you to change what you say, what you said initially, is because police have talked to you and made you change your mind, correct?
It had to make me, from my original, that more information was needed.
Right, so my point is, you talked to them at first, back in December, right after the shooting happened, right?
Yes.
And then law enforcement met with you 2 more times and gave you information, right?
Yes.
And they told you that if you were helping Jennifer Crumbley, you would be in trouble.
Judge, objection, we're getting dangerously close to what defense counsel has sought to exclude, and I need to be able to redirect.
Yeah, let's be careful.
Well, the door's open.
Okay, let's be careful.
If counsel is gonna lay the implication of a certain reason,
Well, you're asking whether law enforcement threatened him in order to get him to lie?
Yeah,
then the door is wide open for the people.
It might be,
Thank you, Judge.
well,
I don't care if the door's open. That's fine. Mr.
Yeah, then I think we need to excuse the jury and have the
That's fine.
defendant make a record.
No, Your Honor, we've already done that. That is not what needs to happen, but if the jury needs to excuse, that's
Something
fine.
you tell me, you tell me.
This is something different.
Well, there's allegations here that somehow this witness was intimidated by the police, and I would take that very seriously. So if that's true, the jury should know. So That's a serious implication. So,
Judge, we can't allow counsel to say those line of questions without, and prevent the people from having the witness give the whole story.
I'm not trying to keep the whole story. Go ahead. We can do that right now.
Now that we
They
know
wanna
the
make
whole
a record
story,
that's not
I don't
needed.
think this
I'll
opened
ask
the
the
door,
questions.
but I'm fine with
Okay.
the door being
Mr.
open.
Malone,
if,
Mr.
For,
Malone.
for
Okay.
proper purposes, we need a record made, Judge.
okay. All right, 10 minutes, guys. Maybe 5.
Oh, I hate when I forget a password for a stupid thing. Oh, I'm not a robot. Let me pick pictures of
Okay.
cars.
Okay, everybody be seated. Actually, I think I might ask you to step into the hallway just for a minute, okay? We'll be right with you. I know it's not a very comfortable position to be in. We're doing our best, okay. You may be seated. Okay, so we had a motion to eliminate, gosh, when was that? November, March, when was it, 2022? And certain evidence was excluded, right?
Yes, Judge. Specifically, counsel sought to exclude all evidence of extramarital affair.
Okay,
Now,
so, yeah,
as an offer of proof, this witness, when asked, will testify that he didn't want that information out in the public domain.
Yeah, I planned on doing a recap after like each day, and then I got sidetracked and busy. So I haven't been able to do a daily recap. My initial thought was I was going to do like every couple of days. But to be honest, LaBecky, I think what I'm going to end up doing is rather than a pre-recorded recap, I'm going to go live on Saturday morning before my Jody area stream and do a recap for the week. I'll go over all of my notes. I'll go over the witnesses and things like that. I think that's probably what I'm going to do. So if you can hold out till Saturday, I can give you a breakdown each and every day, identify what happened on what day and things like that. But that's just the only way I can really do it in my schedule.
Now, I didn't ask him any of that information. Counsel is choosing to cross-examine him in a fashion which makes it appear that he's either been intimidated or willfully lied about statements made. He has a reason why certain statements have changed.
Jules was
Judge,
interviewed
and
by
if
Legal
counsel is
Voices
going
yesterday.
to be
Okay.
allowed to introduce this to the jury, we have to be allowed to rehabilitate him and show what actually happened. And if counsel does
By
say
the
the
way, if
door
you
is
guys
open, like
wanted
she just
some
said,
background
First, I would like
information
the record
about
from
all
Judge
the
Crumbley.
parties involved, including this guy, Karen, the judge, Miss Smith. It's all in my Discord if you guys are members.
herself, that she acknowledges what this means. It is her decision in consultation with her attorney and it's part of trial strategy.
well, credibility of witnesses is always an issue, and so is the motive of a witness.
Thank you very much
And,
for
I
the
did
super
exclude
sticker.
that evidence at your request, subject to later information that if indeed something having to do with the relationship lent itself to gross negligence or dereliction of duty, right? So I did grant that motion. So what is your position now? Because the jury can't be led to believe that they, waterboarded this guy to get him to talk or something, right?
Your Honor, my position is that if the court has found I've opened the door, the court has found I've opened the door, and I would like to proceed with
Ew, I
questioning.
see.
Oh, okay.
Jules on with Legal Voices.
Well, I'm gonna put that right back in your lap, right? Because you're asking me. I'm asking you.
Oh, I'm fine. I would like the door to be open. I would like to be able to fully cross-examine
One
this
of the
witness.
tenants was a friend of theirs. Let him stay.
And Your Honor, I would object to the court inquiring, asking Mrs. Crumbley about this. This is trial strategy that's left to the attorney.
Judge, no, we need to have.
The
full
Fifth
record
Amendment
for
stuff
our
has to do with
purposes.
Ethan Crumbley.
Of why
Ethan has pled the Fifth and is going to refuse to testify when everyone thought he was going to.
you're out to defend it, just the way the Facebook message was introduced, that it is in consultation.
Or are they
with
talking
her
about the
attorney.
Facebook
She
messages?
understands
Because
what this
that's
means. She understands that counsel cannot use that prior ruling to
the
her advantage.
defendant's
She
own
understands that
statements.
at her behalf, counsel has sought to exclude certain things and was successful. But now counsel is adamantly requesting that ruling not be put in place, allowing the prosecution to cross-examine this witness and when the defendant testifies as well. That's all out in front of the jury. So that's not fair game for when the defendant takes a stand for which she's indicated she's going to do.
Okay, well, I guess I would say if the defendant takes the stand, it is fair game to the extent it's relevant,
Of course,
right?
it's always to the extent it's relevant. I can certainly envision a possibility how it might be.
Your Honor, I suppose the first thing I need is a ruling if I've opened the door and if this evidence is now relevant about the affair. Because I still think it's relevant that police threatened and made Mr. Malosh say things that were inaccurate, irrespective of the affair.
Okay, well, I don't know what happened. Did they interview him for 3 hours and then threaten to call his wife? I don't know. I don't know what happened.
No, they threatened him like I asked him about his job, his pension, losing those things.
That's
And
counsel's characterization of something that is certainly not evidence. The question is not evidence, and that is certainly that we're going to explore now.
Well, I guess the prosecution is saying he initially had a motive, perhaps not to be completely truthful to the police because he didn't want his private relationship with the defendant revealed, which you know, I guess is understandable, but it sounds like maybe he wasn't completely open and honest with them as a result of that.
But
But
now all prior, and interrupt, but now all prior consistent statements would be admissible under MRA 801. But first,
yeah, I'm not going to let you let the jury think that the police, you know, threatened him or did something to make him say something he didn't mean, just to avoid repercussions to him, whether it's employment wise or personally. And you know,
That's fine. Your Honor, I have opened the door and I want that door opened and I want to fully examine this with this witness.
I want that door opened. I like that.
again, what you're
I'm
from the
an
defendant.
answer. Okay, can you raise your right hand? Do you swear or affirm the testimony about to give is a true self?
We did.
Okay,
We
can
got
you-
caught up, Josie. We got caught up from yesterday. The parts that I didn't stream, and then I went back a little bit to look at this cross from the Jennifer's lover, lack of a better term, because I really like this cross, and so we're just waiting for the court to go live with the feed, and then we'll be back up and running. We should be going with a live court here any minute.
Keep your hand down. This is probably, I want to make sure, this has been kind of fast and furious here, right? Okay, so I want to make sure you know what was going on. A year and a half ago, there were some motions that were filed about keeping some evidence out.
Correct.
I guess I would suggest that now that we're here 2 years later and there's more information about the case, I can't even tell you if I'd rule in the same way, knowing everything I know now. But that being said, I want to make sure you understand what your lawyer said, which is that I previously ruled that in and of itself, the fact that you were having a romantic relationship with this man, to me, was not evidence in and of itself of gross negligence or dereliction of duty. Therefore, I granted your attorney's motion to keep that information out of the trial. You understand that, right? Okay, but now this gentleman is being questioned about why he did or didn't make certain statements to the police. And your attorney has indicated in front of the jury that he might have some motives, or maybe he's been threatened by the police. And she has said to me that she wishes to pursue that line of questioning. And I want to make sure that you are supportive of that.
I trust her, so yes.
Okay, so you understand that then we're going to crumple my order up about that and throw it in the trash and go forward.
Thank you for reminding
You
me,
understand that?
Christine.
And you agree?
I
And you
will
agree?
update
Yes,
my
yes.
notes now.
Okay. Do anything?
Judge, I think I should make a record so the defendant and perhaps
For those of
counsel
you
knows
who
for sure.
don't know,
It's not just an
I,
affair of one man that was
take
uncovered.
all my
There's
notes
web searches now.
today,
There's
and I
trips during
put
work hours.
them in my
There's
Discord as
when
well.
she was on
Photographs
actual
and
work
other
trips
things, so
with other
it
individuals.
really
It's not
messed
just
me
this
out.
person. It
Okay,
changes the tenor of the entire
I don't
trial.
think that's appropriate. You're asking why this.
Judge, counsel has alleged that two investigators with 30 years of experience have committed basically a crime by intimidating a witness and lying to a witness, and that it requires a strong and accurate response. This changes the entire case, Judge. I can't let that comment go without being corrected.
Okay, well, I don't know any of this information. You're going to ask him, this witness, why he was protecting her, or why he didn't give full information to the police. We're not going to go off into Never Land and talk about trips or
Well, trips with him, though. Trips with him when she said she was at work or using her son as an excuse to go somewhere. Trips with him in particular, Judge, that goes to the heart of gross negligence and failure to adhere to your parental duty. That is a part of the case that we moved past.
I
The
don't know
court issued the
anything
ruling.
about that.
Your Honor, lots of people have
It was
affairs
excluded.
and don't have children that shoot up a school. That's not true.
Again, counsel's now seemingly asking for the same ruling that she
No,
had
I'm not.
achieved before.
I'm not. I don't care. I don't
Okay,
care.
I don't know what you're asking me to do, because I haven't seen any of this evidence. At the time that I granted the motion to eliminate, I don't even think some of these things were known. So when you say you're opening the door or whatever's happening, I want to be clear on how far the door is open, because I also don't want to have this isn't a trial about she isn't charged with being immoral. Okay,
Of course, but she
that's
is
not-
charged with failure to adhere to her
I
parental
Look at
understand
a
duty.
that.
judge
I
who
understand
doesn't
that.
want
It's
this
going to
to
come
treat
out
this
that they
like
had
the
an affair,
Murdoch case.
Okay, it is not because of the affair that Mr. Maloche changed his statement. The first time Mr. Maloche was interviewed, he told them about the affair. The second time he was interviewed, he told them more about the affair. The third time he was interviewed, he told them even more about the affair. That's not his motive for changing his story. His motive for changing his story is because law enforcement
Oh, is it civil in the
put
chat?
pressure on him and made him fear he'd lose his job.
Yeah, I had to end early, so we went back over the parts that I missed, and then I just wanted to go back to this particular part of the whole opening the door and the cross-examining of the lover, the affair guy, and because I thought this was fairly good cross, and I really liked it, even though it opened the door. So we're just exploring this again. But hey, Kurt.
all right.
It is completely inaccurate. Again,
Okay.
now
It's
we have to
in
introduce
evidence.
witnesses.
Okay, I'm not addressing that right now. I'm addressing the, now we're going to put in all this.
Yeah, the state was
information
winning the case,
about
and now they're concerned that
affairs
they might have put
and
a
all
witness
kinds of
on the
things
stand that was coerced by
that
police to
she
give
was
statements that may
spending
be
time with
false.
him instead of her son.
How interesting.
How far are we taking this? That's what I want to know.
I guess it depends on the questioning.
Okay, well,
Because if that's the record, and if that's the request, and if that is the defendant's wish, Judge, that's fine. But we are gonna go through that door with the evidence that we have.
I'm not privy to the information. I don't know what happened. I don't know what the police reports say. I don't know what he said.
Good morning,
about his
Jackson.
relationship with her, right?
Welcome
I
to
don't
your
know that.
education for today.
But, it's also, this is not a trial about her morality, so I want to make sure that we stick to the elements of the case and what you're required to prove, which is not that she's a bad person. That's
Judge,
not what we're here about.
Council has made it a trial now, and if law enforcement is appropriate or not. So
Whether law enforcement was appropriate with Mr. Malash or not has been made an issue.
Yes.
But, are we gonna have another week? of
I'm
trial
confused,
about-
tired, and grumpy. Okay, so what I thought the cross was strong. This was I explained it to Sean from Potentially Criminal yesterday after Joe's stream. I feel like it was like watching the Detroit Lions. I was I was super nervous, and I was like, oh, don't go there. And then when she started really going after this witness about how the police were coercing him into giving different statements each and every time, and that his statement from the original was more closely to the truth than what he ended up giving in the third day or the third time he was interrogated for 3 hours. And I was like, yes, yes, yes. And then all of a sudden the prosecutor stood up and said, no, she just opened the door. And I was like, no, what did she do? And then she was like, blow the door open. I don't care. I got like really nervous again. And then after hearing about the nothing burger that was the affair, I was like, okay, cool. So we still got the guy being coerced by police. And she got the final word with this guy, and that he was coerced, that his stories changed because of the pressure that the police were putting on him. And the fact that anyone who supported James or Jennifer or backed them in any way, shape, or form was being, I think his words were exposed, crucified, and something. I can't remember exact terms. I was like, oh my God, that's perfect. Okay. So I sent Miss Smith an email yesterday telling her that I liked that cross, and I thought it went well, actually, overall. I thought it went well. And the fact that during the rest of this cross-examination, the state looked super scared, jumping up and objecting to everything and wanting clarification on everything. To me, if I was on the jury, I would think the state's scared of something. The state is scared of this guy. So it was very interesting and very good, and I liked it.
How terrible Mrs. Crumbley is, and
this is the same argument as when the court brought up the pictures of the home. Nobody is arguing that they're terrible or dirty. We're arguing that they were grossly.
This is not in front of the jury, by the way, right
now.
now.
That's
The
why
jury's
I
been
was
removed.
relevant as to that.
And Judge, we stuck to the very fine line that this court gave us in the ruling. Counsel's the one who has suggested, not just suggested, but actually alleged that 2 investigators intimidated and lied.
I understand that. That has definitely been raised and definitely should be evaluated. But
Hey, yeah,
I
Oakland
don't
County
know
is
what else
my
you're-
county. Welcome.
You're asking to present.
Well, at a minimum, those investigators have testified regarding their statements. At a bare minimum, Judge, there's a number of items found off of the defendant's phone regarding the extramarital affair. The timing.
A lot of
it
that,
is
too.
important.
Why
If
didn't
you want
anybody
us
look
to
in the
stick to
bag?
what happened with Mr. Malash, that's fine, but there is a.
I thought
vast
this
amount
cross went
of
really
evidence
well.
to draw upon, and I'm uncomfortable at this point with the defendant saying, I guess, maybe. I think she needs to speak with her attorney, and I think that record needs to be made clear.
We've already spoke
I
about it,
catch
Your
the
Honor.
chats.
We've spoke about it extensively,
I
and
don't.
an affair
I
is
miss
what an
most
affair
of it.
is, and if they want to sit here, it'll just make my case even stronger that all they are doing is punishing Mrs. Crumbley
Morning.
for the wrong things.
Okay, but I guess I'm at a disadvantage because I don't know, only the defense and the prosecution know what's going to come out. So does she know the extent of what's going to come out? I don't. So,
She knows the extent of what happened, and what's going to come out is going to be the truth about what happened.
okay.
And at this point, her life is more important than her dignity in terms of she had an affair. Lots of people have affairs. I mean, that's the bottom line is at the end of the day, it doesn't mean you know your kid's a school shooter. It doesn't mean that you know your child is going to kill people.
Well, I understand that's your argument, but I have a duty to evaluate evidence, determine if it's relevant, and if its relevance is outweighed by its prejudice. So that's what I'm trying to do, sort of in the dark here.
Well, I believe that the affair is not.
Yeah,
the
today's
moment
trial is
for
going to
Mr.
continue
Malash
right
to
here
say
as soon as
that
we
the
have something
police
up.
Put pressure on him the way they did to change his statement.
I understand
But
you told me that. I don't know what's coming in beyond that. I don't know.
I to be quite honest, they can bring in wheelbarrows and stuff to show the affair. I mean, if anything, it
I
just
don't
goes
think
to
I've
my
been to
case to show they
Goodrich.
don't have a real case.
Okay, well, they say that there's
Gone to,
evidence
like,
that when she
Sault
was
Ste.
taken
Marie
into the
area
first meeting,
around
she was
there,
with
and
her
then
lover.
Windsor.
I don't know, that's an example.
Uh-huh.
I don't know what's gonna come out, so I'm,
Niagara. I don't know where Goodrich
so
is,
what
but it
we're
doesn't
gonna
sound
do, Devin?
familiar.
Yes.
As long as the defendant's satisfied, Judge.
okay, I don't know what to say. I don't know what the evidence is gonna show. But I'm not positive the jury hasn't already figured that out anyway. You ready for the jury?
Yes.
All right.
All right, now they're going to bring the jury back in. We're going to continue this process.
Can you bring up Mr. Malash with him?
Please walk this way.
Still waiting for a court feed from today.
Mr. Malash, you are still under oath, okay? Okay, go ahead.
Yeah, I know. I caught that on redirect too, but then I feel like there was a recross as well that was allowed. And the last word was essentially he felt pressure. So, it's back and forth, but it's more of optics for me than the words. I feel like the state was really anxious about this witness being crossed about this. And I'm hoping the jury picked up on that. But irregardless, it's all smoke and mirrors because at the end of the day, there's no evidence that she knew or could have predicted this, which is fundamentally required under the gross negligence standard. So the gross negligence rule, first, the defendant knew of a danger to another. So right there, right? You have to know that there's a danger to the other students in the school. You have to know that your son poses a danger. Even if we want to assume that this is some sort of standard we're going to put on parents, you have to assume that she knew of the danger and knew that the situation required ordinary care to avoid injury, and that exercising ordinary care could also have prevented the injury, and that the defendant failed to exercise ordinary care. I don't see any evidence that supports this. And although evidence doesn't also, isn't always required for a jury to convict, we've seen that many times, the optics also come into play here. So if we have a witness that was potentially coerced by police, we have a distraught mother, you could see her crying in the back of the police car and things like that. I think that the optics of that might help with this particular case. Even though there's no evidence, we still need the jury to be sympathetic somewhat to the defendant. So,
Thank you.
Grumpy.
Mr. Walsh, we were talking about the 3 different times that you spoke to police, correct? Yeah. It's fair that from the very beginning, the first time you talked to police, you told police that you and Mrs. Crumbley had an extramarital affair, correct? You told police from the very beginning your relationship with Mrs. Crumbley involved a sexual relationship, correct? And so when you're in here testifying, it's fair to say that law enforcement talked to you about the affair right after the shooting. You told them all about it, right? I'm sorry.
Yes. Judge, I think counsel needs to be specific. She's saying law enforcement using general terms, and she needs to be specific in asking this question.
Well, there's a lot of different law enforcement, so it probably would be good to be specific.
The first detective that you had an interview with, you told him that you and Mrs. Crumbley had a sexual relationship.
Yeah. Again, identify who she's speaking to.
Do you recall who was the first, which officer are you talking about?
Which one am I talking about?
Yeah, the first, you're asking him
Sure.
about the first one who interviewed him. I'm assuming you know who that is. There's lots of law enforcement.
I know,
Sure,
which
are
is
you
why
live right now?
I have the name. But
Okay. Do you remember who it was initially?
You're not live right now.
Okay.
it appears to be Lieutenant Weir. Does that sound correct? Oh, no, I'm sorry. You talked to Brian Joseph the first time, correct?
I don't know.
Okay. You have, Okay, does it sound right if I said you spoke to Brian, to Joseph, I'm sorry, Brian, I'm saying your name. Okay,
I will agree with Kurt that I'm not a huge fan of this defense counsel. I think she could have been doing a regardless, I'm civil grumpy. I do think that she could have been doing a lot better. And when I say like yesterday was good, I'm not saying like this is the best defense work I've ever seen. I meant she's getting progressively better. So I'm seeing a trend. Although I have a feeling the state's going to run out of witnesses before she really gets into her stride, which is disappointing. But we got two Canadian dollars from Tara again. Maybe defense is playing dumb. She play DA over BF. She played DA over BF. I don't know. I don't think she's playing dumb. I just don't think she's that quick on her feet. And I honestly, I really don't like her style at all. I think she's getting some points out there, but I don't like the way she's presenting it. And yesterday was just like the best day. Prior to this, all of her crosses have been what I've been saying all along: short little jabs. Get in a few little points and be done with it. You don't need this long, convoluted, messy, connecting the dots cross examination that drones on and repeats itself. Just short little jabs. And that's what she did earlier yesterday. And then she went into this, which I thought was good. Good, it wasn't the best, it wasn't the smoothest, but it was definitely been. Yesterday was the best day she's had so far. And Civil's trying to gain consciousness. Well, good luck with that. I got up extra early today just to get caught up from yesterday. She is loud.
At 12:10, you went to the Oakland County Sheriff's Office, the Brandon Township substation, correct?
Correct.
You were interviewed at approximately 15:30 hours, so that would have been what, 3:30 in the afternoon.
Correct.
Okay, and on that day, I'm having a difficult time telling
See,
which detective it
I'm
was
not a
that
fan
did
of her
that
on cross
interview.
because
It was during that interview, though, that you gave them a copy of your Facebook.
yeah, on the
Messenger
whole, she's
thread,
pulling out good
correct?
points. I just don't like her
You gave it to
style,
them
and I
on
just
thumb
hope it's
drive?
resonating with the
And
jury
you specifically did turn
because
that
it's not with me.
drive over to Sergeant Brian. Do you recall that?
No, I don't have a feed yet.
The person,
I mean,
if I said
there's
the
various
person that
sources
you
for it,
handed
but
the thumb
nothing is
drive
up.
over to, was that the same person who did the interview with you?
Yes, they use the thumb drive on the computer.
Okay, I'm just checking. If the police report says you gave the thumb drive to Detective Joe Bryan, does that sound right?
I had no possession of the thumb drive. We were on a computer at the substation.
So he asked you for access to your messenger.
Correct.
You gave him access.
Correct.
And Detective Joe Bryan was the one who downloaded the messages.
I don't know the detective's name. I think Joe Bryan was a different interview.
Okay, so
Yeah,
you
her
don't know
voice
the
is
name,
too
but you know it was a
whiny.
detective at the substation
fan.
from the Oakland Sheriff's Department.
Correct.
Okay. And on the report,
Yeah, she has a
I
bad
also see
habit of
source
asking
Lieutenant
that
Weir.
one too
I'm just
many
having a hard time
questions and then
identifying
asking the
which
same
police
question
officer
over
it was.
different
You're sure it was
ways.
a police
And
officer or a
in this
detective
tone, I'm
that
just
you met
not a
with,
fan.
correct?
Yeah.
And you're
Yesterday
aware
was
that that interview was video recorded, correct?
At the substation.
Yes.
I was not aware.
And it was the interview that took place that was a little bit less than 2 hours.
Okay.
Okay, the day after that interview is when you were.
I understand it's cross-examination, but counsel can't just make a statement with the word correct at the end and then the witness clearly not understand and then just move on as if that's the truth.
Okay,
We have to be
yeah,
specific.
give him a second to think about it. and
Yeah.
question.
Okay, and I'm sorry, well,
I don't think they're going to call Megan. I don't know why they would in the first place. So Megan Amirowitz was a young lady, 18, that was unalive. She was convicted for unaliving her father back this past summer. And I interviewed her and her mother. She was in Oakland County Jail and made friends with Jennifer and said Jennifer was like a mother to her. And then she was there for the first day of jury selection. I saw her, I chit-chatted with her a bit. And then the first day of trial, she was also there. The state said that they were on her witness list and intended on calling her, so wanted her removed for sequestration so that she doesn't hear the other testimony. And there's suspicion in our chat that they don't really intend to call her. They just didn't want any emotional support for Jennifer in the courtroom because there's really no one supporting her in the courtroom that I am aware of. That's my suspicion, that they're really not going to call her. And I don't know what they would call her for anyways, but
so, I don't remember my last question. I think I was just establishing a time frame. You did the interview on Friday, December 10th. 2021.
That was the first time.
Is that true?
Right. Yes.
Okay, and that was 1 week after the last time you had contact with Jennifer Crumbley.
Yes.
The first time when you spoke with the officer at the substation, you disclosed to them that you had knowledge about Jennifer Crumbley.
Done and done. Excited.
Yes.
And you said that you told them right away that you had had a sexual relationship with her.
Well, I can't. I'm streaming
And-
here.
The fact that you and Jennifer Crumbley had a sexual relationship is certainly something you did not want to be public, correct?
Correct.
You talked to police again, we talked about in February for an hour. Was that also at a substation?
The second interview?
Yes.
No, ma'am, that was
The cat has 3 names, but I call it PP.
at a building over here, part of the county complex.
So you met them at the county complex and you had the second interview, which was just under an hour long.
Correct.
When you had that second interview, now that was in February of 2022, you told them again, you confirmed for them again, as much as you probably didn't want to, I had a sexual relationship with Jennifer Crumbley.
Correct.
In the third interview, back in December, just a couple months ago, they asked you again for more information and you told them again you had a sexual relationship with Jennifer Crumbley.
Correct.
Now, the prosecution may ask you a lot of questions.
Just in the form of the question, doesn't matter, but I asked Nanda.
He needs his junk adjusted. Thank you for the
My question
$2
is,
super chat
when
again.
you talked to law enforcement and you changed,
Again, I'm sorry, it's
Okay.
specific matter, okay? So if counsel's gonna request these kind of questions from the witness, she has to be
I
specific.
can't even get my question out.
Okay, well, he needs to know, because there are 3 different.
I can't even get my question out.
Thank you, Judge.
Okay. Over the course of the investigation, you testified
Excited.
earlier
It's Sunday,
that
right?
your
That you were
answers to
asking me
certain
about?
questions have changed. Correct?
Yes, I've had it.
You've added, okay. But one thing you have not changed, it's not the statements about your sexual relationship with Jennifer Crumbley. You've always said you had a sexual relationship.
Correct.
As police came and talked to you a second and a third time, they wanted more details about where you had sex and other details about those experiences, correct?
Correct.
Now, when I was asking you if you felt like you were threatened in any way, that had to do with feeling threatened that your job was at issue or that your benefits could be lost,
Judge,
correct?
I
Oh,
object again
let me
for the
pull up
question.
the
She needs
court
specific. She
feed.
can have something like threats. That needs to be specific.
Okay, then I'll go to the third interview, I'm sorry.
Yeah,
In
yeah,
the-
be specific.
Okay, I'm gonna be very specific. In the third interview, when you talked to them in December, they specifically said to you, talked to you about your job employment as a firefighter, correct?
Correct.
They specifically talked to you about the details of your benefits, including your pension, correct?
Correct.
They made you feel like if you didn't give answers they
That's in
wanted,
the form of the question. They made you feel. How could he possibly testify to what somebody else's
Okay,
intent was?
okay.
It would be speculation.
No. It's how he felt.
I'll ask how he felt.
Okay.
When you were in that third
All right.
interview,
So nothing's going on in
you
court.
were
I've got the direct
scared
court
at the
feed.
thought
Nothing's
of
going on.
losing your job or benefits.
No, I was not.
You do not want to lose your job or benefits.
No, I don't.
And when you were in that conversation with them, it was during that third interview that they asked you the same questions you had been asked many times before, correct?
Correct.
And they were saying very negative things about Jennifer Crumbley to you during that third interview.
Judge, specific.
Yeah,
Objection in the form of the question.
yeah, negative like what?
They told you that they had evidence of Jennifer lying about things, correct?
Correct.
They gave you the impression that you didn't know everything about Jennifer Crumbley.
And speculation, Judge, they gave
I'm
you the
asking you some
impression. Hang on, I'm not
questions.
done. They gave you the impression. If she wants to cross-examine him on statements, she can, but she can't make a broad statement about what their intent was. That's speculation.
Well, their intent is speculation, but you have specific examples of things that were said potentially by the police to this witness. You can ask the witness that.
Specifically, the officer talked to you about ranks within the fire department, correct?
Correct.
They talked to you about seniorities, correct?
Correct.
They talked to you about all the training you had to go through to take each position and the seniority levels at the fire department.
Correct.
You explained to them how you got to each position at the fire department, correct?
Correct.
The officer explained
See, I
to
feel like
you
all these
that it's important
objections that the
all
state is
cards are on the
lodging
table, correct?
to all these questions makes them look scared of this witness.
Correct.
And then the officer begins to talk to you and reassured you you're not in any trouble. Is that a true statement?
She needs to stop rolling
And
over
they
for
begin
this
to tell you things
misogynist.
that officer tells you.
Chat from Tara
He's
again.
not trying
I
to be
agree.
threatening to
I don't
you,
know about the
but he wants to
misogyny
put
thing,
the
but she
cards on
needs
the
to stop
table,
rolling
correct?
over.
What page are we talking about?
It's at 18 minutes and 57 seconds in the third interview. Do you recall that?
Yes.
And when he told you that the cards should be on the table, I'm asking your impression, took that to mean that your job and your benefits could be on the line if you said anything favorable for Jennifer Crumbley.
Objection, he just answered that he wasn't threatened. He just was asked that question and said, no, I wasn't threatened.
Okay, was there a specific threat made to you?
No, ma'am.
Was there any kind of veiled threat? Did you take anything as a veiled threat?
Yes, just that the information that's now out.
The court hasn't started. The feed is up.
Out publicly.
Okay, so there were veiled threats made against you.
Hold on.
I'm just clarifying. That was,
What is veiled threats
Well,
mean?
I asked if there were any.
I know, Judge, and that's fine. The court's entitled to ask whatever the court
Okay,
likes.
I asked if there were any veiled threats, so that was his invitation to say, yes, they said that they would call my boss, or they said that they would, you know, make sure everyone in my.
Yes,
community-
I have,
or whatever it is.
unfortunately.
Those are all great questions to ask.
Okay,
and I will.
all right.
Usually it's in family law court, though.
when you were interviewed in the third interview that lasted 2
Yeah,
hours.
this is reminding me of a family law court trial, right? I do a lot of family law, and this is how sometimes family law goes, especially because for some reason there's a group of attorneys that feel like they need to act like this in order to gain their clients' approval, especially in family law, because it's so traumatic for them, the clients, that they need an attorney that's going to be so dramatic. This sounds like a family law case. That's what this sounds like. Every time she tries to talk, he bulldozes over her.
5
Yes.
minutes. It's fair to say you discussed far more than in the first and second interview with police.
Correct.
And when you were interviewed the first and second time with police, when it was closer to the shooting, you would agree with me that you were truthful in those interviews.
Yep.
And during those first and second interviews, you also, in between those two, wrote a statement that you typed
All
out.
right.
Okay, so some of the information that you're saying now is
We
only
have a live
from- and
feed,
I'll go
but there's
through
no
specifically
volume.
what I
So
mean.
I'll switch over here in a second.
Right, so when you were interviewed in those first and second interviews, you never said that you thought there was something wrong with Ethan or that he was disturbed, correct?
Correct.
And today,
Nothing wrong with Ethan or that he was disturbed. That's where we're going to leave it. Everyone, maybe we need to put a time code in here, but we are going live now to court currently this morning. Make sure we don't miss anything. Get this going up now. Let's see. Boost it. We can't hear them talking today. All we hear is a lot of clicky clacky. All right, so we are live for day 6. We just did a recap, or we watched the part of day 5 that I missed. We did a little bit of the cross-examination from the gentleman which Jennifer was having an affair. The defense counsel had a really good day yesterday. I hope it's keep going.
We are all here.
Your Honor, I do have something I need to. Sorry.
So they're on the record, counselor.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990FH.
Good morning, Your Honor. Karen McDonald, appearing on behalf of the people.
Thank you, Mark Keeston, on behalf of people.
And good morning, Your Honor. Michigan Smith on behalf of Jennifer Crumbley.
They're all here. There you go.
Okay, my question, or I'm asking the court when there's an objection, if we can all slow down. And if I'm objecting to the prosecutor making these speeches on the record that
This
go in front of
needed
the
to be
jury.
addressed 5
What
days ago.
speeches are you talking about?
Yesterday during the questioning, when Brian LaRoche was up, the prosecution, when they would object, they would start to just say,
Well, I guess the first thing, and you guys, in the heat of battle, people forget this, even though they know it. that you can't make a record if people are talking at one time, but there should be a legal objection and a response to it. Things kind of went sideways yesterday because I think that the prosecution was saying to you, Ms. Smith, you may have opened the door. I think it's already open. Are we going there? So I think their intention was to warn you, stop you, or let you know that if you were going to go there, they were going to go there. So I really think the prosecution was making a statement or interrupting you for the purpose of wanting to comply with my order excluding certain evidence. So, things got a little crazy yesterday. So,
Your Honor, I believe it was beyond that issue and it was on other questions. And I'm going to tell the court, I did the same thing at points. And looking back at the tape, I said things, I just would ask we slow down with objections and that neither side say things that should not be put on the record in front of the jury.
okay, so objection and a response.
Thank you.
Okay.
So as we went through exhibits 348 to 400 yesterday, we stipulated them, but I don't think they were formally admitted, so I just moved for the formal admission now. Here's the photographs from the witness.
Yeah, no objection.
Did you receive my email about the sealed record?
Yes.
Yes, Judge.
Okay, so I want to do that not while the jury is
Hopefully
meeting.
today
It won't
is the
take
day the
much
state
time.
rests.
Sorry, I'm looking for my exhibit list. So, I'm sorry, Mr. Keys, you're moving for the admission of exhibit.
There were 348 to 400. They were agreed upon by defense, but I don't think they were formally admitted by the court. I just want to make sure the records.
Yeah,
I neglected to ask for their admission, Your Honor.
Yeah, I think there was sort of an understanding. So, 348 through
Shows
400.
no respect.
Ms. Smith,
I wish the judge.
Yeah, I made no objection and I did have down they were admitted, but either way, there's no objection.
Okay, 348 through 400 are admitted.
This is a
I
woman
want
who
to
had
get on
been
my desk, so I suspect that's where my exhibit list is. Anyway.
Let's see. I want him to try. Yeah, I mean,
I believe so.
she's
Yes.
not.
Who's the first witness?
Lieutenant Willis.
Lieutenant Willis? Okay.
She's not going to admonish him any more than she's doing
Judge.
right now.
We will be playing a portion of the Oxford High School surveillance video. I'll let the court know before
Okay.
to also inform the victims in the courtroom and so the media is aware.
Yeah, the media's been very cooperative, so, yeah, I'm sure the.
Why are we still showing these
Of
videos?
course.
And Your Honor, on that exhibit, the court knows I've objected, the court's made a ruling. Can we just not move for objection in front of the jury so I don't have to tell them I've objected? We know it's admitted.
Oh, you don't want to object, are you saying you don't want to object in front of the jury?
Yeah, because it's already been
Oh, I
admitted.
understand, so your objection is noted for the record.
Thank you.
Wicked was
I-
wicked, totally Pip.
Ongoing objection to it.
Right, thank you.
All right.
All right, for the jury?
It was a
Morning,
year
Ms. Seaman.
after
Thank
she
you
was
for being
elected.
so timely. We appreciate you. I'm going to ask the prosecutor for the next witnesses.
Lieutenant Timothy Willis.
Could you raise your right hand, please, I'll help you out.
I do, Your Honor.
Can you please step up, have a seat, and then would you please speak into the
This
record?
audio is horrible today.
Timothy
Delete it.
Willis, TIMOTHY WILLIS.
Go ahead, prosecutor.
Thank you, Judge. I just need to make sure this is connected.
Is this on, Judge?
What's that?
Is this on?
That usually is last. That usually is
They
on
did
last.
something
Thank
with
you.
the audio, probably because they were
Is the
picking
screen
up
on?
the
Yes.
Yeah, it's
defendant talking to
the
her
last thing that
attorney.
was on original.
May I proceed, Judge?
Go ahead.
Sir, how are you employed?
I'm a detective lieutenant with the Oakland County Sheriff's Office.
What is a detective lieutenant?
My duties include, I'm one of two detective lieutenants in the Investigative Forensic Services Division. We offer support services through investigations to our agency and really law enforcement in the region. My duties include the Special Investigations Unit. I'm in charge of that. I'm in charge of the Fugitive Apprehension Team. I'm in charge of the Computer Crimes Unit. I'm in charge of our warrants unit.
And we've heard about the Special Investigative Unit through Sergeant Joseph Bryan. Does that individual work for you as well?
He does.
Okay, so specifically the Special Investigative Unit, can you tell the jury what they do?
So the Special Investigations Unit handles major crimes for our agency. We often get requests from other agencies to assist with their crimes or handle them. These crimes range from high-profile
You're damned if
cases,
you do and you're damned if you don't. All right, Emily?
political cases, whatever really they kind of request. Our training is pretty expansive in as much that we handle like larger complex cases.
Okay. And how long have you been a
Jay-Z
lieutenant?
to the pre-law
Since 2016.
Okay. And all told, how long have you been a police officer?
I hired in 1996, so I'm approaching 28 years.
Remember to click
Sir, I'd
the
like to
number
direct your
tab.
attention to November the
and,
30th,
take the link.
2021. Do you recall that day?
I do.
Were you notified of an active shooter situation at the Oxford High School?
I was actually at the prosecutor's office discussing another totally separate matter, and the prosecutor and her chief assistant came in and advised me, was I aware that there was a shooting at the Oxford High School, and I was not at the time.
Okay, so you were meeting on a different case completely?
Yes.
Okay. And do you recall approximately the time that occurred?
It was around, understand it was a very difficult time to remember exactly, but it was around 1 o'clock.
Okay. And what did you do when you were notified?
Prior to that, we had recently had a similar, but it was a false alarm incident at a different school. So my initial thought was this was another one of those, just someone pulling an alarm or something happened. I immediately collected my things. I got up and walked. I made a phone call. For the life of me, I've been trying to remember who I called. I cannot remember. I do remember them telling me it's real.
Okay. And when you were told it's real, what clicked in with you?
Oh, he's gonna cry.
I went downstairs.
Okay.
We'll see you in a
Take
bit,
your time.
Miss K. Grift.
I went downstairs and immediately got in my car and went lights and sirens to the scene.
Okay. When you say lights and sirens, what does that mean?
My vehicle is an undercover vehicle for all intents and purposes, but it is equipped with lights and sirens to respond to different things. So, police term, we call it coding. It's just like when you see cops racing to the scenes, it was very similar to that, except my car is an undercover type vehicle.
Do you recall how long it took you to get there?
It was somewhere within 20 minutes, I believe it was.
Okay. Do you remember the drive at all?
I remember portions of the drive to the scene. If you're familiar with the area, M24.
Just a heads up, I'm gonna probably be in and out a lot today because I streamed early, so I didn't get a lot of work done. So I'll be like popping out to work and things like that.
Lapeer Road
I'll
is
be
the
here.
major route that we took to get there. It's the major road to get there, and it was completely lights, sirens, cars, just flooding northbound on Lapeer Road, and it was chaos.
So I'm going to show you what's already been admitted as People's 5. This is a map of the Oxford High School. Can you see that on your screen?
I can, sir.
Okay. Can you tell me what you observed when you first arrived at the school?
I observed when I came, there was students leaving the school. There was police officers flooding into the school. Emergency first responders. I know some of our people came right from their home address. It was I remember being shocked at, I live in a neighboring community, and I was just shocked that we have that amount of resources in a northern Oakland County school that quickly. Because I really moved to get there. By the time I was there, people were just flooding that place.
Do you recall where you went? First of all, let me ask you this. Did you go inside the school?
I did.
Okay, when you went inside the school, what was the situation?
I have no recollection of where I parked exactly, but I know I went into the front office area. You can see on right there where it says office.
Okay.
That entrance on the south there.
So this would be the main entrance to the school?
Yes.
Okay.
Captain Todd Hill, he was then a lieutenant, had already set up an incident command post, an interior post. Understand we had a perimeter all secured. We were securing all the doors, no one in and out unless you were law enforcement or emergency first responders. And we set up, because it was so cold that day, it wasn't ideal. However, the area where we were at, we determined to be relatively safe. So all of us responded to that area to start handing out our assignments. We refer to that as the interior command.
Okay, so you said incident command, interior command. Tell us the difference.
I'm sorry. So the interior command is just the location on the interior. Incident command is where most, if not all, the decisions are made. So at the time, the incident commander, Captain Hill, his focus was casualties, safety and security of the building, and searching for additional shooters. When I was driving to the scene, I do recall them saying, we were getting tips from, imagine being a civilian, or, driving around and seeing cars fly by you, hearing about a shooting, we got tips just flooded into our 911 center about, I think the shooter's in this car. I think the shooter's in this car. There's a man in a camouflage jacket running through the gravel pit. We think that's a shooter. So it was just, all we knew to do was go to the school first. We had no idea what else, if anything, was going on. So the exterior command was set up to first to protect the school. The interior command was set up to handle the issues going on within the school that, for lack of a better term, were most known at that point.
Okay, so you were a lieutenant at the time?
I was.
Okay, and at the time you were also in charge of the special investigative unit?
Yes, sir.
You said lieutenant. Now Captain Hill was focused on the active scene, so
yes, sir.
Clearing and casualties, things like that. Okay, what was your focus then?
So immediately upon entering the thing, I had a brief conversation with Captain Hill, advised that I would be handling the investigative portion of this. And we started then devising a plan, the best way that I could participate in the active investigation while the other stuff was going on. There was so many tips, if you will, social media tips coming in about this, that, and the other that, a lot of them certainly proved not to be true, but they had to be vetted. So, I could not just go in and start investigating the scene. There was several opportunities, i.e. For us to interview. We heard victims were at hospitals that needed to be interviewed. There was obviously tons of staff, personnel, and students still on the scene that we wanted to talk to and discuss.
All this
try to
really
figure
needs
out
to
what
say
happened.
is I went to the house or I went to the
Would it be
bag.
fair to
and
say
grabbed
that
the
it was
journal.
your responsibility
They
to
gotta go
coordinate
through
this
all of
investigative effort?
first.
Yes, sir. So my job, that's exactly what my job is. My job is to direct those resources to the follow-up investigation.
Would it be fair to say that you are the officer in charge of this case?
That's fair to say.
Tell the jury, please, what does it mean to be an officer in charge?
So as I stated earlier, I direct the investigation, meaning identify and attempt to interview or have my team attempt to interview victims, witnesses. I collect, decide, I assist. You saw Bob Catellis up here from the crime lab. Him and I worked together about obtaining what evidence we deemed was going to be necessary for this case. I direct officers, to secure I directed the officers to secure the Crumbley home because we learned where the shooter lived. At the end of that, I comprised the information, and then I turned it over to the prosecutor's office, and then we discuss charging decisions.
And that's what an officer in charge does in every investigation.
That's right. This investigation was not unique to that. We do them with all of ours.
Now, it's fair to say that there was a massive amount of evidence uncovered in this case.
Yes. Imagine we estimated approximately 1,700 people in the school that day. They weren't using their lockers. There was backpacks, cell phones, just dropped in. Obviously, they were worried about their safety. So we just had a lot of evidence within the school, not counting, evidence at different hospitals from victims, the shooter's home, things of that nature.
Okay. Judge, may I approach the witness?
Sure.
This is Exhibit 1. We have stipulation.
I think they're using this officer to introduce the journal, but any chance they get, they're going to have these officers talk about how horrible of an event it was.
Sir, I'll just give you all
Rush
of
there,
it. Okay, one
why
on
they're at the
top.
school,
Yep.
why they have access.
Can you tell me,
to
please, what I've
information.
just
They're
handed
just
you?
These are the
through all
autopsy
of them.
protocols for the 4 deceased victims.
All right. Again, redundant. No one is disputing this. Well, to be fair, if they came off as like hard asses and unemotionally affected by this, it probably wouldn't be a good look. Probably wouldn't be very sincere either. So I'm fine with him getting emotional.
Sir, tell us.
And the
you've
judge
reviewed
never
the-
said that he couldn't get that witnesses couldn't get emotional. They said not to emote, don't grimace, don't scowl, don't things like that. That's what the judge actually
the
said.
autopsy protocol in this case.
Yes, sir.
Do you know the identities of the victims who were murdered on November the 30th?
I do.
Okay. I'm going to show you what's been admitted, stipulated to as Exhibit 418. Who is that?
That's Hannah St. Juliana,
Okay. And how old was she when she was killed?
14.
And sir, can you tell us, please, how she was killed?
The official cause and manner of death from the autopsy protocol is multiple gunshot wounds, homicide. She was shot in her upper torso, her abdomen, her thighs.
Could you refer to Exhibit 2?
I'm sorry, and her left forearm. I'm sorry.
You don't need to apologize. Referring to Exhibit 2 now.
Lieutenant, can you tell me if you know, did I promote or didn't promote you, Lieutenant? Can you tell me if you need a break?
Yes. Yeah. I'm
Okay,
sorry.
just let me know, okay?
Yep. Thank you.
Now, this is People's 419 on the screen. Now, also referring to, this has been stipulated to, also referring to Exhibit 2, autopsy protocol for Madison Baldwin. Sir, how old was she when she was killed on November the 30th?
17 years old.
And how did she die?
Again, cause and manner of death was gunshot wound to the head. Manner of death was homicide. It was a close contact shot, meaning the the firearm was either on or near the victim's head when the trigger was pulled.
Referring now to Exhibit 3. That's an autopsy protocol for Justin Schilling, is that right?
I think I have St. Mary's 3,
I'm
Justin Schilling's
sorry.
4.
Thank you, St. Mir. And how old was he when he was killed?
St. Mary was 16 years old.
This is Exhibit 420, it's been stipulated to. Tell us please how Tate was killed.
Again, the cause and manner of death from the autopsy protocol was gunshot
We
wound.
don't really
Tate had
know.
multiple gunshot wounds.
Retarded
Manner of death was
anymore.
homicide. Tate was shot in the back of the head at a further distance.
Now Exhibit 4, sir. And that's the autopsy protocol for Justin Schilling.
Yes,
I'm showing what's been admitted, stipulated to for admission is People's Exhibit 421. Sir, is that Justin Schilling?
it is.
How old was he when he was killed?
17 years old.
Tell the jury, please, how he died.
Justin Schilling, you'll see, you'll observe, but he was cause and manner of death from the autopsy protocol was gunshot wound to the head, homicide. He was also shot at close contact to the back of the head.
Sir, were others wounded and suffered gunshot wounds as well inside the school?
Yes,
Do you know their names?
I do.
Can you tell us who they are, please?
There's Phoebe Arthur, Elijah Mueller, Kylie Osage, Riley Franz, John Asciutto, Aiden Watson, and Molly Darnell, who testified earlier.
Thank you, sir. Sir, tell us what happened when you assumed, may I approach?
Sure.
I'll take those here, sir.
Thank you.
Tell us what happened after you assumed the lead of the investigation. So where were you when this happened, and tell us the first thing that you did.
So the first thing I did was collect myself because I was pretty overwhelmed. And then we were determining areas of the school were had searched, and we were getting kids to the reunification point, which is, I think, was testified to at the Meyer. As that was happening, I made an announcement that I was handling the investigation to the 100+ emergency first responders that were in that office area that we saw earlier. And I said, if you're an investigator, come see me. And in hindsight, I don't know if it was the most efficient way of doing business because 100 investigators started walking toward me. I've never obviously dealt with anything like that before, but partners from the ATF is where I met Special Agent Brandon, partners from the FBI, local law enforcement from all over the region, all offering help.
Okay, so was it your responsibility at that point to direct certain officers and agencies to do certain aspects of this investigation?
That's correct. They, for instance, Special Agent Brandon approached me with his partner, I believe, and said, do you have the registered owner of the murder weapon? And I said, at this point, no, I did not. He's like, I'll take, let me take some information off the gun. We'll handle that. We'll track that down for you. And he did that, and I saw him.
One or two questions, maybe.
I heard from him a short time later, where he advised the gun was registered to James Crumbley.
You have no reason to believe that Jennifer was involved at all directly with the
And
unaliving
you
of
discovered
these
that
people or
weapon was
something.
purchased
Maybe,
on November the
maybe, if
26th,
anything.
2021.
I don't even know if he owns
Mr.
it.
Crumbley?
That's right. Just a few days prior on the Black Friday before.
Now, while you were on scene, did you come to learn the identity of the shooter?
I did.
And then was a decision made to secure the Crumbley family home?
It was. The shooter was on his way to the Oxford substation. I directed a couple of my investigators, Sergeant Joe Bryan, who you saw, to attempt to interview him at the substation. In addition, now that we knew who the shooter was, I directed detectives from the Pontiac substation. Lieutenant Marsban kind of spearheaded that.
I'm aware of Costco.
That part, and to go to the shooter's home to look for any additional casualties. It's not uncommon in a
Right.
shooting.
How's my audio
situation
now
where
compared to the
the
mic?
shooter starts in the
compared to
home
the court?
and then goes to the school. So I was concerned about that initially.
In a school shooting situation?
That's correct.
Does it sound
you had
better
learned
now?
about that in your training?
Yeah, and just by prior school shootings,
Okay.
it's certainly not uncommon for that to happen.
Mangs, you have to be a member. If you're a member of my channel, you get a link to the Discord. It's for members only. As a little perk, we have all the photographs and documents and pretrial motions and orders and stuff on this case, as well as the other cases that I
And
covered.
so you
They're
sent
all linked there.
officers to that location, 112 East in Oxford?
I did.
Now, at that time, was there a concern of explosives?
Yes. So
If
now,
you
again,
testified,
understand
he's
everything's
pleading
happened
the
very,
fifth.
very quickly.
So I don't know
People
what they're gonna do.
started doing open source searches on the name,
The name of whom?
the shooter,
Okay.
and finding different things. And the internet is a very expansive place, as we all know. And there came a video from YouTube of him deploying a Molotov cocktail, which is essentially an accelerant in a bottle with some sort of ignition device, wick, if you will. You throw it, and when you throw it, it blows up, spreads, because the fuel inside it kind of spreads. So there's a YouTube video of that. There was also, and I'm sure we'll get to it, there was also a journal with written passages in it that described secondary devices, meaning, there was a concern, and again, at this point, I went back to Captain Hill and advised him, hey, look, there's a concern that there may be secondary devices in and around the school.
Okay. So when that information became known to you as lead investigator, what steps happened next?
So Captain Hill,
Well, it wasn't made under oath. He wasn't testifying. He was just giving a sentencing statement. And that's the thing. But the court has allowed so much hearsay from Ethan to come in already, and like super secret double hearsay that they probably would allow it.
contacted the Michigan State Police bomb squad. While that was happening, I wasn't present for this, but it's my understanding a canine from the sheriff's office alerted, an explosives canine alerted on the backpack that was found in the bathroom the shooter exited prior to the shooting. So
What does that mean, an alert?
So the alert means that the dog detected some sort of explosive. Now, it could be a legitimate explosive. It could be a firearm. It could be ammunition. It could be something of that thing.
Okay. So what was done to alleviate this threat?
So as I stated, Captain Hill called for the Michigan State Police bomb squad. They went in with a robot. And I have no expertise on how that works, but they determined that the bag was safe.
Okay. Now, sir, you were obviously on the scene at the school on November the 30th,
Probably not,
2021.
I was.
And you became aware that the Oxford High School has a number of security cameras.
That's correct.
Okay. And as officer in charge of the investigation, did you also interview witnesses or review witness statements?
I did.
Okay. As a result of that, did you learn the path the shooter took on Oxford on November the 30th, 2021?
Now
Yes,
they're
sir.
building a foundation for the video.
So can you tell us in what hallway and outside what room the shooting started?
Yeah, from the map earlier, you saw the highlighted area. That's all commonly referred to in Oxford as the 200 hallway. There's a short hallway and then a longer hallway. The shooter exited the bathroom adjacent to room 258 and that's when the shooting began.
I'm going to show you what's already been admitted as People's 12. What are we looking at here?
So this is the backpack that the shooter carried into the bathroom that was examined for explosives that we found on the scene.
And what else do we see in this picture?
So you can see that there's some personal effects. There's charging cables. There's a journal. There's a book.
Okay. When we reference journal, this is what we're talking about?
That's correct.
Okay. Now, what of note was discovered on those pages of paper? Not in the journal, but the other pages.
Yeah, so there was over 90 loose leaf papers you can see right there. They're different assignments or whatever. And can't hold me to it. Over 50 were had drawings of firearms on them.
Now, sir, did you have the opportunity to review that handwritten journal that's depicted in People's 12?
Yes, sir, I did.
Okay. Describe what that journal is.
So the contents, sir, or describe the journal?
Both.
So the journal was a hardbound leather type journal. Should be in there. You might do cut it over more. It was there was approximately 22 pages of written information in the journal. It appears from some of the dates that it was written from the back cover to the front. The earlier dates seem to be on the back side, if that makes sense to you. Like I said, it was about 22 pages total in length.
Judge, I'm going to mark this for demonstrative purposes only as exhibits, so the record's clear. I believe that's 428, again, for demonstrative purposes.
I'm sorry.
The actual journal?
Yes. Is that just?
It's just
Okay.
the hard copy journal.
Okay, thank you.
Yeah.
He's not going to know KPM. And there was already testimony that they didn't. Sound is music to my ears. Opening evidence bags.
Okay. So that black notebook you're holding in your hand, that's what's depicted here in Exhibit 12 that I'm magnifying.
That's correct.
Okay. Now, these papers that we just talked about, we said over 50 with different pictures of weapons. There's no evidence that was ever turned in the school. Is that correct?
Yes, I have no evidence of that.
Okay. And you've had the opportunity to read the entire journal?
I have
Okay. Out of that notebook, how many pieces of paper have actual writing?
22.
And does one of those 22 pages include just a drawing and a quote from a book?
Yes.
Okay. Now, out of the remaining 21, how many reference the school shooting?
Every single one.
Well, so many pages,
So
they must have
there are
seen it.
some-
Must have spent months writing it.
That have been admitted, some
Or not.
portions of that. I'm going to go through those with you.
The journal was
So
in his
you're
bag.
aware, we've numbered them to keep them straight for you as well as the jury. Number one is the drawing, page number 1. Page 22 would be the back cover of that journal. Is that clear?
Yes.
Okay, and the back cover of the journal has actual writing on it as well.
I tend to read a lot of my kids' stuff, but I don't read their journals. Well, sometimes I do, but it's not every day. Once or twice.
Yes. 401.
Are you gonna go through?
Only the ones that have been.
I understand, 401.
They're all 401.
Oh, they're all 401. I see, thank you.
Correct.
You said individually, so I got confused.
Okay, so this has been admitted.
Journals
as
can be
page,
good.
401. Sir, in reading the
Journals can be
journal, were there passages in there indicative of a request for mental health help?
Yes,
Can you read what's been identified here as page 6 of that journal?
yes. The shooter writes, I have zero help, as you can see on hold, for my mental problems, and it's causing me to shoot up the fucking school.
We'll move on to page 5. Could you read this passage, please?
In this one, the shooter writes, I want help, but my parents don't listen to me, and I can't get any help.
Well, this is page 19. Can you read that?
Yes. Shooter writes, my parents won't listen to me about help or therapist.
Sir, in that journal, were there entries
Well, this
about the
is-
shooter's
it looks
desires to
bad.
obtain a 9mm handgun?
However,
Yes.
This is also exhibit
I
401,
will say
page
that
22. Could you read those quotes, please?
Yes.
just
The
because
shooter
you're
writes,
saying it
I
doesn't
want to
mean
shoot
it's
up the
true.
fucking school so badly. Soon, I'm going to buy a 9mm pistol.
And there's no
Sir, were
indication.
there any passages regarding the shooter's plan for the actual shooting?
Yes, there were.
Okay. Here's page 3, also exhibit 401. Could you read that, please?
Yes. Shooter writes, I'm about to shoot up the school and spend the rest of my life in prison.
Were there any journal entries about the shooter's access to the 9mm handgun?
There were.
This is also exhibit 401, also page 3. Could you read that, please?
Yes, sir. The shooter writes, first off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this now. So yeah, I'm going to prison for
Are
life.
they
And
not?
many people have about 1 day left to live.
Are they not going to admit the portion where he
Now, is
says,
the journal
"You need to find my gun where my dad
written
hid it"?
normal size fonts, or are there certain passages that are bolded and larger than normal size font?
Both.
Okay. And were there drawings in there as well?
There were drawings.
Okay. Were the drawings small or were they large?
Yeah, there were large drawings.
Okay. What's an example of a large drawing?
Yeah, so there was a large drawing in the journal of a firearm being pointed at the back
Yeah, I
of
know. Why would they do
of
that, right?
presumably a woman's head. There was a drawing depicting a 9mm round, caliber round versus a 22 caliber round. Those types of pictures were found in the journal.
Okay. And on the cover of the journal, what does that say? The actual cover of the journal itself?
It says apartments.com.
Okay. Lieutenant, you said you've seen the Oxford High School security footage that depicts the actual shooting.
Yes, sir.
Is it just the only
I'm
parts of the
going to
journal?
Introduce that now. This is exhibit 402. It's been admitted.
For everyone.
I would like, if the court could instruct the media not to play that.
Yes, the media has agreed, and I'm going to request that the media not play, show the video in the school. That's surveillance footage of November 30th, 2021, and this People's Exhibit 402.
402. Yeah.
And the victims who are present are aware of the content of this specific video.
Yes, sir.
All right, go ahead.
Before we get
So I thought
started,
maybe they would
tell
try to
us
get out
please
in
what
front of
this-
it, bury
this
it
view
in like
depicts, what
30
hallway.
pages.
Okay, so if you can recall back to the highlighted areas of the school map, this is that short hallway. The shorter portion of the long, it's all of the 200 hallway, but it's the shorter portion of the entire.
Can I stop you for a second? Are you okay if the audio is on still?
There's no audio.
Well,
Oh, is audio?
there's streaming in the courtroom, and there might be audio from the news camera, so I just want to make sure that there's no objection.
That's fine. There's no audio of the video. Is what I
Okay.
meant.
Right, okay.
Okay, so this is the short portion of the 200 hallway?
Yes, and the bathroom that you see right there by the drinking fountains is the one that, correct. That's where the shooter will go into and then emerge from and begin his shooting.
And that's where that backpack was found?
Yes, sir.
Okay, so this doorway here would be the doorway to classroom 258?
That is 258 there, yes.
Okay. And just so the record is clear, this video begins at 12:46 p.m.
Yes,
and the actual shooting began at 12:51.
51. Correct.
I'm going to play right now. Again, this is 12:46. Tell me if and when you see the
Because it's
shooter walking down the
emotional.
hallway.
Because it's emotional.
He is behind the young lady in the red sweatshirt right there. He's about, with the mask on, the black shirt, and the gray sweatshirt.
So I will say this: there's only one date in the journal that I am aware of that was brought up in preliminary examination. It was like November 27th or something like that. It was like the day the gun was purchased or the day after or something like that. Right around there. It's before the shooting. And seeming to indicate that he might have written all of this within a couple of days before the shooting. Also, there's a passage in there that says, I'm ready to go as soon as I can find where my dad hid my gun. The state didn't show that. So I imagine that's coming out on cross.
Shirt.
Okay. And that's with his backpack over his shoulders?
That's right. Yes, sir. And he's going to make a right turn into the bathroom here.
So we have a split screen at this point, and that's
Just a camera angle from the other hall, or from the same hall facing the other way.
Okay. I'm stopping at 41 seconds. Identify who you see in this video.
So that's the shooter. If you want to, the two, that's Phoebe. On the left there is Phoebe Arthur. To the right is Elijah Mueller.
Okay.
This is John Asciutto. So these four young ladies here in the Carhartt or the brown jacket is Kylie Osage. Directly across from her is Hannah St. Juliana. This is Riley Franz in the pink backpack, and across from her is her sister Bella Franz.
Okay.
At the very end, you can see the beginning. That's Madison Baldwin walking up the hallway.
And this is at 12:51 and 12 seconds on November the 30th?
That's correct.
Sounds like Jennifer is having a hard time with this. I don't know that Jennifer's ever seen this before. Defense counsel said that to see these videos, she has to go to the prosecutor's office to watch them. Jennifer's been in jail, so I don't know if Jennifer has ever seen these videos. From my understanding, yes, they're actually showing the unaliving of the students right now, which, in my opinion, has nothing to do with Jennifer. This is all shock value. They're watching the video. There's no sound. So the jury is currently watching the video of the shooting at Oxford High School. Hey, Tara. Tara. I say it wrong. I got a banner at the bottom of the page. Jury is watching video of the shooting at Oxford High School. We're not allowed to watch it. Yeah. Yeah, pretty much. We're watching the mom fall apart because the cameraman is an asshole. They showed one incident with the first witness, the teacher, that was shot, but they didn't show the whole thing. It would be Jennifer who's crying into the mic, it sounds like. John Gary spoken just like my wife. I have no idea how long this video is.
Lieutenant, why do the officers have to run past Madison, Anna, and Kylie?
In our training for active shooters, You were trained to respond, drive up right to the door if you have to, and go in, search for stimulus, meaning sounds, gunshots, or whatever. Run to that and eliminate the shooter. Stop them, whatever, however you can. Because the situation was active and the killing hadn't stopped. You can't stop and render aid. I know. If I could just finish this part, I'd appreciate it.
I'm sorry.
No problem.
And I would agree with you to the
I,
extent that it would rise
I
to
know
the
those
level
officers.
of child neglect or child abuse, but not for involuntary manslaughter.
And that is the hardest thing they're had to do in their life.
We take a break, Jeff.
Yeah, looks like a 10-minute break.
All right, for the
I
jury.
was thinking I might have somebody in the courtroom today, but I'm not sure if they are there. But if they are, I will definitely am. All right. After that, we need a little.
Yes.
There you go. See, you can all distress a little pat. She just turns around. Oh, day night was good. Day night was good. Went and saw Wicked last night. My wife had never seen it before. And if you guys had seen Wicked, it changes your whole view on the Wizard of Oz. Like, you don't watch the Wizard of Oz the same way ever again after watching Wicked. But it was good. We had a good time. And then I ran back here and got on with Joe from Good Logic for his 24-hour stream in my tuxedo, and then promptly went to bed. Oh, yeah, she has gained a lot of weight, Glenda. A lot of weight compared to how she looked in her mugshot. Like this. That was 2 years ago to how she looks now. Yeah, she's a completely different person. I do live in Oakland County. The cat has 3 names. I call it PP. Hey, Baker.
Yeah. So they got here people and mother.
There we go. I just turned it down. What was that?
I said they got to hear about all the deaf people and how is that tied into the mother?
Well, because we have to establish that 4 people were unalived, remember. Even though the defense is stipulated to it and they've showed plenty of evidence of it already, we still have to make sure that the jury knows that 4 people died.
Yeah, and we had to have police officer cry on the stand because that's not prejudicial to the defendant at all.
I know, it's ridiculous. I'm filing a motion right now on one of my criminal cases, and they just want to bring up all kinds of stuff that's not relevant. It just goes to like emotional and, look at all these bad things that happened in the past, and therefore this person is guilty now. That's the case. That's the thing I'm working on right now. Like, none of this, it's not relevant to whether or not the mother is culpable. We know what, and the defense came out in an opening statement and said, we're not contesting that what Ethan did was a very bad thing. That it was the gun that James had purchased that was used. We're not contesting any of this stuff, but the state is going to show you all this stuff and try to get you emotionally wrapped up in it. And they are absolutely are. They want to end with this. This might be their last witness, actually, because they said they
Yeah,
had 9 total.
Yeah, and they said yesterday they might rest yesterday.
Yeah. So this is witness number 21. And then they had, let's see. So they said they had 9 at the beginning of day 5. And we had a total of 1, 2, 3, 4, 5, 6. So this is witness 7. So there might be 2 more witnesses after this. Yeah.
But still, where did they put the mother in fault of his actions? Yeah, she took out cash. Yeah, because she needed a lawyer. She clearly stated that to the horse lady. Then you
She
had
stated it to the horse lady. She stated it to everyone. Was like, I think I need to sell everything to pay for a lawyer.
And Sue has a great question. What does the journal prove if she never read it? Yeah, he said tomorrow is the day. So she had to get up, put him in school, read the journal, and say, "Oh my God, he's going to do this today."
Yeah, but the journal was
doesn't
with
prove
him.
anything. Yeah, and so how is she supposed to know? That's
yeah.
I really.
Like if you look at the jury instructions, the biggest thing is that that the defendant knew of the danger and the likely outcome, and then failed to exercise reasonable care to take some steps to prevent it. Well, that involves, first of all, knowing, and then also not just knowing like he suffers from something, but knowing the likely outcome. All right, knowing that he was going to shoot up a school, and I haven't heard any evidence. We've seen bad things. We know he did it, right? Let's start with that. We know he did it. We know he talked about doing it in his journal. We know he texted his friend, I think, once about doing it. But aside from him planning on it, we don't have any evidence of her knowing about it in advance.
And the friend is charged with the same charges too, because he knew about it when he texted him, right?
Well, you know, one would say.
No, of course not, because that wouldn't help.
Oh, God, your name, Volpe Fox. I'll just call you Fox all the time. Fox, welcome to the pre-law status. Make sure you, as well as any other new members to the channel, click the member tab, take the link to my Discord page, where I have a bunch of content about this case and other cases that I covered. With this case particularly, the most recent thing I just updated were the journal entries that were presented in trial. I also have my notes from various days of the trial. I have the other photographs from outside the warehouse. I got a ton of stuff related to this case, and others are all in my Discord. And thank you very much for becoming a member. He wasn't suicidal, though. Well, yeah, remember, the only thought was he had potential suicidal thoughts, not that he was in immediate harm. The counselor even said that he wasn't necessarily in immediate harm of suicide. They just wanted to keep an eye on him and didn't want him to be alone and get him counseling. Yes, like Baker says. Hang on. Solo layout. There we go. Hit the like. Hit the death paw up.
I could see only 50% has hit the like, and it helps the algorithm. If you like what Dave does, and he does a great job. He is about the smartest, top 3 smartest lawyers I know in Michigan. So hit the like.
I just let Baker say it all for me. Yeah. I mean, you're obviously here watching it. Someone asked a great question. How is journal not hearsay if he's not testifying? Okay. So the journal entry is being admitted, much like the text messages, under 803.1. So 803 is the exceptions to the hearsay rule. A hearsay is an out-of-court statement offered for the truth of the matter asserted. You can't cross-examine that. So we say, no, you can't bring those in. There are certain exceptions. The most famous is statement by a party opponent. So anything that Jennifer has said is a statement by a party opponent and can be admitted. But there's other ones, such as excited utterances, recorded recollections, things like that. The 803.1 is present sense impression, which usually is the present sense impression of the witness, not somebody else. But the court is using that to get the journals and the text messages in, which I don't think is the appropriate exception. I don't think there is an exception. And when Ethan said that he wasn't going to testify because of the Fifth Amendment, I thought the state was going to be screwed because they wouldn't be able to get the journals or anything else in. So, but the court has allowed it. And so that's how they get it in. And so because those parts are in, I would say the other parts, such as Dad hid my gun, I don't know where it is, and I wrote all this on November 27th or whatever date it was, should be admissible as well to show that it was written very shortly before the shooting. And Ethan himself says Dad hid the gun from him. So let's get all of his hearsay statements in. Let's use all sides.
Yeah, you got another one from Fox.
Did I know?
Yeah.
So this area, Oakland County, Oakland County in general used to be very, very Republican conservative. It's one of the richest counties in Michigan. And over the last, I would say 10 years, it has shifted primarily Democrat. However, where they come from and where actually a lot of the jurors hail from, if I remember correctly, it's fairly rural areas. So you get kind of a blend in Oakland County. You get the, liberal Democrats in the southern eastern part of the county. And then you get the, rural Republicans in the more northern part of the county. So it's an interesting blend right now.
How's your read on the judge? Because if they're arresting, of course they will never get direct, but how's your read? Has she been fair? I don't like all the speaking objections because, as we always say, you can never unring the bell, and as soon as the jury hears it, they know it. You can say all the things about, oh, please disregard, and no, that doesn't happen. And they get to speak those speaking objections. I really don't like it.
Yeah, like I said yesterday, speaking objections, to the extent that you've seen it in this trial, are rare in Michigan, but they're not super frowned upon. Generally, what you would want to do is say, objection, she's leading the witness, or he's leading the witness, and then it'll either be sustained, or if there's an objection, assumes facts not in evidence, things like that. That's usually fine in Michigan. But everyone seems to be laxed as of late, and the speaking objections come out a lot more often, and the judges are not cracking down on them unless someone brings a motion like the defense counsel did this morning. I say it's 5 days too late.
Yeah.
She brought a motion and said, Judge, can you please instruct the prosecutor to stop with these speaking objections? Not only for the jury, I bring them often a lot in bench trials because I don't want the objections to be coaching the witness. Right. If I'm cross-examining and I ask a question and the other side objects and does a speaking objection, which is essentially feeding the witness a question, that happens a lot, and I can't stand it. And courts in Michigan are just so laxed about it.
Yeah, but a bench trial is way different than a jury trial because, again,
it is.
The judge knows the rule, and
the judge knows the rules, but I don't like the coaching of the witness.
No,
and that's what I think it's done a lot for.
But again, it's worse when you put stuff in the head of the jury, because, as I said, you can't unring the bell when you put it in there.
Let's see here. You always called me Fox. It's all good. I know, because I can't pronounce the first name, but I thought I'd give it a shot. The witness interrupted Shin's objection and the judge did not intervene. How does that happen? So a lot of times when people are on the stand, they're like caught up in their answer. They're usually nervous. Even cops, I guess, sometimes get nervous. But when you object, sometimes the witness continues to answer, even your own witness, even though you've told them, listen, if you hear an objection, stop talking. They'll still continue to talk. And so depending on what their answer is and how the objection is ruled on, the answer will just be allowed to stay or to be struck in or whatever. But ideally, you want to tell your witnesses when you hear an objection, you stop talking. But that's You hear that all the time because witnesses are not in court every day, and they just sort of they're continuing to answer the question even though other people are talking.
Can I do something for on your show?
Yeah,
I
give
haven't
it
done it in a long time. Good morning, genitals.
It's genitals in the chat. I haven't seen genitals. Oh, there we go.
There's always genitals in the chat.
Yes, that is. Well, I don't call it that. I call it the cat cam. But yes, there is a cat cam. Because why not? This case is so tragic. Every once in a while, we like to pull up the cat.
Yeah, I just don't like this politics through the courtroom. It's a very American thing, and it's very disturbing how far they will go to. If they can't win in the voting booth, we'll just do it in the courtrooms.
Yeah, I know. That's the thing, is that this is absolutely a political charge. Oh, I didn't realize I was a couple of minutes behind. I'm just bringing it up live, and we're still waiting. At least we're live now, waiting. Yeah, absolutely. So, what are your thoughts on the defense counsel? You've been watching this a little bit on panel or in the background. How do you think she's performing?
I said it the first day I was on. I don't like her way of speaking. I think she speaks like she thinks the jury is retarded. Late in French, sorry.
These
Her
days, she
voice-
can get away with it.
Yeah, it's my accent. I don't like her voice. I don't like her way of speaking, and I feel like she's in over her head. She seems flabbergasted every day, like she's running a day behind or something. And I hate her Canadian ways. I'm so sorry. I didn't. Oh, did I say it was a joke about unaliving myself? Oh, I'm so sorry. And I can't do a Canadian accent. I've been trying all day. It turns into a Scottish. But no, I really don't like her. Yesterday, I think she did okay with the last two, maybe 2.5 witness. She did okay, but before that, I'm not sure I would bet my life on her.
Yeah, like I said before, I'm not a super fan of her style at all. I just don't like her style. I think she's hitting some points, but I would do them in such a different way. And then she has a tendency to sometimes, quite often, ask way too many questions of the same thing and sort of, what do I want to say? Like, I don't know, just make a mess of things. Make everything confusing and all of that.
It's kind of like my pro say down in the treehouse. He batted like a 0.01 because he had some really good questions, and then he just muddied the water with the rest of it. He could have questioned his witnesses for 10-15 minutes, and he would have had a great case. But he went on for 4 hours. It's the same here. You have 2-3 great questions, and then she goes into something totally irrelevant, and it's kind of like she gets in her own head or whatever. As you talked on with M&M's yesterday, she's not capable of thinking on her feet.
I see John Gary's making friends in the chat. We love John Gary around here. What did he say? I saw photos of their home and have heard much testimony proving neglect. And you know what? I'm on board with the idea of child neglect, neglecting a child. Sure, I can get my head around that. I can't get my head around the involuntary manslaughter. That's the biggest thing for me. I feel like if they brought a neglect charge, child neglect charge, they'd probably get convicted. You know, at the end of the day, I'd be like, okay, I'm fine with that. It's just the intentional or the involuntary manslaughter charge I have a huge problem with. She's probably a little overwhelmed. Yeah, she did lose her team when she split, right? So remember that she had a partner and they were in a firm. They had several employees. And because of this case, they had to split their firm. And so now she said yesterday, it's just her, which is, it's just me, right? So in my firm, I used to have like 8 employees and it was great. It was really expensive, but it was also great. It was also a big time suck because you have to follow up on everybody and everything. But now it's just me. And so I understand that feeling of everything is on your plate. Does she seem to accidentally ask good questions? Maybe they're accident. I don't know. Yeah, absolutely. Jennifer could get convicted and James could get acquitted. Absolutely. It's gonna be a different jury. It's gonna be a different set of facts. He was differently involved. He purchased the gun. She supposedly was the day-to-day provider and he wasn't of the child. You know, whatever, who knows how his case is going. But yeah, absolutely.
Yeah, but again, let's put all of our liberal thoughts aside. Should they ever have brought this case? No. Have they proven this case? No. This is, and again, I'm coming from a breathing heart, not even liberal country. I come from a socialist paradise, and this is wrong on each and every level. This is wrong. This lady has her life ruined, and then the state wanted to ruin it some more because they want red flag laws or whatever they wanted to have in Michigan.
Just Jen, I'm not saying because the house is messy, it's neglect. That is not at all what I'm saying. I'm saying is that based on all the evidence that has been brought in, if they were to bring a child neglect charge, meaning you neglected the health and welfare of your child, they could probably get a conviction. That's all I'm saying. And I would be fundamentally okay with that from a legal standpoint. I have a problem from a legal standpoint with this charge. So hopefully that clears up my position. Someone had a question about the seal.
There were victims and family of victims using the restroom in the hallway, and apparently a juror was in the same restroom as the juror walked out. There was no communication, no words spoken. I just wanted to place it on the record.
Okay, no, I appreciate that. At one time, I don't want to tell you the inner workings of, we have 2 jury rooms going here. We've had personality issues, we have privacy issues. There are 4 bathrooms there, so. Okay.
Thank you. I just wanted to make.
No, I appreciate that. That's why I don't want him going to the cafeteria.
I'm not saying they neglected their child. I'm saying legally, from a legal standpoint, the charge is sound, right? They're parents. They have a legal obligation to care and provide care, including medical and mental health treatment for their son. The law is sound on that. The law is not sound on a manslaughter charge when you have an intentional wrongful actor intervening. So that's what I'm saying. The law is sound on a neglect charge. The law is sound on even maybe contributing to the delinquency of a minor charge, assuming they can get the facts straight on that. But the law is not sound on the involuntary manslaughter charge.
All right, you may be seated. Lieutenant Lewis, you're still there, all right?
Yes, Your Honor.
Go ahead.
Thank you. Sir, you mentioned earlier that you directed officers to the Crumbley family home at 112 East in Oxford?
Correct.
Okay. And approximately how far in distance is that home to the school?
A mile.
Okay.
Yeah.
And as officer in charge and as a sheriff's office employee, you're aware that vehicles have in-car recording capability?
Yes.
Okay. So I'm going to show you what's been, I believe, stipulated to is Exhibit 341. This is an in-car video of Deputy Zajak's marked patrol car. That's 341.
Was that admitted to Joe Bryan or not?
No, just 342 was.
And I'm sorry, we have no objection to 341.
Right, 341 is admitted.
Let's say little to none on rebuttal.
Sir, so we're clear, the deputies arrived at 112 East at 2:48 p.m., 2:49 p.m.
Yes.
And that's November the 30th, 2021.
Yes.
And as we saw in the video, the shooter was taken into custody at 1 p.m.
Yes.
Okay.
Correct.
Why is she in handcuffs? Can you take the handcuffs off of her, please? Okay, plug it in first. It's not gonna be long for those handcuffs, I promise.
Why am I in cuffs though? It hurts, like it really hurts.
Wow, what's that?
Why am I in your cuffs?
I don't know. I don't know. I asked them the same fucking thing.
They didn't do anything.
Is that her?
Okay. Yeah, that's her. I just wanted to be clear on the date, so that's why I paused it. It's November 30th. So this is the day of the shooting at 14:50. So 2:50, like 3 p.m.
Real numbers.
Okay, whatever.
I'm getting claustrophobic.
I mean, don't freak out in front of the cops. This is gonna be a lot better if you don't make the situation.
You're gonna get copyright struck.
I know. I was just thinking that.
Okay, push my glass in my nose, please. Put chapstick on my lip, please. And then my fucking phone.
She seems angry.
Yeah.
Why are you so confused?
Why are you in fucking handcuffs?
Yeah, why is she and he's not?
You're going here?
I set it down and then I have a cop. I need a gun.
Why are they in our house?
Kind of want to go dancing now.
Yeah.
This was just right after. This must be at the police department actually, because this was right after. And I think they drive them then to their house, and then they go get a search warrant for the house. Remember the timeline. They called them and asked them to come down to the substation in Oxford. So they went down there. They did their interview, which we've already seen. Then they put them in cuffs, put them in the car, drove them to their home, where then they searched the house. That's James next to her. No, of course not on break. What am I doing? Yeah, I thought so too, that this was after they got arrested, but this is dated November 30th. So this is the day of the shooting. And it puts it in timeline between their police interview and the search of their home. That's the music in the cop car, because when you arrest somebody for this tragic event, you want some good music playing.
Yeah.
Who's Patrick? Oh, maybe they are at their house.
He's not gonna be able to hear you. Jen, he can't hear you.
They're probably yelling at a neighbor then if they're at the house.
case something happened.
I'll be right back.
Anything happens, we do not answer any questions without a lawyer. Leah, my name is
It's Jennifer.
Jennifer, come on now, hey, hey, us off.
Are they just playing this to show she was angry
49 p.m. November the 30th.
instead of crying
This
and feeling
was-
sorry?
After they had spoke with Sergeant O'Brien at the Oxford substation, correct?
Yes.
Okay. And the video that we saw with Sergeant Pesky, that occurred directly after this.
That's correct.
Okay. So when she was taken out of the vehicle, she was placed in a different vehicle, and that's where Sergeant Pesky spoke with her.
Correct.
Okay. And then as Edward Wogrowski testified, they arrived home from the location data at 2:30 p.m. after the substation.
Yes.
Okay.
So I had the timeline right, just the location.
Sir, do you know the date in which Jennifer Crumbley was charged?
Good morning, Trash. Or Stash.
December 3rd.
Okay, so the shooting happened on Tuesday, November the 30th. December 3rd would have been a Friday.
That's correct.
Okay. And,
I believe it was noon, around noon.
okay. Tell us what happens when someone is charged with a felony in the state of Michigan. The process they actually have to charge you document.
So the prosecutors give me a warrant. I go in front of a judge and I swear to the facts of the case. The judge authorizes the warrant.
Okay. And that's what we would commonly refer to as a swear to.
Swear to, correct.
All right. And did that happen in this case?
It did.
Is that a closed proceeding or is that open to the public?
It was open.
Okay. In fact, it was broadcast at that point.
There was media present for that, yes.
And they were, Jennifer and James Crumbley were not in custody at the time of the swear to, is that right?
That's correct. They were not.
We've already heard from Dave Hendrick about the fugitive apprehension team in that part of the investigation. Tell us please how retired Sergeant Hendrick's team got involved.
So upon being made aware that charges were coming, we knew that they weren't at the residence. So I had Sergeant Hendrick, who worked for me, deploy the fugitive apprehension team to locate the suspects.
Okay, and that's purely a law enforcement function, would that be correct?
100%, yes.
Okay, so as a detective lieutenant in charge of all of these different divisions, that includes the fugitive apprehension team?
Yes, sir.
So the decision then would have ultimately been yours.
Yes, I told him to go attempt to look for him.
Okay. Now that was that on Friday the 3rd or was that prior to Friday the 3rd?
I don't recall.
Okay. He testified yesterday that he recalled it being Thursday the 2nd. Is that accurate or you just don't remember?
Yeah, I don't. I think it's accurate, but I don't remember it specifically.
Okay. That's fair. Now, during the course of your investigation as the officer in charge, did you learn where the defendant went after her phone was seized in the evening of November 30th, 2021?
Yes.
Okay. And I guess as a reference point, Lieutenant Sam Marsman testified yesterday as to the date and time when her phone was seized. You were here for that testimony?
I was.
Okay. So I'm going to have you walk us through that timeline.
Okay.
Now, we've heard about the track phone purchases.
Yes.
Did you discover where those purchases were, where those purchases occurred?
Yes, at a Walmart in Lapeer.
Yeah, but weren't the officers telling them to go get the track phone?
Exhibits.
Yeah, she was told to get a burner.
Yep, from the police officer that took her other phone.
This is exhibit 404. I don't believe they have an objection.
Any objection to 404?
No.
404 is admitted.
Okay, so this is a photograph of the exhibit. What are we looking at here?
This is the purchase receipt for the track phones from the Walmart in Lapeer.
Okay. And did you learn where they stayed that night?
They stayed at a hotel in Lapeer.
You took their
Which
phone,
leads to
you kicked them out of their
405.
home.
I don't believe there's objection to 405 either.
No,
The police took their phones and kicked them out of their house. Well, where did they stay? Well, they stayed at a hotel, and they got track phones.
Yeah, and there was a lot of people
4 or 5
protesting.
submitted.
Yeah, outside their home, and the media was following them around. We saw the picture of the media outside the place where they got arrested. Why do you think they were hiding from everyone?
Yeah.
Thank you, Judge. This is 405. What are we looking at here?
This is a receipt for the overnight stay at the Holiday Inn Express in Lapeer.
Now, did you do the swear to for the shooter as well in this case?
I did.
And when did that occur?
That was it was on the December 1st. I want it. Time was sometime in the early afternoon.
Okay, if I said 3:51 p.m., does that sound right?
Yeah, that sounds about right.
Do you know where James and Jennifer Crumbley were then?
Yes, it was a swear to, much like we do typically, open to the public. They were I believe they were on Zoom in their vehicles.
That proceeding's open to the public, is that right?
Yes, it is.
I'm going to show you. First, let me ask you, did the investigation uncover where they stayed the day after the shooting, December the 1st, 2021?
Yes, it did.
Okay. This is Exhibit 408.
no objection.
408 is admitted, 407 is not.
They skipped.
Correct, Judge.
Okay. Thank you.
Instead of renumbering all the exhibits, we thought it.
Oh, no, it's all right. I just want to make sure I was keeping up.
Thank you, Judge. 408, what are we looking at here?
This is an extended stay in Auburn Hills.
Okay. And this is where the defendant and her husband checked in December the 1st, 2021?
That's correct.
Does it indicate a checked out date?
December 3rd, 2021.
Okay. And that's that Friday?
Yes.
The lady who's coughing.
Now, we heard from Sergeant Hendrick.
I want to
retired
catapult
sergeant.
her.
The court coffer. I know she follows around all of our trials.
Hendrick, that they recovered a vehicle belonging to the Crumbleys in Auburn Hills.
They did.
Okay.
Hey,
Is
Wendy
this the
H.
location where that vehicle was recovered?
It is.
This is Exhibit 409. Photograph.
No objection.
409 is admitted.
What are we looking at here?
This is one of the two vehicles owned by the Crumbleys, backed in a parking spot at the extended stay in Auburn Hills.
During the course of this investigation, were banking records from the Crumbleys obtained?
Yes.
Specifically on December the 2nd, so that'd be the Thursday, did you find that they had withdrawn cash on multiple occasions?
Yes, they did.
This is Exhibit 411. I believe this is covered under stipulations as well.
I'm sorry, did you say 411?
411, yeah.
That's not 411.
No, the next slide. I don't want to publish it until you confirm that it was stipulated.
Yes, it is.
Any objection to 411?
No objection, sorry.
411 is admitted. And again, 410 is not
Correct, Judge.
previously.
Yeah, thank you, Judge. Okay, what are we looking at here in Exhibit 411?
This is a withdrawal of $2,000 withdrawal transfer, $2,000 from Flagstar by Jennifer Crumbley.
Now, Edward Rogowski told us about replacement phones. Did you uncover that James and Jennifer Crumbley, after buying their track phones, bought another set of phones?
Yes.
Okay. And do you know the date and location where that happened?
That was in Owasso.
Owasso, Michigan?
Yep.
Okay. And that's on December the 2nd, 2021?
I'm sorry. Yes, it was on December 2nd.
Okay. This is going to be 413, the T-Mobile receipt.
No objection.
413 is admitted.
Yes, just 413, correct.
Mhm.
All right. And so what are we looking at here?
This is the purchase of the two replacement phones.
Okay. And that was Owasso, Michigan, on December the 2nd, 2021?
Yes.
Okay. What's the relative distance from Owasso to Auburn Hills?
It's about an hour.
Now, did they obtain more cash in this time frame?
Yes, they did.
Back to the banking records. This is 411. No objection to this. I believe we stipulated to this. Is that correct, counsel?
Yes.
Yeah, they're just trying to make him sound guilty
This is
because
Friday,
they were
December
running.
3rd, 2021.
But this is not an
And what is the
intentional
withdrawal amount of cash
murder
this is?
case, right?
$4,000.
There's no consciousness of guilt.
No, and again, this doesn't
So
prove
evidence
she
uncovered in
knew what he was
investigation
doing.
that shows
Yes,
This
the
is after the
transfer or
fact.
Withdrawal was made from the defendant's son as well.
Yes.
An hour is not a unit of distance.
Exhibit 414.
Did I miss something?
Again, it's covered under stipulation.
Yeah, he said about an hour away.
Move to admit.
Oh, how far is it? An hour?
Objection to 414?
No objection.
414 is admitted?
See, I didn't
What are we
catch
looking at
that
here
because
in
that's how I
exhibit
talk.
414?
So this
not
is
that far.
the
It's like 40
Simply
minutes.
Kids savings account, Ethan Crumbley's account.
Okay, and specifically on November the 30th, 2021, do you see a withdrawal from that account?
Yes, there was a $3,000 withdrawal that day.
And November 30th, is that significant to you?
That's the day of the shooting.
Okay. And how much was left in her son's account?
99 cents.
Yeah, so they had to liquidate cash quick because they were in trouble.
So what we can tell from the banking records and messages, at this date and time, the defendants obtained $6,000 in cash, $3,000 transferred from their son's account, and they were attempting another $5,000 from horse sales.
That is right. Yes, sir.
Now, do you know where the defendant went after after she checked out of the Auburn Hills Motel?
They traveled to the address in Detroit, the warehouse.
Okay, and that's the address that William Creer testified to yesterday, 1111 Belleville.
Oh, yes, correct.
So I'm going to show you portions of that exterior surveillance footage that was obtained. Before we do, we've already talked about the timestamp difference. The timestamp on the video is about 22 or 23 minutes fast. Is that correct?
Yes.
So these will be, we marked them separately for convenience as 415 and 416.
Okay.
And the people will move to admit and publish now. We'll start with 415.
Any objection to 415 or
Yes.
416?
No
Show them
objection to
at
415. There is an objection to 416.
arriving at
because Mrs.
Bellevue.
Crumbley's not a part of it.
Judge, I think it is relevant to show what happened with the vehicle and why, especially in light of Mr.
How
Berkeley's
does this
testimony yesterday
prove anything
and
to
Mr.
do
Creer's testimony
with
yesterday.
the
Your Honor, it
pewing?
doesn't involve Mrs. Crumbley. So I
They're on the run. They were wearing black clothes, keeping their hoods down.
I think it's relevant.
And in constant
But
contact
it's-
with police.
It's non-testimonial. I'm going to
It's-
admit it first.
I've seen some
Yeah, I'll
stupid
start with,
criminals.
415.
Only the journal
Again,
entries.
The timestamp is 11:20 and 35 seconds on November the 3rd. I'm sorry, December the 3rd, 2021.
That's right.
Okay, so actual time.
Well, it
would
hasn't
be
really
on
been said why she was
8
taking
a.m.
the money.
Correct, sir.
Okay.
We're just assuming. If you look at those security videos from yesterday, you'll see my car going by. Which, if you guys want to see the outside of this building, I did post a short video yesterday. I went by yesterday. That's not really a lot to see, but you can tell that it's not an abandoned place, right? There's shops and businesses going on there. But it was portrayed in the media that they were in an abandoned warehouse.
That's Suzuki next to a. Is that a Porsche? No,
What we
that's
see here in the
a
video at the 11:21 timestamp.
Yeah, so that's the a friend of the defendant who activated the security gate to open it, and the defendant pulled in and parked.
Okay, and again, this is the parking lot at 1111 Belleville in the city of Detroit.
Yes.
What are we proving here, Baker?
Tell me if you see anybody
It was
recognize-
snowing early.
I
That, yeah.
recognize the defendant.
Okay, this person right here.
Yep.
Yeah, she's on the run.
Yes.
You can clearly see she's on the run.
And your friend had you identified as this individual?
That's correct.
Is this a hotel or what are they staying at?
It's an old warehouse
In this
from
city as
the
well?
automotive
Yes, that's
industry
James
that's
there.
been converted into like different lofts and office suites. So there's like art studios. One of the guys testified that he does his coffee brewing there. It's like a commercial building. And that's about it. There's no like rooms. It's not a living place, but it's just an office building.
Oh, that's the guy, the smoking guy.
Yeah,
Who,
yeah.
They might have went out for a smoke and they were running. I called the police.
Here in the magnified portion?
Yes.
Like I said yesterday, this is not a nice area. It's an okay area, but it's not a place that you want to wander around at night. And if you hear a bunch of commotion going outside with police, you're probably just going to stay inside. I would.
Agree the unknown.
Okay, now I'm gonna play you 4:16. Before we start again, the timestamp is 16:10. First of all, what is 1600 hours?
That's 4 o'clock in military time.
Okay.
4
And
p.m.
And this would be, so shortly before 4 o'clock actual time on Friday the 3rd.
Yeah, 3:48, I think, something like that.
Yeah, they're running with less than $7,000. How far are they going to get? That's a good question, Melissa. I don't know. If parental termination was brought, I don't think so. Why would they bother? He's in jail. They were all in jail, so. Yeah, why wouldn't they just go to Canada, right? They're literally 5 minutes from the border. Why wouldn't they just go to Canada? They were really running.
Do you have a hard border? No, you don't have a hard border to Canada. It's pretty easy to get over if you come in an American vehicle. You're just more or less being waved over, like when I go to Germany.
Yeah, pretty much. I mean, you do have to stop and answer some questions.
Yeah, but you'll just wave your passport and they'll say, business or pleasure.
Sometimes I mess with them. They're like, where are you coming from? Michigan? Where are you going? Canada? They don't like those answers.
He turned the car around so they're ready for a fast escape.
I see.
She's guilty. She's guilty now.
What's worse, jail or Canada? It's a tough call these days from what I hear watching Viva. I still probably pick Canada because at least you can like go hide out in the woods somewhere. Make friends with the moose.
So this is about 4 hours after the charges were officially announced? Is that
That's
right?
correct.
Okay.
Yeah, you have to show ID.
About a day
That's
or
for
so
sure.
after the fugitive apprehension team began looking for them?
Yes.
Your Honor,
When charges?
Your Honor, I would object because this witness is saying no on the fugitive apprehension team. They came to my office on Friday.
Hold on,
And so
hold on,
he
hold
would-
on.
Wait. Okay.
He wouldn't have personal knowledge of the fugitive apprehension team, and he's saying the wrong date.
Judge,
Okay, well,
counsel can't insert that.
well, you can testify, but I want to know.
Have these
his,
two
personal
met
knowledge.
at a bar
Yeah,
at some
no, one
point
thing
and she didn't call him back the next day? He
You know,
hates
I
her.
wonder.
He
I know,
hates her
he's
like
so- he hates her so bad.
you can just feel the bad sexual energy between these two. It feels like they had she didn't call him back, or she laughed or
know.
something.
Let me I didn't even realize I had the volume turned down. I apologize, everyone. But let's hear, unless it just did it now. Let's hear what the judge has to say here.
Wrong date.
Judge,
Okay, well,
counsel can't insert that.
well, you can testify, but I want to know from his personal knowledge. You know, one thing I think that would be helpful is, I don't think, would anything refresh your recollection about when the swear to was?
The swear to for, we mentioned two, Your Honor. So you talking about the swear to for the defendant?
Yes.
The swear to for the defendant was the December 3rd.
December 3rd.
December 3rd.
Okay.
Right.
So when did you contact the fugitive apprehension team?
Sure, they thought.
December 2nd, evening or late afternoon, evening time to get an idea where the defendants were, because we believe charges would be forthcoming.
But they said that he said they came on the 3rd.
You mean Hendricks?
Yeah, and Hendricks came to my office on the 4th.
No. Hendricks, Friday the 3rd is when Hendricks testified that he showed up there.
It's all in front of the
conducting
jury.
Surveillance prior to
So
noon.
they're getting in
Oh, he
the
was
fact
there
that they
without
showed
me.
up at her
Okay.
office in front of the jury.
It's all on the record.
Okay, yeah, you have to rely on the evidence from the witness stand, okay? And you have to rely on your collective memories and your notes, right? Go ahead.
Thank you. Okay, sir, you testified earlier that the swear to that was broadcast was noon, Friday, December the 3rd.
Yes.
Okay, and this video is around 4 p.m. Friday the 3rd.
Correct.
Okay, now, Luke Kirkley testified about looking at a
Not
poster
Michigan style.
online, and that's what spurred him to call 911. Do you recall that?
I do.
Okay. And so when a BOL or be on the lookout is announced, is a license plate of a vehicle also given?
Yes.
Okay. Was the license plate on this vehicle in the front of the vehicle or the back of the vehicle?
It was affixed to the back.
Now, sir, Mr. Rogrowski already testified about the location data for Jennifer Crumbley on the day of the shooting, November the 30th, 2021. Do you recall that?
I do.
Okay, and as officer in charge, you're aware of that information that he uncovered?
Yes.
Okay. Just want to confirm that Jennifer Crumbley never stopped by her home at 112 East after meeting Mr. Hopkins at the Oxford High School?
No, she went directly back to work.
Okay. Now, you've had the chance to review phone logs as well as other information from social media and information obtained from Jennifer Crumbley's phone.
Yes.
Okay. And sir, do you have any experience getting someone same-day mental health help?
Yes, I do.
Are there facilities available for that?
Yes, there's a facility on this complex called Common Ground that's available for that.
In reviewing the phone logs of Jennifer Crumbley, was there any indication of any phone calls to a facility of that sort?
No.
In fact, any phone calls to any doctor's offices,
No.
counselor offices,
No.
any hospitals,
No.
any mental health professionals at all?
No.
Thank you. I have nothing further.
Cross.
Okay, thank you. Sergeant Willis, I want to go back to the pages from the shooter's journal that were admitted. You don't have any evidence to suggest that Mr. or Mrs. Crumbley ever saw the journal, correct?
I'm sorry, miss.
You do not have any evidence to show that Mr. or Mrs. Crumbley ever saw the journal.
Here we go.
I'm sorry. It's been a tough day. So you're asking me do I believe Mr.
No.
or Mrs. Crumbly?
I'm asking you.
Oh,
you
do I have
any-
evidence?
Do you have any evidence to believe that Mr. Crumbley or Mrs. Crumbley saw the journal?
No, if I had evidence of that, I imagine the charges would be different.
If you had evidence they saw the journal. the
Wait,
charges-
what? If I had evidence of that, the charges would be different. How would they be different?
Is he charging people or is the court charging people?
Well, the prosecutor is. It's not him or the court.
No, so yeah, of
I
course, but-
imagine. What would the charges be? Oh,
yeah, murder.
would you get him for
15.
conspiracy or some BS? Remember, people. I'm not just like saying stuff to say it. This right here makes it clear that gross negligence means more than carelessness. Means that the defendant knew of the danger of another, or to another, rather. Knew of the danger to another. So the Crumbleys must have known in order for this charge to stick. And if he's sitting here saying, I have no evidence that they knew, and if I did, the charges would have been different. The charge is that they knew, and they did nothing about it.
Would be different?
Yeah, murder. I
Okay.
would imagine.
Okay.
Murder.
So the journal was located in the backpack that belonged to the shooter,
Yes.
correct?
I don't
Correct.
like that answer.
There were also
You should
a
have
number of
recorrected
other
that.
papers in that backpack that you described.
Yes.
You don't have any evidence that Mrs. Crumbley ever saw any of those papers, correct?
Correct.
Now,
So, in order to be guilty of murder, you must intend the outcome. You must intend the unaliving, right? So he's saying, I have no proof that they knew, so we charged them with a knowing violation. But if we had proof that they knew, then we would have charged them with an intent violation. You just upcharge and hope for the best? Is that what you're saying? You're admitting to that, officer. That's what you're doing here.
Yeah, and again, he can't prove they read the journal at any point.
Yeah.
And
No,
he can prove they pulled out some cash and went to sleep at a friend's house. Why is that? What has that to do with anything? I'm sitting here trying really hard to not just be, I hate the state, because I love the state as a socialist. But this guy just comes off, and I hated that he just had to say, it's been a tough day. You could clearly answer all the defense's the state's question. The second the defense took over, it's been a hard day. No, you needed time to think because you got caught in being an idiot.
Yeah, no, but just think about what he said. We charged them with a knowing crime, knowing and failing to act, but we don't have proof that they knew. If we had proof that they knew, we would have charged them with intentionally murdering these kids. Not because they had intent, but because they knew. That's ridiculous.
in the journal, you've testified about certain statements the shooter wrote in the journal, correct?
Yes.
And specifically, one of the statements that you testified about was where the shooter wrote, "I have access to the gun." Is that correct?
Yes.
In the journal, there are other statements where he indicates he is looking for the gun, correct?
Can you tell me which ones you're referencing?
Sure. So I'm going to hand you, Your Honor, may I please approach?
I'm sure, just show Mr. Peasley.
Sure.
I have a copy of it too, if that helps.
Judge, just briefly, this was subject of a prior court ruling.
Yes. So
And
I ask everybody to be really careful. All right.
Okay, so I was going to show 788, just this one line.
okay, again, Judge, maybe we should have a minute outside the presence of the jury.
Oh, now the
Can I
jury
just
shouldn't listen
approach
to all
and I
of
can
it.
show
What do
you?
we have?
I have it, and I know.
Do you want
exactly what it
to,
is.
do you want
No,
me
it's not that. We have to discuss the court's prior ruling.
I would have gone into it,
Your Honor, I
KPM.
think, okay.
I would have gone into it.
I'm
Yeah.
going to excuse you for 10 minutes.
I would have said, in order to prove this,
All
you're
right,
saying
Mr.
that they knew and failed to take reasonable steps, but you have no evidence that they knew. But if you had evidence that they knew, not only would you have charged them with this, but you would have upped it to murder, which is an intent. I absolutely would have hammered him on this.
You can stay down. Hold
Now I
on.
don't know what they're getting.
Fine here, Your Honor. Thank you.
I'll be brief, Judge. The court is where I'm going.
I am well aware.
Yes, so it's, and the court rules specific passages to be admissible under specific portions of the hearsay exception in response to defendant's request to exclude the entire journal. If, I don't want to speak for what counsel is doing, but if counsel is going to admit other portions that have already been ruled to be inadmissible, that's something that has to be discussed on the record, and I think it's something that has to be ratified, Judge.
Well, I am, of course, going to warn everybody about opening the door because this journal is obviously very, very disturbing. However, if when you put the black robe on, you can read people's minds. So I'm assuming that Ms. Smith is seeking to admit on page 788. I don't know where my dad hit it.
Yes.
And also on
that needs to
page
be admitted.
795, where he says I have to find where my dad hit the 9mm. Isn't that what she's seeking to do?
He brought a motion to exclude the journal entirely. The motion was partially granted in that the state said that they would only admit the parts that were already showing. So now she wants to admit a different parts. Now her motion though was to exclude it entirely. And since the state's allowed to introduce some of it, they should be allowed to introduce other parts of it. But she only wants to introduce the one page. And the state is saying, well, then we're opening the door to admitting the entire journal, which is BS, but we'll see where it goes.
Yes.
That's what it looks like.
That's correct.
Are you seeking to do anything beyond that? Be specific, because
There's,
I can't unring the bell, right?
that's correct. I'm seeking to do those two with the claim about access to the gun. And the detective also testified to a statement about I'm going to get the gun. So I wanted to impeach him with, on 789, there is a statement that says, it's one line, however, I don't want to be caught as that will make me getting the 9mm impossible.
It's not impeachment because he's not the declarant.
Well,
No, that's why none of this should be admitted.
I'm hamstrung
Period.
because
he
statements are
was
coming
declarant
in by
when
a
you needed him to be.
I know,
This-
right?
This is state BS again. We can use him, and the second you want to use him for exactly the same thing we just used him for, he don't know
Yep.
anything about it. He can't
Yep.
do that. This is
Well, so if you can't do it because the declarant isn't available, then you shouldn't have admitted the journal at all entirely. No other text messages because the declarant is not available.
parent that I'm not allowed to call as a witness. And under the
Okay,
same,
well, I want to back up a second. I never said that you could not call.
Because they're arguing over the admissibility of
I
evidence,
was
not
getting
the
the vibe
witness's
that would be the
testimony.
ruling of the court.
No, that'll never be the ruling of the court. I'm not telling you that you can't. I am not, as a judge in this court, telling you you cannot call the shooter as a witness. However, we've been over this before. We're going to go over it again this afternoon. Pursuant to case law that everybody's aware of, including a case called Jackaloni. It's 399 Mich 642.
let's say she calls the
1977
shooter and he
No one
pleads
is
the
allowed.
fifth. I don't know if he can do that when he's already plead guilty, but he doesn't want to cooperate. Can she then read it into to the record?
No. No, the problem is that this should never have been admitted without the declarant anyway. The judge granted it being admitted under 803.1 present sense impression, which whatever, then it all comes in and you can piecemeal it for prejudicial purposes. So you can piecemeal it under 403, saying it's more prejudicial than probative, or 404, whatever the rule is. But it has nothing to do with hearsay at this point because she's already said that it's coming in.
To put a witness in front of this jury who was going to take the fifth. No one. It's not me.
Well,
I'm not keeping you from calling someone as a witness, but his Fifth Amendment rights have been asserted repeatedly. And I can't let you put a witness on the stand. Anyone, the prosecution too. I wouldn't let the prosecution put someone on the stand, knowing that that person was going to take the Fifth Amendment, take the fifth. If someone takes the fifth in front of the jury, it's over. It's a mistrial. I can't let you do that, right? And I also asked before, aside from what is your favorite color, I can't imagine something you could ask the shooter that would not implicate his Fifth Amendment rights. His current attorneys, the state defender's office, have asserted his rights. They've said he will not testify.
I understand that. I have said I would still like him to testify, so I just need a finding by the court that under case law, he's not going to testify.
I'm not making a finding that he's not going to testify. His lawyers have asserted the fifth. You're not allowed to put someone on the stand that will take the fifth. And in reality, if they say he won't testify, I don't know what am I going to do? I'm going to insist that he testify and then hold him in contempt and put him in jail. Is that?
Well, Your Honor, I understand the court's position, but for the record in this case,
and by the way, I understand your position as well.
I've indicated, for as far as our position, I've indicated I don't believe the shooter should be allowed to plead the fifth because he was sentenced He's made statements about the crimes. He pled guilty to
Yeah, but he's
all
filed a
24
motion to set it
counts,
aside, his plea,
in adult
and
court.
is appealing his
And
sentence.
so I don't
So you
believe,
think that's over? You think that's over?
It's
well,
not
I
over.
think there is not case law that says he gets to continue his Fifth Amendment rights beyond that plea. I don't disagree with you that
His appellate rights?
he's going to pursue an appeal. I don't disagree.
Ethan has a
Alright,
guardian
so,
ad litem,
what
court-appointed
do you think he does not have, still have?
quasi-guardian.
There's case law directly on point.
I know, and some of those are indicated in the letter provided by the state appellate defender's office, right?
Yes, sir.
I understand your position. I also understand to a certain extent, I don't, even if he was called as a witness, you understand that then the prosecution would have a right to cross-examine him, right? So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not permitted to put someone in front of this jury who's going to take the fifth.
I understand
Yes.
that's the ruling then, that the law doesn't allow me to. Is that correct? Okay,
By smarter, higher courts than this one.
if that's the ruling, is that the court is going to follow the law the court
I'm
said,
going to follow the law.
then I've preserved the record and I'm moving on.
Okay.
So then these statements are coming in. They've come in as present sense impressions,
Okay.
and I'm not using them at all for the truth
Stupid
of the
reason
matter
to get those
asserted,
statements
because
in.
I don't know whether he found the gun or didn't find the gun or was looking for the gun, but this statement shows his state of mind, so I believe it falls under the exception, saying he doesn't want to be caught because it will make him getting the gun impossible. So his state of mind is not wanting to get caught. And that's important impeachment to the testimony from the detective that he said he was going to get the gun.
Okay, so are you addressing that statement, or also there's the, I don't know where my dad hid it, and there's a statement, I have to find where my dad hid the 9mm.
The two hiding ones are one issue, and then the second issue is I don't want to be caught.
All right, and
that's it.
Okay, so let's break this down for everybody who might be coming in late. What we're talking about here is Ethan's journal. Ethan had a journal that was written approximately close to the time of the shooting, within a few days, at least according to the dates. The argument is that he wrote these things down, and James and Jennifer Crumbley, in this particular case, must have known about this because he wrote it down. They should have seen this. And Ethan was slated to testify because he's pled guilty and he's been sentenced. It was assumed that he was going to testify. However, his guilty plea, there's a motion to set that aside because he was sentenced to life without parole, and his no parole issue has been appealed. So him testifying could jeopardize future sentencings, or if there is a trial down the road, if his guilty plea is set aside or whatever. So his attorneys have filed the notice saying that he's pleading the fifth. He's not going to testify. Without a foundation from the author of the documents themselves, generally they're not admissible. The court has made a ruling that Ethan's text messages, as well as this journal, can be admitted under 803.1, which is a present sense impression exception to the hearsay rule. I don't believe it's legally sound, but the judges made the ruling. With that, the defense asked that the entire journal be struck, but under 803.1, the prosecution was allowed to submit certain portions of it. Now, the defense is asking that a couple other passages also be admitted, specifically where he says, I can't get caught or else I won't be able to pull this off, and I need to find where my dad hid the gun. Those two are critical for the defense, and so it sounds like the judge is going to allow that, but that's the issue that's going on. So hopefully everyone's up to speed.
okay, do you have any legal support for that? This present sense impression.
And just straight impeachment rules.
Again, impeachment doesn't apply here. Impeachment is if a witness he didn't make the statement. I mean, that's not in dispute.
It's not the fact that he's
I can-
pleading the fifth is not a mistrial issue
I
for this
can
case.
impeach through other witnesses. I can impeach by omission. I believe under straight impeachment rules, I can use this. This is being admitted as substantive evidence. So I can impeach with something written on a napkin.
Okay, but I guess what he's saying, and this came up too with regard to the privilege records.
Correct.
Which we'll talk about again. Who are you impeaching though?
I'm impeaching.
The judge is saying that it can't be done in front of the jury because it's potentially prejudicial, and there must be a Michigan Supreme Court case on that or something, but not in front of the jury. So the court knows and everything like that, but they're not going to call them up to the stand and say, I plead the fifth in front of the jury, which I don't agree with. I feel like you should be able to.
Shooter's statements that have been deemed substantive evidence, and I'm not given the option to impeach through the shooter.
Oh,
So I'm seeking to impeach
is it
through
unduly
the
prejudicial
officer
stuff?
in charge.
Okay, so why would
There must be a court case in this.
It's
I
not
don't know. I
permissible.
haven't looked it
It's
up.
not under, and council has not cited the rule for that. It's not permissible. And I just want to inquire of the court if council is permitted to do that. Am I allowed then to ask about other passages?
Well, that's what I'm concerned about.
Make a ruling on
I mean,
two
there are a
passages.
number-
They relate.
Two passages.
I mean, just in the first two pages alone, Judge, we have if you see the picture of the gun on Instagram, we'll know what's up. We have,
Yeah, all of these things, I've been,
But again,
all these things.
did the parents
except
know
for the
about
period of
this?
time that
This
I
should
stayed
be
by
what
the
they're
Supreme
trying to
Court.
figure out.
To me could have been addressed, so this sort of doesn't feel like the time to be doing this.
Earlier in the trial, when I found that the court wanted to know what objections were going to be made, I stood up and said, I know this is going to be an issue. And the court said, we'll handle it down the road in trial. I made the court aware of that. That was on Monday or Tuesday when there was some friction about another objection. I said, this is going to be coming. And the court said, we'll cross that bridge when we come to it.
Okay, because I guess my position is that we should have crossed that bridge before we impaneled the jury. That's just, and
Judge, we put the passages the court specifically ruled as admissible, nothing more.
okay, but why would her request to allow those three passages because they're present sense impression?
Well, I don't necessarily agree there's present sense impression because there's certain requirements for present sense impression as well as state of mind. We can't be talking about a future plan. And there's Brady, his friend is gone. He has no friends. My wrist hurts from writing in this, fucking book so much. I haven't felt generally happy in years. I can feel the evil around me. Even dogs sense it. I mean, that's just
Listen, one passage does
That
not
doesn't
equate
impeach
another.
Anything that I'm using, and the
again,
prosecution didn't seek to admit those things.
Did the
I
parents
also
read
We've
the
only
journal?
admitted what specifically would be
Did
covered
they know
under
he felt
the rules.
evil around him?
Sorry, what were you saying, Baker? It was a little loud. I couldn't
I'm
hear
just saying, again, we are arguing about all of this stuff. What does it prove? Did the parents read this in journal every morning after he went to school? They just flipped through it and said, oh, today he felt evil around him. So better get him to a health professional. Or is it his journal and he had it with him at school, so they had no way of knowing what he wrote that night?
Well, I think, so the implication is that he wrote it, so they should have seen it or they should have gone through it. But the idea that Ethan is even saying in the journal that his parents hid the gun is important to get out, right? Uncivil. So what they said was, okay, so Ethan can't testify because he's pled the fifth. And so there was a ruling to exclude the evidence or exclude the journal and all of Ethan's text messages. The judge made a ruling under 803.1 in Michigan, which is the present sense impression exception to the hearsay rule. A statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. So under the present sense impression rule, I have cats fighting, sorry. The court has allowed limited text messages between Ethan and his friend and limited journal entries in. And now the defense wants two additional passages of the journal, And the state is saying, well, if you allow those in, you have to allow everything, which is nonsensical to me. I don't understand that position from the state.
That the court permitted us to over a year ago.
Yeah.
We're not trying to push the envelope here because as the court is, we don't want to inject any kind of error, Judge. So we kept this extremely close to what the court has specifically authorized.
Well, which provisions specifically do you say are present sense impression? Because I don't know that they are, you know, I don't know that they are. On page 78, I don't know where my dad hit it.
I sent on civil link.
I'm finding the provision right now.
Yeah, Baker, you're right. When he's not yelling at her like a
It's just,
sworn
my concern is more on opening the door.
But he's-
Well,
there's still
yeah, that seems
there's some
to be
sexual
the-
energy right there.
I don't believe that.
When the judge is turning to the court rules or bench book.
I believe my impeachment is very limited.
Hey, Kurt.
Hey, MLS, what's going on?
Not a whole lot. Do you know Baker, by the way, below me?
Hi, how you doing?
Hi, I'm doing fine. How are you?
Good, I'm great. Yeah, so I'm confused and I needed a second opinion from another lawyer because I don't understand what's going on. So first of all, I don't buy present sense impression. We're talking about the diary, by the way, of course.
Yeah.
So
Yeah.
with respect to the diary, I don't understand present sense impression. And to the extent that that makes sense, I don't understand why that wouldn't also apply for what the defense wants to offer. I don't really get how one can be present sense and the other isn't. I'm confused.
I am extremely confused as well. I was confused when they first said that they were going to allow the journal and the text in under present sense impression. It doesn't make sense to me. Because it's not the witnesses, on the stand that's saying it or writing it down. But then for the prosecution to say that adding those 2 additional passages is opening the door to all of it, or that just because or he's only allowed to admit his part. I honestly don't know. It doesn't make sense to me either. I'm just as confused as you, and I don't have this motion nor the court's ruling about it.
Yeah,
So
no,
I
I'd
can't
really
dive
like
into
to see the reasoning on whatever motion eliminate I'm sure exists on this issue.
Yeah, there were 2 motions filed, and actually there was a hearing set for the week prior to this trial starting, which I was going to cover, and then they dispensed with oral arguments, and the judge was going to issue a written opinion. I haven't actually seen that written opinion, so I don't know exactly what the reasoning is. But she made a finding. She said repeatedly under 803.1, which in Michigan is present sense impression. So I don't know. I am absolutely at a loss as to how it's present sense impression and why, like you said, it applies to certain passages but not other passages. I have no idea.
I don't buy present sense impression. Present sense impression is typically I'm observing something as it's happening. I don't really think that applies to your own mental state about what you're feeling.
And it's also used when the witness on the stand is the one that's testifying, right?
Right.
Yeah, you have a cop who didn't know Ethan at the time or was in the room with him when he wrote the journal, but he knows his present state. How? And why can't he then just turn around and say everything else in the journal? I read that, so I know everything he thought about.
And putting aside that issue, like even if you get to the idea that's a present sense impression, with respect to Ethan, how does that apply with respect to the mother without evidence that the mother knew of it? So, because we're all talking about the mother's mental state, right? So
Right.
without evidence that the mother was aware of it, then how does it speak to her mental state is beyond me at all.
Did you hear what the officer testified to first few questions on cross?
Yeah.
Do you have?
I heard him say exactly. Yeah, we have no evidence of this. I heard him say exactly that.
But he said if they had evidence of the knowledge, which is essential to this charge, they would have upped it to murder, which is an intent charge.
Also, object legal conclusion.
I know, right? There was no objection to that, and I thought she should have followed up on that a bit. But
no, I don't buy any of this with respect to the journal. With respect to the text messages with the mom, easy enough. Statement of a party opponent. We bring in the whole thing for rule of completeness. The text messages to a friend, I don't know, haven't thought about it hard enough. But with respect to the journal, That's a pretty big thing to bring in. That's a big deal. And I don't buy any of this rationale. Is that you, Nick?
That is me. Hi,
You've
Kurt.
changed your look.
It's ponytail, and I trimmed the beard.
Nick, do you understand any of this bullshit?
This is live. This is live. We are 10
Okay.
minutes behind the court schedule, but yes, we are live. No, Nick doesn't understand any of it.
Yeah.
Nobody does.
Yeah,
None
I
of
mean,
this makes sense.
I'm still trying to get a grasp of why the parents' responsibility is at a criminal level. I can see a civil, but then again, I'm Swedish. We don't have anything close to this here.
Oh, don't worry. I've already raised all those questions before too. Don't worry about that. I'm with you on the law. I read the Court of Appeals decision on the interlocutory. I'm not sure I buy any of this either.
It goes in circles, doesn't it? That Court of Appeals opinion.
Yeah, I don't buy any of this either.
Well, hang on.
I'm hijacking your stream for a while because we can go live. I'm hijacking your stream for a while.
Sure.
It's limited to 3 sentences.
Okay,
And then
okay, you're offering under 803.
under 803, let me just find it.
8033 is then existing mental, emotional, physical condition.
.803.3. Then existing mental, emotional, or physical condition. 2 is excited utterance. 4 is statement made for the purpose of medical treatment.
Someone has to explain this to me like I'm 5. If the statement is, I'm looking for the gun, I can't find the gun, on what possible basis is that not mental impression, if any of this other stuff is? How does that work?
Mental, emotional,
I know, right?
Emotional or physical condition.
I think
I don't even agree with the premise, but assuming the premise is true, how's the conclusion not follow?
Right?
it also says such as intent, plan, motive, design, and so his plan.
When 2 lawyers are confused, you know it's all going to hell.
When the judge breaks out the bench book.
Not get copyized, I'm sorry. His plan.
No, and again,
to
I'm here
act
as
in
the
a way so he's
non-legal
not
fella.
caught, I think does
Like
fit
the 12
under
people who are
rules.
going to convict her. I don't
Because it
understand
talks about
anything
intent,
of what's
plan,
going on
motive,
right now.
design,
And I
mental
know we are
form,
watching
and
behind the
bodily
back,
health.
but sitting back there in the jury room,
The crux of the issue is that for a year,
the way
and a
they were
half,
sent out,
we had just
and again,
those 5 or 6
court is not about
portions
law,
that
it's
were dismissed
about
by the court.
juries.
This trial was
Uh-huh.
prepared from the prosecution standpoint.
And
with
this
just
case-
those dismissal because the court was very specific in this
It's
ruling.
so confusing
So now-
to everyone.
Defense is using that,
We didn't have
that
the-
ruling as a sword and a shield. And so if the
Uh-huh.
court wants to make a substantive ruling mid-trial,
Wait, who's
I
allowed?
think I'm entitled to at least a
Court
minute
does
to
not.
Your Honor, I'm the one that filed the motion that brought this issue up. I filed an appeal with the Court of Appeals.
I'm aware.
Okay. I got their exhibits after trial started, identifying these
Okay.
portions of the journal.
Okay.
That after trial
You've
started,
had this journal as have I.
as
for
absolutely.
A long time.
I have,
long
and that's
time.
why I filed an extensive motion about it. But now that they're using bits and pieces.
She filed an
to
extensive
trial-
motion to get the whole thing out, and the court allowed 4 or 5 passages in under this 803.1 present sense impression. But now apparently it's not good enough for her.
I really need the judge to explain this to me in excruciating detail. I need this motion in limine response. I need the judge to explain to me in excruciating detail how some of this is present sense and other of it isn't, in a way that makes any sense to me.
Let me see if I can get it while this case is.
Please find me the magical order on the
It
motion
should
in
preclude
limine.
me from impeaching.
Okay, but that's what I'm going back to. Who are you?
This better be good. That's all I've said.
To impeach someone who's not testifying.
It's complicated because I can't impeach the person that I want to impeach through testimony. So you're right. I'm hamstrung.
I'm allowed.
My client has a constitutional right to present a defense, though.
I'll turn myself down
And
more, I guess.
I'm getting hamstrung and stuck because of
I'll cut
other
myself in half.
extraneous legal issues. This is
I don't want to
straight
blow out your
impeachment.
guys'
So
ears.
what I'm providing
Sorry.
is not to be admitted as substantive
If
evidence.
she can't impeach his testimony through the diary and all of that stuff, Why
Her
was
own
it allowed
motion to
in?
exclude. We didn't move to exclude any of this evidence.
She has the
Also
right
did
to
it after the
confront.
Preliminary examination,
Uh-huh.
and this court was specific in its ruling.
Well, there should have been a motion to include.
That would
And
seem reasonable.
There's
Yeah.
no rule.
And
there's no
if she is not
requirement for
allowed,
anybody,
I
any
would call
party
for a
to have
mistrial.
motion to include, especially when counsel specifically identified this piece of evidence as being inadmissible. The court made the ruling.
Well, I guess if I'm saying if you were, if you fear at all that this court would rule incorrectly, you would still have an opportunity to appeal that ruling.
And we didn't appeal the ruling. We
And
didn't
Your
appeal.
Honor,
Oh,
I have
yes.
not, I would have filed a motion if there was substantive information additionally that I wanted to admit. I've never filed a motion to have the ability to impeach. I'm asking to impeach. No one files motions to say, may I impeach this?
Because this is the third
That's-
time during the trial.
There's motions in limine with regard, this journal is very disturbing and, every time any of us.
Yeah, it is very disturbing, and there's a 403 problem there too, as long as we're
This isn't
discussing
a
issues.
glaring Thing in this trial, this isn't a middle of the trial type of game plan here.
Right, just so the record, just so the record is clear, because I know the court's aware, we went through the Facebook messages detailing the alcohol use. We talked yesterday in depth about the extramarital affairs that were previously excluded. And now the journal, this is the third time mid-trial. We just need the ground rules. The court gave us those ground rules a long time ago. We prepared a case in accordance with that. So if the door's open, the door's open.
Okay, well, that concerns me too. I'm going to take a brief recess.
Thank you, Judge.
So you can step down.
Thank you.
Yeah, Judge, you might have fucked up in your prior rulings.
All right.
Then here we are.
So here we are waiting. Okay. You guys keep talking while I'm looking this up. I'm trying to,
Yep.
I've got it. I just got to find it and order it.
Yeah, I need this. I need someone to explain this to me step by
But
step.
I don't think anyone can explain it to you because again, it's just I'll make a ruling and then someone raised a stink about my ruling. I don't know why I ruled that way. It doesn't make sense. What if this guy can be put in there to talk about Ethan's present sense of mind or whatever it's called? Why can't he do it on the rest of the journal? Well, he can't because I don't know. It's
So the DA speaks from both ends here. Only what we want in is allowed. What you want in is not allowed.
Yeah, that
Yeah,
confuses
exactly.
me.
That
How's that
makes an
logic work?
inconsistent ruling from the judge, who should have predicted this.
And
And
I
yeah,
don't
also
think-
under the rule of completion as well.
Yeah, I don't even think it qualifies as present sense because it's not related to the event itself. Like present sense would be someone observing the event. For example, look at that car. Look how fast it's going. That's present sense because you're observing the thing. This is planning, preparation. It's like I'm not even sure you can be criminally tried for what's in the journal before the event occurs because it's planning, preparation, statement of intent, but arguably there's no act that would allow criminality on its own, on the own
no,
paper.
because he can always step back from the crime.
Right, he can always step back and be like, you know what, I changed my mind. I'm not going to do that after all. What a whoopsie thought that was, right?
Yeah.
So without some sort of step to effectuate the intent, you can't even get to attempt. So
I have the motion in limiting to strike the evidence. I have the people's response, and I have.
Do you have the judge's decision?
No.
Okay, that's less helpful.
No. Oh. I mean, I can order those two documents, but there is no opinion or order regarding that. That's been written.
How's that even possible? How can there not be an opinion or order written about this?
I don't know.
It is.
There's additional motions
oral
to
hearing.
strike.
It is a fairly critical piece of evidence.
There's an offer of proof regarding the motion to strike, and then there's a people's response to that.
Someone in my chat is saying
there's
the
no
judge's.
opinion.
Someone in my opinion, someone in my chat is saying that the judge's opinion is under seal.
There's no.
I mean, that's just what someone in my chat is saying. So I don't know.
There's a protective order that's under seal. Copy of protective order, but I think that has to do with Ethan filed a motion to intervene and notice of Fifth Amendment, and I think that's what's under seal.
Also, by the way, I take exception to the judge saying I'm not the one keeping you off the stand. The law is, as opposed to like, there's a difference somehow.
I know that was
Yeah,
so dumb.
I'm just enforcing.
that's
I'm
the-
just enforcing the law. No, well, no shit. That's your job.
Yeah.
Yeah,
She
that's
is
the
Judge
sole
Jet.
purpose.
I am
She's
the law.
there. Yeah.
Do you want these?
Her-
You want these motions, anyways? I don't have an order. Let me see what I can do here. Let me see what these look like. I'll get them shortly. I won't get them.
I guess we can see what the state wrote in their BS of how this somehow qualifies. I mean, I kind of know what it says without reading it, but I already disagree with it.
It's a lawyer speak of we wanna.
Yeah. I mean, I know what it says without reading it. Of course, it's present sense. He's writing this thing as it's happening. It's a real time dictation of the thoughts. Of course, it's present sense. Do.
There's it's like a notebook, and there's 21 pages that were written in, and all 21 pages apparently depict or talk about some sort of school shooting, and his life is horrible, and the gun, and where the gun is, and that he doesn't have access to it, and whatever. There's only one date on it. I don't remember the exact date, but it places it right around between the time the gun was purchased and the shooting. It's like, I want to say it's like November 27th. So it was written very quickly, at least according to the date that was in there.
I am Dave. Trial is on break right now, so that's why we're discussing the trial.
Yeah, you can see it right here. See, we're just waiting.
So we are doing just as you want. But again, I just love that all of these state witnesses get the defense dementia. The second he asked, or she asked him a question, it's been such a tough day, I can't remember. You were perfect. You could remember all the kids you saw that day and how bad they were. And the second the defense asked, and I really hate that. I've been doing this for a year now. I hate whenever a state witness who works for the state goes on the stand, they get dementia. They can't.
Yeah, but that is because they've been only prepared for one part of the story. So
that is a fair point. The state has taken time preparing their witnesses. Heaven forbid we use the word coach, and so they know what the state's questions are going to be. So they've had the ability to hone their testimony with respect to the questions.
But Kurt, as a lawyer, wouldn't you also say you might be asked this question, and you might need to prepare an answer, something like this, instead of just sitting there. It's been a horrible day.
I've never been a prosecutor, so I couldn't really say, but I could imagine a prosecutor not prepping you, because then they can honestly say, "Well, I have no idea. I haven't thought about it."
Yeah, but it just looks, to me, it just looks bad to the jury whenever, because it's always the state's witnesses. Because a regular person most of the time will just blurt out stuff, but people who work for the state, they get the dementia.
Yeah, they're professional witnesses, so they know what to say.
Yeah, and it pissed me off that the prosecution chose to put the most emotional cop they could find on the stand for this part at the end of the state's case.
I've been in doing jury duty for more than 12 years. I have seen one person cry on the stand who wasn't a victim. I have seen two persons who were victims crying on the stands, and they were raped a lot by a guy in a very bad way. The other one was a guy who was the ME, not the ME, but the physician who took in a murder victim, who was, let's just say, the pictures weren't that great to watch. That's in 12 years, I've seen three people cry on the stand, and this guy got so emotional. He's a professional. My dad was an EMT worker for almost 40 years. I never really saw him cry much about his work, because you see bad stuff and you get used to it. To me, it just seemed phony. I'm sorry.
So these are the segments that were admitted. Well, hang on, Kurt. Let me get this banner off your face. All right. So these are the segments that were admitted. So under present sense impression. So I have zero help for my mental problems, and it's something. Causing me to shoot up the fucking school. That's a present sense impression, apparently.
No.
No, because
I want
he's
help,
talking
but my
about he's
parents-
talking about a future event. Then it can't be present. I mean, yeah.
I want help, but my parents don't listen to me, and I can't get any help.
No.
No.
My parents won't listen to me, won't help, or a therapist.
No.
Won't listen to me
No.
about get or a help or a therapist. I want to shoot off
Up the effing school.
Yeah, up the effing
badly.
school so
I
badly.
want to shoot. Soon I'm going to. That's present sense?
No, and I can see from here that's two different pens.
I'm about to. That's present sense?
I'm about to shoot up the school and send the rest
How-
of my
how-
life and spend the rest of my life.
How in the world is this accepted by the judge as present sense?
It's not present sense impression. It's just not, because it's talking about his own mental state. That's not present sense impression. Present sense impression is something you observe as a
and-
witness.
And again, the last 2.5 lines.
These are the only parts that were omitted, by the way.
Yeah, I'm fully committed to this. So yeah, I'm going to prison for life, and many people have about 1 day left to live. He can still step back from those thoughts. He hasn't done it. This is not the minority control report. Minority report. We don't do pre-crime.
I mean, it's all the relevant as it relates to Ethan, because it speaks to his intent. Plus, it's a party opponent statement, so it's just non-hearsay in the first place, at least under the federal rules. And so no problem there. But as it relates to the mother, I don't see it.
The other thing is that if this is considered present sense impression, if these things are, then why would it not be present sense impression to admit the parts where he says, I just need to find out where my dad hid the gun, or
That's a really good question. That's the same question I've been asking.
Right? Why, if this is present sense impression, is that not present sense impression? Why do we have to go to these other rules that everyone's looking through?
I know what the problem is, though. I've just figured it out.
What's that?
I just figured it out. If the defense gets this in and the judge is like, well, we're going to admit it all now, and she tells the defense that, it's going to be viewed by the Court of Appeals as waiving the entire objection, because now the Court of Appeals is going to view it as the defense inviting the error. So if she doesn't cross on this because she can't, then she can raise the issue on appeal, like, yo, it came in besides my attempt. But she's like, no, I want to bring this in. And the judge is like, are you sure? Okay. The Court of Appeals is going to view it as waiving the objection. So the judge is basically putting her in a no-win position. Either you do it now and waive the objection of the Court of Appeals, or you don't do it now, the jury convicts, and then you are relying on the Court of Appeals to say, this was legal error to the point that it requires reversal, which they're not going to do that either, because the Court of Appeals is going to say harmless error. Well, yeah, it was a mistake to let it in, but so much other evidence, so who cares, right? So she's being put in a no-win position.
Yeah, and this goes back to the judge to protect the process, she should go back on a ruling. The problem is you can't shove the toothpaste back into the tube. You can't.
No, there's no way she can go back without declaring a mistrial.
Yeah.
Yeah, because the
But
jury is
she
treated
should.
now.
She should, but she won't.
I mean, if you realize as a judge you effed it up that hard, then that should be what you do.
Yeah.
It's like, well, that was a mistake.
This
Let's
has
try
been
again.
extremely stressful on her and the whole court administration, because they made a decision that no other jury trials are going to take place while this one is going on. Although one judge managed to sneak one in, apparently. But
Why would they do that?
Because it was such high profile and they had to bring in so many prospective jurors. That's what they said. That no other jury trials are going on while this one is going on. And so they have motion hearings and whatever, but no jury trials are going on while this one's going on. So like the judge is under a lot of pressure to like get this done, get it done quickly, and don't F it up.
When is she up for a re-election?
I don't know.
I have to count that in. Yeah.
Yeah,
But,
this is a really great case. If you land it and people are happy, then you're reelected. But if she has to admit I made a boo boo and now it has to start over, she might be out of a job at the next election. So she will probably not admit to doing something stupid.
There's that problem too.
Needs to be a mistrial.
Yeah.
Yeah, no, this is all kinds of a mess of a case, and the defense counsel isn't helping. But you get caught up in these things. So, what you were just saying, Kurt, though, if she files a motion to exclude this evidence, and the judge overrules her essentially in part, she can say then, doesn't she have a valid claim? Like, well, if the judge was going to allow part, then I'm allowed the other part in, even though I really don't think any of it should come in. You don't think that there's you think she's waiving that then?
I think the Court of Appeals could very well look at that as waiving it. Yeah.
But in the Young Thug trial, they had a similar last week where the judge put on the record that you don't waive the appeal issue because this is something the other part did.
It arguably, even if it doesn't waive the issue with respect to the portions that are already admitted, so even if it preserves that issue, because she would cross on it and the judge is like, well, I'm going to allow these other parts in, then presumably you could say the Court of Appeals is inviting that error because she's like, well, only because you asked did these other portions come in. So sure, the first parts are excluded, but the other exciting parts of the journal are let in, so we still don't care. There's any number of ways for the Court of Appeals to slice this to make the ruling that this is going to be maintained.
And you've seen the Court of Appeals work in this case specifically. With the
that would be one of the reasons that's driving me to that conclusion. Yeah, I think the Court of Appeals might be somewhat motivated to maintain a guilty verdict. Whatever would make me think of that? Well, geez, let's look at the evidence before us.
Michael Drum with the $4.99 super chat. Thank you. Do we know the dates of the journal entries? The page numbers are far apart, so to me it seems like it could be a large gap between them. So the only date that's been identified during the preliminary examination, which is really when this came to light, was, I can't remember exactly, it was somewhere between November, I think it was November 27th or so, which would have been after they got the firearm, before the shooting, right in that couple of days. That seems to be the only time that the journal was really dated at all in any way, shape, or form. And there's been no evidence that the parents even saw it, even knew it existed. And of course, Ethan isn't talking, so we don't know. But the date puts it within that window. Thank you very much for the super chat, though. I don't want to make sure I didn't miss any others. I don't think so. So that's where we're at. We're just waiting for the court to come back. Are you streaming this too?
I'm hijacking your stream at the moment, so I'm just streaming this StreamYard thing. So I told you, I hijacked your stream.
Joe did that.
They're going to go directly into lunch, right? It's almost 12.
And they might, yeah.
Well, if they break for lunch, I'm breaking for lunch.
Yeah, we might break for lunch, just depending on what's going on, or we might just continue it straightforward.
Unless we can find the exciting decision that somehow makes this all make sense from a legal perspective, because I'd love to have my mind blown.
Yeah,
I think if you stand up and run into your fridge a couple of times, it'll make sense after. But
I ordered it. Well, I don't know when it'll get here because the clerk's gotta send me an email with it, so it takes a bit.
Oh, it's one of those courts. Oh, that's fun.
Yeah, you got to order it online, pay $1 per page or whatever, and then you eventually get it. All right, they're bringing her back in the courtroom.
Also, not for nothing, why do we have 7 different police officers on the side of the wall? Does that seem a little excessive to anyone else?
Yeah, it does. It does a little bit. Well, there's more outside in the hallway too, but the jury doesn't see that.
And again, she never did this to anyone, but they're treating her worse than Daryl Brooks. Daryl Brooks just had one guy sitting behind him.
Yeah, I mean, I recently watched the Jeffrey Dahmer trial. There was only the bailiffs there, and that's Jeffrey Dahmer.
Well, I will say that the Oakland County Sheriff act as bailiffs in this court, but there's definitely a lot more than they usually have, which is like 1, maybe 2.
Yeah,
Yeah.
but at least they are not out on the street stopping cars for tinted windows.
And they want to look like a mass murderer. That's for sure.
Dave, I'm gonna jump off before it starts up again because I have
Okay.
stuff. But
All right, take care, Baker. Everyone go subscribe to the Broken Baker. He's Danish. He's a Danish professional juror, but we don't hold it against him.
Professional.
And if someone
Kurt,
could
so
put a
nice to
link-
meet you. And Nick, we will be
Yep.
coming as soon as the ice settles. We'll take back our country.
2279990F8.
All right, take care, Baker.
Thank you, Mark. Peace and bad people.
Chairman Donovan.
And she meant to put it up.
Okay, so I'm gonna have some,
Absolutely.
a couple questions for you. This is certainly one of the kind of things that you want to spend some time on. Initially, I want to point out that you have said you want a statement. However, I do not want to be caught, as that will make me getting the 9mm impossible. That's what you said you want. Okay, here's the problem with that. It might be a future plan, but this isn't a future plan not to get caught planning to shoot up the school. This is a future plan with regard to Jeffrey, right? Which is discussed
How is the other things not?
extensively prior to this, right? Jeffrey, Jeffrey would be the bird and the bird head,
Oh,
right? So,
Oh.
I see, okay,
so there's,
that would
so,
open the door, okay, I see what you're saying.
yeah, so.
Yeah, and of course I would ask,
I do not want to be caught, as that will make me getting the 9mm impossible. He's talking about getting caught with the bird head in a jar and the
Oh yeah, we don't want that
terrible
coming in.
things he did to baby birds. So I'm pretty sure that you do not want that to come in.
right, I don't want the baby birds to come in. I
Okay.
thought when he said, I don't want to be caught, it was being caught, like having mental problems.
It's the problem with not having the
with
declarant
bird, being
available.
caught with any of the stuff he's been doing.
Okay, well,
I didn't take it to be the bird, but I see what the court's saying.
if you.
And you're
if you
right, if
read-
that opens the door to the bird, then I don't want to open the door to the bird.
There's an extensive discussion prior to that with a picture, and about him dumping the bird's head in a bathroom, and
Is that on the same
people will
page?
talk about it for the rest of the day because I want the attention. However, I do not want to be caught, as that will make me getting the 9mm impossible. He's not talking about getting caught with the plan to shoot up the school. He's talking about
Okay,
getting
I understand
caught
this part,
with
sort
putting
of.
the bird head in the bathroom and hurting the birds. So I think it's pretty safe to assume that you do not want that statement.
That's correct, Your Honor.
Okay, here.
All right, that I understand.
I know I'm going to regret this. I'm going to let you respond to this, but I also wonder, you say you want his statements. I have to find where my dad hid the 9mm, and I don't know where my dad hid it. It's hard for me to understand what that impeaches, because we just saw a video where Mr. Crumbley is telling Mrs. Crumbley, she asks him specifically, where was the gun? And he says, I put it in the dresser, right?
That's the other gun. That's the other two guns.
Okay, but there's also statements to the police about isn't there a statement on the video to one of the police officers?
Yes, sir.
About where it was? Was that the armware one?
Yeah, where she hit the bullet struck.
Yeah, but
No,
this
she
is
did the bullets
the
in the door
Ethan's
for
statement.
Yeah. Okay, well, isn't there other statements in this trial about where the SIG was?
Yes, Judge. And it's
Hid.
lots of different statements. That's part of the
Hidden.
case.
It says it was
Where?
hidden.
Okay.
Yeah.
All right. So anyway, the bird, Jeffrey's staying out of this.
Yeah, I agree
Okay.
with that.
All right.
And I misread that. I did not.
Okay, well, it's hard to read, so anyway, what else do you want to say about this?
Judge, this is the people's issue here, is that well over a year ago, this issue, as well as a number of other issues that have been addressed the last few days, have been settled. It was June 27th of 22. It was appealed. The application to the Court of Appeals was filed on July the 18th of 2022. This is a pattern now that appears to be part of counsel's strategy. That's fine.
At least
But
we have a date for the
people
order,
should be
June
entitled
27th,
to
2022.
Now prepare accordingly.
Sorry, what was that, Kurt?
Because he just said it was settled June 27th, 2022. Presumably that was the date of the order from the court on this issue.
I guess, but I'm not seeing it.
Okay.
It's a
council has
appeals
promised-
court. So it's
the Court of
should be in the
Appeals.
I'll take a Court of Appeals decision and maybe they'll explain it to me.
Yes.
Jury that Jennifer Crumbley is going to testify. That's significant because that entire Facebook thread has come in. That's over 2,000 pages. I know from my memory, there are a number of messages that will be very important at cross-examination. But because it's been sprung up mid-trial at the request for an unredacted copy of that, I want time to go through that before the defendant takes a stand, so I
What's the
can
date?
have every passage ready.
I'm sorry.
June 27, 2022, I think is what I heard.
What?
The Facebook thread
The
between
Facebook, okay.
Jennifer and James Crumbley.
Okay.
Your
chat.
Honor,
Did you catch the
prosecution
date?
moved to admit the whole thing. I have no objection. I'm ready to go with it.
Okay.
They moved to admit the whole
Okay,
thing
wait.
in front of the jury. Now he's saying he's not ready for
Wait a
it.
minute, am I missing something? I'm talking about the journal right now.
Yes, this is the pattern, Judge, the pattern of strategy. And again, counsel's entitled to her own strategy.
Right.
However, we are entitled to prepare our witnesses accordingly, including the cross-examination of the defense witnesses.
It's your
We
case.
responded to the defendant's motions with the journal in particular with a select number of passages that firmly fit within the instructions provided by this court.
And that was in response to her motion. wasn't it?
Yes, Judge.
The
and
state has
it's
had the
court's
discovery
order,
for
not
longer than the
defendant's order.
defense.
So we're following
You're
the
not
court's
prepared,
order when we
not an
prepare the trial.
excuse.
Again, if counsel wants
Shit,
to
really.
reverse course mid-trial as part of our strategy, that's her decision. But we
He's
need
trying to
have
make
the time to prepare.
his problem
So I'm
their
asking for
problem.
the court to give us the time to go through that Facebook thread, as the court gave defense counsel time to go through statements of her clients, her own client
How-
statements before.
how
Mr. Rose
does-
testified.
Reading this portion of the
Okay,
diary
you
open
guys
up a 2,000
have
page
gone on
Facebook
and
thread?
off into Never Never Land here. I want
question
to
mark?
address the journal and then finish the lieutenant's testimony. I also want to make the sealed record during the time period that the jury is eating lunch. So at this moment,
A sealed record. That's exciting for
I'm
both of
going to
us.
indicate that I am very concerned about the journal. The journal is extremely disturbing in many, many, many ways. And I do not want to risk the door being opened. But more importantly, these statements, I have to find where my dad hid the 9mm and where, I don't know where my dad hid it. I don't know if that it impeaches anything in this case, because there's already been plenty of evidence that he found it, right? There's evidence, the shooter found the
Yeah,
gun,
but
right? And there
he's
have
not
been
on trial.
statements made,
Jennifer is
by
on
both
trial.
the defendant and her husband to
This is about her
in
knowledge.
text, whatever it is, indicating that the gun was hidden in some way, obviously very poorly. But the gun was hidden in some way. The gun, as far as we know, was not sitting on the kitchen table. So I don't think this impeaches anything. I don't think it's contradictory. More importantly, I don't think under any circumstances, any more of this journal should come in. And in the event that it was going to come in, I think that it should have been handled prior to the jury trial. I am trying to very much protect any potential appellate record. And I do not want to delve into this journal. I think that would do nothing more than hurt Mrs. Crumbley severely. It's highly prejudicial. So that's my ruling about the journal.
If the journal
I don't think
is
I don't think the
highly
contents of the journal matter because you have to prove
I
it.
appreciate if we did that when the jury's at lunch after we get the.
and you already let parts of the journal in,
Okay,
so
let's finish him, okay?
I don't know. What are your thoughts, Kurt?
I'm confused.
this is strange.
Okay,
Yeah.
their lunch arrived, so they.
You already the rest.
So the judge basically denied those two portions of the journal coming in.
Yeah, but I don't understand why, because if that opens the door to the rest of the journal, why doesn't or the prosecution's part that they wanted in? Why don't
You can step down.
Sorry.
you have the rule of completion, the right to impeach? I mean, there's so much.
I think I sent, had my assistant send an email. Yes, yeah.
So are they
I think my
done with
assistant
Cross?
sent an early morning email to
I don't know what is
about
happening at
making
this
a
point.
sealed record presented Michigan Rule 8.119.
Yeah,
Yes.
only the state gets to cherry pick.
Yes.
All right, so because of that, I'm going to exclude everyone but the parties. We're going to do that briefly, then I'm going to allow Ms. Crumbley to go downstairs and eat her lunch, and we're gonna break until 12:30.
Just
Alright.
before
We're
we
breaking
go off the
for-
record, I just wanted
Okay.
to complete the record that we were speaking.
Okay, go ahead.
So, we've gone through this. I don't want to belabor the point. The issue that the people have is that it appears that council is trying to usurp the court's order without notice to the people. And that makes it impossible.
Okay, let's start over with this issue, because I was talking about the journal and then you
Yes,
started
Judge,
telling me,
it's-
so start over, okay?
Thank you, Judge. The journal appears to be a pattern of strategy, which is without notice, mid-witness, shifting from what the court has
What do you
already
mean without
ordered
notice?
to what counsel chooses to be convenient. And again, if that's trial strategy, that's trial strategy, but we have the court's order, not the defendant's order. And I don't believe it is appropriate for any party to usurp a court's order. And I also don't think it's appropriate that the people will have to respond off the cuff. I want to make sure that our witnesses are prepared.
Okay.
I want to make sure the materials necessary for cross-examination are prepared as well. So,
Okay, so the issue
prepared.
right now is the numerous Facebook communications between Mrs. Crumbley and Mr. Crumbley. That's the issue.
that's,
That came in.
And Your
that's
Honor,
the piece of evidence.
Okay.
Within that piece of evidence, there are a number of issues to explore.
Okay,
Within that piece of evidence, it includes items that defense counsel had previously sought to exclude and this court did in fact exclude. So
Your
that
Honor.
was the discussion that we had when Mrs. Crumbley was placed on the record, and she said under oath that it was her decision upon consultation with her attorney, knowing that we could cross-examine. I just want to make sure that people are given the opportunity to review all of those 2,000 messages or 2,000 pages of messages appropriately before that cross-examination begins.
Your Honor, I just want to point out that the prosecution moved to admit the entire thing in front of the jury. So I believe if I objected, it would look like Mrs. Crumbley is hiding materials. And we've taken the trial strategy actually based on their trial strategy, bring it all in.
okay.
And so when Mr. Keys.
It was a
did-
redacted copy.
Okay, I
But
don't
listen,
understand, I don't
when-
understand why we're,
He's-
taking a trip down memory lane. The whole thing came in already.
Right, it came in, but I'm saying he asked for it. That was days ago. And I'll tell you what,
And then you agreed to it.
I did. And since that time, I've read the whole thing and I'm ready to go with it. What
Okay.
he's saying is that he's not ready to go with it, even though he moved to admit it. And even though it was days ago that he moved to
Just
admit
to
it.
correct the record, we moved for a redacted copy and for counsel to specify exactly what portions were redacted in accordance with your order,
And
Judge.
the next day I got back to them, which was days
I'm
ago,
gonna ask
and
you to
I
keep your
said,
voice down because the walls are paper thin and the jury can hear you.
I got back to them the day after and I said, we're not asking for any redactions. They said, fine. We made a record with Mrs. Crumbley, no redactions.
Okay, when is this gonna come up anyway? How far are we gonna get after Lieutenant Lawrence?
I guess it depends on how often this comes up. And this is why I bring it to the court's attention that
This will come up when Mrs. Crumbley testifies, if she does, right?
certainly,
Okay, is that the only time?
well, I brought up the pattern to the court's attention because it does appear to be a pattern. The only reason I bring it to the court's attention now and our objection to that is because it appears to be a continual theme. So I want to bring it to the court's attention now, and I want a record made of it. That's why I bring it up now.
Okay, well, you can't admit something and then unadmit something. There's no court rule that says you can do that, right? Okay.
No, it's the redacted portions, it's the portions within that would have been inadmissible prior to,
Yeah, I did it.
okay.
Yeah,
And we said we still.
We're letting it all hang out.
We're letting it all hang out.
okay.
I don't want any redactions.
Letting it all
because I
hang
think
out.
it makes it, Mr. Keys has made it look like if we put redactions in there, we're hiding stuff.
I
So
don't
I'm
even know
not,
why we're talking about this.
we
The
shouldn't
whole
be.
record came in. It is in evidence. It is fair game. Okay? All right, that's what we're doing.
With respect to the sealed record, I just like to rely on my written pleadings.
Okay, well, you probably are, but I'm going to make a record of those because privilege, there are
There are
privileged
sealed pleadings
conversations between the shooter
and
Yeah, I
sealed
think they're
decisions.
regarding-
Is that what we're doing?
Yeah, it's regarding Ethan, I'm pretty sure.
and I'm going
Okay,
to
so we have no idea what's going on because everything's sealed. That's great. That's very helpful.
Yeah.
This legal education is brought to you by nobody because no one can talk about what's going on because we have no
yeah,
idea.
Throwing everybody out.
Yeah, they're gonna toss everyone out except for the parties and address something on the sealed record, probably having to
This
do
will
with
be
the
on the
minor and his
Oh, yes.
mental health records, most likely.
This-
But-
this-
We have no idea because we're gonna find out. there was a motion before trial to admit Ethan's medical records that were used during his Miller hearing, and those were granted. But those were also granted at the time when Ethan was going to testify. So now I think there's a privilege argument. I think Ethan's counsel is now here to argue because they filed an interpleader to exclude his medical records as well as to impose the Fifth Amendment. And I have a feeling that's what's going to be argued right now. Just looking at the court record, there was a bunch of interpleader filings and responses to those. So that's most likely what's going to be argued right now, not off the record, on the record, but so that we can't see, because he's technically still a juvenile.
Is he?
Yeah, he's only 17. He hasn't been
tried as an
emancipated.
adult, so we get it both ways.
Yep, get it both ways. Yep. And so everyone in my
Mhm.
chat, or not everyone, but a lot of people are like, well, how is he tried as an adult and still holding the parents accountable? The trying of it as an adult in Michigan just says that instead of going into the juvenile, we're going to try to redirect him sort of approach, we're going into the punishment approach for this violation of law. And it's an option if the juvenile commits anything that would amount to a felony. So they can still charge him as a juvenile and sort of redirect him with therapy and counseling. Whatever.
I agree with the confusion of the chat. I understand the principle that we're going to charge him as an adult, but as the judge said earlier on a different issues, like you can't have this both ways at the same time. If he's an adult, then he's an adult.
Yeah.
Well, get this. So the prosecution argued during the Miller hearing that this was 100% on Ethan and that his parents essentially were not to blame when it comes to Ethan's punishment. And now they're arguing contradictory to that in this case. That's partly why I wanted to watch the Miller hearings to see what their arguments, their position was going to be.
I wish they could take that in as an admission from the prosecution.
Is there some sort of collateral estoppel issue in there where you can argue the prosecutor can't argue both because collateral estoppel?
I was going to look into it and I never did, but I would hope that the defense counsel would argue that, but I never saw it come in as an argument in a motion or anything. So. I would imagine it would be a collateral estoppel issue, but I never researched it under Michigan law, so I don't know.
Yeah, I mean it's the same fundamental thing. You can't argue both things at the same time. Once you've argued one, you're stuck with it. And this is a collateral proceeding. I mean, it's related to the same underlying facts. So I view it as collateral, and therefore you're stopped. You can't take position 1 minute and then take exactly the opposite position the next.
And it's the exact same two prosecutors too. It's not even like it's different prosecutors out of, if you want to make an argument about that, the representation, whatever, but still at the end of the day, it's the same party. It's the state.
Right. The prosecutors are irrelevant, but to the extent it's relevant, then you got that too. Yeah.
Yeah. What is the reason for having a different judge at the preliminary hearing? So a preliminary hearing is at the district court level. When you're being charged with a felony, the local city court kind of thing determines whether or not there's probable cause that there's been a felony and that the defendants are the ones that committed it. And then you get bound up to circuit court, which is where we're at now, who will actually hear the case. So that's how that works, because we don't really use grand juries in Michigan. So that's the procedure that we have.
Okay.
Please explain how Jennifer Crumbley was charged as an adult when she acted like a petulant child.
That's funny.
I like that. That's a good one.
Yeah, but two different crimes, yes, but one is dependent on the other.
Yeah, I mean, it is technically different parties, but still, I mean, it's still the underlying same event. I feel like there's got to be something in there somewhere.
I feel like that too. And then as I was kind of balancing it out, I'm like, well, parties are allowed to plead in the alternative, even in criminal cases. So
in some states they are. Are they in Michigan?
Yeah, you can plead on.
So they were actually arguing both at the same time, and therefore it's not stopped. I love it.
Yeah.
Okay,
yeah,
that's good.
So yeah, so that's allowed too. And I was just kind of like puzzling it out in my mind. I didn't do any of the research though. That I probably should have.
So yeah, so they were in the prior case saying Ethan is completely responsible. Also, Ethan is not completely responsible, and you can argue both, even though they're mutually inconsistent. Love it.
Yeah.
That the feds allow that. The feds allow that too. Mutually inconsistent pleading. Yeah, it's this and also not this at the same time.
Yeah, isn't that nice? Well,
Yeah.
we had an issue with that Georgia Supreme Court with inconsistent positions on like insanity and not insane at the same time, committing the exact same act that resulted in 2 different crimes.
Yeah. Somehow. Yeah, that makes sense. I'm not sure how it makes sense, but okay. I mean, I understand how at least hypothetically you could be insane in one moment and not the next. So if there's any difference in the crime or any difference in time, I mean, hypothetically you could split the difference. But if it's literally the same exact event, it's a little bit hard to say how you can be insane for one and not the other. But I remember reading that Court of Appeals decision too, and they're apparently okay with it, so no problem. Although I suppose in some ways it does parallel the Supreme Court's decision when it comes back to the idea of mutually inconsistent verdicts generally, because the feds have dealt with this before. The most obvious example I can think of is when it comes to felony murder. So, for example, felony murder is the death that occurs during a felony, usually an inherently dangerous felony. So the convenience store robbery is a classic example, right? We're going to go rob the convenience store. Someone pulls out a gun. Someone dies. Felony murder. So logically, you need conviction on the underlying felony for it to be felony murder, because that's the thing. But it has been known to happen occasionally where the jury will say, no, there wasn't the underlying felony, but yes, felony murder. And even though that doesn't make any logical sense, the Supreme Court of the United States in such situations said, yeah, we're good, no problem, that's fine. Because we don't know what the jury was thinking. We don't know if it was a compromise. We don't know if they were trying, we don't know which is inconsistent with the other. So we don't know what to do. And so it's fine, no problem, it's all good. The law's a strange place sometimes.
Yeah, I just don't understand how. I mean, I get the idea in civil cases, certain civil cases, like say unjust enrichment and conversion, where you're like, okay, it's essentially 2 sides of the same coin, different theories, where somebody stole money from you, and as a result, they were unjustly enriched, right? I get that with certain civil things, but not in this sort of context. Either you did this or you didn't do that, Can the defense call the doctor that assessed Ethan's mental health? That might be actually what they're arguing over right now, because there's a big thing regarding the mental health issue. So, but we don't know.
Yeah. Okay. I'm very confused. But then the law doesn't always make sense to me. The law is a strange place.
Well, it's hard for the law when they're trying to create new law in the midst of a trial.
That too. Yeah, we're literally trying to create a brand new criminal cause of action before our eyes. That's fun too. That's good.
Yeah, they're just kind of throwing everything up in the air and hoping that it lands, or at least the state's hoping that it lands on their side.
Yeah, I asked I had a Twitter poll the other day where I asked, would it be the same if Ethan had used a car or a knife or a frying pan? Why is it important that he used a gun if the end result is the same?
And sort of backwards from there, which is where I've sort of raised the issue. Because we live in a common law system in the United States, this is a brick in a wall. And where does it go next is always a relevant question in the United States. It's not so much, slippery slope isn't so much a fallacy as a reality in the common law system, because things never really stop. And so where does this go with respect to other crimes and other parents, particularly, by the way, because parents do have an affirmative duty with respect to their children. They do have an affirmative obligation to clothe them and feed them and keep them warm and all kinds of stuff. So hypothetically, you could charge a parent for not doing things that caused the child to commit a crime. So just as a random hypothetical, if you had a parent who knew their kid was in a gang, for example, then now they didn't do anything to support it, but they knew it. And maybe they knew, for example, their kid dealt drugs and knew that there's drugs in the house or guns in the house or whatever it is. Maybe the failure to act is sufficient. Maybe the failure, even if they don't know those things are in the house, maybe the very fact that the kid is in a gang and that would inevitably lead to violence, maybe the failure of the parent to take steps to prevent him from being in the gang any further, maybe that's sufficient. And I raise so it raises all kinds of fun and exciting questions. And this is where my prognostication powers run out, because although I like to think I'm reasonably intelligent, I can't foresee all ends. And this is where I don't know what happens next.
There are so many unknown ends as a result of this conviction if it happens. like you just said. And the problem I have is that what you're setting up is, so within this theory, right? First, they would have had to have known that there was an issue. Let's assume they knew that there was an issue, right? There was a danger out there. Their child posed a danger, and then failed to take reasonable steps to prevent it. Okay, what does that look like? Is that getting him counseling? Is that pulling him out of school for that one day, and then he goes back the next day and does it, right? We assume that the crime happens at some point. The shooting happens somewhere down the road. So they get him counseling. Well, do they get him enough counseling? Is he going as often as he should? Is he getting medication? Did they forego medication, which is a parent's right, in lieu of alternative therapy and things like that? Essentially, what you're setting up is the state can say, after the fact, mind you, you didn't do enough. We're not going to tell you what you need to do ahead of time, but after the fact, we're going to say you didn't do enough. And
You're basically winding up into a strict liability universe. The bad thing happened, therefore you're responsible. Don't you know it's inherently dangerous to have children? Lol.
Yeah, and which is interesting because this court ruled that you can't have the hearing that we listened to about what do you call it? The pathway to violence. It's inadmissible, but that's the prosecution's theory here. That the parents should have known that Ethan was on a pathway to this.
It's actually slightly worse than that. It's slightly worse than that if you take the Court of Appeals at its word. Because what the Court of Appeals literally wrote was that it was reasonably foreseeable that the parents could have foreseen that Ethan was going to commit a shooting on that day. So apparently what the Court of Appeals thinks is foreseeable is he was going to shoot people on that particular day. And to me, that seems like an awful lot of foresight.
Yeah.
They said it at the same time. They said it twice, by the way, in that opinion, just for the record.
But so we have the foreseeability part, right? Which is the known part, right? But then you still have to take reasonable care. So you're talking about an hour and a half to 2 hours. What's the reasonable care that could have taken place within that 2 hour window that would have alleviated this criminal liability? Colorado may as well. Wait, what is this? Thank you for the $1.99 super chat.
And also, somewhat relatedly, how many warning signs do you need as we're trying to split the difference between the school and the parents? Just how many warning signs do you need before you have some obligation to foresee?
Right. Yeah, and they have the school counselor up there saying, okay, you have to go to work. No problem. We can keep him in school. But they're not liable criminally because they have immunity or whatever it was.
Well, they couldn't foresee it because they couldn't foresee it because they didn't know enough. If they'd only known more, when the parents knew enough. So I suppose the question is, assuming both those things are true at the same time, which I'm not even sure is a premise I grant, but let's play. Where's the line in between? Where's the line in between? How much do you need to know before you're liable? If what the school knows isn't enough, just how much more additional things do you need to know?
Yeah, and if a school counselor and the other person says, well, are you as a parent, are you supposed to, okay, they must be lying. Or do you believe them on their word? And because they have this absolute defense in, it doesn't matter, we're immune for criminal liability. Or no, civil liability. And the prosecution won't charge the school or the counselors.
Yep.
Because it's the parents' fault for listening to the counselors.
Apparently.
I am shout with the $5 super chat. It becomes the end of society because it leads people to stop having kids. No one wants to be charged with another's crime. There's still going to be people out there having kids, unfortunately, but they're going to be the type of people that would get committed or get convicted for other people's crimes. But it leads the intelligent people to not have kids. That's for sure. I say homeschool them. That's the key.
Well, that's criminal because you failed to get your child sufficient socialization. That's why he acted out criminally and shot up the park.
Oh,
don't you know?
Right. Yeah, damn it. Yeah. But it goes beyond. Like somebody said,
you tell me what the reasonable steps are. You tell me what the reasonable steps are, and I'll play prosecutor and tell you why it's not reasonable.
Well, someone said lock up all your guns was like rule number 1. Okay, so the kid takes the kitchen knife. Now what? Is the parent responsible? They didn't lock up their kitchen knives.
Yeah, but he took the car keys and plowed into a mall.
Yeah.
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 So yeah, no, all of this is absolutely ridiculous. Homeschooling does not equal no socialization. That's true as a fundamental rule, but we can't know for certain that you got enough socialization if you're homeschooled because you're not out amongst
Hey,
kids every day.
I'm the prosecutor. I say it's no socialization. You prove the opposite. That'll be good. Yeah, go with that. Let me know how it works out.
What a mess. Let's see here. Sorry, I'm just pulling. I'm just to see if I got this.
You
email
know
back
where your
in.
children are. I mean, every decision can be looked guilty in retrospect, and we've seen prosecutors do exactly that with a lot of things. Oh, you used Full Metal Jacket. Of course, that was reckless because you wanted the bullets to overpenetrate. Oh, you used jacketed hollow point. Of course, that's reckless. You wanted to cause maximum damage. Oh, you loaded your own ammo. Well, that shows foresight to commit murder because you were planning it all along, don't you know? Oh, you did. No, there is no right decision. This is what you guys don't seem to understand or appreciate. And there's any number of prosecutors that do this. Oh, you killed this person, after a long period of cooling off. That shows how cold-blooded you are. Oh, you killed this person immediately. That shows just how violently tempered you are. There is no right decision. Everything will be held against you. There is no right answer.
No.
Everything's screwed. You're done.
Oh, you as a parent, you like wearing camouflaged cargo pants? That means that you're teaching your kids how to hide.
Yeah, that's right. Give me a couple minutes. I'll figure out how not.
We didn't even know to go to read.
Yeah. Give me a couple minutes. I'll figure out how not buying them camo is a sign of recklessness.
Yeah,
we didn't even need to go that far in this case alone. For the whole fleeing thing. The witness, the police officer witness said, yes, I told James and Jennifer. First of all, they didn't want to give up their phones because they didn't have the phone number. So I gave them a pen and paper. They could write them down. And then they happily gave up their phones on the warrant. And then I told them to go buy burner phones as an alternative, a track phone or whatever.
Right.
And
then they did that. And that makes them more guilty.
Exactly. That makes them more guilty. Yep. And the prosecutor's next witness. Well, they had these track phones. They must have been on the run. It's just, there's nothing you could say to the police. There's nothing that you don't have to say to the police. They're going to use all of your normal things against you.
Well, as always, as ever, I will continue to remind you the mantra, I want to remain silent. I want a lawyer. Because the MLS is not wrong. They're going to use everything else, every other possible way. But why give them one more things? In particular, by the way, of course, words from your own mouth are juries eat that shit up. So you say it from your own mouth, you're toast. So it may be true that this is not like keep your mouth shut, therefore you won't go to prison. I'm not saying that. I am saying open your mouth, you're going to prison. So keep your mouth shut and hope for the best.
It's exactly right.
Yeah,
the court is still
Yeah, well, they're on break for 40 minutes. They're on lunch now.
Yeah.
Oh, okay.
And it's always easy for another part to say these people to say, no, you did wrong. An example, what was it? San Francisco said, oh, we are, what do you call it?
Sanctuary city?
Yeah. Okay, said the other states and started busing people there. Oh, no, you keep
not
that.
Like that.
Yeah,
I do like New York and Chicago being not like that, and they're trying to sue people for sending people then that way. It's like, but they won't admit they're wrong. They won't just say we were wrong. So that's hilarious.
Kurt, I wanted to ask you, did you see the part where they were basically saying Jennifer refused to ask questions until she was with an attorney? They talked about that in this case. Don't you believe that it'd be a violation of her Sixth Amendment right?
Well, I don't know for sure because I thought on the portion I saw, she phrased it as a question. She said something like, don't you think I should get a lawyer or something like that? I don't think she said, I think James Crumbley said it more definitively, but I thought that Jennifer Crumbley stated it more ambiguously. Am I wrong about that?
It wasn't the police interrogation part. It was in the police car, I believe. I might be wrong though. My mind's a blur in this case at this point.
And it would also depend, of course, if she kept saying things after that, because you have to actually, when you want the right to remain silent, you have to do that. Because if you start volunteering things again,
Mhm.
Yeah, that's a real problem.
Yeah.
So she might have said, I want a lawyer, and then
Mhm.
kept talking. And that doesn't work either. Yeah.
Yeah. In my opinion, as long as if you say the word lawyer, and as long as you don't say I do not want a lawyer, then you should have a lawyer, no matter how it's phrased. But
I'm not saying
that's
you're
not
wrong.
the
I'm just saying
standard.
that's not the law in the US. Apparently, it is the
Yeah.
law in Canada. Apparently, any ambiguity, the police do have an affirmative duty to clear up. So that's nice for Canada, but welcome to the USA. What can I tell you?
I thought Canada
Yeah.
too also you had to make a affirmative statement of some sort. I thought I heard on one of Ethan's streams recently.
Yeah,
Like,
you have to make.
Yeah.
I think you do have to make an affirmative statement, but you're not
Yeah.
allowed a lawyer in the room no matter what you say, which is kind of funny. So that's fun.
Yeah.
So you can talk
And
to a lawyer, they just can't be in the room with you. So you go consult a lawyer, and then you come back and you open your mouth. So that's great.
Can you bring in the piece of paper that your lawyer wrote out for you? Say this and only this.
Just hold up the sign. Just hold up the sign.
Exactly. Yeah.
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 Tape
but
it right to your forehead.
Yeah. I don't remember the phrase "I want a lawyer, dog." How was that ruled?
That case was wildly misreported. The lawyer dog case was wildly misreported. If you actually go to the judge's decision, see what he said, it wasn't about the lawyer dog. It was because he asked it as a question. What he actually said is, I'm going to paraphrase it, but I'm going to get pretty close. He said, if you all think I'm guilty, then maybe I should get a lawyer dog. And that's not a request. That was the basis of the judge's decision. He didn't actually say, I want a lawyer dog. He said, maybe I should get a lawyer dog, and that doesn't count.
See, that's the same thing
thank
that Zach Anderson ran into. And now, first of all, he talked for an hour before he even mentioned the word lawyer, but he was like, either take me home or get me a lawyer. He gave him an option. And they kept asking him questions. And he was like, all right, I want a lawyer now. And then they stopped.
There you go. Exactly.
But it took him an hour and a half to get there, unfortunately.
All you have to do is state it. But any ambiguity, do you think I should get a lawyer? Is it a good idea if I get a lawyer? What do you think? Is a lawyer nice? Lawyer? Like any sort of ambiguity.
I want
the Supreme Court's
a lawyer.
That's what I say. That's what I say.
Yeah.
I tell my channel all the time. Meditate to it. Use it as your mantra in meditation. I want a lawyer. I want to remain silent. Just that, only that. Don't alter it. Don't say other words. Don't add words. Just that, please. That'd be great. And if you feel that urge deep inside that you feel like you need to say something, just say it again. Just repeat it. The lawyer, your future lawyer thanks you.
And don't even phrase it as "I want a lawyer," because that can be construed as a question. I want a lawyer.
Yeah. No.
So somebody said that Jennifer wanted to homeschool because she didn't want to spend much time with her kid. Let's assume she doesn't want to spend that much time with her kid. Kurt, have you heard any evidence in this trial? I don't know how much you've watched, but
I've watched it all.
Okay. Is there any evidence that one, she knew, and two, she failed to take corrective steps?
Not as much as I would like. No, not really.
Okay.
No, there really is no great evidence that she knew because we have statements that really don't go to that level of depth. There's really not sufficient information, in my humble opinion.
Now, do you think, despite that, the jury will
saying that?
Yeah,
oh, yeah.
No, that's true.
No, absolutely. The defense's burden is to prove innocence. No doubt.
That's my thought. And that's why she has to take the stand. Not only because it was mentioned in opening statements, which, by the way, please never do that. Please never say that your defendant is going to take the stand.
That's really not a great idea.
But now she has to take the stand. Not only because of that, but I feel like, and sitting through jury voir dire, I even thought the same thing. Just where the Q&A was going back and forth with the judge and the attorneys and the jurors. I was like, this woman's going to have to take the stand. Okay, so Robbie with a $9.99 super chat. Thank you. Do not discuss your day. Do not provide any information beyond your name, address, etc., etc. Ask if you're detained or able to go free. If free to go, leave. If detained, ask for a lawyer and shut up. Not legal advice, but that's pretty good.
I generally agree that you should give your name, notwithstanding any law to the contrary, because you'd give anyone your name. So why not? I mean, if any random person said, "What's your name?" I presume you would tell them. So why not tell the police? Because what does it matter? And yeah, and other than that, I tend to agree. Yeah.
Yeah, generally, if somebody asks me for my name, I really want them to state theirs first.
Well, this statement, by the way, is do not provide any information beyond your name and your address. So
I understood that. I agree.
Yeah, okay.
Name, address, date of birth is fine.
Yep.
Yeah.
Love the panel. Thank you very much for the 2001. I'm assuming that's one, right?
Richard
Yeah, no,
W in chat. Richard W in chat literally says, "I don't tell strangers my name." Richard W, I have bad news for you. You told me your name.
Oh, KPM wants to know if you do probate cases for some reason.
No.
I didn't think so. You do mainly appellate stuff, right?
My practice in the past has been patent law, intellectual property.
Okay.
At the moment, I'm on hiatus, but my love is appellate law. So yeah.
Okay.
All right. We've got a half hour. I'm going to use this half hour to go eat lunch. So
Sure.
I'm going to sign off for now, but I've enjoyed talking with you, and maybe I'll pop in later. So does the link you sent me earlier still work for this afternoon?
Yeah. I'm just going to keep it going. I set up an
All right.
afternoon stream, but I don't think I'm going to kill it. So.
All right, great. Well, I'll talk to you guys later. Love you lots.
All right. Take care. Thanks, Kurt.
All right, bye.
Take care. Bye.
You can see he was getting so frustrated in chat. He's like, "Give me a link." Yeah, he needed to vent a bit. It's a very frustrating case. I'm frustrated by it for a number of reasons, notwithstanding the defense's approach to this case, but also definitely the state's approach.
Yeah, because they are using Ethan's statements and words and actions against Jennifer, which means she has to prove innocence towards somebody who now can play the fifth. And I
You have the right, fundamentally. It's in the U.S. Constitution and it's in the Michigan Constitution, probably all the other state constitutions. You have the right to confront your witnesses against you. They're using the journal and Ethan's text messages against Jennifer Crumbley. How, at a fundamental level, despite the court rules, despite the hearsay rules, despite all this other procedural bullshit, how is it fundamentally that they should be able to do that when she cannot cross-examine Ethan? And so on a fundamental level, on a fundamental constitutionally protected right, those exhibits should not come in. If they are going to come in under some bullshit exception, then the defense should be able to cross-examine them with the very same document. If you have documents that contradict themselves, such as this journal, they should be able to do that. I agree maybe with the judge's opinion on the I better not get caught or I won't be able to pull off the school shooting thing. If he's referring to the bird torture thing, then okay, fine. We don't want to open the door to that. But the other one, which is I need to find where my dad hid the gun, I don't think that should be excluded for any reason.
No.
Now, I'm hoping. What's that?
No, because if that is written simultaneously with the other stuff, then it can be limited to that part alone without bringing in the rest, because apparently it's okay for the state to limit what's been brought in from the journal. Then so should the defense.
Right. I have to give a shout out to my brother. You guys might have seen him in the chat, but he went by Zingerman's. And if you guys know Michigan and Ann Arbor, you know Zingerman's, and brought me a sandwich. So thank you for that for lunch today. So I don't know the case that the judge was referencing, but apparently there's a case in Michigan that says it is highly prejudicial to have a witness appear on the stand in front of the jury and say, I plead the fifth. So prejudicial that, in fact, it will lead to a mistrial because the jury
That's weird.
Unfavorably tainted. There's no direction. There's no jury instruction that could be provided to the jury that could correct this highly prejudicial thing. And
But
that's all.
I mean, it's a constitutional right that you can't hold against them. That should be it.
Yeah. So
I mean, that goes back to
I
the
haven't-
Constitution.
I haven't seen the case that they're talking about. I have to imagine that the logical leap that the court made in that case was if the defendant was forced onto the stand to sit there, the defendant, as the one charged in that case, and say, I plead the fifth, that would be highly prejudicial and would result in a mistrial, right? We can all agree to that.
Yeah.
The defendant has a right to not testify. And so just sit there and say nothing, and you can't hold that against them. But if you make them get on the stand and say, I plead the fifth, that would be highly prejudicial, and you can see where the court would declare a mistrial. Now,
Yeah, but there's workarounds around that, and we saw that in the Depp case with Waldman. Under advice of my attorney, I choose to not answer this question. You don't have to say I pled the fifth.
Yes,
If that answer is the yeah, but if the answer in itself is the prejudicial part, then you can tailor your answer.
I'm not saying that it's the right decision. I'm just trying to think logically how the court would have gotten there. So then if it's highly prejudicial for the defendant to do that, maybe it's highly prejudicial for a co-defendant, right? A co-defendant. Two guys rob a bank. Co-defendant to do that. Okay, so now we have co-defendants. We're wrapped up in this. It would be highly prejudicial. And then that extrapolates to another case where they call a witness that's not necessarily a co-defendant to plead the fifth. Well, that would also be highly prejudicial. I'm just sort of kind of taking the logic leaps as to how we got there. Still think it's a dumb ruling, but
yeah. But in this case, the person's words are being used in the trial, and it's a as we have said it already, but I can repeat it. It is, to my understanding, a fundamental right for a defendant to
confront their witness, confront the witnesses against them.
And if they can't put him on the stand, then you should confront it with the written word. In this case, the journal, which in part is already let in under some rule. Yes, but then you can limit the impeachment with that specific part of the journal.
And the other thing is that if the witness or whoever, the defendant taking the stand and pleading the fifth, would be highly prejudicial towards the defendant, you obviously would want to exclude that. But if it's highly prejudicial in favor of the defendant, wouldn't there be like if we're going to err, let's err in favor of something that might be beneficial towards the defendant rather than the state? And I see not allowing Ethan to testify at all is highly prejudicial towards the defendant. So if we're going to err, let's make it in favor of the defendant.
Yeah.
Jojo with the $10 super chat. I am so glad David's streaming this trial for a homeless internet lawyer. He's pretty good at breaking it down for us. Thank you very much. Yes, I am a homeless internet lawyer. I appreciate that very much. Best troll I ever had. What's his name? Kevin? I think Kevin. He needs to come back. So Ethan's attorneys filed a notice. It's in there. I can't get it, but filed a formal notice of his intent to plead the fifth, and that is the public record. Well, actually, I could get it. I just don't have it.
But does that predates? When was that filed? Was it before or after the decision from the judge to let parts of the journal in? Because
it was after. It was after, but it was a day before the trial was to start. It was Monday before jury selection on Tuesday.
Did the defense file a motion to exclude the entirety of the journal then?
Yeah, so the defense filed a motion to exclude the entirety of the journal. The state filed a response saying we want at least these 5 things in, whatever they were, under the 803.1. And the judge decided that it's a present sense impression, even though it's not, in my opinion. When Kurt has a hard time rationalizing something, I'm going to go with Kurt.
That's a horrible decision. That's a horrible decision because present sense. Okay, how immediate does that have to be? Is it 5 minutes? Is it an hour? Is it a day? Is it a week? Where is that limit?
Well, so the court rule makes it clear that it doesn't have to be a recording made immediately upon the present sense, but it does have to be in contemplation of what you were thinking at the time. But what you were thinking at the time, the you in there is the witness on the stand.
Yeah.
Ethan's not on the stand. So it doesn't apply, even if it was a present sense impression. But it's not, because he's talking about what he plans to do in the future, not what his sense of the situation is right now. I'm lonely. If you wrote that down, that would be a present sense impression if Ethan was on the stand.
Yeah.
Not anyone on the stand.
Yeah, that's a bad ruling from the judge. And even if she doesn't, I mean, nobody in that, except maybe the defense, wants a mistrial.
Yeah.
But that's irrelevant, because if you F up as a judge with a ruling and you now realize it, which I assume she does, then she should have the integrity as a judge to say, I fucked up. It's a mistrial.
So Robbie with the 199 super chat asks, what if you didn't know the witness will take the fifth? So if you generally don't know, then we come to a few issues. All right, so let's assume the witness pre-planned to take the fifth, but didn't tell anybody, and then gets up on the stand and was like, I'm pleading the fifth, I'm not doing it. The problem runs is that if he doesn't have advice of counsel. So if he doesn't have his attorney show up with him, then that's going to be a problem that the court's going to have to address. And the witness actually might be found in contempt of court for kind of like backhanding this whole thing and pre-planning it, right? He knew before he walked in that he was going to plead the fifth, didn't tell anybody. That could be contempt of court proceedings. If he has an attorney with him and he's advised by that attorney that he's going to plead the fifth, that attorney should have an obligation, I think, have an obligation to inform the court so nobody would know. What you generally see is something similar to if you go to the Zachariah Anderson case when OA was testifying and they were asking questions and she started to answer stuff that might be in the realm of things that we don't want to divulge, whether it's the fifth or something else. The court then stops and says, all right, hang on a second, stop answering the question, removes the jury, and then appointed her an attorney to go speak with. And then they came back and then they had proper guidelines. That's generally what you would have. But if it was bad enough, they'd have to order a mistrial at the end of the day.
Oh, by the way, the judge in the Young Thug trial set a new record today. He was 1 hour and 50 minutes late starting today's. Yeah.
It's ridiculous.
20 past,
so you're going to stream a half hour of trial?
I'm going on at around 5:30 with my recap of today. But here's the thing: if all I got was a half an hour before lunch, then I can do everything tomorrow instead, both today, because it will be a 20-minute stream this afternoon.
Is it Segan Rose? Am I saying that right? With a $10 super chat. Thank you for covering this, David.
Sure. I trust your pronunciation, Dave.
I'm always good at my pronunciations.
Yeah.
Thank you very much for the $10 super chat. Kyle, that was his name. Kyle needs to come back in my chat. He was awesome. He's the best troll I've ever had. What is the judge doing? Is she trying to set? No, the judge isn't trying to set up anything. The judge, I know this judge. I practice in front of this judge. She's not a lazy judge. She's a very considerate judge. She's a very fair judge, in my opinion. I think she's made rulings that are fair on both sides. I don't agree with some of her rulings, but I believe that they were measured and were in the best application of law that she found. Although, again, I can disagree with her and still say that she's a good judge. I don't think she's throwing this one way or the other. She has actually thrown up a lot of roadblocks in front of the state, specifically with their expert witness. She could have very easily allowed the expert witness to come in for the state, which would have been horrible for the defense. But she rightfully, in my opinion, found that the expert wasn't credible. So I think she's trying to be fair, whether you agree that she's fair at the end of the day or not.
Yeah, everything in the courtroom is under a judge discretion. So
Whiskey 77 with $4.99 super chat.
That's not nice, Whiskey.
Here is the whiskey hair plug donation jar. I'm okay with my hair. May you one day have luscious locks. Oh, while milking your horse. Thank you very much, Whiskey. You know what? My hair does what my hair does, and I have never been concerned about it.
Yeah. And
but I appreciate the
I saw this before. I think the case the judge is looking at for the fifth claim is People versus Gens.
Let me take a look at that.
And NM law allows the fifth period, so to me this is odd. Yeah, I agree, because it's well established in Supreme Court decision, pleading the fifth should not be counted as prejudicial in any way. It's just they don't want to answer, and they have the right to. It's a fundamental right, and that shouldn't be held against you. But in Michigan, it does.
Well, let's see what this case has.
Thank you for your $2 super chat.
Yes, thank you,
Robbie. Okay.
Well, that's good. It's overruled. Let's see what it has to say. The court was called upon to determine whether any constitutional or evidentiary errors occurred, and the people called the witness to the stand in two criminal cases, knowing that the witness would assert the privilege against self-incrimination in front of the jury. Court concluded that neither defendant was denied the right of confrontation or the right to a fair trial in violation of due process because no testimony was given by the witness on which they could have been cross-examined. Okay. All right. So I get the theory. So like if your right to confront a witness against you isn't violated because they were never actually called against you because they pled the fifth. And that, okay.
But how does this apply to this case where his words is already in evidence through the journal?
And the mere calling of a witness to the stand, even knowing that he would assert his Fifth Amendment rights, does not rise to the level of a constitutional violation. Court found that the prosecutorial misconduct amounted to an evidentiary error as the prosecutors were armed with the knowledge that the witness initially connected with the crime would claim a privilege, in spite of the trial court's ruling that their privilege was invalid. Finally, adopting so the court affirmed the conviction of one defendant and reversed the conviction of the other defendant because even though evidentiary errors occurred when the people called the witness to the stand in two criminal cases knowing the witness would assert in front of the jury, it was highly probable that the tainted evidence did not contribute to the verdict against the defendant. Okay, I just read a quick summary. I didn't mean the law, but it sounds like it was saying that calling them to the stand when you know in advance that they're going to plead the fifth is prejudicial, and that because you're not calling them to the stand, you don't have a right to call someone to the stand to plead the fifth because they're not actually testifying. So it doesn't violate the confrontation.
But when it comes to these different, the right to confront, pleading the fifth, and you have the rule of completion, and you have the present sense, don't you weigh these rights as a judge?
Yes, you should weigh the rights, but the like the judge said, I'm not preventing you from calling him to the stand. The law is preventing you. What she's citing, it sounds like this case, is that we can't call him to the stand without declaring a mistrial.
Yeah.
Because if he goes up on the stand and pleads the fifth, we know in advance he's going to plead the fifth. So we can't call him to the stand without causing a mistrial. So I'm not going to allow you to do it. So says this 1998.
With that conclusion, that should go towards why did she now allow the journal in, even as present tense? I
Yeah, I want to see. Do I
these
have those?
these two are in confrontation with each other. These two rights, the right
Well, yeah.
to plead
So
the fifth.
if you don't have the witness, I still don't have the motion, Jim. If you don't have the witness, then you can't admit the evidence, generally
Yeah.
speaking.
Yeah. And if the judge has had prior knowledge about the witness pleading the fifth, why did she still allow that in under a different rule? Because that case should have precedent over that rule, in my opinion.
State v. Moore. Let me take a look at this case. State v. Moore. Is this a Michigan case? That's the only one that really matters. Let's see. State People v. Moore. Moore v. State. 2004 case. All right, let's take a look at People v. Moore. Well, the case the defendant was convicted of felony firearms under on review. Each defendant contends that his conviction for felony firearms on the aiding and abetting theory should be reversed because he did not assist in either obtaining or retaining possession of the firearm, citing a Supreme Court decision and Supreme Court overruled
2002 cases, Alpha Fox said.
No, okay. Let me find the 2002 case because that was not going anywhere. That was obviously not the right case. 2002 or 2022?
2002.
Do you have a citation? That might help.
Alpha Fox Adam, how do you have the case number?
Yeah, case number or citation number. Citation number will be something like a 3-digit number and then MISH or MISH app for Michigan Court of Appeals and then another 3-digit number, something like that.
He says 2002. He doesn't have citation.
I can't find it. You said it's a Michigan case, though? Is it a appellate case? I'm not finding it right now off this cursory search. But there's like two. There's State v. Moore, and then there's People v. Moore. There's a few things.
You have People of Michigan v. Jeffrey Moore, 2002. Then you have People of Michigan v. Louis Moore, 2002.
Oh, sounds like family, maybe? Family? Well, in this new era of prosecuting family, you can only, all you have to do is prove guilt of one, and then the others are off. They didn't do anything to prevent it.
But here, this Fifth Amendment statute they bring in, that's an actual defendant. Ethan is not a defendant.
Right.
So
yeah,
does it really apply?
Well, it shouldn't. All right. So this is what the here, let me do it this way.
1977.
Let's pull this up. Okay. So this is the present sense impression rule. And let me widen this out a touch so we can see it all. So the present sense impression, this is 803 hearsay exception, 803.1. Present sense impression, a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter.
But perceiving the event, what then you have to have what does perceiving in this mean? Because it might mean one thing in the dictionary, another thing when in court, in law.
Mm-hmm.
So, but perceiving the event, in my opinion, is when it happens or immediately after. This is a day to a week before.
Right.
So
it's
I don't
also
think
recorded recollection. Recorded recollection, I think, might actually be more appropriate. A memorandum or record concerning a matter about which the witness once had knowledge, but now was insufficient recollection to enable the witness to testify fully and accurately. No, I guess it really doesn't apply.
No.
Although he's not really available. So presumably he's unable.
There must have been other cases that relies on that are similar enough to make the ruling.
Yeah. I don't know.
Otherwise, I don't see
haven't
the
heard of
ruling.
cases. Yeah, I don't either. So, but the hearsay rule simply is, for you who don't know what hearsay is,
there are more. There are also many exceptions to the hearsay rule, so it's not. Can it even be a rule anymore?
A statement is an oral or written assertion or nonverbal conduct of a person, such as nodding your head, trying to communicate information. All right. Hearsay is a statement other than the one made by the declarant.
I think your mic just disappeared.
My mic?
Yeah, in the middle of the sentence, you disappeared a bit. You were talking into a can.
Oh, sorry. I'll try to be more focused in my voice modulation. But essentially, all of this writing by
You have
Ethan,
a voice modulator?
No. Do I sound
No.
really weird? Hang on.
Oh, hi, Mo.
Hey, Mo. All right. I hear noise from the court, and I was wondering if that was affecting my microphone. Is it all better now, or is it still giving you guys issues?
It sounds good now.
And I haven't tried this sandwich yet, Mother. I saw you. It's a curious circus court. I agree. Brent, let's see. I gotta eat my sandwich. I haven't eaten lunch yet. I've had half a pickle and half of I don't even know what I'm eating here. But if you guys ever get to Ann Arbor, check out Zimmerman's. They're amazing. I'm not a huge fan of you of them or Ann Arbor.
Do they have DoorDash to Sweden?
You'll be in Ann Arbor one day, Nicholas, right?
Yeah.
Maybe?
I will try to get to Matsuri in August, and maybe before or after I can. Yeah, maybe before or after I can get up to Michigan.
See, got it.
Oh,
nice big tuna sandwich. They're known for like their corned beef, but this sandwich is huge. This is like 2 meals. Where is T-Bone? I don't know where T-Bone is today. I've seen her in the chat.
Yeah, I've known DoorDashing to Sweden might be an issue because I can't even get the pizza delivered because I live rural.
They say that the sandwich is going to have to go through customs. Zingerman's. Zingerman's. You guys all checking in from Michigan? Zimmerman's. What I say? Zingerman's. Well, I pronounced it wrong if I pronounced it wrong. Zingerman's. Never go to Michigan. Your state sucks. Well, your state sucks more. Welcome, everybody. We've been just killing time here, waiting for the court to get back. Let me make sure all the audio stuff is set up. I can't. I think it was Ken's counseling couch was asking about subtitles. There are no subtitles available on this feed. So I know there's a way to set up immediate subtitles on my feed, but it's not going to help us necessarily with the court feed. I don't think.
I just checked. If I want to drive from Houston to Detroit to Michigan, 18 hours.
Yeah,
that might
I've
be a
done
stretch.
that drive before.
I mean, it could be fun. I mean, it's a 3-day trip. So if I'm taking, I mean, I was originally going. I mean, a week in Houston. I mean, a couple of days before, then the Matsuri convention, and then possibly go home. But if I drive up there, get a rental.
Yeah, everyone seems to be loving the state seal. I like our seal a lot, actually. I don't think it belongs on our flag, though. I don't like seals on flags, but I do like our seal. It's got it's a moose or an elk. I can't remember. It's a deer and an elk, I believe. On the other side, we used to apparently have elk. I ran into a moose camping though in the Huron National Forest here in Michigan. That was fun. There is a way for your feed. There's also a way to do it on the court feed if you use Chrome. I'm not using Chrome. I'm using Edge because I like Edge. But I'll figure it out. There's also another thing that I'm going to be doing. I was going to try to do it before this, which is start using Streamlabs. But I want to do a stream where I'm just playing random videos and inviting random guests on and off to figure out all the settings. And I didn't get a chance to do that before this trial. But once I get that set up, I'm going to be able to really boost the volume quite a bit on the original court feed. So we don't have these real quiet courts, and I can really fine tune our levels. So hopefully we don't even need subtitles because everything's nice and loud for us. So after this trial, I'm going to do a sort of a laid back stream with a bunch of panelists and just play some random videos. I don't even care what they are, just to practice with all these settings. And so that's going to be coming up. I might even try to do it this weekend, and then I can get that going for next week. I just don't have the time to do it while I'm spending 8 hours streaming a trial. Is the defense doing any better? Yes, but not as strong as I would hope. So it's like it's great based off of what we've seen, based on the baseline that we've established. Not.
Now you're disappearing again, at least for me. Chat.
Can you?
How's Dave's?
Nick, I'm going to send you the link for this. Can you operate it for a few? I'm going to restart my computer.
Okay. There. Hold on.
We are absolutely live. I put it in private. So what we're going to do, folks, we're going to have Nick take over controls since he has admin controls. And then I am going to bow out for a second, restart my computer, and come right back to you all.
Yep.
So I'll be right back, guys.
It's my feed now. Hey. I have control. We can still understand. Let's see what's going to happen. How is the defense doing? Well, that's a matter of contention. Here. Dun, dun, dun. Sound is up. Let's see if I can find any. Jen, is the prosecution going to rest in time for defense to start today? Well, this should be the last or second to last witness that is on the stand. So they either they end it or they are going for end of day to get the jury to rest on it. Can't hear you. Oh, no.
No.
Speak a longer sentence.
Oh, sorry. So do I sound better now? This it happens with StreamYard after these long streams. If I go beyond 5 hours, this happens.
Well, now it sounds better, but it all of a sudden it just goes into a can and stuff like that.
I'll just try not to talk so much.
Oh, here we go.
Not really. It's messed up.
Yeah, but
Well,
prosecution going to rest in time for defense to start today. If I were the prosecution, I would try to end of day.
I will be right back. One more time.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good afternoon. We had a hearing that was conducted under seal, pursuant to 8.119. And the court ruled that there is an absolute privilege that is in there that belongs to the shooter. Therefore, none of the psychological or medical records of the shooter will be eligible to be admitted in this matter.
Okay, psych is out.
So none of his records are coming in, huh?
No.
Is this any better at all?
Have sound booster at 300%.
Okay. So none of his records are coming in. None of
The psych records. Oh, David froze. Or I froze. No, I think Dave, you froze.
No. So with none of Ethan's records coming in, it means that the state can't try to show that he had a medical condition.
Yeah,
also
but then
the
again,
defense
defense precluded from showing that they no mental issues.
Yeah.
Lieutenant Lewis was still in the prosecution.
Appreciate you guys sticking around during my technical difficulties.
Lieutenant, you are still there, okay?
Yes, Your Honor.
Go ahead.
Hi there. You were testifying that on December 1st, I believe you said you got an arrest warrant for Ethan Crumbley, correct?
Correct.
And I'm sorry, for Mrs. Crumbley, for the shooter.
Correct.
And on that date, he was on Zoom for a court hearing.
Yes.
And during that court hearing, Mr. and Mrs. Crumbley participated on Zoom from their vehicles. Is that a fair statement?
Yeah, it appeared they're in their vehicle, but they're on Zoom.
Now, on Friday, you went to the court and did what you call a swear to in this case. Is that correct?
That's correct.
That's when you went in and you told a magistrate or judge the facts that you swore to in order to secure an arrest warrant for Mrs. Crumbley, correct?
Yes.
Now, on that date, you never told and I'm asking if you ever told Mrs. Crumbley, you personally did not tell Mrs. Crumbley you need to be here at the court, correct?
I did not.
And when you were at the court, were prosecutors present?
For the swear to, are we talking about?
Yeah.
I'm not sure. I don't recall.
You don't recall seeing me there, correct?
No.
You recall seeing lots of media there, is that right?
Yeah, there was lots of people there, but yeah. Yes,
Was it media or people?
both.
Okay, so lots of media and people.
Yeah, I didn't know everyone's credentials, but there was people. So I don't know who was intermixed in the group.
And on that date, you secured the warrant. Is that a yes?
Yes.
And the next thing that happened was the prosecutor had a press conference and announced it, correct?
Objections to relevance, Judge?
It's because he has a guardian ad litem that supersedes court
It
appointed.
was on the media in the
We
public
can
domain.
stipulate that it was
Yeah.
him.
Yeah.
I think that's even.
Okay, yeah, you can answer it. If you know.
Can you say it again, please?
Yeah, the next thing was the prosecution announced at a press conference that there was a warrant for Crumbley's arrest.
I don't know that.
after the arrest warrant was secured, you're aware that a search was started from fugitive apprehension teams, U.S. Marshals, Border Patrol, to find the Crumbleys.
I'm not aware of that.
You're not aware that there was any kind of search?
No, that's not true. I was aware that there was a search that I directed our fugitive unit to conduct.
Okay, so you were aware that there was an outstanding warrant for Mrs. Crumbley,
Yes,
and you were aware that there were going to be efforts to locate Mrs. Crumbley because of the warrant.
yes. If I recall the swear to, the judge said the defendant had, or her husband, the defendant had to turn herself in by 4 p.m.
And there's
that day.
Okay, and defendants can do a variety of things. I believe we've already established this in trial. They can drive around in their car with an outstanding warrant and end up getting a ticket and taken into custody, correct?
That can happen.
They can go to the police station and turn themselves into police, correct?
Yes, that can happen.
They can have a lawyer make arrangements, set up a time and go to the court to turn themselves in.
Yes, that can happen.
Okay, so there's a couple of different ways that a person can come into custody, correct?
Yes, there's several ways.
I have no further questions.
Just briefly. That hotel in Auburn Hills where James and Jennifer Crumbley stayed, how close is that to the Auburn Hills Police Department?
I don't know exactly, but it's like right across the street. It's very close.
Okay, nothing further.
All right, you can step out of your excuse.
Easy enough.
This is next one.
Maybe we have no more questions?
Sure.
Oh, they better call Megan Amirowitz. They forced her out of the courtroom. And if you guys don't know who Megan is, she is a young lady who was convicted last summer of unaliving her father. Very nice girl, though. It was completely accident sort of thing. And she became friends with Jennifer in jail.
Arrest, but before we do, I just want
Wow.
to make sure the court's exhibit list reflects the same as the people's as far as initial evidence.
State forced her out of the courtroom, saying she was a witness.
Following along too, right?
Yes, I have my offices.
I'm going to
So I'll
send
go page by
Megan
page
a
on these
link.
here. Every exhibit on page 1, it's 1 through 30. Every exhibit on page 2, 31 through 59. Exhibits
Arrest
60
at
through
12:50
76,
on day 6.
and then 78 through 94. That's on page 3.
You've missed so much, Jung.
So they arrested.
All exhibits on page 4. That's 95 through 122.
Yep. State has rested.
Okay. So they forced her out as support with no intent of calling her.
I have 112 as amended. Yes.
Yeah. And what I was saying is, Valhalla, is that the state put her on the witness list and kicked her out of the courtroom under sequestration orders. To my knowledge, she was the only one for like emotional support for Jennifer in the courtroom. And they said that they intended to call her.
Yeah,
Exhibits
that's slimy.
164 through 169.
They could call her on rebuttal. That's true. I won't send her a link.
171
Okay.
through 179. Exhibits 183 through 186. Exhibits
Surprised
188
Valhalla hasn't figured out a way to
189.
whistle his way up on the panel and stream to his channel.
183 through 186.
Everyone else has Joe, Kurt.
188 through 189.
I don't. Maybe I should.
Exhibits 191 through 205.
You have 187 now.
Correct. So we have 188 and 188. Two
Yeah.
they are admitted. 191.
If I go to Matsuri,
205.
everything included, it's about
Exhibits 210.
airfare, hotel,
213.
ticket to Matsuri, the event
Exhibits 215
is roughly around $2,000. If I rent a car and drive up to Dave, that's another $700
I'm only identifying.
I'm worth it though.
plus gas.
Um,
Yeah,
I'm worth it though.
not 215.
That's the part you're forgetting.
yeah, exactly.
It's a cost
And-
benefit analysis.
Yeah,
Exhibits
and I
216
plan to
through 223
hold a
are admitted.
24-hour stream in March or April,
Exhibits
ask
231 through
yeah, to support it,
239
which
are
I should,
admitted.
I think.
Exhibits 242
No hairbrush
through
in jail.
247 are admitted.
They're just talking about exhibits. That's fine. We don't need to listen to this. But the
Thankfully, we have Ms. Nally here.
no hairbrush in jail. I wanted to address this. So Oakland County Jail is close by, but they wake everyone up really early when they got to transport them to court because they're not the only prisoners that's being transported.
248 was admitted.
So they wake them up, and then everyone's got to get dressed and ready, and then they usher them into a holding cell.
We're all
Then they
admitted.
put everyone onto a bus. Then they drive them over. Then they sit in the basement of the courthouse in a holding cell,
284.
and then they bring them up. It's not like they're just freely coming and going and can groom themselves. They're not allowed to have any brushes or combs with them on transport.
272
The
was
lawyer
admitted.
can't give them anything.
And then
So
278
she brushed her hair at like
284.
4:35 a.m. this morning.
This is what I do this. 285 through 291 were all admitted.
How sound do you hear also with the court?
296 and 297. 285 through 291.
I'll be loud. Oh, my automatic settings
282
were.
was admitted.
I changed my automatic settings.
296 and 297 were
Okay.
admitted. Exhibits 300.
Prosecuting
through
attorney is
309
a
were all
public
admitted.
official. You can write to her.
Exhibits 316 and 317 were admitted.
Get an electric car, Nick.
Yeah,
Exhibit 340 through 345.
I can get
were all
a Chevy Spark for 6,600 bucks.
347 through 357 were all admitted. As were all exhibits through 388 on the next page.
No, don't threaten them.
89
Don't threaten her. I didn't say that. I thought you just said like write her a letter saying you don't like this.
exhibits.
Express your
408,
disdain. Yes.
409
Don't
were
send
admitted.
threats. No.
411 was admitted. 413 through 423 were admitted. Exhibit 426 was admitted. And then we identified two items as
Somebody in
demonstratives.
chat was like, yeah, send her a threat sarcastically. And that's why I was emphasizing, no, don't send threats. I know it was sarcasm in the chat. I just wanted to emphasize that.
135, Judge, we can go back to that page, please. That was not it. I just want to confirm
Okay,
that it's
I'll
correct.
update the Discord link right now.
135. That was not admitted.
Not admitted.
Thank you. And Judge, the two demonstrative exhibits that were just identified for the record, 427, 428.
Ooh, I could get a Ford Mustang convertible for 900 bucks.
Okay.
My son insisted on renting one when we were in.
Yeah, it's not a good car for long travel.
All right, so,
We were in Tampa.
um,
All right, we'll do it.
Your Honor, I believe at this point, the court needs to excuse the jury for a moment.
Yes, motion for directed verdict.
Or a Dodge Challenger for
Or if you want to do just
1150.
whatever you want.
okay.
I don't have
That's a
friends
good-
that are streaming this.
Yes, okay, that sounds good.
Oh, that know I am streaming this. Yes, I do.
All right, well, I might excuse the jury for.
Oh.
Yes, sir.
I'm gonna excuse you for a minute, okay?
All right, the jury.
Like 5.
I've heard a lot of bad things about trains in the United States.
I have attorneys that are like opposing counsels on my cases, calling me, asking me how the stream is going, how the trial is going. Defense counsel knows that I'm streaming. The prosecutors know that I'm streaming. The judge's staff and the judge know that I'm streaming.
Motion now, if you wanted to, I guess I would indicate, I think it's a policy of the sheriff's department to have someone stand close to the defendant. Is that correct? So I guess I would like that to occur outside of the site of hearings.
Oh, you mean like here?
I think that they're going
That's
to
fine.
require that a deputy stand here, so rather than make that obvious, I would invite the jury to have a seat and have the.
She's within arm's length reach of the jury.
Can she go up there now?
Sure, unless you want to. bring
And so
it up.
now they're concerned about protections for the jury.
Okay, go have a seat up there. And the deputy's gonna be behind you. You're just gonna start in the box, okay?
Could you raise your, oh, wow, yeah, can you raise your right hand? Do you swear?
All right, here we go.
I do.
Defendant is testifying.
You can be seated, Ms. McKay, when you have a question.
I would. For the record, can you start by stating your name, please?
Oh, sure, yeah, you can post it. Let's see what it was like.
Hi. Can
Hi.
you start by stating your name?
It's Jennifer Crumbley.
And Mrs. Crumbley, you and I have been working together since
It's gonna get exciting.
December of 2021, correct?
Correct.
And is it fair to say that over these last 26 months, we've discussed whether or not you intended to testify a number of times?
We have.
Do you want to testify in your case?
Yes.
Do you understand that if you did not testify, this judge, this court would give the jury instructions that it cannot be held against you?
Yes.
Do you understand that after I question you, the prosecution is going to be able to cross-examine you?
Yes.
And do you understand they're going to be able to cross-examine you about all of the evidence that's been admitted in the case, including all of your text messages or your Facebook messages to your husband, all of those messages with Mr. Malosh, all the evidence in the case,
Yes,
correct?
I do.
They get full reign on cross-examination. We've gone over that, is that correct?
Correct.
And do you have any questions for myself or for Judge Matthews about testifying?
No, I don't.
Are you doing this because anyone has threatened you or coerced you into testifying?
No.
Is this your choice?
Yes.
Is it voluntary, freely made by you?
Yes.
Is there anything you think the court should know about this decision?
No.
Just,
Do you have any questions for me, Mrs. Crumbley?
I do not.
Okay. All right.
Should we address council's motion while the jury's out?
Motion, well, I guess.
Yes, they have commissary.
sounds good, thank you.
I'm putting a link to the Oakland County Jail site in the chat. I can't turn it up. Nick has the controls.
If you need to take a break for any reason, let me know. Okay.
I can try to post mine again if mine was louder. I don't know. if
I put it
is.
up to 600%.
Okay.
I can't do more.
And it's probably more than I can do.
If we're still going to inquire, council, any other defense witnesses after Mrs. Crumbley?
I'm not sure, it depends on child care.
So who would that person be?
I'm not sure. They have never told me who they were calling. I'm not sure.
I thought they told you the night before.
Yeah, I'll tell them tonight. I've been in court with Mrs. Crumbley all day, so I don't know who I'm calling next.
I guess it's going to be hard to believe that we're going to get past her. Maybe we will. Maybe we will. Do you think we will?
I don't know. It depends how long the press is. I believe I'll get through her. All right for the jury.
Can you guys hear it okay? Is the court? We're dealing with what we got. I am definitely nervous.
Not so much about Jennifer, but I don't know what the defense will question.
Mrs. Crumbley, would you raise your right hand? Do you swear or affirm the testimony about today is the truth, so help you God?
I do.
Thank you. Would you
We
state
can
your
turn
name
our
and
mics
spell
down.
your
It's Jennifer Crumbley, JENNIFER, CRUMBLEY.
Go ahead, Ms. Smith.
Remember, I'm going to pull the podium up just so I can see a little bit better.
Okay, sure.
Uh-oh. I think it might have been the microphone.
Is that your microphone?
Oh, good. Nothing like destroying the only mic that we had.
It seems like it's being detached.
Is this defendant in defense counsel enduring?
All right, good afternoon.
You pull up or going up? Is this going to go well? Yes or no? There's no in
Is there any
between.
way we could put the screen on?
Sure. Usually that one goes on last, so.
And what I'm gonna have to do is I'm gonna leave this unplugged for a moment so that when I need an exhibit, I'll just plug it in.
Okay.
Because I don't have those fancy like in between slides.
Yeah, this one goes on and then that goes on, but
Well,
they don't all go on simultaneously.
they don't. Okay. Let's see if it goes.
I guess I feel like I'm the only one who can see.
I turned my microphone down to 50%.
This one is not on. Oh,
I can
there.
turn mine down if I need to
Let's see
balance it
what
out.
happens when I just go like. Okay, I'm gonna have to put it on
Okay,
each
mine's
time,
down to 50
so
as well. So let's see how this
I
works,
apologize
guys.
in between exhibits. So that I'm gonna pull it out.
We can't boost the volume anymore.
All right, Mrs. Crumbley. Can you please start by identifying yourself? Tell the jury who you are.
My name is Jennifer Crumbley, and I'm a defendant in this case.
And how old are you?
I'm 45.
Mrs. Crumbley, the jury has heard so much testimony. Do you agree?
Yes.
Okay. I'm going to go a little bit faster through things. And if there's something we need to explain, or if I'm cutting you off, let me know. Okay. And you understand that as I speak, you have to wait for me to finish speaking?
Correct.
Okay. So, Mrs. Crumbley, very briefly, go ahead and tell the jury what you did for a living.
I was a marketing director at a real estate acquisition company.
And how long did you hold that position?
5 years.
Now, does that kind of position include any kind of presentations or public speaking, anything like that?
Not a lot.
Okay. And how do you feel right now about talking to this jury?
Public speaking is probably my biggest fear. So very nervous.
Okay. And at times, you have been upset during this trial, is that correct?
Correct.
Are you okay to keep proceeding?
Yes.
I want you to tell this jury just a little bit about your personality, and I think we've seen some of it on the videos. Is that fair to say?
You have.
Okay, let's talk about when you have a really stressful situation. What is your, like, let's say an animal dies in your family or a person dies in your family. How do you handle something like that, news like that?
I go into a go planning mode. I internalize things, and my reaction is to take care of other things that may have to be taken care of, like financials or things that keep the house running. I tend to hold things in, and I let it out when I'm alone. So having a lot of emotions for me is difficult.
Now, in this case, aside from this case, is that true in other situations of your life?
Yeah.
Can you give the jury like an example?
Yeah, my husband had a hard time holding down a job after his mother passed away. So when he would lose a job, I would actually be the one finding the ones for him and sending them from Indeed or Monster and taking plans of how we're going to put certain things on payments. It's just, I take control of things. That's just what I do.
Okay. And you, I want to talk to you. You mentioned your husband. When did you and James Crumbley meet?
In October of 2004.
And how long have you been together then?
It will be 18 years this September.
And are you still together and married at this time?
We are.
Have you spoken to him recently?
No.
How long has it been since you've spoken to him?
A little over 2 years.
So since the day of the shooting?
Correct.
Or not shooting, the day you were arrested?
Correct.
You have a son?
Yes.
The jury's heard a lot about your son. Okay. I want to talk about your son prior to November 30th. Okay. Tell the jury how old he was at that time.
He was 15 years old.
And give the jury an idea about what kinds of things he was into, what his hobbies included.
Oh, he was really into bowling. He was actually really good at it. He was into metal detecting.
What do you mean by metal detecting?
He would have a metal detector, so we would go to the beach, or we went to Florida out by the ocean or the neighbor's yard. They weren't there anymore, so you go in the neighbor's yard and see if you can find old coins or cans or whatever he would find. But he really liked that. He was into his BB guns and target practice. We had a half acre of land in the village of Oxford that went straight back. So in the backyard, we set up little targets that we got from Amazon that you can just kind of shoot down like little whatever. See, he was into his video games. He did soccer from age 3 until 9th grade. He had a lot of different interests. Coin collecting.
Do you have some interests?
I do.
Okay, we've heard about horses.
I like horses. I also snow ski. I'm a big reader, and I worked a lot, so I didn't have a lot of time to do the reading.
Okay, now when you say snow skiing, did you ever back up. Were there any activities that you and Ethan enjoyed doing together?
Yes. I joined the ski patrol because the family can ski free, also to help people out. So I got him into skiing at the age of 7, and he would come out with me on my patrol shifts and come skiing with me. So we were in that together.
What about horses? Did he ever go out to the barn with you?
He did, but he didn't really like horses. The one horse I had was kind of aggressive, so it intimidated him, and it kind of turned him off from going to the barn. It's kind of boring if you're not the person with the horse. There's a lot of standing around and a lot of nothing.
Okay. So would you spend time together with him at home?
Yeah.
Okay, tell the jury what kinds of things you guys did as together or as a family.
We did a lot of board games. We also had the virtual reality set for the PS4, so we did a lot of the Beat Saber. You can probably do that.
I don't even know what you're talking about.
It's like you're holding lightsabers and has music, and you have to like hit the beats, but it's all in 3D. So it's a virtual reality headset.
Okay, so you would do that with him?
Yeah.
Okay, what else?
We had a pool. We liked swimming together. Really just normal stuff.
Okay, did you do holiday things?
We did.
Give us some examples.
So every year around Thanksgiving, I always cook Thanksgiving dinner. The day after, we would go cut our Christmas tree down. And then we decorate that weekend. We watch National Lampoon's Christmas Vacation. Halloween, we grew our own pumpkins. So we always carved our own pumpkins and had a whole bunch put around the house. Easter, it's normal family stuff.
Did you have an interest in like home improvement kind of stuff?
Yeah, our house was an auction house. So basically it was wrapped in blue tarp when we bought it at auction. So we've been trying to improve the house since 2015. So we new roof, exterior, and then I've been working on exterior and interior ever since.
Were there things that your son was interested in outside of video games? Was there anything academic that he was interested in?
He really liked history. He was a big history buff. We can play Trivial Pursuit, and he would get me in history every single time. But that's probably his. That was
Careful
probably
going
his
too
only
far into
favorite
that.
subject. The rest he could do without.
How did he do in school?
He did good if he applied himself. His problem was he didn't try as hard as I think he could. So he had up and down grades. I would say it's about average.
Okay, and when you say about average, was that something that you talked to him about? Was that something you monitored? Tell the jury about that.
Yeah, you heard about the Power School app during this trial. So I had it on my phone, and I was on it multiple times a day. And his grades will fluctuate based on what assignments the teachers turned in on the Power School app. Our biggest struggle with him were missing assignments. That was the one thing we battled all the time.
Ooh, I can relate.
Why was that a hot button issue for you?
Because there's no reason why he should have missing assignments. He had a homeroom class and get assignments done in.
Okay. There were, you talked about your job. What were the average hours you worked a week?
I usually I got to the office between 7 and 8 in the morning and leave anywhere between 4 and 6.
And we've heard lots of evidence already. It was family friendly.
Yeah.
Were you able to go and leave and go as you needed to?
Pretty much, yep.
Did you care about your job?
I did a lot.
Okay. Explain, did you have any changes in positions over the year or year and a half, 2 years before this?
I did. When I first started with the company, I was hired in as a social media coordinator. I stayed in that role until about 2020. I got promoted to director of marketing. And I held the position until I was terminated.
Okay. And you were, did you work during COVID?
I did. I worked remotely for about 6 months during COVID. Then I went back to the office in, I believe it was August of 2020.
Did you enjoy work?
I did. It was fun. It was marketing's, it's exciting, and I like doing graphic design. I did. I really liked my job.
Now, the jury
I would
already
concur with
heard
you, Jen.
about Brian. Brian testified.
Correct.
Tell the jury about Brian.
Well, I've known him since high school. We've been friends since then. He's part of the horse community. He has horses. And as you heard yesterday, we did have an extramarital affair. It's probably the extent of our, but we were good friends too.
How often in terms of the affair, how often would you spend time together with Brian during 2021?
Maybe an average of once a week.
Okay. How long did the affair last over?
About 6 months.
Do you feel like that affair caused you to neglect Ethan or not spend time with him? I'm sorry, your son, in any way?
No.
Explain why you don't feel that's the case.
Because when I met with Brian, it was in the mornings. On his way home from the station, he would pass my work. And so the time I was coming to work, we'd meet at the Costco parking lot, and that was it. He'd go out about his day, I go about mine.
And is it fair to say that you lied to keep that affair going?
Yes, I did.
And I apologize if I asked this, I just am not writing notes. Did you say the date range that started?
It was around spring of 2021.
Okay.
I don't like the way she talks about the affair.
As far as you knew, did you ever talk to your son about that?
No.
And did you ever talk to your husband about it?
No.
If anything, you lied to him about what you were doing, or lied by omission, not telling him.
No, yeah. As far as I knew, I was going to work in the morning. That was
okay. Outside of those morning times, how many other times would you say you and Brian got together?
It was 2 or 3. I went on some business trips
Good
where
question,
I
Jen.
would stay overnight, and he would meet me. He would meet me at the hotel.
So that happened 2 or 3 times?
2 or 3 times.
Were there other business trips you took where he did not meet you?
Yeah, there's quite a few.
When Christy Gibson Marshall testified, do you remember who she was?
I do.
Who was she?
She was the assistant vice principal.
And she commented she knew Ethan in elementary school, or she knew your son in elementary school, correct?
Correct.
And she said, she testified obviously already about recognizing him. Did that surprise you?
No.
She also mentioned something
This is at normal
about
speed, right?
emails with you. Do you recall having email exchanges
Nicholas?
with her?
There is one with
What?
regarding his report card.
This is on normal speed?
Getting additional help
Yep.
in math.
It sounds very
Was
fast.
there any time at that point or into high school that you ever had to email with teachers about discipline issues?
Not discipline, no.
How often would you email about missing assignments or grade type issues?
That was a regular thing.
Okay, and you said you monitored power schools every day. Approximately how many times a month would you say you went to the teachers, or was it weekly? I don't know.
It would be, I wouldn't say it was on a regular basis, but when it happened, it was a series of messages. He'd be struggling in geometry. And so me and the teacher would message back and forth quite a bit. And then he started getting better and it was die off. So it was sporadic, but it was a lot when it happened.
Now, we saw pictures of your house. How did you feel about seeing those pictures?
Horrible.
Okay, why is that?
Because my son has a very messy room, and it was right after Thanksgiving, and we hosted Thanksgiving, and it was pretty messy. It was kind of embarrassing.
Okay.
Really embarrassing.
Explain the 2-bedroom thing, or what was going on with that.
So Ethan, sorry, my son, he had 1 bedroom and it got out of control. And every time I go to clean it, I just shut the door. I just didn't want to deal with it. So then I told him he could just use the guest bedroom until I can get his room deep cleaned. The day before Thanksgiving, I was deep cleaning because we have people over every Thanksgiving, and my intention was to clean both rooms, but I caught my oven on fire in the self-clean mode. So instead of, I had the fire department out and everything. So instead of getting his rooms clean, I was scraping out the black charcoal stuff inside your oven so I could cook dinner the next day. But yeah, he was in a second bedroom because I didn't want to clean his room anymore. It was enough.
Did you have any plans to do anything with all that stuff?
Yeah, we're going through a lot of stuff because he outgrew a lot of the clothes and the shoes. There's a lot of toy-like things that he doesn't use anymore, so we're just going to pack it up and donate it.
Okay, and when were you planning to do that?
Between
I'm not a fan of the room
Thanksgiving
thing.
and Christmas, before he got new stuff.
Now, we saw a video. I guess I want to talk to you about, there's one friend in particular your son spent a lot of time with, correct?
Correct.
Okay, and we're not going to say his name, but let's just refer to him as the friend.
Okay.
Okay. Overall, was that your son's only friend?
That was his only friend that came over. He did have friends that he talked to during school, but that was the only one that he spent time with outside of school.
And how often would you say he came over?
Oh, he used to walk home with them every day from school. The summertime, he'd go on camping trips with us. Sometimes he would spend more than a week with us. He called him my second son.
Okay, he was the second son. Did you know he was going to be moving away at any point?
Not that abruptly, no.
Okay, so when he moved away, is it fair to say it was a surprise to you and your son?
It was.
What kinds of things would the boys do together at your house?
Oh, they go down to the lake and go fishing. They would walk to Little Caesars or Frosty Boy. They go in the backyard, shoot the BBs. They go swimming in the pool. We took them bowling a lot. They played video games.
Now, when you had him over at the house, or I guess was it more common for him to be at your house or for your son to be at his friend's house?
My son has never been to his house.
Okay, why is that?
Because he had OCD, not my son, but his friend had OCD issues and he didn't want other people in the house.
Kind of sounds like he was
Did that
left to
friend
his own
exhibit any
devices.
issues?
No, not at all.
A little bit.
Okay, so were you surprised when he moved?
Yeah, very surprised.
We saw evidence that you had Life 360 on your phone and it was on James's phone, right?
Correct.
Can you tell the jury what Life 360 is, what the point of it is, why it's on the phone?
It's a family tracking app, so you know where people are at. My husband's mother-in-law got sick in the middle of April, and instead of me worrying about where he was while he was down in Florida with his mother and I was up here, we just installed the app on his phone, so I knew if he was at the hospital or if I knew he was at his dad's house. So just that way at the bottom, I'm always worried about him and places he goes. So it's just one thing that eased my mind a little bit.
Do you is that something you frequently message your husband? Where are you? Where are you? Where are you?
Mm-hmm, a lot.
Okay, so the jury's going to see the entire stack of exhibits. If they go through all of your messages, how often a week would you say you're on top of him about where he is?
Daily.
What about your son? Were you ever worried about where he was?
I mean, not during the day. He was at school. If he didn't get home from school the time he was supposed to, I'd worry about him.
Okay. And did you ever ask James about him in messages?
Yeah.
Okay.
Yeah.
The prosecution introduced evidence that makes it sound like you and James only talk about these horses.
Actually, the form of the question makes it sound, and this is direct exam at cross, so this should be non-leading questions as well.
How often would you say you discuss your horses versus your son when you're messaging each other?
A lot more with the horses.
Why is that?
Because my horses, at least, were accident prone, and my husband didn't know a lot about horses. They were more my thing. With him working from home, a lot of times I'd have him go out and check on him, tell him what to do. He started getting into him. He had questions. I knew my son was at school. I knew where he was at during the day. I can talk to him after school. Horses can't talk, so if something's wrong, we got to kind of figure it out. But yeah, we talked a lot about horses.
fair to say that, did you have additional conversations with James about horses and or Ethan?
Yeah.
How often would you and James talk about or talk to Ethan?
Well, talk to him every day. Talk about him probably every day too.
Okay. What kind of, did Ethan have scheduling things you had to work out?
Yeah, he had bowling practices throughout the week, bowling matches, and he worked part-time at a diner. So we had to work out transportation and scheduling with that.
In terms of your relationship with your son, how did you think your relationship was?
I thought we were pretty close. We would talk, we did a lot of things together. I trusted him and I felt like I had an open door and he can come to me about anything. I mean, I felt as a family, the three of us were really close.
Okay.
So
you're
want
getting
Jung's
a
thoughts
lot of-
on this.
No, it's okay. You're getting a lot of redness here. Is that normal?
Yes, because I'm talking in front of people and my nerves act up. So I get splotchy and I might break out in hives and I apologize.
Okay,
Or
you
this
are
is a
okay.
traumatic
Yeah, I'm fine.
event.
Okay. So with regard to your son, did you ever go through his text messages, go through his bedroom? What kind of a parent were you in terms of going through those things?
I did not go through his text messages. I didn't have a reason to. His bedroom, I would go through when I clean it. When I come across things, I look through it to see if it was something I needed to keep or throw away. But I never went through his text messages.
What about, you did say you went through his grades.
Correct.
Did you end up having discipline issues with him?
A couple of times we did, yes.
What kind of things would those be over?
Missing assignments in his grades.
Okay. Well, any other things that were discipline issues
No,
at school or at home?
no.
Was there ever a time where you took away your son's phone?
Yes.
Okay. Do you recall when that was?
I don't remember exactly. I just know he got really angry about it. But we took him away a couple of times. We've taken his video games away.
Why did you do that?
Missing assignments in his grades.
Okay. So same stuff.
Same stuff.
Okay. We're going to talk about some of the text messages. And you would agree the prosecution admitted some text messages about one of those times when you took away his phone.
Correct.
Okay. So we'll get there. Okay. I want to talk about mental health. Did you ever believe that your son needed mental health treatment, therapy, counseling, anything?
No, I mean, there's a couple of times where Ethan had expressed anxiety over taking tests, anxiety about what he was going to do after high school, whether it was college, military. So he expressed those concerns to me, but not to a level where I felt he needed to go see a psychiatrist or a mental health professional right away. No.
Did you ever deny him or say, no, I'm not going to take you to a mental health professional? Did he ever ask you?
No, I mean, one time when he was talking about what he wanted to do for his future, I don't know, he was feeling really down about it and stressed. My husband did call his school counselor to try to talk to him because they do a lot of future academic planning with the tech school.
Was that a mental health issue?
No, it was more or less addressing what was upsetting my son at that time.
Okay. And what was upsetting him?
The fact that he didn't know what he wanted to do. His grades weren't that great, so he was stressed out about getting into college. He was just having a hard time with his future goals.
Was there ever a time he was considering military?
He talked about it, yes.
Okay. Any other things that he talked about?
He wanted to go into video. He wanted to design video games. He wanted to own his own car shop, like not be the mechanic, but own the shop that mechanics worked at. But that's about it.
Okay. Were there other kinds of health treatments you did get for him? Like, did you take him to the doctor?
Yeah.
How often or for what?
When he got sick, if it was obviously, well, during COVID, it was different because every little thing I freaked out about. So we'd take him to get a COVID test or take him to the doctors. But growing up, it would just be if he had a headache that persisted for for longer than a week. But most things are nothing serious.
Did he have insurance? Did you have insurance coverage on your son?
My husband did.
Okay, always, or were there times where you didn't?
All the way up through October of 2021 when my husband lost his job. And I was going to add him on to my health insurance in November of 2021 at the end of the enrollment period. That was the only time that insurance lasts with him.
Was that one of the outstanding things going on the day that all of this unfolded?
It was.
Despite, in addition to physically going to the doctor, did you have access to some kind of virtual plan?
Yeah, through my company. It's called Allied Health Network. It's a virtual doctor's visit. And actually the prescriptions were free too. They didn't cost anything. So we use that. If we had strep throat, you can take a picture of the throat, send it to the doctor, and they can treat it from there.
Were there times that you called that did virtual visits regarding your son?
Yeah.
And were there times, did you ever go to an urgent care or anything like that?
Yep.
For what kinds of things?
Well, usually for sports physicals, but if he was younger and had a really high fever and his regular doctor couldn't get him in, we take him to urgent care. He's never had an injury or anything, so mainly just that.
Was there ever a time that he had an issue with a mole on his back?
Yeah, he had a mole in the middle of his back. And when I was putting sunscreen on him, I noticed it changed color. So I made an appointment for the doctor to take him in to take a look at that.
Now that was when he was much younger, correct?
He was about 7, I believe.
You mentioned something about headaches for a week. You took him to the doctor. Was there a time where he had a headache issue?
Yeah, he was getting really bad headaches that we couldn't figure out what it was.
When was that?
Started young, probably around 5 years old, and he kept complaining. The doctors didn't really see anything. We even got X-ray of his head to see if there was any bumps.
The object is irrelevant when he's 5 or 6 years old.
I was asking, I didn't know when it was. I was just asking if she got a medical.
But it's gone on through the years.
Okay, and
so then we found out that he needed glasses. So around 8 or 9, we got him glasses. That didn't work. He got X-rays done for dental in middle school. Found out he had a severe underbite, which was causing tension in the back of his neck. So we got him braces in 8th grade, and once he had his braces, that seemed to fix the headaches.
okay. Now with the braces, was that an easy process?
No,
Why not?
because he's horrible at brushing his teeth. He went use the water pick we got him. He wouldn't brush properly. He would constantly get cavities in his braces, so we ended up taking the wires out because one time he had 13 cavities under the braces. And we're trying.
I'm sorry. Prior to him getting braces, did he ever have cavities?
Yeah, I had a few.
Okay, but did the braces? Was it more after the braces?
Yeah, because he wasn't brushing properly around his braces, so he was getting them under, and we had to get the wires removed and take them to get those filled until we could get the wire put back on.
Okay, so it was like an off and on procedure.
Yeah.
Okay. I want to go through some exhibits for you that the defense has proposed as exhibits B through XX. And I'm going to ask, I wanted to add one more on as YY.
Judge, counsel's proposed a number of exhibits appear to be from Facebook, not from a subright extraction, but from Facebook. Some predate the incident by years. So
No speaking objections.
I don't mind any exhibits around the date of the offense or even the relevant time periods, spring of 2021. But prior to that, it doesn't appear to be relevant.
You need to know the entire history. You're charging her with being
They have the
neglectful.
specific pictures I was using since October. The specific pictures, isolated, not all the pictures, but specific pictures I was using. They never filed a motion to exclude any of those.
They don't have to, right? Okay, so We'll go exhibit by exhibit. I haven't seen any of the exhibits, so they obviously will be treated differently.
Okay, Your Honor, would you like me to bring you the hard copy, and then if the exhibit's okay, we can put it on the screen?
Yeah, I can submit it. I'll put it on the screen.
Okay, and I did them
They
just,
have a copy, three copies of all this. right? Yeah, I haven't seen any of them, so.
and we've, I
Hey, Mo.
actually had them redacted.
I've seen you, I just didn't say hi to
and then
you.
sent the redacted version
Was
to
busy.
cut out the faces of any minors.
Okay.
Okay, so I'm gonna bring the court, what's been marked as B through, this is YY if it's admitted, B through YY. May I approach?
Sure. Thank you.
Okay. Now, B is, I have a little bit of a problem because I was going to have my client hold those, so I don't put them on the screen. Because I don't know which ones, if any, the prosecution will stipulate to. So
I can be used to her.
okay, so the first proposed exhibit is B.
It's more than one
It's
page.
several pages. It shows thumbnails throughout the years so the jury can see the variety of things posted on. Because the prosecution introduced text messages.
How many pages is B?
I believe it's 14. They're just like thumbnails. I'm not going to go through each thumbnail either.
Oh,
This one
that looks like a lot of
where does
pictures.
the second one start?
It's C, Exhibit C. Exhibit C would be the next exhibit. Okay, do you recognize what the court has just handed you?
Yes.
Okay, what is in Exhibit B? What does it appear to be?
These are pictures I've posted on Facebook.
Okay, and there's a lot of them. Is that a fair statement?
Yes.
Okay, are those are all the pictures you posted on Facebook? They're not from they're from the whole period, correct?
I mean,
What's the period?
Well, when did those start and go through?
I would say mainly 2000.
There's not
20?
any dates on that copy?
I'm
There's
just-
no dates on my
I
copy.
don't think there's any dates.
I can tell by the. Looks like from 2020 to 2021.
Now, do you post on Facebook a lot?
I do.
Like way too much?
I do.
Okay, so I am not gonna go through every Facebook post you've made. You understand that, right?
Yeah.
Okay. Would this exhibit give the jury an idea of what you post about generally if they just took a look at the variety of pictures?
Yes.
I have to object to the relevance. Again, it's from the time period that's relevant. I have no objection to these coming in. But even the defendant doesn't know with specificity when these were taken.
She says they start in 2020.
She thinks.
No, I know.
And there's no dates on there. Yeah, you'll have your turn. There's no dates on there. And if it's from the spring of 21 onto the shooting event, that's fine.
Your Honor,
That's
the
the time we talked
prosecution has
about.
made it sound like,
Okay, you specifically asked that you guys have to talk at the same time.
sorry,
Yeah.
I did.
All right, so.
So B appears to be a thumbnail version of pictures. The rest of the exhibits are pictures with dates next to them.
Okay.
And that might be the best way to go through which ones are from.
Was, this happened.
How's this sound, guys?
November
How's the sound
30th,
quality?
2021,
That's right.
and things have been put into.
We did a hot
evidence
swap.
with regard to the defendant and the shooter as early as April.
I have an echo.
March. Okay, so.
Your Honor, I believe they've gone back longer in terms of some of the testimony that's come out.
Well, I guess I was going to say that. So I don't think that.
Okay. Sorry, we just paused it for a second. Nick, you got to jump off. We just did a hot swap of the feeds so that Nick could jump off. He's got to get going.
Yeah.
All right.
Okay. Yeah.
Thank you very much, Nick, for joining me.
Yep. Thank you for having me. See you all later.
Nick's
Bye-bye.
channel, by the way, is pinned at the top of the chat. You guys should all go check it out.
Thank you.
The pictures starting in 2020 are yet remote. I don't know if there's any, I don't know if there's anything amongst those pictures that is particularly problematic. It's hard to look at them all, but the time frame in and of itself, I think, is appropriate.
Well, there are some, just so the court's aware, there's 20, posts from 2017, 2019.
Those are in the following ones where I did picture by picture. So those will go through after this exhibit.
This exhibit
Is 2020 and 2021.
Okay, so just with regard to the time frame itself, I think the time frame is close enough in time. So I'm going to overrule an objection
Okay.
with regard to the mission of those pictures just based on the time frame.
All right.
But there's a lot of little pictures, so I don't know if any.
No, that's fine. We can go exhibit by exhibit.
I'm sorry?
I said we can go exhibit by exhibit.
Yep, that's Jennifer on the stand.
The pictures in 2020, the pictures in Defendant's Exhibit D are small, so the exhibit contains a lot of little pictures. So I haven't looked at those. I assume the prosecution has, so I don't know if any of the pictures are objectionable with regard to the individual pictures. So
Just it's the relevant dates was the objection.
Okay. So Mrs. Crumbley, the jury is going to get these if they want to sit and look at all of them. Okay. I don't want to go through all of them. There ends up being pages and pages. What are all of these?
The ones that are on the screen right now is Christmas of 2020 with the 2 white dogs and us posing in front of the Christmas tree.
I'm just trying to get like an over idea of topics that are in the photos.
Animals, us going on vacations at the Sleeping Bear Sand Dunes, Leelanau, camping, holidays, more camping, horses, garden, my home stuff, cooking, more camping pictures.
Okay.
We got a bathroom remodel, another Christmas picture.
Okay. And so these pictures give an idea of the variety of things you posted.
Yes.
So if your Facebook messages appear to have more discussion of horses, how would you characterize the amount of horses on Facebook compared to the rest of your life?
Over the last couple of years, more. It was hard getting a picture of my son as he got older. He didn't like me taking pictures of him. But yeah, over between 2020 up until 2021, there was a lot of pictures of horses.
Okay, I'm going to unplug this and move to Exhibit C. This goes back to 2019. I just put like 1 or 2 pictures from that year as Exhibit C. Well, C and D. And so if the court just wants to let me know what.
C. Okay, so C and D. You can identify this picture.
Yes.
What's in C? What's the date of it?
It is June 26, 2019.
Okay, and what is that? What is it a picture of?
It's a picture of my son holding his chinchilla.
Okay, and then what about picture? Let's see here. D.
Do you need the date?
Yeah. What's the date?
Hi, McKinley.
Hi. It's August 9th, 2019.
Okay, and what's the picture of?
My son petting our horse.
Okay.
You know, Judge, it's fine. I don't have any problem with either.
Okay, so you're admitted.
Yeah, the rest of them.
The rest of
All
them?
of them?
Yep.
Okay,
Thanks, Judge.
thank you. Okay, so
You're talking, then you would be talking about E through, I don't know if it's just pictures, there's some others. This goes to XX, so.
and I'm sorry, it should go to YY because I added on just one more. So may I approach Mrs. Crumbley just to give her YY?
Okay, do you want me to give this to all of them?
Yes, and then
Okay.
we'll just go through each one.
Do you agree with all these exhibits or just?
Yes, we just need the dates identified. That's all.
Didn't
We'll
give
put those on the
any-
record.
Well, I'm
Well,
not gonna hand them to her.
not that's in evidence.
Look at them first, so.
I think they're not objecting to any of them, are
No.
Okay.
None.
Okay, So Mrs. Crumbley, the jury's gonna have access to these, so let's just go through them. We are gonna identify the dates for the record though, okay? So going to exhibit, let's see here. This is C. What's the date on C?
That's June 26, 2019.
And what is that?
That's my son with his chinchilla.
Okay. Now I'm gonna go down to D. What's the date on that one?
That one's August 9th, 2019.
Okay. And what's going on in there?
That's my son with our horse.
Okay. I'm gonna go to E.
That's his first day of 8th grade. That's August 26, 2019.
Okay. And it's fair to say that I just picked out, these are not all your posts,
No.
right?
I don't want to keep you checking, but the form of the question has to be appropriate. Fair to say, is this a
Okay.
direct?
I'm asking a really stupid question, but I'll ask it in a better way. Am I showing every photo from your Facebook page?
No.
You post more, or how about, do you post more photos than what we see?
A lot more.
Okay. We're not gonna go through all of them though,
No.
okay? So this is the first day of what? I'm sorry, last day of,
It's the last day of middle school. It's his first day of 8th grade.
okay. I'm gonna go down to F. What's been admitted is F. What date is that on?
October 11th, 2019.
Okay, and what's happening in that photo?
He just got his braces put on.
Okay. And let's go down to the next one, which is G. What's the date on G?
October 13th, 2019.
What's happening in G?
We're apple picking.
Okay, so these are just posts of events or things you're doing, correct?
Correct.
Okay, this one is older. It looks like or maybe not older, but what's the date on this one?
November.
I'm sorry, I'm on H.
Mhm.
Okay, go ahead.
November 7th, 2019.
Okay, and we see your son in this picture on the left, correct?
Correct.
What's going on in this picture?
He's on his the 9th grade Washington D.C. trip with the school.
Okay, I'm gonna go down to I. What's the date on I?
May 23rd, 2020.
And what's happening in that picture?
Can you scroll up a little bit? We're somewhere up north. I don't remember where, but we're on probably a camping vacation.
Okay, he doesn't look thrilled to be in the picture.
He doesn't like pictures.
Okay. Let's go down to J. What's the date of J?
May 23rd, 2020.
Who's in this picture?
It's my son and James.
Okay. I'm gonna go down to K. This is a post you made?
Yes.
What date?
August 5th, 2020.
What are you showing there?
The house when we first bought it and the improvements we made so far.
Okay, so this is like a comparison before and after?
Yes.
All right. L, what's the date on L?
August 16th, 2020.
Okay, and there's a large black box out. What's under the
I like
box
this
without
approach.
saying who it is?
His friend.
Okay. So where are
Showing
you
how
guys
much he
in
was
this
in her son's
picture?
life.
Looks like we're up north.
Okay. Then we're gonna go to M and we're on September 28th. I'm sorry, what's the date of this picture?
September 28th, 2020.
Okay, what's this picture?
That's a picture of my son and our horse.
Okay. I'm going to N. What date is this?
October 23rd, 2020.
Okay, and what is this a picture of?
Something Ethan drew. Sorry, my son drew.
Okay, and why did you include this? Why did you post about that on Facebook?
Because he's always a really good drawer. He just draws all the time. And we got a lot of artists, actually tattoo artists in our family, a lot of good drawers. So said it was in his genes.
Okay, that's why you said art is in his genes, in
Correct.
the genes.
Correct.
Okay. All right, I'm going to O. What's the date on this one?
October 30th, 2020.
Okay, and what's going on here?
We are carving pumpkins for Halloween.
And there's a big black box.
That's his friend.
Okay. I am going down to P. What's the date on that one?
November 21st, 2020.
Okay, and who is around for this picture, even if you can't see them in the picture?
It's me and my husband and my parents. We're down in Florida over Thanksgiving.
And what is this that you're doing?
We're playing Dark Tower.
Okay. Did you guys play games with Ethan often?
Yes.
What games did you guys play?
We played Trivial Pursuit. We played What the Meme. We played Yahtzee. We play card games. We played a lot of Uno. The one with all the dice, Farkle, I think it's called. Yeah, Farkle. I don't know. We played a lot of games.
Okay, I'm gonna go down to Exhibit Q. What date's that?
That's November 24th, 2020.
Okay, and we see who's in the picture?
My husband and my son.
Okay, Exhibit S. What's the date?
January 22nd, 2021.
Okay, what's going on in R?
My son and his friend are playing Jenga.
Okay. S. Do you know the date on S?
Can you scroll up?
It's for some reason this
Probably
one
not
is
playing
different.
euchre.
Well, it looks like it says February 25th, 2021.
And what's going on here? What's happening in February of 21?
They're at a bowling match.
Okay. Now let's go down to T. What's the date on T?
February 26th, 2021.
And what's happening here?
My stepdaughter came up and visited from Florida, and that's my son with his arm around her.
Okay. And with these photos, again, are there on your real Facebook profile, are there more photos or is it just what we're seeing?
There's more.
Okay. So what's the date on this exhibit U?
May 15th, 2021.
Okay, and what's the point of this post? There's a couple pictures.
I was showing our backyard improvements that we've done since we bought the house.
Okay. And then let's go to V. What's the date on V?
May 16th, 2021.
What are you showing here?
Our garden.
Okay. Now, this is W. What's the date on W?
May 29th, 2021.
Okay, and who's that?
It's my son and Dexter, his kitten.
Okay. Dexter is mentioned in one of the tapes. Is that correct?
Yes.
How is Dexter mentioned?
When we were at the substation, I asked my son why, and he said, because I just did take care of Dexter for me.
So when he said take care of Dexter,
He's meaning his kitten.
X, what's the date on X?
May 29th, 2021.
Okay, and what's going on this date?
My son and Dexter just hanging out in his bed.
Okay, we're gonna go to Y. What's the date on this one?
It's again the same thing, Mads.
May 31st, 2021.
Okay, who's in this one?
My son and his kitten.
Okay. Z, what's the date on this one?
June 13th, 2021.
And where are you guys?
We're at Cedar Point.
Is this like a family trip?
Yes.
Did you guys do a lot of family trips?
Yes.
Okay. A lot of family trips during summer of 2021?
Yeah.
Okay. We're here in exhibit AA. What's that? Yikes, I bumped it. What's the date on this one?
June 26th, 2021.
What are you showing here?
My garden.
Okay. This is exhibit BB. What date?
June 27th, 2021.
Okay. And what are you doing there?
In the pool.
Did you guys go in the pool with your son often?
Yeah. He'd join us.
Okay. And then let's see here. We've got CC. Date?
July 4th, 2021.
What's going on here?
My son and his friend are playing badminton against my parents.
Okay. Is this at your house?
Yes.
DD. Date?
July 11th, 2021.
Okay. What is this?
Me and my son and his friend we found a little spot off the Pollyant Trail, which runs through Oxford. And there was some weird big boy stuff going on. So we kind of walked around and checked it out.
Okay. Let's see here. EE. It looks like there's 2 posts on this date.
That's pretty.
What date is that?
That's July 30th,
What's that?
2021.
Okay. And what's happening in these posts?
It's pretty.
The first one I posted, my son and his
Should come to
friend are
Michigan
both
sometime.
passed out from a lot
Mm-hmm.
of hiking we did that day.
Okay. What about the next photo from?
Those are pictures of the campground that we were at.
Okay. And so you took, is it fair to say you had the friend on vacation?
Yeah, most of the time.
Okay. July 31st, I'm sorry, what's the date on this one? I'm on FF.
July 31st, 2021.
Okay, what is this?
We went to the Sleeping Bear Sand Dunes.
Okay, and where it says like plus 29, what does that mean?
There's 29 more photos that go along with that.
Okay, we're not going to show them all. Okay. All right, we're going to GG. What's going on here? What's the date?
August 21st, 2021.
What are you guys doing August 21st, 2021?
My son and his friend were putting up a tent in our backyard and doing backyard camping.
All right,
Okay.
it's getting a little
What's
repetitive
the
now.
next one? You posted this on what date?
I posted on August 21st, 2021.
Okay, and what's the point of this post?
It was a memory from 3 years
Do
ago
not
of my son
invoke
and his
deer come
friend with our horse, and I was pointing out to my son's friend's mom that they were so small 3 years ago.
Okay. What about this one? What's the date on, let's see here,
August 25th, 2021.
Okay, what's this?
That's his first day of school.
Okay, what grade?
10th grade.
And let's go to JJ. What's this date?
August 29th, 2021.
Okay, what's going on in this picture?
Me and my son were taking a picture for his old football coach. I tagged him in it. This is the only picture he would take
This
with me,
seems
so
all
he
very
can say hi to
normal
his coach.
stuff.
Rope.
All
It's
right,
not
what
just
about
pictures.
date on this one, which
To
is
me, this isn't like curated pictures. This is pictures of them going places. So I don't know. You don't put the bad stuff up on social media. I get that, but this is a lot of normal stuff, right?
marked as KK?
September 6th, 2021.
And what's going on there?
My son's leash training his kitten.
Do cats ever walk on a leash?
It wasn't successful.
Okay. Next picture.
That was good. I like
What's
that.
the date?
September 18th, 2021.
Okay. And what are you doing here?
We rented a houseboat for the weekend, and my husband and I are walking around the outside on the dock and was sneaking pictures of the boys inside the houseboat playing card games.
Why were you sneaking pictures of them?
Because they wouldn't let us take any pictures of them.
Okay. Typical teenagers. All right.
That's my biggest concern.
What's
Dory,
that
too.
date?
This could be any one of us
September 18th,
parents.
2021.
Okay. And what were the photos here?
I know it was the houseboat weekend. We went to Mackinac City, so I think it was something in Mackinac City.
Okay. And then the blacked out box, is that the friend?
I think it's the friend's parents.
The friend's, okay.
Oh no, the friend, but never mind. I saw. Never mind.
Okay. NN, what's the date on this one?
September 21st, 2021.
Okay. And what's this?
My son and Dexter sleeping.
And now we are at September 20. I'm sorry. What's the date on this one? I'm on 00.
September 26th, 2021.
Okay. What does that show?
We were breaking up our side steps of the deck and planting a flower bed in the front of the house.
Okay. So we're in fall of 21. Is that fair?
Yes.
Okay. What's the date on this picture? I'm on PP.
Ooh, the cat.
October 3rd, 2021.
Okay. What's this picture? What are these pictures about?
We decorated our house for the Halloween.
Okay. And then let's go here to QQ. Date.
October 9th, 2021.
And what's shown in this picture?
Our front porch that we redid.
Okay. Called it a makeover.
It was.
All right. And then let's go here to RR.
We see you.
What date is that?
October 15th, 2021.
Okay. And what are you doing there?
I was just showing what we've got so far with the paint job, remodeling the living room and dining room, basically.
Okay. Next one is SS. What's the date on this one?
October 25th, 2021.
Okay. What is this?
This was a text I sent to my son. Him and my husband were going somewhere. I don't remember.
Spam. I love it.
But I was just checking in. I said, you guys are okay? And my son made the comment, no, we're in the back of a white van headed to Alabama, because he's very sarcastic and I found it funny and I posted it.
Okay. Was he sarcastic or I'm sorry.
Go ahead.
Explain the sarcasm.
And that's an example of it right there.
Okay.
Yeah, he was always sarcastic, always messing around with us.
Okay. When you say messing around with you, we're gonna get to that when we talk about some other posts. Is that fair?
Okay.
Okay. So let's go down to this photograph. TT, what is this? What date?
That's October 29th, 2021.
Okay. And what are you doing?
That's where we're on the virtual reality playing Beat Saber.
Okay. And then this one, okay. Okay, what's the date on this one?
November 26th or 25th, 2021.
Okay, and what's going on here?
Thanksgiving.
Okay, Thanksgiving, is this Thanksgiving Day?
Yes,
So this would have been Thursday.
correct.
Okay. We're going to talk more about the next couple of days more slowly, but I'm going to go through the pictures first, okay? And then I'm going to take them off the screen so we can talk a little more. Is that all right?
Becca Lynn, welcome.
Okay, so what's the post? What is this post? What's the
Discord
date on this one,
link and
VV?
number change.
November 25th, 2021.
And what is this picture? What are these pictures showing?
Our family, my aunt and uncle, my cousin, her husband, and then me, James, and my son. And then it shows us playing dice.
Okay.
Or left, right, center.
Is this on Thanksgiving?
Yes.
All right. And then on WW, what day is this on?
That's November 26th, 2021.
Okay. And what were you guys doing on this day, November 26th, 2021, which is a day we're going to talk about in more detail?
We were cutting our Christmas tree down.
Okay. And then ultimately we have XX. What date is this?
November 27th, 2021.
Okay. So this would have been Saturday.
This is really good.
And what's going on in this picture?
Leading right up to
we
the
got our
event.
Christmas
Nothing
decorations and everything, yeah.
abnormal.
Okay. Then we have YY. What day is this from?
November 26th, 2021.
Okay. And what's happening in this picture?
My son and my husband are laughing at me because I dragged them around the whole tree farm to pick the tree. So they were finally happy it was over.
Okay. So that's YY, right?
Right.
Okay. I'm gonna close this for just a minute
This is that's
and just make sure
that's
that
4 days
exhibits
before.
B through YY were admitted.
Yes.
Okay, and then the defense is only gonna have one other exhibit, but we'll get to that one, okay? Okay,
Fair enough.
so Mrs. Crumbley, I wanna go back and talk to you. We went through a lot of Facebook pages, obviously, or pictures. On Thanksgiving, who was at your house?
It was my aunt and uncle, my cousin, and her husband.
And what did you guys do, if anything, that
You
night?
pull up.
Well, they were there probably till about 7 or 8 o'clock. So we played left, right, center, just the normal family stuff.
Did anything seem off or strange with your son?
No.
Was he spending time with family members or was he in his room? What was he doing?
He was back and forth. He would come out and play games with us, or when it got to adult talk, he would go in his room and play his video games.
Now, we definitely saw a lot of his friend in the photographs. Were there other times where he would not have his friend with him?
Yeah, there were times.
Okay. Was he happy? Was he okay without his friend? How was he?
Yeah, I mean, most of the
Yes,
times
definitely
it was just the
should
three
be.
of us. It was usually out of state travel.
Okay. Let's see here. Okay, so on the day after Thanksgiving, what did you do that day?
I went shopping. I go shopping every year, day after Thanksgiving, Black Friday shopping. I wake up at 4 o'clock and I go shopping.
Okay, so where did you go that day, if you remember?
I usually go to Meijer, and then from there I'll head up to Marshall's and Lapeer. And then sometimes I will hit the not Home Depot, the other home improvement store, Menards. I would hit Menards.
And on that date, when you went, it was the 26th, correct?
Yes, correct.
Do you know, when you left your house, did you know what James and Ethan, your son, were going to be doing that day?
No, they were sleeping when I left.
Okay, when you got home,
accident.
were they home or were they where were they?
They weren't home.
Did they ever come home?
Yeah, I texted my husband, asked where you're at, and I believe he called me and told me that him and Ethan were at the Acme firearm store looking at guns.
Okay.
And then they came home from there.
Okay, did they purchase a gun that day?
They did.
Okay, the prosecution brought in exhibits showing the receipts, all of that. You weren't with them when they bought the gun, correct?
No, I was not.
Okay. You did post on Facebook a photo of the gun. We saw the post, correct?
Correct.
And in the post that's been admitted already, you described it as your son's.
What the hell? Hang on.
I don't know, but why was that so much louder?
Needs to understand some details, okay?
Hang
If I
on,
ask
let
a
me back it up.
question,
In kitchen counter,
they came home, did they show you the gun?
mystery.
They did get one.
Right.
Now, did you object? Did you say, I don't want that gun in the house? Anything like that?
No, I was more angry that they cut into our Christmas tree. I usually cut my Christmas tree down right after I get back from shopping, but I had to wait for them. So I was irritated at that.
When they came home, did they show you the gun?
I didn't do anything. That
Yes.
was
Okay,
Fox
and what did
2.
you guys do?
Hang on, I'm gonna back it up. I wanna hear
They
that.
had rented a 9mm firearm store looking at guns.
All right, I backed it up. I don't know
Okay.
what that
And then they
plane
came
was.
home
That
from
was
there.
5
Okay,
minutes.
did they purchase the gun that day?
They did.
Okay, the prosecution brought in exhibits showing the receipts, all of that. You weren't with them when they bought the gun,
No, I
correct?
was not.
Okay. You did post on Facebook a photo of the gun. We saw the post, correct?
Correct.
And in the post that's been admitted already, you described it as your son's Christmas gift. Can you explain who wanted the gun? What does it mean?
They had rented a 9mm at the shooting range before, so they knew it was the type of gun or the size gun, I guess what it is, that they wanted to get. And my son and my husband did a lot of texting back and forth. My son did a lot of research on it, and they're comparing different ones that they wanted to buy. That went on for a couple of months. My husband just kind of kept blowing it off, like, not right now. And then I guess when I was out shopping, they said, well, let's go try on Black Friday, see if we can get one on sale, if there's any deals going on.
Okay, so they ultimately did get one.
Right.
Now, did you object? Did you say, I don't want that gun in the house? Anything like that?
No, I was more angry that they cut into our Christmas tree. I usually cut my Christmas tree down right after I get back from shopping, but I had to wait for them. So I was irritated at that.
When they came home, did they show you the gun?
Yes.
Okay, and what did you guys do?
They just showed me it was on the kitchen counter, and then my husband put it up and we went to the Christmas tree farm.
What do you mean by put it up?
He put it back in the case with the cable lock and back in the bedroom.
Okay, let's talk about just guns overall. This jury needs to understand some details, okay? If I ask a question, you don't know what I'm talking about, let me know. Because are guns your thing?
Not really, no.
Okay, but do you have awareness about guns within your home?
I do.
Okay, who is responsible for storing the gun?
My husband is.
Okay, explain why you say he's responsible for that role.
I just didn't feel comfortable being in charge of that. It was more his thing, so I let him handle that. I didn't feel comfortable putting the lock thing on it. I just rather not let him do it.
And I think in one of the messages that was admitted with Brian, you called it a string lock.
Yeah,
Okay, do you understand now it's a cable lock?
I do.
Okay, so were there ever any times where you would take the cable lock off or put it on?
No,
Now, there were, prior to buying that gun, did James own any other guns?
he did.
How many?
2.
And by 2, the jury has seen the Derringer and the Kel-Tec. Were those the other 2?
Correct.
Okay, so those are the other 2 guns. How were those stored?
They were stored in the safe.
Okay, and was that different than the 9mm?
It was.
Okay, explain to the jury the difference.
We had a gun safe, so when they bought the 2 other guns, they transported the 2 other guns into the gun safe, and then everything else. Well, I don't know. Everything went, like the cable lock and the other case went somewhere. The 9mm was in a case, but it was locked it was in the case locked with a cable lock.
Okay, and
No, the father did not plead guilty. Ethan pled guilty. The father's trial starts in March.
how the cable lock that was on the 9mm, what did you have to use to get the cable lock open?
A key.
Okay, did you have possession of the key?
No,
Okay, where was the key?
it was I collected German beer steins, so it was in one of the beer steins.
Where are those located?
Throughout the house. We have them on top of there's a ledge over the refrigerator in our kitchen. So they go from wall to wall. Then we had corner shelves in our house that had them. We had a lot.
Okay. Did you know which particular beer stein the cable lock key was in?
No.
Do you know if your son knew which beer stein it was in?
No.
What about ammunition for the 9mm? Was there any bought on the 26th when the weapon was purchased?
No.
Okay, so that day, we saw obviously your Facebook post. You describe it as your son's gift. Did he have free access to that gun?
No, it was for him to use at the shooting range only.
Was he allowed to take it out?
Not without my husband around.
Did he know where it was kept?
My husband hid it usually in our bedroom in different spots.
Okay, what was the intention of hiding it?
That's just what you're supposed to do.
Okay, and when it was hidden, was it locked in any way?
It had the cable lock on it.
Okay, and you again testified about the key being in a beer stein?
Correct.
Would the beer stein be right by the cable lock? or-
No.
Okay, so where would the beer stein be?
It would probably be in one of the ones in the kitchen.
Okay, so the key's out there, and then you've got did you know where the gun was hidden in your room on November 26th when you put it away?
No.
Okay, on November 27th, we saw the whole video of you going to the shooting range with Ethan, correct? Or with
Correct.
your son, correct?
Correct.
Okay, on that day, we see in the video that you carry the gun case into the gun range, right?
Correct.
Okay, how did the gun get to the gun range?
Well, my husband had got it ready for me and put it in the back of my car, and
What
I
does that mean, got it ready for
took
you?
the cable lock off, put I guess I put the magazine things in the case and put it in the back of my car, and then I drove with my son to the shooting range with the gun in the back of my car. That's how it got there.
Okay, did you see him or watch him take the cable lock off that day?
No.
Why not?
I think I was just doing something else. I didn't pay attention.
Okay, so when you got to the gun range, we saw in the video you carried it to the counter. Is that accurate?
Yeah.
Okay, the jury's seen all this, 5 bullets, and then you guys go shooting, correct?
Correct.
Okay, we obviously see you and your son. That shows the whole experience while you're there.
Correct.
Okay. So while you're there, how interested were you in shooting that weapon?
I shot it a couple times. I don't know. Shooting's kind of boring. I'm more like skeet shooting, where actually something's going on. So I shot it a couple times, and he did the
I
rest.
agree.
Okay. And
Boring at the range. Skeet
did you
shooting's
end up
fun.
posting something about it being a Mother's Sunday?
I did.
How did you feel about that day?
I mean, it was a fun day. He asked me if I wanted to go to the shooting range with him, and he's never asked just me to go before. My husband was doing DoorDash, and I felt good about it.
How many times had you been to the shooting range before that day?
Once.
And when you went the one other time, who else was present?
My husband.
So this was the first day you're the only adult going.
Correct.
Okay, so after we see obviously in the video you carry the gun in the case out. Did it have the cable lock on at that point?
No.
Okay, so what did you do from there?
This is when we're leaving.
Yeah.
I put the gun in the back of my vehicle and drove.
Explain where in the back of your vehicle.
So in the back of the SUV, it has a little thing that opens up where the spare tire is. I put under there.
Okay, and then where did you go?
I went home.
And did you take the gun in the house?
No, I took the bullets in the house and hid them, and my husband took the gun in the house when he got home from work.
Okay, so was there a period of time that the gun was not in the home but in your car?
Yeah, probably for a couple hours.
Okay, why is that?
I just don't feel comfortable with it. I don't. That's his thing.
Okay, so on that Saturday, it was left in the vehicle and your vehicle was locked.
Correct.
Do you know if the gun was brought into the house and put away?
Yes.
Okay, how do you know that?
My husband told me.
Okay.
Yep.
Did you watch him do anything in terms of putting it away? Or if you didn't, just let me know.
No, I didn't.
Okay. The next day is Sunday, correct?
Correct.
And on that day, was there any, do you recall any issues with the weapon, any issues with the gun?
No.
Okay. Now, when the next day is Monday, is that right?
Correct.
Okay. What did you do on Monday?
I went to work.
Okay. And on Monday, we heard the voicemail you got. Is that accurate?
Yes.
Describe for the jury overall what happened or what you were dealing with that day.
I received a voicemail on my phone while I was at work. It was Pam Fine, one of the school counselors, calling to let me know that my son was looking at bullets in class. She let me know that they had a meeting with my son and that he said what he was doing was wrong, admitted responsibility. They gave him an example about teachers, even they brew beer at home, should be looking it up in school. And it was
Yeah, just by way of by friends here. I've been watching other chats, and yeah, I mean, a lot of the answers could go the complete, interpretation of the answers could go the other way. So I don't know. I'm not sure about this.
It was kind of upbeat, and then she ended up with, he understood. He went back to class. Just want to let you know. If any questions, please give us a call. Have a good holiday.
Okay. And on that date, did you call Miss Fine back?
No, I did not.
What was your reaction to getting that message?
I mean, it was pretty black and white. I mean, she said what happened. They seemed like they solved the problem, and I didn't have any questions.
Okay. So on that date, did you end up saying anything to James about it?
I believe I did.
Did you say anything to your son about it?
I did.
What did you, and I think we saw text messages. You said, next time, don't get caught.
Yeah, I said, seriously looking at bullets in school. And then he went through a long couple of texts about teachers looking at his stuff. And he was worried about he was going to get in trouble. And then I said, next time, don't get caught.
What did you mean by that?
So there's an ongoing thing in our house. Someone always asked me the trouble I would get in high school because I was a little bit of a troublemaker because I always got caught. Like all my friends could be doing the same thing and I'd be the one to get caught. So I was kind of referencing to that.
Okay. So you said that, and did you feel you had to discipline him or do anything beyond talk to him about it?
No, we talked. I listened to the voicemail and that was that.
Okay. Now, I'm going to go back for a couple minutes to talk to you about some exhibits the prosecution introduced from earlier in the year. Okay. So I'm going to start with what's been admitted as exhibits 155 through 160. Okay. I'm going to pop them up on the screen and we're going to just talk about each one briefly.
You have to.
So I'm going to go to 155.
Not rehearsed, but they went over this. They've talked about this. She's asked this question.
Plug my.
So she knows what the questions are.
It's not hard to plug it in.
What her answers are.
Okay. So I'm going to start with 155. Okay. This was already admitted, so we're not going to belabor this. Okay. Oh, I'm sorry.
The phone call not returning to school was the school then said the school
There it
said.
is. Okay. So we've
Call
already
back if you have any
talked about this with other witnesses, so I'm going to go
Was it?
a little bit faster. If you need me to slow down, let me
She didn't have
know.
any
Okay.
questions.
This is Ms. DeRiker's email with her and Sean Hopkins. She's telling him, when you get a chance, can you call your son down and see how he's doing? He's failing my class, tries to sleep all the time in class. Sean responds, I'll catch him by the end of the day. Thanks, just a little worried. And that's that. You heard testimony about that, correct?
Correct.
Were you ever aware there was a time where your son was failing a class and trying to sleep all in capital letters all the time in class?
I can't remember what class director was. So I'd probably be aware if he was failing that class from Power School, but I was not aware that he was sleeping all the time.
So did anyone from the school let you know in May of 2021, hey, he's sleeping in class and failing?
No.
Okay, that was exhibit 155. And would that show up on Power Schools, that the emails between them?
No.
Okay, exhibit 166. This is from September 8th, 2021. It starts off with an email from Miss McConnell to Sean Hopkins. It says, can you please touch base with Ethan Crumbley? In his autobiography poem, he said he feels terrible and that his family is a mistake. Unusual responses for sure. He writes back, thanks for the heads up. I'm in senior meetings throughout the day. I'll try to catch up with him. Were you aware this was ever a discussion or an issue?
No.
Were you aware that Mr. Hopkins ever talked to or tried to talk to your son?
No.
Did anyone ever call you to make you aware of any of this?
No.
If you heard this, how would you react, or what would your reaction be?
All for speculation.
I'd be definitely concerned why he feels like his family's a mistake and he feels terrible. So that would be a concern to me.
Okay. So this is something you were unaware of.
Correct.
And in fact, when did you find out these emails existed?
When we started getting discovered.
Okay, so in this case.
Correct.
All right, so I want to go to 157. This is on November 10th of 2021. This is Miss McConnell sends Sean a message. Ethan Crumbley is having a rough time right now. We may need to speak with you. Sean writes back, I'm sorry, I was in a meeting through the end of the day. I'll catch up with him. Were you ever made aware that there was some issue on November 10th where your son was having a rough time?
No.
Did anyone from the school ever let you know?
No.
Did you ever see anything like this prior to us getting materials in this case?
No.
If you heard your son was having a rough time, what would you do to follow up?
I would talk to my son, find out what's going on.
Okay. And I am going to minimize these for 1 second. I want to go back to some other dates that were discussed and exhibits were admitted. And I'm going to go back to
They're all dismissed for
March
immunity.
20th. I'm sorry. Let's start. We go in order. So March 16th of 2021, the prosecution has admitted exhibits 85, 86, 85 through 94, and let's see here. 85 shows you guys are making plans, and you say, I'm going to get drunk and ride my horse. Can you explain to the jury what you meant by that? And I'll get it up on the screen.
I was going to have some drinks and ride my horse. It was St. Patrick's Day.
I'm sorry, that's on the
What?
17th, right? Okay, the 16th though.
What did you mean by that? I was going to get drunk around my horse.
Oh, I'm sorry, you're right. Okay, so explain that again. So let me get it up on the screen because I'm messing up. Okay, 85. Okay, so 85,
you were actually going to do that.
I'm sorry, you're right. So on page 85, 432 is the page number. You write, I'm going to get drunk and ride my horse. What was your plan that night?
I was going to have a couple drinks and go for a trail ride with my horse.
Okay, did you do that night?
Yes.
And on people's proposed
I mean, it might be
exhibit
truthful.
86, or their
Don't write it.
exhibit,
Yeah.
this was
Don't write down things, people.
Come on.
That's bad. I mean, okay, it makes her look bad, right? The question ultimately is, did she neglect her son? And if on St. Patrick's Day she's having a few drinks and kicking back on her horse when her son might have issues, it just doesn't look good. And again, this is all in hindsight. She doesn't know anything's going on. This doesn't tend to prove that she knew anything. It just looks bad. That's all. It just
Why? What is everybody? Okay, so I missed something. What is the thing about don't get caught?
So Ethan had looked up bullets at school, and there was an email that went, or a voicemail, sorry, that was left for Jennifer about that, and said, "Hey, everything's fine." He said it was a hobby that you guys go shooting. I sent him back to class. Call me if you have any questions. Otherwise, have a good holiday. And so she texted him, Ethan, and said, "Really, you're looking up bullets?" And he said, "What? Oh, yeah, I already talked to the teacher about that. It was no big deal. They were snooping on my phone. Stupid privacy." And she's like, "All right, well, you can't be doing that in school. Next time, don't get caught. Learn not to get caught," or something along those lines. And her answer to that is that it was an ongoing thing in the discussion in the household that Ethan would always get caught when his friends were doing the same thing and his friends wouldn't get caught. And so it was an ongoing discussion. Well, don't get caught then, and so that's
Yeah.
what she was referencing.
I mean, that makes sense.
Yeah, I have those same ongoing conversations with my son. I say don't be stupid. But what it means is, how about don't do it in the first place? Don't get caught doing it in the second place. Don't post it on the internet. It's
Yeah.
a general encompassing of don't be stupid. So,
Yeah. Okay.
oh, she would always get caught when she was in school, not his friends. I thought she mentioned though the friends too. So, or maybe it was she would always get caught and her friends wouldn't. That's what it was.
Oh,
You're
okay.
right. Thank you for correcting me.
It was a text thread between you and your son. Let's see here. This is a text where the prosecution admitted to show that your son texted you, okay, the house is now haunted. What time was that text at?
It says 6:03.
Okay.
I don't know if this says -4. I don't know what that means.
Okay. And then the next text, some weird shit just happens and now I'm scared. Next one, I got some videos and a picture of the demon is throwing bowls. I'm not joking. It fucked up the kitchen. I'm just going to be an outsider for a while. Can you at least text back? Okay. Do you recall this day on March 17th, 2021?
It didn't stick out to me until this whole. No, I don't recall it exactly. I just remember it ever since we got discovery on this case.
Okay, so on March 17th, there was a point when did you ever see these texts?
I probably didn't. Not that time.
Do you recall seeing these texts at any point prior to this case?
I'm sure I did, but they weren't. No, I don't know. I mean, I'm sure I saw them, but they just didn't stick out to me until this case.
Why didn't they stick out to you?
Because it wasn't anything that was anything serious. It was Ethan just messing around.
You got to explain to the jury, how did Ethan mess around?
So he's been convinced our house has been haunted since 2015. It was built in 1920. Around that time frame, him and his friend would go down to the basement and play a Ouija board. So they thought we had a house ghost. So it was around that time when he would mess with us that things were going on in the house. Silverware was flying across the room. Doors were slamming. He actually took a video of the door and showed me when I got home. And you can clearly see where he's standing back with his phone, looking at the door that's open. You can see him walk up the door and you can kind of see him slam it and him trying to say, see, our house is haunted. So it was that kind of stuff that he did.
Okay, and did that continue on into 2021 when you'd get messages like this?
Only a couple of times, but I think he just got over it. Like it wasn't. He got bored with messing around with the ghost.
Did you mess around with him?
Yes.
Okay, what did you do to him?
When they were downstairs in the basement playing Ouija board one night, I went and flipped the circuit breaker off in the house, and he thought it was the ghost they conjured up on the Ouija board.
Did James ever mess around with you or with Ethan?
Yeah, a little bit.
Give us an example of what he did.
He said a lamp fell off a ledge in the basement, and so he named the ghost Victoria. So he was convinced there was another house ghost. So just kind of like an ongoing, like our house ghost, we called it. My son named it Boris Johnson. My husband named it Victoria. It was just a little phase.
Was there ever a time where James pretended he got electrocuted?
Yes.
What did he do?
We were remodeling our living room, and he was taking the old ceiling fan down and having to figure out what wires go where to the new ceiling fan. And as he was reaching up, he pretended to get electrocuted, and he fell on the ground and was shaking. And I ran up and I kicked him. I don't know why I kicked him, but I did. And then he stopped. And I realized he was joking, and my son had the phone recording the whole time.
So this kind of stuff between you, your son, and your husband was like typical joking around kind of stuff.
It was.
Okay, so when you look back at these texts now and you see that there's a demon throwing bowls and things like that, now looking back, do you think, oh my gosh, he had mental issues?
No,
What do you think was going on?
just what I said, that it was just him messing around. He only did it when we weren't at home, and it was for a short period of time, and then he got bored.
Okay, so on that date, the prosecution admitted all kinds of stuff to show you were with your horse, and James was with your horse, correct?
Correct.
And you guys were with your horse?
Correct.
How long would you have been out there? What was a typical trip to the barn?
Usually about 3 hours. It takes about a half hour to get the horses tacked up and ready. We usually rode for about an hour, and then anywhere from a half hour to 45 minutes to cool them down.
And with respect to the horses, did you and James go out there? Did you go every day?
No.
How did that work? Who went? How did you guys pick?
Whoever felt like going or had the most availability. Sometimes I'd work late, past 6 o'clock at night. I couldn't go. There's nights that my son had to go to bowling that had taken. It just, whatever happened that day, we just say, I'm going, or you're going, or it just was a day by day thing.
Okay, so I'm going to skip ahead. This has been admitted as Exhibit 84. This goes to March 8th and 9th. Okay, do you remember talking about those dates?
I think so, yeah.
Okay, now on those dates, the prosecution admitted Exhibit 84, which is up on the screen. These are texts between James and you, and it looks like you're saying you're going to have to skip the barn tonight. Do you recall that?
Yes.
Okay. And then you ask, is Ethan going to bowling?
Correct.
James says IDK. What does that mean?
I don't know.
All right. And you ask him about that. Okay. And I want you to describe, what are you doing in these text messages up on the screen here, these 4 in a row?
Can you go back to the green one?
Yeah.
Okay.
Here, I'm sorry.
That's fine. I got it now. I was just texting him, asking him if he was home from school yet.
Okay.
And if he had his phone on him.
So you're texting.
I think looking at this, we must have gotten into an argument about his grades and took his phone away the night before, which is why I was asking if he had his phone on him.
Is it common for you to text repeatedly about someone? Are you home? Where are you?
Yes.
Okay. So in your messages, is it fair to say we're going to see that a lot from you?
Yes.
Okay. Your husband wrote back, he does not get home till 3:16. Did you know what time Ethan got home every day?
I knew it was after 3, like shortly after. I wasn't sure to the minute.
Okay, well then you wrote, I told you to pick him up because he's upset and I don't want him to do anything stupid, God damn it. What did you mean by that?
I don't know, just if he walked home, I was worried if he was upset, he would just walk to Little Caesars or Frosty Boy and not let us know, and then I'd worry, or he'd take the route through, there's some kind of woodsy area to get to the trail to our house, and there's some homeless people that live back in there. It was just more or less, I was just worried about him just not wanting to come home because we got an argument the night before.
So when you say I don't want him to do anything stupid, were you worried he'd hurt himself or anything like that?
No.
And James responds, dude, chill, he is fine, and I am trying to fucking work. Your next question, does he have his phone? Is that right?
Correct.
Okay. And then he says he won't answer while he's walking. The exhibit speaks for itself. And then you start up with, I'm seriously freaking out. Is he home yet? And then it looks like a blank message. Yeah. Why are you freaking out so much?
Because he didn't tell me he was home. So, and I think he must have, I don't know, just me with work, I couldn't get a hold of him. So it was like, why can't I get a hold of you? Why can't I get a hold of anybody?
Okay. Did this concern you ultimately that something happened that day, or did this get resolved?
I think he just got home and that was it.
Okay. Now, the next day, which would have been the 9th, you and James, we can agree, went to the barn together that day, correct?
Correct.
The prosecution provided a picture, GPS exhibits, phone data exhibits, correct?
Correct.
All right. On that day, we agree you guys are at the barn together.
Correct.
Okay. I'm going to go to the prosecutor's exhibit 82 that was admitted. Okay. And you send him a message to Ethan that says, where are you? Or Ethan sends you a message that says, I'm sorry. You send a message to Ethan saying, where are you? At 3:17 and 32 seconds, UTC -5, correct?
Correct.
All right. So then Ethan sends you all these texts. Can you get home now? I think that someone's in the house. Someone walked into the bathroom and flushed the toilet, left the light on. I thought it was you, but I came out, no one was home. There is no one in the house though. Dude, my door just slammed. Maybe it's just my paranoia. But when are you going to get home? Okay, what was going on that day?
So if you go back to the beginning of the thread.
Okay.
Is it the beginning? So you can see the time on there. That was the time I'd be driving home from the barn. And when I got home, he just asked me why I didn't answer the text. And he said weird stuff was going on in the house again. And that was that.
Okay, when you walked in, do you recall discussing these messages with him?
It was mainly, I've been trying to text you. Why don't you answer? And I told
He
him,
said that or you said that?
he said that.
Okay.
And I told him I was driving home. I wasn't looking at my phone.
So why weren't you looking at your phone, or what's going on with did you have a signal? Do you not have a signal? What's happening?
I could have had a signal. I don't know. I probably just had my phone in the front seat of the passenger side and didn't look at it.
Okay. When you're out at the barn, do you get every text that people send you?
No.
What's your signal like out there?
I have Metro PCS, so it's not as good as somebody had AT&T and Verizon, but there's very limited spots.
That's like the lowest. That's like
at any
that's
barn I've been
rent.
at where there's any type of signal. Usually you have to find the one spot you'll see everybody
Metro
standing
PCS
at
works
talking
in
on the
the
phone,
city.
but it's not all over the barn.
What about on the roads to the barn?
So that barn we were at, it was between Oxford and Groveland area. So all those roads, once I pass the market, there's no signal until I got to a fire station. Then I have a signal, and then once I pass the fire station, I wouldn't have a signal. When I hit a grocery store, I'd have a signal. Once I got past the grocery store, all the way to the barn, I had no signal.
Looking back on these texts now from March 9th, okay, seeing him say, there's someone in the house, I think. Someone walked in the bathroom and flushed the toilet, left the light on. Do you think he was having mental issues that day?
No.
What do you think? What is your conclusion about these messages at this time?
He was just messing with us.
Okay. Is this the kind of messing you previously talked about?
Yes.
All right. I want to go to March 20th. This is People's Exhibits 96 through 100. They established on this date you're out at the barn. This is you. Yes?
Yes.
Okay. And another picture of you.
Yep.
And we've got data showing that you were out there, correct? And there's a text message exchange that was admitted as People's 96. I'm going to put that up on the screen for you, okay?
Okay.
So in People's 96, this is between you and your son, correct?
Correct.
He says, can you at least text back? You're asking, where's your dad? Text me when you're done yet? And he starts up with, I finished picking up the room. I cleaned until clothes started flying off the shelf. This stuff only happens when I'm home alone. I picked the clothes back up though. That's at, it looks like 2:34, and we may be off by an hour or so because it's that UTC. This one's -4. Your next text is jumping in shower, text your dad if I don't respond. And your text, no matter what the time zone is 6 hours later. Do you recall getting these texts?
It's 2 days.
Messages?
It's 2 days and 6 hours later.
Oh, I'm sorry. You're right. 2 days and 6 hours. So do you recall, though, getting these couple on the 20th about, I finished picking up the room, I cleaned until clothes started falling off the shelf. Do you recall that?
Only when we got discovery.
Okay. Now, looking back on these days, are you thinking, oh my God, he thought things were happening that were crazy?
No.
Do you think anything of it now?
No.
What do you think is happening in those messages?
I just think he was messing with us.
Okay, so those are 3 times where you guys are at the ranch and he's messing with you. Is that a fair statement?
Yes.
Sean, have you watched any of this? Oh, you're muted, man.
I just got back from the airport.
Oh, okay. Yeah,
how
she's
is
been
she-
testifying for about an hour.
Oh,
Well,
really?
actually, hour and a half.
Okay.
Hour and a half, something like that. Yeah. So they started off with going through a bunch of Facebook posts, basically going back years, showing normal activity all the way up until November 27th when they went Christmas tree hunting. She said that she admitted to getting drunk and riding a horse, which wasn't the best thing, but she's like, yeah, it was St. Patrick's Day. I had a few drinks and I went, trail riding. It seems honest, right? So
Did they get to the, you said there's text messages where Ethan said like, well, I can't find my gun because my dad hid it. Did that ever get brought up before the state closed their case?
It was attempted to get in. It was in a journal entry, and the judge excluded it and said it could not come in.
Why? Because he's not here?
Yeah, essentially. But they allowed 5 or 6 other parts of the journal to come in.
Well, I don't understand. I guess I don't know.
I know. We had Kurt on here, and he was ranting and raving. He's like, I don't get it. I don't get it.
If it all either all can come in or it can't come in.
Right, exactly. Well, they didn't want it all in because apparently all of it in looks bad. So the defense counsel was like, all right, well, then I'm not going to fight for it to come in. If you're going to say, Judge, then it all comes in. I just want these 2 lines. I'd rather not have any more of it come in than all of it come in.
Did she proffer at least, I hope?
She did. She did.
Okay,
It's
good.
all on the record. So, yeah.
Okay, good. All right, well, don't mean to interrupt.
And at that time, that was months and months before November. It was in March. Is that correct?
Yeah.
Okay, so beyond March, was there other times where he was saying these goofy texts and messing around?
No, I don't think so.
So there's 2 more dates I need to ask you about. I'm going to go to April 4th. Which was a Sunday, and that is going to be exhibit that was admitted 101. Okay. So exhibit 101 are text messages. And these are between, who are these between?
Those were between my son and his friend.
Okay. Now, prior to this case, did you ever see any of these messages?
I did not.
Were you aware any of them existed?
I was not.
Okay, so this is from April 4th, and your son's saying, he's the one sending messages that say, I hear people talking to me and someone in the distance. I actually asked my dad to take me to the doctor yesterday, but he gave me some pills and told me to suck it up. Like, it's at the point I'm asking to go to the doctor. Was there ever a time where he asked to go to the doctor around this time?
I don't think so, no.
Then he says, my mom laughed when I told her.
Yeah, don't read them. Just
Was
say,
there
have you ever
ever a
seen
time
them?
where he's asking for help and you're laughing?
No.
He writes to his friend, and this is just later that night, but I'm having bad insomnia and paranoia, and I need help. I was thinking of calling 911 so I could go to the hospital, but then my parents would be really pissed. Okay, so this is all one long conversation. Is that right?
Correct.
He says, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again, but this time I'm going to tell them about the voices. This text message or instant message thread, were you even aware of this?
No.
Do you remember any time where he came and talked to you and said anything about hearing voices?
No.
Do you recall there ever being a time where he asked you to go to a doctor or to get help and you said no?
No.
Or laughed at him?
No.
So when you see these texts with his friend, do you have any idea, and if you don't, that's fine, do you have any idea what he's doing with his friend?
I don't have any idea.
Okay. Do you know if him and his friend messed around with each other like you and your husband do with him? I'm sorry.
He should have to have personal
When
knowledge.
you were testifying earlier, you mentioned that your son and his friend would play within a Ouija board. Is that right?
Right.
when did that happen or in relation to 2021?
I know he got the Ouija board for Christmas of 2020. So for a few months after that, they were really into playing it, and then they got bored with it. It's probably sitting on our shelf getting dust.
Okay. On April 29th, I'm going to turn your attention to that day. Do you recall texting his friend's mother? And I'm going to put up exhibit 104 on the screen. Okay, do these texts look familiar to you?
They do.
Okay, who are these between?
These are between me and his friend's mom.
Okay, and you say, you start off with Ethan is, I'm sorry, my son is in bowling tonight. I just want to let you know, not sure if he needs a partner. Why are you texting that?
I don't know why he wasn't bowling tonight, off the top of my head, but they had partners on certain nights of the week, and so him and his friend were always partners. So I was letting her know that he wasn't going to be there.
Okay, and this is on one date, April 29th. Did you talk to her on other dates, or is this like the only time you talked to her?
We've talked back and forth quite a bit.
Okay. Now on this date, you say he's been acting kind of depressed. I don't know what's going on. I'm not sure if there's something bothering him at school, but he doesn't really feel good. I can't get anything out of him. Friend's mom mentions he stayed home from school today too. The only time they're happy is when they're together. Talking about grades, you mentioned this is all new to me. I'm not used to my son being moody. He's usually pretty happy and we'll talk about anything. I do know he's been stressed about school and his grades. We called the school, but she wasn't in social do it tomorrow. I think his grades have a lot to do with it. I just got to a point where he's got so far behind and we were out of town. He's having difficulties making it up. Where were you guys out of town?
In Florida, my mother-in-law had passed away, so we were gone for a couple of weeks in the middle of April, taking care of funeral arrangements and everything.
And at this time, when you describe your son as being moody or depressed, did you think it was anything that warranted getting medical attention?
No, he was just being quieter. He's a quiet
up.
kid. He was just being quieter than
This is
normal.
testimony helping the defense.
And I'd ask him if everything's okay. He'd say fine, but I could just tell he was a little sad. And I thought maybe I hadn't seen his friend in a couple of weeks. So I don't know if maybe they got into a fight and they weren't talking. So I was asking her if there was anything going on with his friend, which might have caused my son to be quieter than normal. But I think he was just really stressed out because those 2 weeks that we were in Florida, he got pretty far behind on his grades.
Okay, so then it goes on and you end up saying, yeah, me too. I'm glad they're getting along. And it wasn't an issue with those two as to why he was being depressed. The online school is horrible. I've given up too. I told him just to do his best. Don't worry about it. Next year's a new year. And then maybe if his friend is feeling better, he wants to come over to work. And then you're talking about shooting up a gun range in the backyard, correct?
Yeah. Targets.
Okay. So did this issue of him feeling depressed or acting moody, this one period of time, did that go on or did that discontinue?
It discontinued. I mean, it was a little phase. And he seemed to be fine. Him and his friends started coming over more. I think it was more or less his friend wasn't coming over as much, and he just seemed quieter than normal.
And you guys
There's
were
a
out
lot.
you had just been out
There's, I mean, the state has spent 6 days building up a case against her. She's going to be on for a while. Don't you agree, Sean? I think that's appropriate.
Oh yeah, I mean, we spent how long taking a crap on her?
Yeah, 5.5
Been a while.
days. Yeah,
Yeah.
this is going to be a bit.
Right. Yeah. And he just
I'd be
lost his
concerned if it
grandmother,
was
so
short.
That was sad too.
Okay. All right, and then there was one other conversation that you had with his friend's mother that the prosecution introduced as Exhibit 105. I'm going to put that up, okay?
That is legally live. She's got a YouTube channel.
So this is
The link
actually
is in the
from, let's see here, starts off
A lawyer out of Texas.
on, I'm going to go to Halloween, so 10/31 of 21. You say to her, James filled me in on his friend last night. I'm so sorry you guys are having to make such a hard decision. Please let me know if you need anything. What was that about?
We had found out the day before Halloween that his son, my son's friend, went to Wisconsin to an OCD treatment school. We we didn't know. We had Halloween plans. And we were texting with his friend's parents about his friends still coming over to carve pumpkins on Halloween because they do that every year. And then they go out and trick or treat. And we didn't hear from him. And all of a sudden we got my husband found out through his friend's dad that they drove to Wisconsin and he's at an OCD treatment center for at least 90 days. So it hit us really hard because we didn't really expect it coming. He didn't expect it coming. It was hard.
Did you do anything different as a parent when his friend was taken away, essentially, to the hospital or the other school?
I don't understand.
Did you do anything different as a parent in terms of spending time with your son?
I mean, we did as much as we could.
Okay, tell us about that. Tell us about that month.
I think we did more family game nights than normal. He was working a lot.
What's that noise?
What is that noise?
I would check in with him, make sure he's doing okay. That's when I started asking him, do you have friends at school that you can hang out with? And if so, you're more than welcome to invite him over.
Okay.
I was more on point of the fact that he was sad.
Okay. And even though he was sad, did you feel like there was anything where he needed help or needed mental health treatment?
No.
Was there
Destruction
was his
button.
loss of his friend being in his life anything that made you think he needed counseling or a therapist?
Not to that extent, no.
I'm gonna unplug this so that we can go back to some questions that don't involve exhibits, okay?
Yeah, it sounds like the wrong door was open. They have alarms on doors, and if you
Okay.
open it without hitting your card first, it beeps.
So we were talking earlier about the mother-son gun range day, right?
Correct.
You've already told the jury how the gun was put in the car and taken out. Okay. Now, did you ever tell Brian Maloche about the mother-son day at the range?
I'm sure I mentioned it, yeah.
Did you ever tell Brian that the gun was in your vehicle?
Yes.
Okay, when did you tell Brian that the gun was in your vehicle?
On the day I went to the shooting range.
Did you tell Brian you put the gun in your car the day the shooting happened?
No.
So when he testified to that, was that accurate?
No, I think he was confused.
Okay. Did you specifically tell him about the gun being put in your car that other time?
Yes.
Aside from that time that you drove to the range, was the gun ever in your car?
No.
Were you aware Brian had memory issues?
No, I was not.
Brian testified that he never met Ethan. Later in his testimony, he said he did. Did he ever meet Ethan?
Yeah, a couple of times at the barn.
Okay.
And we went, he came to our house, he helped deliver a big TV that we got, and my son was there.
Well, did you ever tell Brian anything about your son saying things or making you upset in any way like that?
No.
Did you ever tell Brian anything about he had mental health issues that you were worried about?
No.
So when we read your messages, which the prosecution admitted, the 77 pages, okay, it's fair to say the jury can read what you guys talked about and you reflect on you talk about the past with Ethan, correct?
Correct.
Okay, so the jury can read those. We don't need to go through those. You agree?
I agree.
Okay. So we got to Monday. Monday is 2 days after you guys go for the Mother's Sunday at the shooting range. Monday, Miss Fine leaves you the voicemail. We talked about that already. Talked about you talking to your son about it, right? Okay, I want to go to Tuesday, the 30th. Okay?
Okay.
Do you remember Tuesday the 30th?
I do.
And that day, we saw an exhibit of you going into work. That happened?
Yes.
Nice.
And we heard
Thank
lots
you
of
for the
testimony
$4.99
already
subscription.
about you getting a call from Sean Hopkins.
Correct. He left me a voicemail and I called him back.
Okay. When you called back, Mr. Hopkins testified that he sent you something. What did he send you?
He sent me a copy of a math worksheet that had the scribbled out drawings on it.
Okay, and I want to ask you, the night before that scribbles out drawing thing came to you, did you have any interactions with your son?
Yes, we did.
What were those about?
I saw in Power School that he had an E in geometry. So we got in an argument again about his grades. We took his phone away and told him that he couldn't go to the shooting range until his grades were brought back up.
Okay, so you guys had this argument the night before. We saw lots of messages where you thought everything was fine that Tuesday morning. Is that how you felt?
Yeah.
Okay, so when you got that math paper texted to you, do you recall saying anything to Ethan on the phone, on speaker?
Yeah, I asked him why he did that.
Okay, what were you thinking at that point?
I was actually kind of angry because I thought he did that in like defiance of us yelling him about missing assignments, and here he is drawing pictures on an empty assignment page in geometry.
So you felt like it was specifically.
That's not that. I mean, I'm assuming it's true, but that's not. I mean, that's a good thing to say, right? So she's been saying like they've been struggling with him not getting his assignments turned in. By the way, I understand the frustration with that. And they had a big argument the night before about his grades, and then he's drawing all this stuff on his assignment rather than doing it in class, and thought that this was just him smart mouthing off.
Yeah, no, I totally get it. But say, I
Makes
never had to
so
worry about
much
that because
sense.
my parents would have beat the brakes off me. So
Right?
Yeah. No, but that makes total sense as to why
does.
they're like, yeah, no, this is not a big
like,
deal.
okay, yeah,
I'm
he's
pissed
being,
at you.
He's being a douche. We get it. Yeah.
Yeah.
She's like, I know how my son acts.
Him sending you a message about the night before.
Yeah.
Is it fair to say you took it personally?
Yeah, I did.
Okay, so what did you do?
I had asked Mr. Hopkins if he had the original, and then he sent it to my email, which then I opened up and looked at it, and it's like, okay.
What did you think when you saw that?
I was a little concerned. I was pretty concerned. He had asked for a parent to come to the school to meet with them, and at this time I tried calling my husband to see if he could go because he was out in the area working, and I couldn't get a hold of him, so I decided to go to the school. On the way to the school, he finally called me back, and he met me at the school, so we went together.
Okay, and when you went into the school, what did you think was happening?
I thought he was gonna get in trouble for what he drew on his assignment. I thought I was gonna get suspended. I was expecting a disciplinary meeting.
Okay, how did you feel about what you saw on that paper?
I felt concerned after seeing that.
Okay, and so we saw that you sent pictures of the math papers to Kira, to Andy, to Brian. It's fair to say you sent them around to people.
I did.
Okay, and to all those people, we've already seen all the exhibits. You expressed that concern.
Correct.
Okay, so what happens when you get to the school with you and James arrived separately? I think the detective testified that he was wrong at first, thinking you went together, but you guys were separate, got there at the same time.
Correct.
Went in. What was it like walking into the meeting with Mr. Hopkins and Mr. Ejak? Who was there?
So when we first got there, Mr. Hopkins met us out in front of where the administration is and walked us back to his counseling office. When we walked in, it was just him, and then my son was sitting in a chair in front of his desk, working on something on his laptop. So when he walked in, he kind of showed us where to sit, and then we shook hands, introduced himself, and started the meeting.
I think her testimony is good. I think it's needed. I think she's hitting a lot of points. I like the fact that she's being honest when she says, yeah, I had a few drinks and got on the horse. That's what I texted. That's what I did. I liked her answer to the last thing. I'm not a huge fan of the style of presentment, but the points I think are good. McKinley, what are your thoughts? By the way, McKinley, Legally Live, is an attorney in Texas, criminal defense attorney as well.
I think it's going well. This part is really sad to me, but hearing her explain it has really Well, it was necessary because now I understand the concern and the reason for sending it to other people. All of that's starting to make a lot more sense. So I think that that's good for her.
Yeah, I do too. I don't know if Sean stepped away for a second, if he's still
No,
here.
I'm still here. I'm still here.
I don't know how much you've heard, but what do you think so far?
I
The
mean,
little that you've heard.
I haven't stepped away since I've been here. I mean, it sounded good, but I guess I got to miss the beginning. So it seems like I've only been here for the tough parts. And I mean, yeah, there's only so many ways you could talk about how this all starts to go down from here. So I think they're doing okay. I think she's doing good, but hey, you're good. Every defendant general looks like $1 million on direct. So
Yeah.
we'll find out when the
audio's
come out.
Yeah.
Your audio's cutting out a little bit. I just
Oh, it is?
adjusted
Oh,
it,
hold on.
but we'll see.
Sorry. Is that better?
Yeah, that's good.
Yeah. I mean, she's doing good, but she's supposed to look good right now. We'll find out on cross.
Yeah.
Did you try to hug Ethan or do anything like that?
I didn't.
Okay. And when, how did that meeting go?
It was pretty nonchalant. It was pretty brief. He started to talk. He basically filled me in on what my son and him were talking about for the last hour and a half. He said that my son told him that he was feeling sad over the death of a dog that we had. My mother-in-law, the loss of his friend. So we talked a little bit about that. We confirmed it. We decided we agreed it was hard on him. He told us that he didn't feel my son was a risk, and actually gave him the option if he wanted to stay at school or go home. My son wanted to stay at school, so we all discussed that.
Did you feel like you were taking the position of, I am leaving him at school whether he can be here or not?
No, absolutely not.
Okay. Were you surprised or were you not surprised? Did you have any feelings about whether or not he could stay at school?
I didn't really. I thought the advice that they were giving us was a good advice. We talked about him being sad, and then he said being around peers usually helps. We all agreed to that. My son gets very stressed out when he does virtual school, so we agreed that it might stress him out more to do his school remotely the rest of the day. But there was never a time where I would refuse to take him home. I could easily, if he wanted to go, take him with me. I had no issues with that.
Okay, so ultimately, did you take a paper from the school?
The counseling papers, yeah.
Okay.
There is a stack, like maybe 10 sheets with multiple counselors listed on them.
Okay, and were you planning to do anything with that sheet?
Yeah, actually, we were going to start. I gave it to my husband out in the parking lot, and I told him I had phone calls at work the rest of the day, so I told him to start making calls once he got done doing his DoorDash.
Okay, now the prosecution introduced and admitted an exhibit, which was a search off of Yahoo about clinical depression treatments. Do you recall ever Googling, but do you recall ever searching that topic?
I don't, and I don't usually use Yahoo as a search engine. I always use Google, so I don't know. I don't recall it, no.
Okay. Do you recall how or if you ever saw anything on Yahoo about clinical depression?
I don't remember specifically seeing anything. I might have looked at something when my husband was going through a really hard time after his mother passed away. He was he was drinking a little bit more than usual, and you just tell that he wasn't right. So I might have looked at something at that time, seeing if he was depressed, but not. I don't know where Yahoo came from.
You don't know how the Yahoo came to be.
Kind of throwing him under the bus.
When you're on Facebook and Instagram and all those things, do you ever hit the clickbait stuff?
Sometimes on accident. Sometimes I do on purpose.
Okay, so that search on Yahoo, you don't remember ever putting that in the search bar?
No.
Okay. But you are saying it's possible you looked at it. Is that?
It's possible.
Okay. All right. So let's go back. So you're at the meeting. How did the meeting end?
So we all decided that my son was going to go back to his class. So we wrote him a pass to go back to class. After he left, all four of us were in the meeting, and they asked if we had any questions, and we did not. And then I said, I'm gonna go back to work. And we left and I went to work and my husband did DoorDash. And
Did you mean to be abrupt about ending the meeting?
I didn't think I was abrupt.
Did you think you ended the meeting?
I think it just automatically ended when they asked if we had any questions and I said no.
Okay. So when there was testimony about that, I'm sorry, strike that.
Let me ask Ms. Smith, I don't want to interrupt you. I'm looking for a natural break.
We could do it now.
Well, does jury, do you need a break? Yeah,
Yeah, that's fine.
I just want to be considerate.
No, we can go anytime. That's
We're
fine.
gonna go on like a 10-minute, 15-minute break.
You're fine. That's fine.
So can you take a break until 5 after 3?
We've been unusually quiet.
All right,
here.
for the jury.
I kind of wanted to hear it. And I've been taking curious notes. So,
Is it okay if I grab these minutes?
What did you say?
so we're gonna go on a break, and I have been unusually quiet during this, but I wanted to hear it, and I've been taking furious notes.
Oh, good.
As much as I could write down. I'm not a stenographer.
So if I understand it right,
What's that?
oh, what is she saying?
I don't know.
And they've been, yeah, since 12:30. So we're going to take about 10-minute break to 5 after 3. Okay.
Judge, based upon the testimony, I need to pull some exhibits, so it'll be longer than 10 minutes. I'd like to get right into cross after her. So, I mean, we'll do that right now, but it'll be longer than 10 minutes.
I'd object. Fuck that.
If that's okay, we're
Good.
gonna
Run out of
need.
time.
You need to be prepared for trial.
Yeah, let's go.
Okay,
Let's
well,
go, counselor.
You've had quite a bit of direct left, I think.
You decided to try this.
Here's some.
I don't know how to.
I've gotten through 3/4 of it, so I'd say I have a quarter.
3/4 of her testimony.
And a lot of it is probably gonna go pretty fast because the exhibits speak for themselves and they've already admitted videos of all of it, so.
All right, you can take them down and, can you guys let me know then?
How far behind are we?
We're going to be on
Sure, we are talking
an
about
undefined
half an hour.
break until the prosecutor feels like they're ready.
There's.
No, I mean, are we caught
we're
up,
trying to
though?
avoid standing up and saying
We're
we
a few minutes
need
behind.
time and having
Okay.
to take another break, but
No, I get it.
we'll go as fast as we can. There's a lot of things she testified about.
Aaron.
He's wants to.
Right.
Well, I
No
was.
one
Remember,
cares.
I moved fast with their exhibits.
Oh,
I
it's
kept
good,
going.
it's
I
good.
didn't take breaks in
It's
between.
good. It's good. I'm more concerned about the jury sitting than anything.
Okay,
Yeah.
sure. Thank you.
But anyway, you would have said you should have been prepared.
All right. What was that?
I'm just annoyed.
No, I would have been like, look, you knew she was going to testify. Like, you should have been prepared.
Yeah.
Yeah, you should have been prepared. No, you get the 10-minute
And
break.
you know what we were going to argue? No, we didn't know.
Yeah.
Like, this isn't a shock.
Do I think something happened to Ethan at school and they're trying to cover up? I honestly have no idea. I mean,
Did he ever state why he did it?
No, no, not really. There are journal entries that talk about him just researching like death penalty and wanting to be going to be like a famous Michigan school shooter and stuff.
Yeah.
But nothing really as to why. So I just want to pull this back up. There's no sound. I just
So it sounds like he was just a loser, not actually a crazy person.
yeah, pretty much. Pretty
Oh,
much just a loser. Yeah, but there's not a whole lot of reasons why for anything. So yeah, no. Okay. I'm trying to digest this direct examination so far. At first, I felt like she came off very unemotional and detached from the situation, and I don't know if that would be good or bad, right?
Mhm.
So if you're just sort of stating things matter of fact, like I am right now, I'm not emotionally invested in the parties involved in this case, so I can talk like this. But for her to do it, actually, I think I said in the comments earlier, she sounds more like a mom testifying in her son's case than her testifying in her own case. You know, like, oh, Ethan was a good kid and whatever. You know, it just seemed more like that, like a mom giving a sentencing statement or something. I don't know. It was weird.
Okay.
We've got some time. Let's go back to the beginning because I just think it was weird. Unless you wanted to say something, McKinley, or something.
Yeah, the only thing I was going to say is the one part that I didn't like just now is when but I get she had to go to work or whatever, but just the not looking up the counselors herself right away when she had been so concerned. She sent the worksheet out to all those people, but that's it.
Well, I think she was relying on James. She gave it to James. He's got a job that's kind of running around, and she had phone calls scheduled. So
Yeah, I'm a single parent, so I don't really understand that, like, passing it off to somebody, I guess probably just because I don't have anybody to pass it off to. But that makes sense.
yeah, I don't know. It's just weird. Here, listen to the beginning.
I mean, I'm not going to lie. I would tell her there's a very good chance she
And what
gets
I'm gonna have
convicted
to
no
do
matter
is-
what.
I'm gonna leave this unplugged for a moment. See what happens when I just pull it. So that I'm not sure who you are. Do you agree?
Yes. We're hanging up. Okay,
Crumbley, and I'm the defendant.
Right, Mrs. Crumbley. Can you please start by identifying yourself? Tell the jury who you are.
My name is Jennifer Crumbley, and I'm the defendant in this case.
And how old are you?
I'm 45.
Mrs. Crumbley, the jury has heard so much testimony. Do you agree?
Yes.
Okay. I'm gonna go a little bit faster through things, and if there's something we need to explain.
I will say towards the end, no.
Or if
But
I'm
at
cutting
this
you
beginning,
off,
she
let me
seemed really
know.
nervous. Maybe that's what it
Okay,
was.
and you understand that as I speak, you have to wait for me to finish speaking?
Correct.
Okay, so Mrs. Crumbley, very briefly, go ahead and tell the jury what you did for a living.
I was a marketing director at a real estate acquisition company.
And how long did you hold that position?
5 years.
Now, does that kind of position include any kind of presentations or public speaking, anything like that?
Not a lot.
Okay. And how do you feel right now about talking to this jury?
Public speaking is probably my biggest fear. So very nervous.
Okay. And at times, you have been upset during this trial, is that correct?
Correct.
Are you okay to keep proceeding?
Yes.
I mean, she looks like she's about to lose her nerve.
I want you to tell this jury just a little bit about,
She does actually.
about your
I don't actually see
personality, and
somebody
think we've
uncaring.
seen
I
some
see
of it
somebody
on
like-
the videos. Is that fair to say?
Yeah.
Okay.
I was
let's
mainly
talk about
listening, I guess, because I was
when
curious to be
you
taking
have
notes.
a really stressful
she's teetering.
situation. What is your,
wonder if she's on
let's
medication.
say an animal dies in your family or a person dies in your family. How do you handle
careful
something
about-
like that, news like that?
I don't know,
go
but
into
I don't know
go
about using the
planning mode.
animal reference
I
there.
internalize things, and my reaction is to take care of other things that may have to be taken care of, like financials or things that keep the house running. I tend to hold things in, and I let it out when I'm alone. So having a lot of emotions for me is difficult.
Now, in this case, aside from this case, is that true in other situations of your life?
Yeah.
Can you give the jury like an example?
Yeah, my husband had a hard time holding down a job after his mother passed away. So when he would lose a job, I would actually be the one finding the ones for him and sending them from Indeed or Monster and taking plans of how we're going to put certain things on payments. It's just, I take control of things. That's just what I do.
Okay. And you, I want to talk to you. You mentioned your husband. When did you and James Crumbley meet?
In October of 2004.
And how long have you been together then?
It will be 18 years this September.
And are you still together and married at this time?
We are.
Have you spoken to him recently?
No.
How long has it
I'm
been
watching
since
the
you've
current
spoken to him?
A little over
If
2
they
years.
come back, we'll go
So
live.
since the day of the shooting?
Correct.
Or not shooting, the day you were arrested?
Correct.
You have a son?
Yes.
The jury's heard a lot about your son. Okay, I want to talk about your son prior to November 30th.
I feel like she's doing
okay?
good.
Tell the jury how old he
Not
was at
bad.
that time.
He was 15
Not
years
the
old.
greatest.
And give the jury an idea about what kinds of things he was into, what his hobbies included.
Oh, he was really into bowling. He was actually really good at it. He was into metal detecting.
What do you mean by metal detecting?
He would, we have a metal detector, so we would go to the beach, or we went to Florida out by the ocean or the neighbor's yard. They weren't there anymore, so you go in the neighbor's yard and see if you can find old coins or cans or whatever he would find. But he really liked that. He was into his BB guns and target practice. We had a half acre of land in the village of Oxford that went straight back. So in the backyard, we set up little targets that we got from Amazon that you can just kind of shoot down like little whatever. See, he was into his video games. He did soccer from age 3 until 9th grade. He had a lot of different interests. Coin collecting.
Do you have some interests?
I do.
Okay, we've heard about horses.
I like horses. I also snow ski. I'm a big reader, and I worked a lot, so I didn't have a lot of time to do the reading.
Okay, now when you say snow skiing, did you ever work? Oh, back up. Were there any activities that you and Ethan enjoyed doing together?
Yes. I joined the ski patrol because the family can ski free, and also to help people out. So I got him into skiing at the age of 7, and he would come out with me on my patrol shifts and come skiing with me. So we were in that together.
What about horses? Did he ever go out to the barn with you?
He did, but he didn't really like horses. The one horse I had was kind of aggressive, so it intimidated him, and it kind of turned him off from going to the barn. It's kind of boring if you're
Sean, what are
not the
your thoughts
person
so
with the
far?
horse. There's a lot of standing around, and
I think it's pretty. I think it's good. I mean,
So what?
you
would
gotta-
you spend time?
you
together
have to
with him
humanize
at
her
home?
and-
Okay, tell the jury.
she
what
sounds
kinds of
like
things
everybody
you
else
guys
who
do
lives in,
together, or
Oakland
is-
County, Michigan.
we
She
had a lot
likes to
of board
ski.
games.
She's got a
We
horse.
also had the virtual
You know.
reality set for the PS4, so we
Yeah,
did
no, I
a lot
agree.
of Beat
It
Saber.
sounded
and how we
normal.
did
I don't
that.
even know what
She
you're
sounds like
It's
someone.
it's like
She
a
makes
Hawaiian
cheesy
lightsabers. It has
potatoes
music,
for
and you have
the
to like hit the beats
for
but
the
it's all
party.
in 3D. So
Right.
it's a virtual
She's a
reality
regular
headset.
Midwest lady.
Okay, so you would do that with him?
Yeah.
Okay, what else?
We had a pool. We like swimming together.
I'm not bagging on
Um,
cheesy potatoes. I love them, by the way.
Me too.
Oh,
I mean, really just normal stuff.
the
Okay,
devil.
did you do holiday things?
We did.
Give us some examples.
So every year for around Thanksgiving, I always cook Thanksgiving dinner. The day
Of course.
after, we would go cut our Christmas tree down. And then we decorate that weekend. We watch National Lampoon's Christmas Vacation. Halloween, we grew our own pumpkins. So we always carved our own pumpkins and had a whole bunch put around the house. Easter, it's normal family stuff.
Did you
Yeah,
have
no, the prosecution claimed that he didn't know
interest
she was
in, like home
testifying.
improvement kind of stuff?
Yeah.
You're always on
Our
notice that
house
they
was
might
an auction
testify.
house. So basically it was wrapped in blue tarp when we bought it at auction. So we've been trying
Besides,
to
they
improve the
promised it at
house
the
since
beginning, so I don't know how you
2015.
can't claim they didn't
So
know.
we- New roof.
Right.
Exterior, and then I've been working on exterior and interior ever since.
That's the neat part, though.
Were there things that
Jennifer could
your
change her
son
mind
was
all the way up until that
interested in
time.
outside of
Yeah.
video games? Was there anything academic that he was interested in?
He really liked history. He was a big history buff. We can play Trivial Pursuit, and he would get me in history every single time. But that was probably his only favorite subject. The rest he could do without.
How did he do in school?
He did good if he applied himself. His problem was he didn't try as hard as I think he could, so he had up and down grades. I would say it's about average.
Okay, and when you say about average, was that something that you talked to him about? Was that something you monitored? Tell the jury about that.
Yeah, you heard about the Power School app during this trial. So I had it on my phone and I was on it multiple times a day. And his grades would fluctuate based on what assignments the teachers turned in on the Power School app. Our biggest struggle with him were missing assignments. That was the one thing we battled all the time.
Why was that a hot button issue for you?
Because there's no reason why he should have missing assignments. He had a homeroom class and get assignments done in.
Okay. There were, you talked about your job. What were the average hours you worked a week?
I usually I got to the office between 7 and 8 in the morning and leave anywhere between 4 and 6.
And we've heard lots of evidence already. It was family friendly. Were you
Looking at
able
the
to go
chat
and leave and go
on
if
the
you
other
needed to?
feeds
Pretty
and
much,
stuff, and
yeah.
they're all kind of split on this.
Did you care about your job?
I did a
Well,
lot.
Okay. Explain.
Actually, David, I do have a
did
big
you
question
have any
for you.
changes in positions?
Yeah.
Has anybody in there said how the jury's been reacting to all of this? Do we know?
No, I
Nobody's
don't
been
know.
able to comment. Okay.
No one. No, I don't have anyone that's been able to comment. I was going to
Okay.
reach out to a reporter that I know that's in there, but I haven't yet because I
Okay.
thought I might have somebody in the courtroom.
Hmm.
But it's like reading tea leaves, really. So I don't know how beneficial it'll be, but no, I don't have any information like that.
Okay.
It'd be really interesting to see how they responded to her. If they all sat up and were paying close attention, if they were nodding, shaking their head, things that I look for as a defense counsel.
Well, I mean, those 10 women have to sit there and look at her like she sounds just like me.
I know, right? I mean, that's what I'm thinking.
Sounds like my mom.
Mm-hmm.
Over the year or year and a half, 2 years before this?
I did. When I first started with the company,
That should be the rule, by the way. So it's like one attorney per party or per witness, right? So since he's doing the objection, he's going to be doing the cross. And I think he's going to come off as
that's not the best. Yeah, it's better if the only female prosecutor up there was Karen, right? Or was there another female? Oh well,
no, just Karen.
Oh, he's the one doing the objections. Oh yeah.
Does Karen have the? Did Karen present any witnesses?
She did some.
Okay.
It was like half and half, I would say.
Okay.
But I thought for sure she'd be doing the cross on this. And he's even the one that spoke up and said, I need to get my exhibits together in order to cross her.
Yeah. Is Karen good at trial? Because I mean, this is going to make it or break it, I think, ultimately.
She's not as bad as like Gravely or something, who's an elected prosecutor and literally has no clue how to try a case.
Okay.
She does know how to try a case. She does know how to question witnesses. She does know how to cross, So she's not horrible, but I haven't seen her on this particular case.
Oh.
Hired in as a social media coordinator.
They're still on break.
I stayed in that role
Prosecutor's
until
still apparently
about
getting his exhibits in order.
2020. I got promoted to director of marketing. And I held the position until I was terminated.
This is replay, by the way.
And you
guys.
were,
So this is
did
from
you
when she
work
first
during
started, about
COVID?
2 hours ago.
I did. I worked remotely for about 6 months during COVID. Then I went back to the office in, I believe it was August of 2020.
Did you enjoy work?
I did. It was fun. It was
Yeah, he can't be
marketing's-
terribly
it's
aggressive.
exciting, and I like.
But then
doing graphic
again, he might
design.
be able to get away with it if it's not
I did. I
him,
really liked my job.
because she's
Now,
the
the
accused,
jury
right?
already heard about
Mhm.
Brian. Brian
Yeah.
testified.
He's gonna
Tell
be
the jury
careful.
about Brian.
Well, I've known him since high school. We've been friends since
No,
then.
this is the affair guy.
He's part
Oh,
of
the
the
one
horse
who got
committee. He has
threatened.
horses. And as you heard yesterday, we did have an extramarital affair. It's probably the extent of our, but we were good friends too.
Work a
How
juror
often
during
would, in terms
the
of the
bid,
affair, how often
you
would
will-
you spend
Yes.
time together with Brian during 2021?
Maybe an average of once a week.
Okay, how long
Less.
did the affair
Does
last
this
over?
count? Gotta
about
go.
6
I
months.
meant prosecution. LOL.
Do you feel like that
Thank you for the
affair
formal
caused
stupid
you
gift, by
to
the way.
neglect Ethan or not
Or member
spend
chat,
time with
rather.
him? I'm sorry, your son, in any way?
No,
Explain why you don't feel that's the case.
because when I met with Brian, it was in the mornings. On his way home from the station, he would pass my work. And so the time I was coming to work, we'd meet at the Costco parking lot, and that was it. He'd go out about his day, I go about mine.
Once a week,
And
they
is
get
it fair
their
to say that
piss
you
me on,
lied
and that
to
was
keep
it.
that affair going?
Yes, I did.
And what, I apologize if I asked this, I just am not writing notes. Did you say the date range that started?
It was around spring.
So they met at the truck stop and got it on.
Okay. And
No,
did,
Costco parking lot.
as far as you knew,
Quality.
did you ever talk
Quality.
to your son about
That
that?
still sounds like where I grew up.
And
do
did
that.
you ever talk to your husband about it?
That's why we got Costco
If
parking lot only.
anything, you
Uh.
lied
It's-
to him about what you were doing, or lied by omission, not telling him.
No, yeah. As far as I knew, I was going to work in the morning. That was.
Okay. Outside of those morning times, how many other times would you say you and Brian got together?
It was 2 or 3. I went on some business trips where I would stay overnight, and he would meet me. He would meet me at the hotel.
So that happened 2 or 3
The
times.
court is on break.
Were there other
currently
business
right
trips you took?
now. Just so if you guys are joining us again, the court is on break currently. The defense is still going to be directing this witness when we get back. This is from like 2 hours ago. Just rewinded a touch. And cross is supposed to start today, it sounds like. because she said she's 3/4 of the way through. So she might finish in the next half hour, 40 minutes, and then cross is going to start. I don't know if it's going to end today or not. But this will be the last witness for today. The defense does have more witnesses, although those have not been identified yet. So, and they're apparently not in court.
Where he did not meet you.
Yeah, there's quite a few.
When Christy Gibson Marshall testified, do you remember who she was?
I do.
Who was she?
She was the assistant vice principal.
And she commented she knew Ethan in elementary school, or she knew your son in elementary school, correct?
Correct.
And she said she testified obviously already about recognizing him. Did that surprise you?
No.
She also mentioned something about emails with you. Do you recall having email exchanges with her?
There is one with regarding his report card, getting additional help in math.
Was there any time at that point or into high school that you ever had to email with teachers about discipline issues?
Not discipline, no.
How often would you email about missing assignments or grade type issues?
That was a regular thing.
Okay, and you said you monitor power schools every day. Approximately how many times a month would you say you went?
Sean McKinley, who would you guys want to see as a defense witness in this case, other than the defendant who's just now testifying? In addition to the defendant, is there? Because I usually try to spot, like as a defense counsel, who else I would really love to have.
I would really love to have the person who let them stay in the warehouse.
Okay, yeah, that's not a good one, or that's not a bad one. Yeah, I could see that.
Actually, what I was thinking of though, it said, the one teacher recognized him. I would bring in another teacher or two, because there's got to be a bunch it sounds like he was a known kid, like he was a known entity in school. So it wasn't like, he was on the honor roll and he just started doing this, or nobody, like he was completely off the radar. Like they knew who he was, so it's like you because they're gonna say, oh, they're gonna pull the crap of like, well, we're just educators, we don't know. You see this kid day in and day out for years on end, and you didn't know something was going on. And I think that would be a good, because if mom couldn't tell, how can the people who are like in the second best position to tell, and actually I'd argue probably even as good a position because of their training and education, couldn't tell. But I mean, because she mentioned it sounds like he wasn't a troublemaker, but he was just known. He was a known entity.
Well, Taylor, that's a foregone conclusion. You don't put someone on the stand unless you know how they're going to testify and what they're going to say.
Oh, yeah.
But assuming they're going to say something favorable, I like the idea of a mental health professional. The problem is that we can't get in Ethan's records. So I think that probably scrapped any mental health professional that might have testified.
Yes.
But that was a good question.
There's that too. I mean, but I feel like she makes it as though like everybody knows who he is, which I thought was interesting.
Yeah. Okay.
Because that was not something I was expecting to hear. Like, oh, they knew about him.
Right. Well, there's been contradictory testimony about that, about what exactly, if he was known, if people talked to him. Like the counselor said, I've never spoken with him. I had one virtual thing with him when he first started. Otherwise, I saw him in the hallway, and then I met with him at that meeting. And that's his school counselor. He wasn't on anybody's radar is kind of the point, right?
Yeah, and I think that would be
doing
helpful
this kind
there.
of thing. Yeah, no, that would be good. I'd be curious to see who they bring in.
To the teachers, or was it weekly? I don't know.
It would be, I wouldn't say it was on a regular basis, but when it happened, it was a series of messages. He'd be struggling in geometry. And so me and the teacher would message back and forth quite a bit. And then he started getting better and it was
I don't know how
off.
helpful
So it was,
it would be, though.
it was sporadic, but it was a lot when it happened.
Now, we saw pictures of your house. How did you feel about seeing those pictures?
Horrible.
Okay, why is that?
Because my son has a very messy room, and It was right after Thanksgiving, and we hosted Thanksgiving, and it was pretty messy. It was kind of embarrassing.
Okay.
Really embarrassing.
Explain the 2-bedroom thing, or what was going on with that?
So Ethan, sorry, my son, he had 1 bedroom and it got out of control. And every time I go to clean it, I just shut the door. I just didn't want to deal with it. So then I told him he could just use the guest bedroom until I could get his room deep cleaned. The day before Thanksgiving, I was deep cleaning because we have people over every Thanksgiving. And my intention was to clean both rooms, but I caught my oven on fire in the self-clean mode. So instead of, I had the fire department out and everything. So instead of getting his rooms clean, I was scraping out
Typical
the
woman.
black charcoal stuff inside your oven so I could cook dinner the next day. But yeah, he was in a second bedroom because I didn't want to clean his room anymore.
So she's too lazy to clean up his room, and she started her oven on fire. Does this help or hurt her? I feel like she's being honest.
I started
right?
my oven on fire like what, 2 days ago? Yesterday?
Of course
Well,
you
there's
did.
going to be a bunch of moms like, yeah, my kid doesn't clean his room. I tell him to screw off.
Yeah.
Just was enough.
Did you have any plans to do anything with all that stuff?
Yeah, we're going through a lot of stuff because he outgrew a lot of the clothes and the shoes. There's a lot of toy-like things that he doesn't use anymore, so we're just going to pack it up and donate it.
Okay, and when were you planning to do that?
Between Thanksgiving and Christmas, before he got new stuff.
Now, we saw a video. I guess I want to talk to you about. There's one friend in particular your son spent a lot of time with.
So her
correct?
boyfriend could come.
Okay,
and
we're not
go
going to
rescue.
say his name, but let's just refer to him as the friend.
Okay.
Okay. Overall, was that your son's only friend?
That was his
Court is
only
still on
friend
break, by
that
the way,
came
people.
over. He did have friends that.
Wow,
he wanted
she is
to
letting
from
them have all
school,
the
but
time
that
in the
was
world to
only one
prepare.
that he spent time with outside of school.
Yeah.
And how often would you say he came over?
We're gonna
Oh,
rewatch
he used to
Jennifer's
walk home with
testimony
him every
before the
day,
court comes back.
from school. The summertime, he'd go on camping trips with us. Sometimes he would spend more than a week with us. He called him my second son.
Okay, he was the second son. Did you know he was going to be moving away at any point?
Not that abruptly, no.
Okay, so when he moved away, is it fair to say it was a surprise to you and your son?
It was.
What kinds of things would the boys do together at your
On
house?
CNN defending
They
Jennifer.
go down to lake and go fishing. They would walk to Little Caesars or Frosty Boy.
Coffindoffer or whatever.
She actually had a tweet out the other day that said, I thought this mother was guilty, but now after watching, I think after the horse lady testified, she's like, oh no, this mother was highly involved with her son. She was probably at her wit's end with him, and she is absolutely not guilty. And I was like, oh my God, praise the Lord. Coffindoffer says that someone's not guilty.
Right.
I retweeted it out.
Was the horse lady like her girlfriend? Could say, like, I know they were friends, but was she like, oh my God? She was like, every day she's bitching about Ethan and he can't get his shit together. Was it kind of like one of those deals?
Well, yeah, kind of, but she always, she expressed concern about her son, and we were talking about getting him horse therapy.
And I don't
how
know
she
what
was
to
struggling with
do.
him.
And
I don't know what to
okay.
do. Yeah.
Well,
although she didn't come off terribly friendly towards the defense, I thought the statements that she was making were pro defense, even though she didn't seem extremely friendly. But for Coffindoffer or whatever her name is to pick up on what I did, because she's pro convict everybody. Everyone's guilty.
All these people on TV are pro. It's all prosecution porn for them. But oh, she's retired FBI. Well, you guys know how I feel about federales, so.
But for her to come out, I was like,
I feel a certain way towards the FBI.
Are you not a
Not
fan?
that
I'm
she's-
not a fan of any of the law enforcement, to be honest.
I mean, if it's federal law enforcement, I have little use for. I understand I need cops in my life, but I can tolerate them, but federal law enforcement, I have nothing but utter contempt for.
Yeah. Are you a criminal defense attorney, right?
Yes.
Okay. Same.
But well, I was gonna say though, the one thing that's gonna suck in these cases for like the horse lady, she has a business, and she has to live in this community. Like even if Jennifer gets sent away or whatever, she has to be in this community. So like if she's like, oh, she comes in there and saves the day, that community is gonna, like your tires are getting slashed. You might get your windows knocked out.
About a third of her
People
testimony
might kill
was,
your horses over this stuff.
I did not want Jennifer to come by because of all of this that was going on. I didn't want her anywhere near the barn. I didn't know what was going on. I was trying to get more information. It was like CYA by a third of her testimony.
Oh, I mean, I'm sure she came off as like hard nosed as she could, but also helped Jennifer because if she came off as like, oh my God, I'm totally sympathetic. I mean, the people in this town would ride her incessantly for it. So
yeah, and the firefighter boyfriend.
yeah, you
actually
told me
said the
about
same
him
thing.
last night. They
Yeah.
coerce his testimony out of him and stuff, and it's like, ooh, lad.
Yeah, but he also said too, in addition to that, he also said that she was extremely concerned about Ethan. They would constantly text about Ethan and things like that. What was going on? Please, God, please let Sean rant about the feds in Alex Jones' voice. I'm game if Sean is. Thanks, Lefty.
Well, you see, the globalists are enabled by the federal government, and those federal government. Well, I'm not saying that Timothy McVeigh had the right idea, but I'm just saying he wasn't the only one with the right idea.
That's great. I've never heard that before. That's awesome.
I got a head cold, so it's like Alex Jones with a bit of a cold. So it's not as good as my Vincent.
Worked for me. I got it. Got me there.
Yeah.
I think Lefty needs a link. Lefty doesn't stream anymore. Look, you got him all excited though.
They go in the backyard, shoot the babies. They go swimming in the pool. We took them bowling a lot. They play video games.
Now, when
The
you
bowling thing is weird
so
to me.
when you had him over
I know,
at the
right?
house,
The
or I guess,
bowling
was it more common
Yeah.
for him to be at your house or for you?
I thought they were like struggling to find him a hobby.
Well, no, I just mean in like 2023, or I mean even in 2021. Like it sounds like they had a school bowling team. It sounds like there was in a bowling league where he could go bowl and get his scores recorded or whatever. It just for all the things he's doing, and then he's just like, yeah, I like bowling. It just kind of doesn't. It just strikes me underwear. Like bowling's fun, but like, what's wrong with bowling? Bowling is hard.
I like bowling. I wish I had time for it anymore. My son, he loves bowling. He wanted his own ball and stuff. I tried to get him on the league. He wouldn't do it.
Did you get him like the little like curved finger thingy too?
Oh, he picked all that stuff out himself. He went to the rink and went to the bowling ball place. And
I remember, watching those guys do the PBA stuff, and it's like, yeah.
Did you
I
call
love
it?
her son to be at his friend's house.
What's that?
Did you call it the rink, like the skating rink?
Oh, did I say the rink? The
Yeah.
alley.
They said the rink. I was like,
I got
that must be a
sports
Michigan
confused.
thing,
Right?
No, it's not. I got my sports confused. It's sports balls. It's all sports balls.
My son has never been to his house.
Okay, why is that?
Because he had OCD, not my son, but his friend had OCD issues and he didn't want other people in the house.
At your house, did that friend exhibit any issues?
No, not at all.
Okay, so were you surprised when he moved?
Yeah, very surprised.
We saw evidence.
Patty B wants to know why you feel she will be convicted. I'm sorry, I don't know your guest's name. Well, if I took down a banner, that would probably help. But yeah, so it's
Why do
legally
I think
alive.
so?
McKinley is in the middle. Sean potentially criminal on the bottom.
I mean, why is she going to get? Why is it no matter what she stands like? I think a 75% chance of being. They could all the witnesses come in and could say it's not her fault, and there's still a 75% chance she gets convicted.
Because she was charged.
This is there's that, but this is a show trial. This is a show trial, and McKinley, I apologize you're on here, but this is a trial about soggy tampons. This is emotional. This is like you're pulling at people's, heartstrings. This jury's not. You're going to be the one to let this woman who killed people. Her son murdered those poor little children in school, and you get to walk away, and like the moms and those families are out there just crying and like, I miss them. Oh, boo, boo, boo. Like this is all about that. This is what it is, and I hate to use that term for it. And like I said, I apologize, McKinley, but this is that. This is an emotionally driven thing. I mean, I'm not 100% sure bench trial might not have been the right idea here. I don't know how that works up in Michigan. If you need the prosecution's agreement.
Yeah, no, they could have done a bench trial here.
Okay.
I'm not sure how much it would have fared though.
Okay. I mean, seeing this judge though, I'm kind of like, yeah, I don't know. But yeah, this is a massive, because I'll tell you guys, you can always, that prosecutor, I mean, I didn't see the opening. I don't think I called Tom ahead, but you know, they pointed at her. That's the bad man. That's the bad man right there. This is, if she had done her job, this would never have happened.
No,
Like,
that's exactly
that's all
what
this is. That's all this is. So yeah, this is going to be the nearest, you know, for if Shannon Smith is honest, she's going to sound like Wellington after Waterloo. This is going to be the nearest run thing you've ever seen.
Well, and the thing is that an acquittal is not going to prevent the state from taking these measures going forward now.
Well,
either.
Oh, an acquittal is going to sting really bad.
Yeah.
Well, and I mean, it'll probably kill it in this county. So.
Yeah, it'll kill it in this county, but it won't prevent others from trying it. That's the thing.
Well, maybe, hopefully not, but
yeah,
I don't know if you guys thought she has a chance. I'm like, this is a show trial. That's the scary thing.
Mm-hmm.
And that's the scary part about show trials. They are show trials.
I think she has a chance. I'm so optimistic that she's going to be acquitted. But I think the fact that this charge was brought, prosecutors across the country are going to continue to bring charges like this until one sticks.
Oh, yeah.
And when one sticks, then they're going to start establishing precedent, because that's going to be appealed.
Yep.
And that's how slowly but surely things happen like this.
Yep, and that's how it works. Once somebody sticks the landing, you can make that argument in your courtroom. Hey, they tried this in Nebraska, and the judge is going to be like, "Well, you know what? We're in Kansas. That's not Nebraska, but close enough."
Yeah,
you know, it's like Michigan. If they works in Michigan, you could try this in Ohio or Indiana. And after a while, if it turns into one of those, like, well, by golly, those yokels in the Midwest are making it work. We can make it work on the East Coast.
The trial is rigged unless I win. I don't have that opinion of this trial. I
think this is kind of rigged.
I have a fundamental legal issue with the charges being brought, with the way that they're being brought, because I don't think the law provides the remedy that the prosecution is seeking. The elements don't line up, and that's the problem I have. And whatever you want to say about this, understand, and every legal commentator on this trial agrees, this is new precedent. This is new criminal law being set in this trial right now. So this is nothing that's been done before. It doesn't fit neatly into any package. And if you want this to be the law going forward, that's fine. You have your opinion, but understand what it is. The state gets to second guess everything that you do as a parent, and you don't know if you did it right until they tell you after the fact. That's the problem.
Well, and it's
right. I mean, because we're dancing around a gray area here.
Yeah.
If we want to say that these parents did not do enough, right? Let's establish, for the sake of argument, that they knew their son had mental health issues, and we're saying that they didn't take the appropriate steps. Well, what would have been the appropriate
what
step?
is enough?
Where do you draw the line?
Yeah.
And every time you draw a line, you get to say, state, did I do enough? Please and thank you.
Yeah.
Because you're not going to know ahead of time. Getting counseling for this kid, pulling him out of school that one day, was that enough?
Yeah.
Again, they're being charged, so we assume there's a school shooting somewhere down the road.
Yeah.
So obviously they didn't do enough, whatever it is, because the school shooting still happened.
Yeah.
So now we are of the point where, okay, well, what is enough to exonerate these parents? And how do we know that ahead of time? Are we just relying on the state to tell us after the fact that we've been exonerated, we're good?
Yeah, well, it's kind of like that meme about taxes. It's like, well, how much do I owe? Well, you come up with a number and you tell us, and then we'll decide if you're right. It's kind of like that's how you pay taxes. You tell the IRS how much you think you owe them, and then you find out if they agree.
Yeah. Well, don't you know already? Yeah, we know. Well, can you tell me? No, you tell us, and then we'll tell you if you're right or wrong.
Yeah. No, and yeah, that's the thing here. It's just, this is going to be, you know, I think it is a bit of a rigged setup here, because I think the judge is not, you know, this judge is not giving them the breaks I think that they would normally. I think they're playing a little hard with this. The state's playing really harder than they play in a lot of situations. So I think I don't think it was fair how this has been set up. I think she was, because she wants to keep being elected judge. And if she comes across as like it's because of her that, Ethan Crumbley's parents walk free, that's going to be used against her. And yeah, Darlene, yeah, I mean, the thing is, when her attorney promised at the beginning that Jennifer Crumbley was going to testify, Jennifer Crumbley has to testify at that point. Because once you make that promise and then she doesn't, you basically have tipped off the hand of, oh shit, we're in trouble. Which that might not be the case, but you don't promise that, which I was terrified.
All week, people in my chat have been asking, when's Jennifer going to testify? And I said Thursday at 2:37 p.m.
Oh,
I
you
was
said at
so close.
2:37? Oh, okay.
I said
that
Thursday
part.
at 2:37. She got on the stand Thursday at like 1:15 or something.
That's close
pretty damn
enough.
close.
Ariel says that Sean joined at exactly 2:37.
Oh,
Oh,
okay.
really?
That's why I was
That's
wondering why
awesome.
it said that. Okay. So
I was
yeah,
good.
the win protects more people than just Jennifer.
It does.
And
It
here's
really
the thing I said that said though about James, if she wins, oh my God, they are going to just dump on James. They are going to go for broke.
They absolutely are. Well, and Jennifer's testimony
Can
threw
be
him under the
used
bus a little bit.
if she gets acquitted. Yeah.
And the defense or the defense might try to subpoena her because, or the defense or either side might try to subpoena her because, assuming Fifth Amendment doesn't apply. But I still feel like there's other possible.
Ohio v.
charges, so I
Reiner
think
still applies.
Yeah.
Innocent people can assert the Fifth Amendment.
Yeah.
I think I might get charged. Why do you say that? I just went through 3 years of bullshit. Like, yes, I think I could get charged again. Sorry, I didn't mean to swear, David. Sorry.
No, you can swear. It's fine.
Okay.
We are all good. We are a First Amendment channel. That's why everyone in the chat is welcome to their opinions too. And there's just no personal attacks against others in the chat, but personally attack me all you want because I eat it up. I love it.
Mr. Binky brings up a good point. Spousal privilege.
Our spousal privilege in Michigan is largely eroded.
Really? Oh.
Yeah.
Oh. Also, I was going to ask you this, David. In Michigan, is cross limited to what's been opened up on direct?
Yes.
Okay.
Yes, it is. It's limited to that, and there's generally no recross unless the state's been allowed to go sort of outside or reopen new issues or something like that. But usually the courts don't like recross either.
Okay.
So, yeah, absolutely. Yep. Limited to direct.
Because
Sean,
yes,
is your fiance the future Mrs. Martin?
Yes.
Oh. Okay. I just realized your last name is Martin. That makes so much sense. Okay. Sorry.
She's been in the chat quite a bit.
Yeah.
Is she in right now? I didn't see her.
No, I
No.
just saw her name and I was like, wait oh my God, that's
Okay.
okay. Makes sense.
She was on the other day when
Yeah.
I think McKinley was on last.
Okay. Yeah, no, because I was just curious because I know because I noticed this from watching the Jennifer Dula or the Michelle Trakunas trial. In Connecticut, it's the same way. You're limited to the what's on direct, which is just weird because in Ohio, cross is unlimited in scope. So there is no.
If there's the opportunity to recall the witness on direct or rebuttal, the courts will often just say, "All right, go outside," because we're just trying to do judicial economy here. We don't want everyone come down and call them back up again.
Okay.
But with this particular witness, because she's a defendant, I think we're going to be very limited on cross.
Oh yeah, no, I think that's a case here. But I was gonna say because in Ohio it's like free for all mode. Like we don't because that's the old traditional rule, and they're like, oh, if you want them, you call them up. It's like I always just think I like the idea of like let's just get to the heart of the matter if there's truth, because they even say it in our evidence rules like we seek to find the truth over procedure.
Right. My if you guys look to my channel, my playlist, it says MLS goes to court. I had a civil trial. It was a bench trial. We agreed ahead of time that when I was the plaintiff, so I would call my witnesses. The other side would be able to direct the witnesses for judicial economy purposes, and then I could like do a redirect / cross kind of thing, and then he could as well.
Yeah.
And it was just for expedient purposes, and we got the trial done in a day.
Oh.
So it was a bench trial. The judge knows the rules. We were all comfortable with it. We only had like 4 witnesses or so, maybe 5. But so we play like that if you have an agreement. But you know, a civil bench trial is different than a criminal jury trial.
What's that banner say?
Which one?
She's got like streamers on her flags.
Oh, the yellow one is the Women's Lawyer Bar Association thing. And then the red one is like the Women Judges Association.
That okay, I kind of like that, you know, I know some people don't like seeing flags up behind the bench because it gives it like a militaristic feel.
Yeah.
Because I've heard attorneys say that, and I'm like, you know what, I get that, fine. But having like also because that's kind of cringe, because that's a take on like having battle streamers on your flag. So like,
yeah,
why do we have that up there? Because it's
all
like,
the judges have like their little association stripes.
Really? Oh,
things,
that's
weird.
That's cringe. Yeah, we just have gold fringe flags in Ohio.
Oh well, you know, well then you're invoking sovereign citizenry.
I mean, technically though, I mean, like in 1804, yes, the gold fringe flag would imply an admiralty court. Like that was actually a real thing.
Was it really?
Yeah, but like that kind of disappeared by like the 1830s. Like a gold fringe flag would have been for a courts martial.
I clerked for a district court judge. She received a pleading about the whole gold fringe thing, and it was noticed for hearing. So before the hearing, she went and changed the flag out. She's like, "What? What do you?"
Oh,
see, she just bought a flag and hung it.
That's my like guilty pleasure. Like I know their lore front to back. Like I love it, and
so insane. There's a guy.
I get used as like I've been used as standbys, and like I love dealing with the Moors. Are so much fun to deal with if you get appointed to them. You can't let them drive you crazy. You just got to go along with it.
Is that lawful law? There's a guy that like started this whole thing, and he was like, you know, when a ship comes in, it makes its berth, and we're all born, therefore we're ships. And it was just this all kinds of nonsensical BS.
Have you ever heard
words sound similar?
Have you ever heard of the quantum grammar guy?
No.
Oh God! So this is a guy. He died a while back, but he has the worst. Like, if this is his haircut, it's the worst haircut in the world. If it's a toupee, it's the worst toupee in the world. He came up with this grammar where it's like full of colons and these weird things. So it's he has different. It was this different way of like it looked like gibberish, and he would say like, you are the, you know, your name would be David - Helm. And it's because that's how you have to do it, as you are the, and it was a take on the nutbaggery of sovereign citizenry. And this guy started up what was called like the Federal Postal Court, which is something Ben Franklin had actually started in like 1780 something. And for like
Federal
a year.
Postal Court.
Oh yeah, it was like a real thing. It was a real court, and then they reopened it, and like, oh, it was. I'll send you a thing about it because this guy, it's so bad. It's basically with him, he would go through it, and he could, if you wrote out a sentence, he'd say write out a sentence, and he'd say none of these are actual words. He'd say they're all there's no nouns in it. You basically have a sentence full of adverbs, and I'm like, I don't know how that works, but. That was his theory, and if there were no nouns, then you didn't have a fact. It's hilarious to listen to.
Well, the judge gave the prosecution like 27 hours to get their shit in order.
Yeah, which I think is wrong. So, but yeah, I love the sovereign citizens. I love their stuff.
They're a lot of fun to listen to. There's a great judge up in like the Traverse City area here in Michigan that always has his cameras on, and he handled one the other day. I think I posted it on Twitter.
Oh, the best one I ever saw though was I never got appointed to this guy, but he was a Moor. And have you dealt with the Moors out there?
I've never personally dealt with them.
Okay, so like this guy.
No, never.
You know who we're talking about? They wear the little fez hats. So like I was in court sitting there, and like this is when I was in Toledo. I was at a law school, and like they like no shit showed up. They had the little fez hat, the Aladdin hats on, and everything. He had his spiritual advisor was a sheikh. Like, you know, he thought he was a sheikh, and he comes in wearing sweatpants and a hoodie, and I'm like, oh, you are the noble leader of this community, sir. And this guy goes up, and he had been chased by the police, and he went on a high-speed chase through town, and he filed a affidavits of fact about a bunch of different things. And in one of his affidavits of fact, he started talking about like, well, yeah, I did it. I ran, and I was trying to call my spiritual advisor, and he told me to keep going. And the prosecutor at the time
I feel like I've seen that guy.
Well, there's a bunch of. Well, this is a common thing they've done. This guy wasn't televised. He was just and it's sad because this kid was like 19 years old and had been bought into this crap. That was the sad part about it. He shows up and he does all this, and the prosecutor is like, judge's like, do you have any issue? The prosecutor was reading through them like, I just got these. I want these stricken. Like he needs to refile these timely and serve me. And she got to the end, the last one where he admits to all the elements of the crime. She's like, Your Honor, I have no objection. I'll let this one get admitted. And the judge said, is this, you're filing? Yeah. And it's like, is this your affidavit? Yeah. And it got admitted. The kid, I guess, ended up seeing the light. Like I had left town at that point, but I guess a couple months later, he finally saw the light. And
they usually do after they spend a few days in jail, right?
Yeah. But like I said, he was 19. Like he had never had any problems. He was a smart kid in school. They kind of cut him a break. I think they gave him a misdemeanor out of it because like he really did kind of get swindled. So
I don't know who that blonde is. I'd say Jennifer put on like a good 80 pounds.
Jail food's full of carbs. There's no exercise. And I'm sure a lot of depression.
Yeah.
Yeah, a lot of depression. You just
A lot of
start eating your sorrows away.
Yeah, I mean, that food's not the highest quality.
Okay, volume should be up. Who said the defense attorney's hair looked bad? I don't know.
She brushed it like a lot during that break, and it had been curled still.
Yeah, she could be on medication too. Everyone, by the way, Josie has an awesome podcast called Wrongful. You can find it on YouTube and Apple Podcasts and Spotify and everything else. You all got to go check it out. If one of my mods could put a link to it, that would be great.
I'm just surprised there's 80 other Josies that snipe that name out. Sorry for the dad joke. She's like, am I going to get endorsed by the Women's Lawyer Guild? She's like, I hope so. Oh, when is she run again, David?
Yeah, I don't know.
Oh.
Okay. Okay. All right. You ready? Okay. We were talking about the meeting at the school, and I think the jury's heard a lot about that meeting. Okay, so I'm going to fast forward. You go back to work, right?
Yeah.
We saw the exhibit of you walking back in.
Correct.
Okay. We heard Amanda Holland testify about how she gives you some advice. Do you recall her giving you advice?
I don't.
Is she somebody you go to for advice?
No.
Why not?
We were never like friends outside of work, and she was Andy's administrative assistant, so it was just formalities really with her. We didn't really have anything in common. Her child was real young. I had a teenager.
Okay. All right. I want to go to the time where you heard there was an open shooter. The jury's already heard how you heard about that. Okay. And we know you got in your car, you drove up to Oxford, right?
Correct.
Okay. We heard about the description of that caravan. Did you see that caravan?
Yeah, I joined it, a black SUV, and that was my fastest way to get to the school.
Okay, so you actually were a part of that with all the law enforcement officers all headed up.
Yep, I just kind of jumped in.
What is that, Lapeer Road?
It started on 75. I work at Square Lake and Telegraph, so I got on 75 from Square Lake there. And it was well before the M24 exit. I would say about a quarter of a mile. The tractors backed up.
Okay. Now, you sent a text, and if you need to see it, let me know.
You sent a text to your son that says, "You can talk to us." Why did you send him that?
After I left the meeting, I knew that he was sad about things, and I just wanted to let him know that he can talk to us about anything. Just wanted to make sure I opened that door. Just let him know that we're there for him. We love him.
Okay, and he said he loved you. Do you recall that?
I do.
Okay, was there anything unusual about that?
Yeah, he's at that age where it was hard to get "I love yous" back out of him. For me to open my text and just see him randomly saying "I love you" was abnormal for him.
Okay, did you think anything at that point?
No, not right at that point. I think I said text back "I love you too." I don't remember. I believe I did. Yeah.
Okay, and later in the thread, you say, "Don't do it." So when you hear there's an open shooter at the school, I want to know in your mind, what do you believe is happening?
Well, my husband had called me when I was still at work, and he said there's an active shooter at Oxford High School. I can't get a hold of Ethan. And that's when I opened my phone and I saw the "I love you" text. And then I texted him, "Are you okay?" In the process of it, I was getting my stuff and running out the door, letting my boss know that I had to go to my son's school. It was on 75 when I was trying to get to the exit, that my husband called me and he asked me where I hid the bullets, and I told him, and then he said the gun is missing. So instantly I'm like, oh my gosh, he's got the gun. I didn't actually think he was at the school shooting it. I thought maybe he walked home and got the gun and was in the field by the school. I didn't imagine my son actually going into a school and shooting. And then when we got more updates, I was like, oh my gosh, he's a school shooter. He's going to kill himself, because in my mind, that's what school shooters have done. They've killed themselves after. So I yelled in my talk to text, "Ethan, don't do it," because I thought he was going to kill himself.
At that point, did you think Ethan had killed anyone?
No, I didn't even think he shot anyone at that point.
Well, that was going to be my next question. Did you believe he injured anyone or shot anyone, did anything?
No. I thought he was going to kill himself.
Okay. So you find out the gun's missing. So you do think he's got the gun, but is going to turn it on himself.
Right.
Okay. So where did you, at that point, you went to the substation? I think we saw the video.
Yeah. My husband had called me when I got close to the house. He said the substation just called and they want us to come down there. They have my son. And so I picked him up on the way and we drove to the substation together.
When you say picked him up, picked who up?
My son was in custody, basically. The
Right.
substation.
So who did you pick up?
I picked up my husband. I'm sorry.
Okay. You picked up James. Okay. What was going through your mind at this point, going from picking James up to the substation?
I don't know. I asked my husband, I was like, "Is he alive?" And he said, "Oh no, we're going down there." I didn't really know what to think. I was kind of it was kind of hazy. It was kind of, everything was a little surreal. I still didn't believe that he actually shot anybody or was in the school. I just knew that there was gunfire. I didn't know. I didn't know the extent of it at all.
So when you're at the substation, did you asked them about fatalities? We saw it on there.
That wasn't at the sub. Oh yeah, I did.
Okay, but you didn't get an answer, right?
No.
At that point, were you thinking that anyone was injured or that anyone was hurt?
He did say there was injuries, and at that point, my mind went to, we can handle injuries. We can handle injuries. I went into kind of like go mode, like, what do we have to do? My son's arrested. I did not think there would be any fatalities.
You didn't think there would be any injuries?
No, I didn't think there would be injuries. I didn't think there'd be anything, but I just went into that mode. Like, we can handle injuries, and we can figure this out and go from there.
Okay.
So I feel like she is
You saw
showing
the interview at the
emotion, John.
substation.
Yes.
I'm not going to go through all that with you, okay? After that, you go to your house. Is that correct?
Correct.
And the next thing, police are at your door.
We were at the house for a minute. We were putting some hot water on the oven, on the stove. My husband walked out back to the side of the house. I saw him walk towards the end of the driveway from my kitchen window. I was sitting in my kitchen on my phone talking to my dad, and I realized my husband was gone for a little bit longer. I didn't see him walk back. So I walked out the front door of my house.
And what'd you see?
There was a bunch of officers with guns drawn on me.
Have you ever been in that position before?
No, I have not.
What did you think when that happened?
I don't know. I remember just dropping my phone and putting my hands up and then being handcuffed. It all happened so fast. It was shocking.
Okay, we saw you sit in the car with James with the handcuffs, right?
Correct.
So we don't need to go through all that.
No.
After that, we saw a video where you're sitting in the car and you talk to police for a long time. There's a lot of long pauses in it, right?
Right.
Okay. I'm not going to go through that whole video right now, okay? But if there's something you need, you can let me know. During the substation meeting, while you're with Joe Bryan,
Judge, this is direct examination.
I'm
Who, what, where,
I'm
when, what
asking a
happened.
question. I'm just putting us in a space. I'm going to ask a non-leading question. Okay. So we all can see that you are using your phone while you are speaking to law enforcement. I want to know what you're doing on your phone. It's not leading.
What were you
And the
doing on
whole
your phone?
jury can hear you constantly saying
What were you
object.
doing on your phone?
I was looking for the paper to show the officer that was sitting next to me. The first one I pulled up, I couldn't get to zoom in, so I had to search through my emails for the other one to get that pulled up. Once I got my phone back, I'm pretty sure I was going through the mass amount of text messages and Facebook messages I was receiving from family and friends asking if my son was okay, because at this point in time, nobody knew anything. I was also messaging with my my boss, who happens to be an attorney, trying to get his advice on what to do. I was on my phone, not going to deny it. I was probably looking at text messages and Facebook messages and just trying to get updates on anything.
Is that the same or different when you're in the back of the patrol car?
What do you mean?
There's a point where you're in the patrol car by yourself.
Right.
Okay, you've got your phone. Tell us what you're doing on your phone at that point.
I now was messaging with my dad a lot because I had dropped the phone when I was talking to him and I got arrested. So I was filling him in what was going on. I was also messaging immediate family members and close friends that my son was okay, but he was the shooter. So that's mainly what I was doing.
What was your state of mind like at that time?
Sorry, I forgot to say
I don't know. It was pretty numb. I didn't really believe. I had a hard time. I don't know. I was numb. I didn't really believe like everything was happening the way it was. It was surreal. My mind was in all different places.
That coughing is annoying.
Okay, so when did you find out there were fatalities?
In the back of the car when I was by myself, and I asked the officer, and he told me there was 4 fatalities.
That's on the video.
Yes.
I'm not going to ask you questions about that, okay? All I can hear is object, and it's very distracting. I would ask them to write notes or something because it's very distracting.
Oh, really? Are they talking to each other? The prosecutors?
Yeah, like, in that loud whisper.
Object.
Okay.
We're not saying.
Objecting.
Okay, well.
Right next to the jury, of course.
Okay. So this is the time where you find out there's fatalities. I'm going to move on to a different topic. On your cell phone, do you have a habit of deleting messages?
Usually it's threads.
Okay, explain to the jury what you do, because go ahead and explain.
Well, on Facebook, I do a lot of Facebook Marketplace, so I get a lot of messages.
What's Facebook Marketplace?
Where you buy and sell things. So the first main screen of my phone will get clogged up with Marketplace messages. So I'll just delete threads. My main people come up that I talk to on a regular basis. If that starts getting full, I delete those threads too. Same thing with text messages. I delete threads until the main people I talk to are up on the main screen, so I don't have to scroll down to find them.
I do that too.
So is that a habit that you started that day, that month? When did you start doing this deleting texts thing?
Pretty much when I got a cell phone. I've always done that.
Okay. Did you go out of your way, in this case, to delete like certain messages?
Not intentionally, no.
And so when there's a message they say you deleted that indicates the gun was locked, do you recall deleting that message?
No, I completely forgot I sent that message.
Or unsending it, I'm sorry.
No, I don't remember.
Okay, there's another message that is unsent talking about we did everything right, that kind of thing. Do you recall unsending that message?
No.
Okay. So when law enforcement got found that
Depending on how serious it is, they'll either just take a break or anything to a mistrial. It just depends on what happens.
there was a lot of
Psychotic
deleted
break
content,
episode.
does that surprise you in any way?
No.
And you don't dispute, you've seen a lot of text message threads that have been admitted. You agree those were a lot of the messages going on, is that right?
Right.
And a lot of those are what were deleted.
Correct.
Okay. So after you're interviewed, there was a point where the police tell you and James, you guys need to leave the house. Is that right?
Yes.
Where did you guys go?
We went up to, the first time we ended up going to the Holiday Inn Express and sitting in the parking lot trying to figure out what was going on, waiting for them to call us.
Was there a point you had to go back to the house?
Yes, they called us to come back to the house.
Did you know why you're going back?
They told us that the search was over and they just wanted us to come back to the house.
Okay, so when you got back to the house, what happened?
We went into the house and then the detective asked for our cell phones.
And were you reluctant about giving over your cell phone?
Yes, I was.
Okay, why is that?
Sounds bad, but my life is in my cell phone. My contacts are in my cell phone. Everything I need is in my cell phone. I don't memorize phone numbers. I have an emergency going on and they're taking my only means of contact away from me.
Okay. There was
She
a
still sounds
suggestion to go
angry
get
about
burner
that.
phones or track phones, prepaid phones.
Correct.
Did you do that?
But like,
Yes,
she,
I did.
she,
Okay.
you need-
so
she needs
there
to
was
pause.
evidence you went to.
You don't use the word burner. Who uses burners? Bad guys.
Bad guys, criminals.
Because I'm surprised that didn't come up at any point with any of these officers. Like, yeah, sir, are you aware what a burner phone is? Yeah. Well, what is a burner phone? Oh, it's something drug dealers use. Like, they should just call it track phone, whatever. But don't like. I get it when you know, and I understand why she uses it because she does criminal stuff. She does criminal law, so like it's criminal slang. Like I totally get it. Like yeah, like it's like my guy's got a burner. Like but like I wouldn't start using criminal lingo on the stand if I have an innocent defendant.
Right.
Yeah. Well, she called her own client a criminal, a dumb criminal. On cross-examination the other day. It's just
Well, no,
hopefully
I
the jury didn't
get
read
that
into
saying.
that.
Well, no, I get that saying if she really did this, that would make her an idiot, wouldn't it?
Yeah, that was kind of
and
context.
you guys
That would make her a dumb criminal.
Well, Scott saying it's popular parlance.
Yeah.
Well, it depends because like the jury they got out of Oakland County, I'm sure is probably the suburban Oakland County jurors, and remember jurors are normies. Jurors are
None
normies.
of them watch YouTube though. None of them watch YouTube.
Yeah, it's normies, not people here. It's normies. So, well, gosh, golly, whose phones are up?
That was funny. The judge asked the jurors where they might learn about information from this in order to identify and stay away from it. None of them said YouTube, and I'm prying. Some of them said social media.
Yeah. So
That's all right.
Yep.
And we saw the receipts. There's been a lot of text messages about threats. Tell the jury about what you were receiving.
Oh, we were receiving so many threats on let me back up. On our new track phones, in my Facebook Messenger, there was a ton of threats. I wasn't getting text threats on my new track phone because I had my number, but my Facebook Messenger was blowing up with threats. Once I got into my email account, that was blowing up with threats. People found my realtor.com profile that I hadn't had for years and were sending me messages through that. I had people sending me screenshots of text threats they found that I didn't know about.
How were you feeling at this point?
I was feeling pretty scared.
Okay, scared of what?
Well, scared that somebody might hurt us.
Okay. At that point, did you ever go back home?
This is the first time, right?
I'm talking after you bought the track.
Oh, no, we went to the hotel in Lapeer.
Okay. So you go to the hotel in Lapeer, and then how long did you stay there?
Just one night.
Okay, so that was the night of
the 30th.
The 30th. Okay. What did you do on the 1st?
We woke up. I knew I had to make arrangements. I had a senior dog and 2 cats still at the house. I didn't know what to do with. My neighbor was sending me updates, letting me know that there was still media around my house, that my house had multiple random pizza deliveries that people were calling in. So I had to get dog food for our dog, and I met her at the actually in the church parking lot behind Red Naps.
Stepped away. What I missed
that afternoon to give her the food.
She got a bunch of like, she's like, there are
and I
pizzas
believe
getting
that
delivered
you
to my
heard
house.
about
It's like,
that and saw the GPS stuff.
yeah.
Did you go to any?
You know that's
banks?
gonna happen.
4chan, man.
Not on
The internet
that
never
day.
sleeps.
Okay. Did you go anytime that week?
Yes.
All right. Why were you going to banks?
When all this unfolded and we found out that it was my son that was a shooter, I get a lot of advice from my dad. My dad's been involved in some civil suits before. He told me that there's probably going to be a lot of lawsuits, and they're going to try to take your assets. And I didn't really have any assets. The bank owned my house, the bank owned my cars, and all I had was the cash in my bank. And he said they could freeze your account. So I went and withdrew money from my account. My dad also deposited extra money in my account during that time to give to us, help us retain a lawyer, which I withdrew as well.
Okay, so you withdrew that money. Did you withdraw anything from an account that had Ethan's name on it?
We transferred money from that savings account to our account.
Okay, explain that account. I know it says Ethan's name on it. Is anyone else listed on the account?
That sounds
No,
plausible.
it's a Simply Kids savings account through Flagstar Bank. So he opened it with $200. I
Not
don't think he
unreasonable
really
at
had.
all.
Yeah,
Not
the police
unreasonable.
are going to freeze your account and
Well,
take the
just
cash out.
everybody's going to. I mean,
Yeah.
like I for people who really do this stuff, it's the term stacks on deck. Like, you need cash right now. Like, there's no there's no time to wait. So
Yeah, when they said $6,000, you're like, oh, for a retainer fee? Yeah, because that sounds about right. It sounds a hell of a lot, or a hell of a little bit to go on the run with. But for an attorney fee retainer, sounds about right.
Yeah, it does.
Any more than $100 left after things he wanted to buy, but I transfer money from my check into that account. So we kind of use it as a savings account too.
Okay, so did you leave any money in that account?
If we did, it was very little.
Okay. So on December 1st, we heard testimony already that your son was charged. You watched online. Is that accurate?
Correct.
Okay. We heard on the 1st, did you guys stay at the hotel in Lapeer or did you go somewhere else?
No, we went to the extended stay in Auburn Hills.
Okay. Why is that?
Probably for the cheapest rates, and it was a decent hotel. Not any other reason why.
Okay. So how long did you end up staying at the extended stay in Auburn Hills?
We ended up staying there for 2 days.
Okay. And then we've heard testimony that charges were going to be announced at some point. Did you know when charges would be announced?
No, I was kind of following the news articles, trying to get updates. My cousin was sending me a lot of texts, saying, I think they're going to charge you too. We didn't think I would get charged, maybe my husband, because the gun was in his name. So we had an awareness of it, but I don't think it really actually set in that it was going to happen until it did.
Okay. So
we heard testimony that on December 3rd, you end up at an art studio. Explain to us what was the hotel? Extended stay in Auburn Hills.
Correct.
Okay. Tell us all where you went. How do you get from that hotel to the art studio in Detroit, and why? Give us the rundown.
So we ended up going to Owasso to get our normal cell phones. They couldn't shut down accounts.
Why couldn't you shut down accounts?
Because the two-factor authentication. So it was sending a text message to my old phone number I didn't have. So I had my employer yelling at me to shut down my LinkedIn account, my Instagram account, because I had my employer's name all over it. So we had to get our cell phones with our old numbers on it to get that back.
Were you trying to deactivate Facebook and stuff too?
I was trying. Well, I already deactivated Facebook. My husband needed to deactivate his Facebook. I had to deactivate LinkedIn and Instagram, and I couldn't get into my email on my burner phone because of that two-factor authentication code thing.
Okay, so you guys went to Owasso and
Yes.
got what?
We got regular cell phones with our old numbers on it.
Okay. Then what?
Then it's when Andre, my friend, called.
Is there any reason you went to Owasso to get those phones?
Yeah, we didn't feel safe in the local area.
Okay, so you drove like the hour they tested. Okay, all right. So then what?
So my friend Andre, who owns the art studio, called and was checking in to see how we were doing, and he wanted to stop by our hotel. It was the night of the 2nd. So he actually came to our hotel that night, and he invited us to come to his art studio the next day just to be around a friend, he wanted to buy us sandwiches. He wanted to show us art studio. He's just a really nice guy that was just offering a friendship during that time when we didn't know what was going on. So that's how we ended up going to the art studio.
Okay, how did you get to the art studio?
I drove.
Okay, drove what?
I drove my car, and my husband left our other car at the hotel.
Okay, so we've heard about how one car is like left at this hotel. That's because you guys went together. To
Correct.
Detroit.
Correct.
Okay. Did you know you were going to get charged at that point?
We had heard they might announce charges sometime that day.
Okay, but I want to know, did you know you were definitely being charged at that point?
Oh, no.
Okay. So you tell us what happened when you got to the art studio. I think we saw him show you where to park. Is that what happened?
Yeah.
Why did you park where you parked?
I was parking close to the dumpster, and he told me to move away from the dumpster because people like to throw stuff out there. So I moved. He showed me where to park. So I wasn't taking anybody's parking space or blocking the dumpster or any of that.
Okay. So then what did you guys do that day?
He showed us around the building. And then we went to the art studio. Andre had a business meeting, I think at 11 o'clock that day. And so he left the building for a little bit. He came back after charges were announced. So he came back when we found out we were getting charged. He brought sandwiches back. At that point in time.
How were you feeling at that point when you found out you're getting charged?
Just freaked out. I've never been charged anything in my life.
Okay. So you've never been charged with a crime like this?
Like this, correct.
Okay. Of this magnitude?
Correct.
All right. So so you know you're charged, or you know that they want
Would you say, McKinley?
What was your plan?
Oh,
I know, right? You've never been charged with anything like this.
Does she have prior
Fair
convictions?
I don't know, but I was just the way that her attorney cleaned that up. I thought, yeah, she's probably got priors for something. Who knows, DUI or whatever.
Well, I was in touch with my attorney, you, and I was taking your advice that we're going to turn ourselves in.
When were you planning to turn yourself in?
The next day, so it would be Saturday morning.
Okay, why was that?
That's when the Novi court was doing arraignments that day.
Okay, so on Friday, the whole afternoon, you know you're being charged. That afternoon, what was your plan at that point? Or what were you doing at that point?
I was debating whether or not to go back to Auburn Hills and stay at the extended stay. And I think this is before we even knew there was a manhunt out for us.
Okay, Your Honor, may I approach the witness with the defense exhibit, proposed exhibit A? The prosecution.
On weekends, the courts rotate around
Do you
as to who's
object to
going to take in
submission?
arraignments
Okay,
on
thank
felony
you.
warrants.
Okay, A is admitted. Can you tell the jury what that document shows?
It's a priceline.com travel itinerary, your trip from December 1st.
Okay.
Last visited 12/3/2021.
Okay, so when you're, okay, on 12/3, are there also searches for another hotel?
I think so. Yeah, well, there's a Priceline checkout, Auburn Hills, 12/4, 12/5. So I think I was looking out for those dates.
So you were planning to, is it fair to say then you're looking for a hotel?
Objection deleting.
All right, so that,
Did I miss it? Did she give a reason why she went to stay at the art studio as opposed to staying at the extended stay?
To be around a friend, right?
The friend said, "Hey, I got a place you can lay low."
Okay.
that exhibit, what does it tell you about your plans for 4/4 to 4/5?
To be in Auburn Hills, extended stay.
Okay, what is Priceline?
It's an app where you can get last minute hotel deals.
Do you agree these are your searches?
Yeah, I'm always on Priceline.
Okay. Ultimately, on the night of the 3rd, were you aware on Friday afternoon if you could go into court that afternoon? What was your awareness?
I was not aware that we could go into court that afternoon. I was just waiting on direction from you to what we're going to do the following day and turning ourselves in.
All right. So the prosecution showed lots of pictures.
That's what I was
of art
wondering,
studio.
if they were like trying to save money, or if there was like, if they were getting evicted from it or something like that, other than just like, hey, I got a place you can hide out. But that's what I was wondering, if there's any testimony about that. Like, hey, we had finite amount of funds.
That's what it looks like, right? All right. Okay. Did you guys sleep on that mattress that night?
Yeah, we did. It was actually in the hallway, a common hallway the business is shared, and we pulled it into the art studio and slept on it that night.
Okay. Did you, the prosecution showed receipts and supplies that were bought, things like that?
Hey, Baker
Who went
Raiders.
to the store and did?
Welcome everybody from Broken Baker. It's a cool kid raid. Yeah, thank you very much. We are towards the end of, it sounds like maybe towards the end of Jennifer Crumbley's testimony, direct testimony anyways, in her own self-defense, or in defense of herself, rather. It's not a
My
self-defense
friend
case.
went to the store. We
Well,
gave him a
welcome all.
list, and he picked up things for us.
Okay. Why didn't you go to the police department? This is so distracting. I'm having a really hard time. I can move maybe and ask. Okay. So you're
Being so loud, they're right next to
who
the
bought
jury.
those supplies?
My friend did.
Okay. Why didn't you and James just go on your own to the police department and turn yourselves in?
Because we didn't feel it'd be safe.
Okay. Why is that?
Just the fact that the entire community and Michigan knew that we were expected to turn ourselves in at the police department, so they would know where to go.
Okay. And so that night, what did you and James sleep there?
We did.
What time did you go to bed? What happened? Just really quickly.
I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. We both, I'm prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep.
Okay. So you each took 4.
We did.
Okay. And so the next thing, the next piece of evidence we saw was them coming into that art studio. Do you recall that?
I
Or a
recall
lot? I
my
have no
husband screaming, and there was people with guns again in our face, officers.
What were you doing prior to hearing your husband screaming?
We were sleeping.
Okay. Were you aware there was anything going on?
No, it was not.
Okay. We saw the video, so we don't need to go through all of that. And the prosecution admitted, I'm going to put it up on the screen, People's Exhibit 150, and I just want to verify with you. I'm sorry, can you turn it on, Ashley? Okay, do you see it on your screen?
I do.
Okay, what is that?
That's an alarm we set for, or I set for the next morning.
For Saturday morning?
For Saturday morning, correct.
Okay, do you recall why?
Tiffany with a $9.99 super chat. There was a text to Brian from JC, I'm assuming Jennifer Crumbley, since James probably isn't texting her, that said she was looking for a place to stay where no one would recognize their names. I read when defense was scrolling on Cross. Interesting. Still, I mean, it still comports with their story, right? That they just wanted to kind of lay low and not have everybody know. Oh, this is why. So the defense made a big deal about this timer early on in the case, and I was wondering what this is for. This is so that they could wake up and turn themselves in. Got it now.
Okay, do you see it on your screen?
I do.
Okay, what is that?
That's an alarm we set for, or I set for the next morning.
For Saturday morning?
For Saturday morning, correct.
Okay, do you recall why you set it for 6:30, 6:40? Is there 2 alarms or 1?
Yeah, there's 2.
Okay, why did you set those alarms?
Because we were going to wake up and drive to the Novi courthouse and meet you there by 8:30.
Okay, and what was your plan there? What was going to be your plan when you got to Novi?
We were going to be arraigned.
Okay, now, there was
Everything's still
evidence.
up.
Oh, whoops. There was evidence that your purse and belongings were found in totes there. Do you remember seeing all those pictures?
I do.
Okay, tell the jury why those were your purse and personal effects were in those bins.
I didn't know if we were going to jail. I didn't know if we were going to be bonded out. I didn't know what was going to happen. So I had told my friend where I left my purse and my backpack, where I did have pretty much all my money in it, to grab those the next day, or when he's at the studio. He's not usually there in the weekend. So I put them in the totes just for extra precaution.
In some of the messages the prosecution admitted, you say that you failed as a parent. Are you a failure as a parent?
I don't think I'm a failure as a parent, but at that time, I guess I felt bad that Ethan was sad at those things. And I guess I don't know. I just felt like I failed somewhere. I don't really know how to describe it. It's just that point in time, I just kind of felt like somewhere I failed.
Do you believe there was anything, do you believe that you knew or had reason to know your son was a danger to anyone else?
No. As a parent, you spend your whole life trying to protect your child from other dangers. You never would think you have to protect your child from harming somebody else.
I feel like it was a weird answer. I don't like her answer. Do you feel like you texted your friend saying that you feel like you're a failure as a parent? Do you feel like you failed as a parent? No, I don't like her answer. No, I don't feel like well, actually, yes, I do feel like I failed him because I didn't understand all the stuff that was going on in his head, and I wish I would have known. That's a better answer, right? But it's frustrating.
That's what blew my mind. That was the hardest thing I had to stomach, is that my child harmed and killed other people.
Do you believe there were things you were thinking at the time, I should do this, but I'm not doing it? Do you look back and think that?
No, I don't. I mean, of course I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
If you could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
Okay.
Over the last 26 months,
I'm not sure this is going to work.
Has this been stressful for you?
What
Very
the?
stressful. Yes.
Have you had a range of
You
emotions?
lost your son to prison. 4 people lost their lives. 4 people lost their children. And you want to say, I wouldn't have done anything differently.
And then to say, I wish he would have pew-pewed us instead. Like, how about you wish you would have done a lot of things differently and he wouldn't have pew-pewed anybody?
And I'd still be with my son and we'd be living happily. He'd be off to college or whatever, graduating soon, or whatever, graduating next year. How about that? Yeah, no, there's a lot of things that I wish I would have done differently if it would have resulted in this, right? But I think she's scared that if she says that, then she admits that there's something that could have been done, right? It's kind of you're damned if you do, if you're damned if you don't. But I feel like there's a better way to answer that.
And this is why you don't get on the stand.
It really is, actually. I mean, this is a good reason why you don't get on the stand. So,
Are you trying to, do you believe you are the victim here?
I don't want to say that I'm a victim because I do not want to disrespect those families that truly are the victims on this. But we did lose a lot.
Okay. You've lost everything.
We did.
that's a tough question, too. I feel like these questions could have been phrased a little differently, though.
Well, that's been her problem all along.
It really has been.
Sorry, I was on a phone. What question got asked?
Oh, God.
Oh my God. You missed this? Okay.
Okay, sorry.
So she was asked if she would have done anything differently, and she said, no, I would not have done anything differently.
Jesus Christ, you can't.
And then she
Well,
said,
oh, no, it gets worse.
Would have killed them instead, like she and the husband.
Wait, what did she say?
She said she wished that Ethan would have killed her and her husband instead.
Okay, that's
And
actually
then there
not
was a-
bad. I trade my
Well,
life
that's
for those
okay.
children.
But it's not the
didn't
way
say it that
it's
way.
the way she said it, I guess. That's not how it came across.
Oh,
then-
God.
And then she asked, we were just saying is that the defense attorney asks like bad questions. And so
Is
she
the
asked,
judge
do you feel like
Mirandizing her right now? It looks like she's getting ready to warn her or something.
I think she's sending the jury out. I think we're done for the day.
Oh.
And then she said, do you feel like you're a victim here? And the witness said, well, I don't want to take away from anyone else who has lost, people and stuff, but I feel like we've lost everything too. It's just a bad Q&A, a really bad answer.
Well,
I wouldn't have
that's
changed
actually-
anything. No, I absolutely would have changed everything, except I
Mm.
didn't know. I wish I
Yeah.
would have known. If I known now what,
I know.
now
Yeah.
back
if I could
then,
go back
I would
in
have
time, I'd
changed
fix
stuff.
it. Yeah. But I think that whole point of like, we've lost everything too, like, yes, I've been in jail for almost 4 years. Like, my marriage is done. My family's gone. I'm never going to have a normal life ever again. I don't think that's actually a bad answer. But
Okay.
yeah, I'm sorry. I didn't get to hear all that. But jeez.
I don't like the one where she says I wouldn't have changed anything. I don't.
Oh,
like
yeah.
that.
That's not. Oh, God.
No. It's the right answer. It's a correct answer because I can't change anything. That's
Yes.
fine. It's the way she said it.
Yes.
I would not have changed anything. So if you knew now, if you could go back, knowing what you know now, you wouldn't have changed anything. It was just a bad way to answer the question. It
Yes.
sounded
Also,
bad.
hey, guys, this is where if you're sitting there prepping with her, no, you're going to say it like this. Like there's a lot of, you're not supposed to tell them what to say. Like, no, it's going to get said this way.
Yeah.
Yeah.
Especially with
to
the
be
defendant.
honest.
That's kind of like one of the ways you kind of get away with shaping testimony. Like, I'm not telling you
There's
what to say, but
nothing
you're gonna
wrong
say
with
explicitly this way.
helping your client answer the question, so long as it's not perjury, right?
Yeah.
So you can help them shape their answers.
Read, listen to, or watch any news reports about the case.
Oh, okay.
Under law,
I thought she
the
was giving like a
evidence
Fifth Amendment
considered and
admonishment.
decided
It's like,
case must meet
geez.
certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news
Yeah, but she
reports
should
do
have
not
said that,
meet
just Jen.
standards,
She
it
should
can
have
be
said that. She
incorrect
didn't.
news
I'll go back. I want to get
that
Sean's take on it.
might
I'll go back.
unfairly favor one side.
Sounds like the judge is sending everyone out and we're done for the day. So we got a few minutes. We'll go back.
Do not go on social media, do not post, do not go on Facebook, do not do research, do not discuss the case with anyone, do not watch the news, do not read a newspaper. You guys have been really great. I mean,
Because I think my answer, I am Dave, is what the defense attorney was going for, but she didn't get. Absolutely. I would have changed anything, but I didn't know. That's the answer you want. But you didn't get it. So you need to ask a follow-up question. Let me just see if they're going to do anything off the record, and then we'll go back.
I will let the jury go right now so that I can ask if there's anything. Do you consider?
Is it okay if she comes out?
Yeah, she can step down. You can be seated. You're going to do cross tomorrow
Yes.
morning.
Cross
And
tomorrow morning.
you know
Okay.
what You're gonna do next.
I don't. Your Honor, my client and I have a number of witnesses on our list.
Okay.
And to be quite frank, I'm gonna go to meet with her,
Okay,
or I have arrangements to meet with her.
okay.
I have opinions about what we should do. I know that our opinions have not matched, and so we need to have some discussions. I just don't know who I'm gonna be calling based on that. But the prosecution has my list.
Okay.
It's the same as it's been, nothing's changed.
Okay.
I actually have 2 names I can give them that I know I'm not gonna call.
Judge, shortly before trial, the people filed a notice of intent to admit something should the defense counsel assert a privilege, that privilege being attorney-client communication. Questions asked of the defendant, I believe, caused a revisiting of that ruling.
Okay, you know what?
They're gonna try to make this defense attorney a witness and have to disqualify from the case.
Thumbnail photograph recovered off of the defendant's phone from a time period where the police were on scene at 1111 Bellevue in Detroit. The defendant has testified that she was waiting to hear for instructions from Ms. Smith. She can't testify to any communications between herself and her attorney without waiving the privilege. That privilege has been waived. We should be now entitled to explore what that text message was. The timing of it was very important, especially considering the timing of the 911 call in Detroit, as well as the timing of the fugitive team's arrival in Detroit, and the timing of.
Oh, what time
the
was that
arrest
text
of the-
message
Are
sent?
you talking about the text that I already saw,
Yes, Judge.
the 2-word text?
Now, but the issue is, when it was seen, it was immediately closed because it was recognized as potential.
Okay, I
very-
understand that. I guess I'm asking you to be more specific without me being more specific.
Well, there were 3 texts, not 2 words.
Okay, no, is that what I saw already?
Yes.
Okay, so I guess a few things come to mind. When I received that, we had a previous motion about this. It's unclear to me whose phone that was. That's just one thing among many other issues.
Right, we can't explore it if it's a potential attorney-client communication. So it was never investigated. That's why we brought it to the court's attention and counsel's attention immediately.
Your
And
Honor,
that's after consultation actually with the Michigan State Bar Ethics Hotline. So
Well, one of the reasons I asked you that is because I know there were 4 phones from there, and 2 of the phones didn't have specific numbers. I don't know if that came from one of the phones that specifically belonged to one of the defendants. That's,
yes, the answer to that question is yes.
Your Honor, if I may, when I was questioning my client, I was asking her what her plan was, what she was planning to do. She said what she was planning to do. I didn't expect that she was going to say, I didn't expect she was going to say anything about me. I thought she was just going to say we were waiting for information, we were waiting to turn ourselves in, waiting for
Not buying
directions, and we had a backup plan. We'll go to court on Novi in the morning. I don't believe she's opened the attorney-client privilege as to this topic. And to be honest, I don't even know what they would have.
this hasn't been an issue since the beginning of the case.
It's not just the privilege, it's also to impeach what we believe to be false testimony. That's important in cross-examination.
Your Honor, the prosecution has tried to make me a witness, but I've made arrangements
feet.
often with law enforcement and prosecution
They're sitting
teams
3 feet apart.
to turn my client in. I have never
The
seen.
police are not required to wait.
I'm not saying that, but
Right.
what the police did is they tried to make me a witness. They made police reports with my text messages and tried to turn me into a witness
when it's typical for
I think you're giving him too much credit.
well, for when it's I texted Karen McDonald and said I was representing the Crumbleys.
Okay, but
On Friday morning, she
police-
would not get back to me.
She doesn't have to get.
I know
back to
she
you.
doesn't.
Police do not have to ask you for permission to arrest your client.
I completely agree. That's not what I'm suggesting. I'm suggesting that I was waiting for Miss McDonald to work with me to turn her in because she texted me the night
Prosecuting
before
attorney does
we'd
not
work
arrange
it out.
fugitive surrender. We
Well,
actually had evidence of that.
I
Sergeant
thought-
Hendrick as well as Lieutenant Willett.
I thought we had professional courtesy going, that we were working together, and then she wouldn't call me back all day.
Okay, so for any of you guys who are lost, what was happening here is professional courtesy, at least in this area, dictates that there's no law that dictates, as the judge said, but professional courtesy usually dictates. If I have a client that's looking like he's going to be charged, I'll reach out to the prosecutor and to the police and say, hey, before you charge him and pick him up so he has to spend a night in jail before he gets bond assessed, give me a call, I'll walk him in. Usually that happens. They don't have to, but that's the professional courtesy. So that was what she's talking about. She said, I emailed everybody, I called them, and I said, hey, before you pick them up, let me walk them in Saturday as a professional courtesy. And she had conveyed that to her client, as I would too. Hey, I'm going to reach out and see if we could just walk in on Saturday morning. So you guys don't have to spend time in jail.
Sounds fine.
And it sounds like, yeah, it sounds fair because we do it all the time. And James and Jennifer were like, okay, well, our clients our attorneys are telling us to hang tight and we'll walk in on Saturday morning. That's the issue. So now that the witness apparently testified skirting that issue, the question is whether or not communications between Jennifer and this attorney can come in. Did Jennifer waive that privilege? Because it's only Jennifer's privilege. It's not the attorney's privilege. So, sorry.
So infuriating.
I know, right? Because this is a professional courtesy sort of deal. There's no law about it, but this is how they.
And I said,
they'd
okay,
use it
then
to
we
hold
have to
them on
go
bond.
turn you in. I want to turn her into a court. So we went to the Novi. We were going to the Novi court at 8:30 because they do weekend arraignments.
Okay, I've heard all of this before, but the thing is, you cannot testify to this.
I understand, but I'm saying that the prosecution is trying to make me a witness by having them
trying
put
to keep
police
within the
reports
guidelines.
together.
That's why we had the waiver.
This came up from the beginning of the case. There was
I
concern about that.
I agree with you, and I thought the concern was over because they dropped it, and I
had to bring it up
No,
yesterday.
they didn't drop it. It's just been dealt with in waivers and motions and things like that.
Waivers.
So, if your client raises something, I guess I'd want you to specify whether it's in a filing exactly what you're saying or exactly what you want to admit, because I think that we're, treading on difficult ground that
Judge-
we've been treading on since the case started.
We signed a waiver specifically for this. It was
Not for
March
this.
of 2022, that paragraph 13 of that waiver, the defendant will not be able to use, and actually the court on the record said, Ms. Smith, you understand that flight is issue, and an issue in this case, the court remembers, but it was early on in this case.
Your
That's why we
Honor,
had the waiver.
Could the court-
This pen is special.
Sorry.
We can't interrupt each other. So I guess tell me what you are specifically requesting.
So
Because
we need,
the chronology, because she says she was asleep, or the police are at the door, or whatever it is.
yes.
With this
it
kind of
goes into
stuff, I
all of
should
that.
say half Irish.
Yeah, it goes
This
into
kind
all
of
of that.
stuff.
So
This
there's
is
this, again,
unusual.
this was a thumbnail of a text message that we immediately, the individual prosecutor's office who saw it, immediately closed it because he recognized a potential attorney-client material. Before he did, he noticed the timestamp on that. The timestamp is exactly, I think it's actually 2 minutes off of a timestamp from a text message between Ms. Smith and Sergeant Hendrick, where Ms. Smith indicated she cannot get a hold of her client. Now, I want to cross-examine Jennifer Crumbley specifically about that because she put that an issue in front of the jury.
Okay, specifically about whether or not she was in contact with her lawyer.
What, can you just have a minute?
Yeah.
It's bad when the clients don't call you back and you're like, I'm trying to get a hold of her.
She can't use your shield as a sword. That's a problem.
Your Honor, I'm suggesting that if my client opened the door to that in any way, that you instruct the jury they're not to consider it and strike that testimony.
we did not intend to open that door. I don't even remember, and I don't even know what that text message is. I saw that. I obviously responded to their filings. I have no memory of that text or this timing. So,
Okay, what does that have to do with anything?
well, I'm just saying that I would just say that this should just be instructed to be inadmissible and tell the jury to absolutely ignore any testimony about any communications with the attorney.
The waiver, the defendant signed the waiver, defense counsel signed the waiver. It's, again, sword and shield, Judge. This is exactly what counsel is doing. And we can have someone from computer crimes extract any conversations,
law,
communications
Max.
between the
It's just
defendant and her
professional
attorney.
courtesy.
The court can review it in camera.
I think what they're doing is
I think that you're
illegal.
specifically
They're breaking the rules.
trying
It's just
to
being an
impeach
ass.
Her statement that
Wow.
I did not talk to my lawyer that night. I'm trying to remember the exact statement.
Well, the timing of when she was awake, when she sent the message, the fact that she indicated that she was asleep, the method in which she indicated how she fell asleep, and with the assistance of 4 Xanax. It's important to explore those particular details, Judge. The timing is crucial.
Okay, well, I might allow you to ask the question. You said you were asleep at 11 o'clock because you took 4 Xanax. I might allow you to ask, isn't it true that you texted your attorney at 11:03 or whatever it is? I might let you ask that. But the thought that you want me to do an in-camera review of every communication between Mrs. Crumbley and an attorney that could potentially breach the attorney-client privilege,
I'd be satisfied with just that timing, that message, Judge.
okay, well, I guess I'm gonna invite you. I feel like every night you're getting a homework assignment. Of course, I have my own homework assignment. But if you would like to send me a case, do a short memo, anything like that, if you'd like.
So
me
the
to-
judge isn't saying
maybe
yes.
at 4 o'clock in the morning, I'll
She's
just-
asking the attorneys to brief the issue.
The issue is that Jennifer Crumbley testified that she did what she did because her lawyer told her to. That's the crux of it. And there's evidence to the contrary. And I want
Google
that
Vice
evidence to be there.
sleeps and
Okay,
deletes
select
people from
people.
chat.
Okay, those are two different things, though. Are you specifically talking about the text?
So now the state's shooting for everything, it sounds like.
Are you talking about other
Mm-hmm.
communication that was dealt with previously?
I think last week is the one we're referring to, Judge. That's
Okay, all right.
the motion that was filed.
Okay.
There's also text messages from Ms. Smith to an officer. There's no privilege there.
There's no privilege.
Correct. So that's naturally going to be part of cross-examination.
Okay.
But specifically right now, I want the court to review that. And we're asking permission to cross-examine on that, Judge.
Okay, well, I think I
Passing
can have someone
permission,
from my staff
jeez.
Go back and see what the specific statement was about that. That's for starters. And additionally, if you would like to give me any law on the issue, I don't know if there's any law beyond what we briefed last week. But
Well, that's why the waiver.
Yeah, the waiver. Well,
I understand what the prosecutor's trying to do and why he wants to do it. The problem is he's running up against attorney-client privilege, so that's
Yeah,
why.
he's right up against the Fifth Amendment and the Sixth Amendment right now.
Mhm.
I may allow me to do that.
She said that she took 4 Xanax and passed out.
Anything
And if
else?
she's responding to text
I'm going to
messages
ask
from
someone
her
from my
attorney,
staff
then
to
she's
do
obviously
that
not
and
sleeping,
determine
right?
exactly what was said. I think that's important.
But
It was
what
in
time
March of
did she?
2022.
They
Oh,
didn't.
you
They're
said-
not talking about. They're skirting around the time. They're not revealing it right now, open in the public. Everyone has. Well, the judge and the defense attorney has seen it. I don't think the prosecutor knows what time that message was sent, and I think that's what he's getting at. He's like, I want to be able to look at this and examine it, but it's already been sealed off. It's been addressed by the court, who looked at it in camera and said, no, this is attorney-client privilege. You cannot see it. That's why she says, you're talking about those 2 text messages that I saw that I reviewed.
Oh,
Waiver
oh, they're
it
just
is.
trying
And
to get it.
the initial
Well,
waiver.
Yeah.
I'm sure I have the waiver. Yeah, I have all those waivers. I'm familiar with the waiver, but what, to review the record to see exactly what Ms. Crumbley said that, okay. I'm trying to be careful. Anything else?
I don't think so, Judge.
No, Your Honor, thank you. I will email the prosecution tonight, who I plan to call.
All right. Thank you.
Thank you, Judge.
All right.
Yeah, no, there's such a thing as professional courtesy, but the problem is when you rely on professional courtesy, if the other side just screws you over, there's nothing you can do about it because the law doesn't support it. So
Yeah.
always be weary about professional courtesy. I had a judge sanction me because I refused to honor professional courtesy once, and that was thrown out so quick on appeal.
You had wait, you had what?
I filed a motion, and the opposing party substituted in with new counsel, and new counsel asked for an adjournment. And I said, no, this is the second time I filed this motion, and I'm not going to adjourn it, even though you're new to the case. Sorry. And so the opposing counsel, this older woman, got up in front of a judge who she's like best friends with. He was like, and he made me come in today, and I don't feel well, and blah, blah, blah. And the judge was like, sanctioned me. I was like, okay, we're going to appeal that. Because you can't. It's a professional courtesy to adjourn a motion. There's no law that says I have to.
Everyone, I don't want to forget, like and subscribe if you have not already.
Yes.
Hang on, I want to go back a little bit. I don't even know where I could find the spot now.
For us. Okay, Your Honor, may I approach the witness with the
I don't know where it is. I don't want to just like keep bumping around and stuff. But I was going to try to get to that spot. I can find it. Oh wait, hang on. That was the end of her.
Oops, there. Do you remember seeing all those pictures?
I do. He bonded out. I didn't know the next day or when he's at the studio. He's not usually there on the weekend. So I put him in the totes. Just at that point in time, I just kind of felt like somewhere I failed.
Do you believe there was anything, do you believe that you failed as a parent? Do you?
All right, this is where it starts, Sean.
In some of the messages the prosecution admitted, you say that you failed as a parent. Are you a failure as a parent?
I don't think I'm a failure as a parent, but at that time, I guess I felt bad that Ethan was sad at those things. And I guess I don't know. I just felt like I failed somewhere. I don't really know how to describe it. It's just that point in time, I just kind of felt like somewhere I failed.
Do you believe there was anything, do you believe that you knew or had reason to know your son was a danger to anyone else?
No. As a parent, you spend your whole life trying to protect your child from other dangers. You never would think you have to protect your child from harming somebody else. That's what blew my mind. That was the hardest thing I had to stomach, is that my child harmed and killed other people.
Do you believe there were
His son's still sniping us
you were
still?
thinking at the time, I should do this, but I'm not doing it? Do you look back and think that?
No, I don't. I mean, of course I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
If you could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
All right, so Sean, what are your thoughts?
Do you feel like you're a bad parent? I mean, in hindsight, yes. Like you say, she should be throwing herself on the sword. Like, oh my God, I completely fucked this up. In hindsight, I clearly did. Like, I don't like. I mean, there was a police shooting. I remember when I was in law school. It happened where I was in law school at, and the guy was on a motorcycle and he stopped. And he's standing on his motorcycle. He takes his glasses, puts them, oh shit, I realize my camera's off. He takes his, I realize I put this on too. He takes his glasses off. You can see him sitting in the body cam. He goes like this from behind, and you see him, and he just turns around real quick, see what's going, bang, and he falls over. Guy doesn't move at all. The cop shoots him. And, the guy was unarmed, completely fucked it up. Cop comes up there and he says, if I was there again, if I had to do that 1,000 times over, I would have shot him 1,000 times.
Oh.
And like there's nothing wrong with saying like, yeah, in hindsight, I probably shouldn't have done that. Or in hindsight, I wish I would have been able to care for my child. I wish I could go like she should like I wish I could get in a time machine right now and go fix this. Now, I don't think there's anything wrong with her saying like, I wish he would have killed us instead of his friends, like his schoolmates. I think that was fine. But yeah, I think they really should have been working on what she was gonna say. And that's something like I think they know she's got to take the stand. That should have been months of preparation. Like this is the movie performance of a lifetime. You need to prepare. And I don't feel like she really had that, or she might just be kind of dull as a human being. I don't know.
Did not like the answer. I didn't like the way she said it.
Yeah.
I can interpret it different ways, but that's the problem is it's left up to interpretation.
Oh,
Hey,
yeah.
Kurt,
Hi, Kurt.
What's up?
Hi, Kurt.
what are your thoughts?
Perhaps the most disastrous direct I have seen in quite some time. Horrific for the defense, and it just she's unlikable, completely unemotional. She has, when she's talking about things in the past, no sense of that she cares, no sense that she feels any depressed. Are you a good parent? Of course I was a good parent. As you look into the past from your present position, did you see any mental health? No mental health in the past. Is there anything you would do differently? Nope. I wouldn't do anything differently at all.
God, that killed me the way she answered that. Oh my God, that was horrible.
Are you a victim? I don't want to say I'm a victim, and that's about the time where I'm like, well, we're done here.
Yeah. Well,
we're done here.
Yeah, like I said, there's ways she could have answered it better, but also I think after a while, you put somebody in jail for like 3 or 4 years, you literally fucking break that person. So I think at some point she's just kind of like, it's hard to like, especially like somebody who's they are a normal, like they're a good person, and they've been in jail now for how long?
Yeah,
like that breaks you, that wears you down. I mean, I think she's that part of that. It's also hard to get around. She's in fuck it mode half the time, I think.
God, yeah, it's like a combination of stress from being in there and just everything going on and nervousness being on the stand. You're fighting for your life. She doesn't really know what to say. What can you say? But
Well, that's
again,
where your
leaves
attorney
it
should
all
help
up
you.
into- Right. You coach them. No, would you do anything differently? Well, obviously I can't. So, but if I knew now or knew then what I know now, then I obviously would have done something, but I didn't know.
I think
that leaves very little interpretation.
I think your earlier observation was correct, though, making law simple. I appreciate that she's been in prison all this time, but a lot of this time, because we need to put her on the stand, should have been spent in prep. And we should have thought about how we're going to ask the questions and how we're going to go about it and how we're going to, and issues. And it felt almost unprepped, which is hard to believe. And the answers, some of the questions, if you knew that's the answer, why even ask the question, right? If you know the answer, if you know the truthful answer is looking back, did you see any mental health? And you know the truthful answer is no, why ask the question? It's like, because it makes you seem completely oblivious. Even in retrospect, oblivious.
With all respect to the defense counsel and Kurt, I had a client that I had prepped extensively on his. I don't put my clients on the stand. I had prepped him over and over and over. But when I put him on the stand and I asked him that question that I had prepped and I thought I knew the answer, he came out with something that was essentially incriminating. And at that point, I was just like, oh my God, I don't even know what to do. And
it happens a lot, actually.
Yeah,
they get nervous on the stand and they just like forget everything that y'all have already prepped, almost, I think. Right.
Well, again, for such a key witness, and this is the witness for you because apparently you got nothing else. Again, you'd want to go through it a couple times, so hopefully that doesn't happen.
I'm curious as to, so I asked Sean and McKinley this question earlier. Kurt, now you have a magic wand. You can call up any witness you want in favor of this defendant. Who are you going to call? Who's a good witness for you? Because there's other witnesses coming tomorrow.
Well, if my magic wand is that magical, I'll call Ethan. Are we ignoring Fifth Amendment implications?
We can't call Ethan. No, but I mean, but who would be a good witness that you think would be other than Ethan?
If there were other people that saw them interact with their child to show like how loving and caring they were, other than just the Facebook reel. So if they were with other parents on other occasions that saw how they were interacted with the child, so they could show that they were responsive to the child's needs and not ignoring them and stuff like that, that might be good.
That's a good one too. I haven't thought about that. That would be a good one. We do a lot of that in family law, actually. But that would be a good one.
Maybe family members, to the extent that there was a lot of what you might call co-parenting on any level.
Yeah.
That you could bring in.
Peggy Cole with a $4.99 super chat. How come the defense attorney didn't post a motion to dismiss? How come the defense attorney didn't post? Okay.
Apparently they said we're going to bring that motion later, even though the judge gave you the opportunity, which seemed odd, but okay. You meant?
I think. Sorry.
No, I'm sorry.
My
You
phone
go
was
ahead.
going off. No. I think it was just for judicial economy. They wanted to get their client on the stand.
Well, I was going to ask you, David, because I know, like, where I'm at in Ohio, if you don't raise that you don't raise the motion for acquittal, that can be considered error, and ineffective assistance. But I mean, there's always courts are going to look at that. But like, you have 2 times to bring it, and I didn't know in Michigan how do they treat it if you don't bring it right away and you wait till the end.
You could bring it by agreement. Like, listen, we're not going to do it now. We're just going to go straight in. We got witnesses ready to go for judicial economy. That's what I said. It wouldn't be a problem. They should bring it though, and they'll probably address it tomorrow morning before anything else goes.
Okay.
But maybe after Jennifer's cross, maybe they'll bring it though. They'll find a time to excuse the jury and address it. Because the defense have hired an expert. What do you think about an expert, Kurt? Do you think I don't know. I was thinking maybe a mental health expert, but the problem is that we don't get Ethan's medical records in. So what's it matter?
Yeah, so what's the expert in?
I feel like there's got to be some way to bring in an expert who can speak to issues that would make it reasonable or not reasonable, or speak to how maybe teenagers behave and that these behaviors perhaps are not as dramatic as they seem in retrospect. There's got to be someone like that.
You know what I was actually thinking is that the expert that the state wanted to bring in, that the judge said no because your own expert says you can't predict this. I'm like, well, then call that expert for the defense.
Right.
Wait, why didn't she do that? Wait, so she already knows the state has an expert who says like completely unavoidable. Like
30% of
what's
the
unknown.
30% of the test suspects or subjects rather, police, mental health professionals, all these professionals only got it right like 30% of the time. And so that's why the judge kept it out. And I would have been like, I'd call
why
that
did the judge keep that? Why did the judge keep that out?
Because it's not reliable.
Well,
that's kind of that's the problem. That's the very problem. It's not reliable.
Well, no, that actually what's an indicia of the reliable? Like she could have brought that in to show it's not reliable. There's no way to know the duty of care. The duty of care. Well, it's not reliable. Then there is no duty of care. The duty of care is basic standards of your duty of care as a parent. Feed them, not beat them, and don't let them die of exposure.
Yeah, for sure.
I mean, that's essentially what it is.
Get that person on the stand. That'd be good.
Yeah, no, like I don't know. Oh God.
I would call them. I don't know why you wouldn't call them. They would be hostile.
I would 100% call them because they're going to have to be, we're bringing in the science. The science is saying that this is not reliable. That's credible science saying we don't know. Oh, God, I can't. I never heard about that. My God, that would have been.
Oh yeah, so I have the judge's opinion on how crappy it is. I'll send it out to you guys if you want to see it. On how horrible that expert is and how they can't predict anything and why it's excluded. And I'm reading it. I'm like, this would be a great defense witness. Sue with $4.99 super chat. Have any of you lived through something really traumatic? It's not clinical. It's not textbook. That's true.
That's true. But remember, like I've said this before, and I going all the way back to the dumpster bros, your jury is full of normies. Normies have common expectations and common experiences. What is traumatic stuff makes you upset and emotional. So yes, you're going to have to explain those things, but people generally have stereotypes and preconceived notions that guide them. And generally, people have issues when it comes to emotional problems and emotional trauma. So they would expect you to react a certain way. And when you react like what seems like as a stone cold psychopath, that's a problem. So yes, everybody reacts differently, but for most people, they're going to say, well, if I was up there, I'd be a mess. And that's, and I don't know if I don't think I've mentioned this on here before. A trial is sales at the end of the day. I'm selling something. It's sales.
It's performance art. It's
Yeah,
performance art.
I'm selling you something. And if your guy's selling you it's no different than selling air conditioners or steak knives or Swanson frozen dinners, really, at the end of the day. Can I get you to buy what I'm selling? My theory, my story. And I'm putting on, facts and things here. Do you like my marketing materials? Do they strike at you the right way? Jennifer Crumbley's part of that marketing presentation. So it's got to strike the right way for that, your focus group, your test audience, your intended buyers. So yeah, that's the problem. You have to meet the jurors' expectations to an extent. And I hate to say that, but that's the breaks.
She wouldn't be able to call James because he's going to plead the fifth. He's not going to testify. And so according to this judge, you can't even call him to the stand to have him plead.
That sounds right. I've heard that case law, but in other cases, other circuits, that sounds right.
Yeah.
Yeah. That said though, I think that's you don't know for sure. And you should have the right to call them and confront them. And if they don't want to talk, fine. But until they do it, you still have that right to confront them.
We were actually read through part of the case law, and the court has said that it's not a violation of your right to confront a witness if they're not actually on the stand and testifying. So they're not violating your rights by not allowing them to be called to the stand, and it could be overly prejudicial to one side or the other to call them to the stand and have them plead the fifth. So we're just going to say you can't call them to the stand. It's essentially what the Michigan case said.
Overly prejudicial, but I mean, let's say he starts talking, then starts pleading the fifth. Are we going to say, oh no, we got to strike it all because it's overly prejudicial? Like, evidence is going to be prejudicial to some level. I mean, it's got to have massive probative value. Like that guy wouldn't even tell us what happened. He wouldn't even come out and, I don't know. I disagree with that concept. It's, like
I don't like it either, but I understand somewhat the rationale in that, you're not being confronted with a witness that you can't, challenge. You don't have the right to confront because they're not being called, right? So they're not violating your rights because he hasn't actually testified because he's pled the fifth. And so, but putting him up there could be a 403 balance, and the court said no. I get the rationale. I don't agree with it.
I still think it doesn't. Well, at the end of the day, too, it also only one side's guaranteed a fair trial. I don't care if it's heavily prejudicial to the state.
Yeah.
Oh well. Oh well.
Well, I think actually the case case originally started with a co-defendant being called. Two guys were convicted, and there was a co-defendant that was called, and he pled the fifth. And so presumably, I don't know, is that overly prejudicial in favor of the defense or in favor of the prosecution?
Well, was that where they went to trial as co-defendants? It was a joint trial.
And I think he had pled out.
Oh, okay. Well,
the guy who was going to testify had pled out, but then for some reason he was pleading the fifth or something. I don't remember. I have to pull it up again. Sign me up for Sean's steak knives, please.
Yeah, thanks.
Thank you, Farrell, for the $2 super chat. But yeah, no, it's been the theme of mine throughout this entire case. I don't like the style of the presentation. I don't know what else to say. The words are kind of there. The points are being made. The lack of evidence is clearly there, in my opinion, but I don't like the style of presentation. And like Sean said, it's all sales. I have nothing else to add other than I don't like the style of the presentation. It was just so bad.
No, I like nothing about the style of the presentation. It didn't make sense. It didn't feel coherent. The answers seemed off. Didn't seem helpful. I'm still stuck on the issue of why we went into all that discussion about the affair and everything. I don't get it. I thought the point of it was to talk about the police corruption, because that was sort of like the issues. Like, I want to talk about the police, and arguably that opens the door. Now, personally, I don't think it opens the door. but we blew right past that issue. I don't care about the door. Let the door go open. But then we get to the end and he's like, well, no, I didn't feel pressure at all. So the state obviously had no problem discussing it because they're like, we're happy with the door. So, we want to discuss it. I thought this was your problem. So you didn't need the artifice. She could have just started, with, how about that affair?
Yeah. Yeah, I agree. I don't think the door needed to be blown open. I think what happened there was the defense is so wishy-washy on the questions. They're so muddied in the questions. She's stepping over the line and the prosecution's taking advantage of it and saying, well, she opened the door. And then the defense is like, well, that's fine. If you're going to say open the door, then open it wide open. And I just want to be able to run with my argument. I don't think it worked. McKinley, you got it off. I'm going to be shutting down. I've been streaming for 10 and a half hours and I am done for the day.
Okay. Bye-bye.
Bye, McKinley.
Oh, bye, McKinley. Yeah.
Bye, McKinley.
Oh,
That was-
shoot, David. Hold on. Give me 1 second here. I'm going to set up my, I forgot to get mine going for.
Oh, you got a stream going?
Yeah, I was going to do, Michelle Trakunis for, part of what they did today.
No, I'll redirect everybody over to you if you're going to keep going with
Yep.
something else.
Yep, I will be. Hold on here.
Farrell, thanks for the words of encouragement. No. So, Kurt, you think she has a prayer of getting
She's
an acquittal?
doomed. She's doomed.
I mean, I still think I think she was probably doomed regardless of who was representing her, though.
It might be fair. I don't know. I'm a fan of good lawyering skills. You think Johnny Cochran get in there and she's doomed?
Yes. This is a political trial. This is a show trial. Nobody cares. I mean, this is a lynching and they want someone to lynch.
I don't know. I think
that's a little dramatic for my taste.
Well,
yeah, no.
This woman did nothing and they want to string her up and throw her in prison because like I said, this is an emotional tampon case. Okay, great. Tate and all these other kids are dead because they, Ethan showed up and started hosing them down. Like, at what point is this her fault? It's not. They wanted someone to blame. They needed somebody to blame. Well, we can't blame the government because that looks bad. So the government found someone to blame. So
I think she should have hired me as well, Farrell. But I can't go chasing the cases. They got to come to me.
Well, we can
what
have
do
you
all
on,
think about
David, as me interviewing you.
All right. Difference in opinion on who to call tomorrow. Is it just? I think it's a little bit of jabbing back because the prosecutor was so indifferent about who he was going to call when, so the defense could prep. And so I think she was just poking back a little bit. She's like, "I'll send you an email about 9:00 tonight. I'll let you know who I'm calling and when." I think that's what that was. Honestly, at least I hope so.
It's no one exciting. I'm quite sure. Whoever this is,
I'm quite sure.
I agree. I agree.
It's all over but the crying, as they say in the song.
It would be amazing if she called that expert, though. It would be amazing. Sean and Kurt, I'll email you guys that opinion, that judge's opinion.
Okay.
On the expert, and that's why I say
if she calls the expert, then I'll feel better.
Everything that this judge has said during this trial, everyone's like, "Oh, she's pro prosecution." She delivered a very fatal nail to the prosecution's case by excluding that expert, and so that's why I'm saying she's fairly balanced. We've talked about lots of things that have been excluded from this trial that the defense seems to be wildly bringing in, despite that. So she's made a lot of pro-defense rulings.
Didn't the judge in the first place say that this cause of action couldn't proceed, which led to the Court of Appeals?
No, well, she said it could proceed. So there was a different standard.
The other way around? Okay.
There was a district court judge that found that there was probable cause that a crime actually committed and that these people committed it and bound it over. Then there was a motion to quash, which is essentially like an appeal to this particular judge on the district court's ruling, which is sort of a higher burden to overcome. And she's like, I don't see how I can overcome this burden on the bind over, and denied the motion to quash the bind over.
Ooh.
And then that went to the Court of Appeals, then the Supreme Court, then back to the Court of Appeals, where we had the oral arguments we heard back in July or whatever they were.
Yeah.
And then, and now we're here. So that's all that happened procedurally. So she maintained the cause of action, but it's a different burden than the original probable cause standard.
All right. Well, I'm going to sign off because I'm tired and I've been streaming a lot. I need sleep.
All right. Take care, Kurt. Thanks for jumping
All
on.
right, I'll see you, Kurt.
Love his
Bye for now,
opinions.
guys.
All right.
Yep.
See you guys.
Thanks.
Everyone go sub to Kurt if you're not already. I'm going to put his link in my description too, so you guys all have that. And Sean, whenever you're ready, you know, put your live stream up
I'm over there. It's all ready to go. Guys, we're gonna do try to get through Michelle Trakunis. I mean, all we know is yes, a lady was murdered and her husband did it, and it's very likely his fingerprints are all over the stuff we found, but we still don't know how Michelle Trakunis figures into this at this point. They still haven't shown us what she did. So that's the only. Well, no, I mean it is dragging on to an obnoxious level. They've
Case
like
is so slow. It's so
well,
slow.
It is, but it's also just like, okay, get to the part of like, do you find like we found this bag? Oh, it's got Fotis' fingerprints. Like, just for the love of God, get to the like, find me her fingerprint inside a trash bag, and okay, fine, she knew. A trash bag covered in blood, like with her fingerprint there. Good, you got me.
Thank you
Just
very
get
much
me
for the
there.
$50 super chat. Thanks, Dave Bob. You are very welcome, Carraz.
That's nice.
Much
50
appreciated.
bones. Yeah.
Nice. It was worth my effort today,
Yes.
but no, I appreciate it very much. Thank you.
Yeah.
And until tomorrow morning at 8:30, I'll send you guys over to Sean here in a second. He can get all of his stuff going. I got to cue.
All right, I'm all set. I'll see you guys over there.
All right,
See you,
take care,
David.
Sean.
Yep. Bye.
All right. Thanks again, everyone, for joining me. Thanks to everyone that joined me on the panel. We had Nick Staroff. We had Legally Live. We had Sean. We had Kurt. And I feel like I'm forgetting somebody. But anyways, thanks, everyone, for the super chats and for joining me. And we'll see you tomorrow for the cross-examination of Jennifer Crumbley.
When I was young, my dad